A good afternoon to all of you. I welcome you to the second class in the PT Marathon. And we were all very excited to witness your enthusiasm yesterday. And we hope to replicate the same impact today. My name is Ankit Sharma. I am a faculty at KSG. I'm also a lawyer by training, and I have expertise in constitutional law, parliamentary concepts, and governance. And the reason that I have been called upon to present this particular session is to take up the important points about the subject of polity, focusing upon the prelims examination this year. Okay, so as I am given to understand that most of you are preparing for the prelims examination this year, and what my agenda, my profile has been to run what we have started calling a marathon session, which is the format in which we have initiated the conversation today. Okay. So okay, with the subject of the Constitution of India, all of us are aware that the subjects in the previous years, the questions in the previous years have been increasing. कॉन्स्टिट्यूशन, संविधान का जो प्रश्न पत्र है पॉलिटी में, वो एक स्तंभ है पॉलिटी का, जीएस पेपर का, प्रीलिम्स पेपर का. एंड वन गेट्स दी अंडरस्टैंडिंग कि अगर आपने संविधान के कॉन्सेप्ट्स को अच्छे से कमांड कर लिया है तो आपको एक कॉन्फिडेंस आ जाता है यूपीएससी प्रीलिम्स में 12 से लेकर 15 प्रश्नों का सही उत्तर देने का. It's a very simple observation in the UPSC exam then, that if you master the Constitution of India, which is not a very difficult subject to master for the prelims, you have a set of questions which are predetermined every year, which are ranging from 12 questions to 15 questions. And if you are able to master some amount of basic concepts and some amount of what you can call current affairs updated with them, संविधान के जो प्रश्न पत्र होते हैं पॉलिटी के अंदर, उनमें आपको एक कॉन्फिडेंस मिल जाता है जीएस को एक अटेम्प्ट देने का. 15 questions is a huge quantum in the GS, in the polity paper, in the prelims paper, and the effort that I'm trying to invest today is to make sure that we can do a kind of the quickest crash course on the entire polity structure, as much as possible that I can cover, in which of course your cooperation is assumed and requested. तो ज़्यादा मतलब हम जो डिटेल्ड एनालिसिस हैं वो शायद नहीं कर पाएंगे इन स्ट्रक्चर्स में, लेकिन मैं कोशिश करूँगा कि जो भी करंट अपडेट्स हम डिस्कस करें उनके पीछे के जो फंडामेंटल फैक्टर्स हैं उनको जल्दी से क्रैश कोर्स के पॉइंट पे एक बार रिवाइज कर लें. ठीक है. मेरा आपसे थोड़ा अनुरोध रहेगा कि डोंट जस्ट सिट आइडली इन फ्रंट ऑफ दिस कंप्यूटर स्क्रीन. थिंक ऑफ दिस एज अ क्लासरूम सेशन जस्ट कंडक्टेड ऑनलाइन, एंड it's easier and better that you have a set of papers in front of you and a pen, and you can take running notes of certain information which I may be dispensing at a faster pace than usual. तो अगर आप एक कॉपी पेन लेके अपने साथ बैठेंगे टेबल पे, तो it would become a little easier for you to document the things that I would be discussing orally in the class. Sometimes I may not be able to write everything on the board because of the paucity of time and the amount of things that we have to cover in the given time. So I would expect you to take notes upon things as if you were sitting in a classroom session. So think of it like a classroom session, just that it is a fast-paced classroom session, and it will extend the normal duration of a classroom session. ठीक है. तो मैं बहुत सारे आर्टिकल्स वगैरह कवर करने की कोशिश करूँगा. आर्टिकल्स का एक फहरिस्त लूँगा, डायरेक्टली एक रिविजन के हिसाब से हम चीज़ों को कर सकते हैं, एंड वी विल ट्राई टू कवर एज मच एंड एज पॉसिबल द आर्टिकल्स ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया टू गेट अ गुड सेंस ऑफ रिविजन, अ काइंड ऑफ अ क्विक क्रैश कोर्स अपॉन द सब्जेक्ट ऑफ पॉलिटी फॉर द प्रीलिम्स एग्जामिनेशन. तो प्लीज़ अब अपने आप थोड़ा कॉपी और पेन अपने साथ लेके बैठिएगा, और कुछ रनिंग नोट्स वगैरह लेने का थोड़ा सा आप एक प्रोजेक्ट रखिएगा, जिससे कि इट बिकम्स एन एक्सरसाइज इन विच यू कैन गैदर एज मच इन्फॉर्मेशन एज पॉसिबल, विच आई मे नॉट बी एबल टू डिस्प्ले ऑन अ पावर पॉइंट और माई सेल्फ राइट ऑन द बोर्ड. आई विल पॉसिबली लुक एट द camera and address you about a lot of things and explain you about a lot of things, but you should have the aptitude to write it out on a piece of paper as a matter of revising your own concepts from the GS classes, and also to take some current updates which I am going to in a way make you aware about. Okay. So having said that, let me just give you a sense of the structure that we are going to follow for this classroom, for this session. Okay. Now, one of the things which is an advantage for us in the polity paper, एक जो हमारे साथ एक एडवांटेज होता है पॉलिटी के लिए, प्रीलिम्स के लिए या मेंस के लिए, दोनों के लिए, वो ये है कि हम पॉलिटी को स्ट्रक्चर बहुत आसानी से कर सकते हैं. मतलब आपकी जो पढ़ाई है और जो आपका रिवीजन है उसके लिए स्ट्रक्चरिंग करना पॉलिटी का थोड़ा आसान रहता है अगर हम जो संविधान है उसकी तालिका से ही अपने स्ट्रक्चर्स को ड्रॉ करें. इफ़ यू आर ड्रॉइंग द स्ट्रक्चर्स डायरेक्टली फ्रॉम द कॉन्स्टिट्यूशन ऑफ इंडिया as they are given in article 1, 2, 3, 4, 5, 6, if we stay tuned with the numerics of the constitution, ठीक है, अगर हम मतलब बिल्कुल संविधान की गणित के साथ चले तो उसके साथ ना याद करना और रिवाइज करना आसान हो जाता है. उससे आपको पता होता है कि आपने कितना याद कर लिया है, कितना आपका बचा है, और उससे रिवीजन करने में बहुत आसानी मिलती है. तो जैसे फॉर एग्जांपल मैं जो कहना चाह रहा हूँ वो ये है कि हम अगर कॉन्स्टिट्यूशन को रिवाइज करना शुरू करेंगे तो वी विल जस्ट टेक वेरी ब्रीफ अंडरस्टैंडिंग ऑफ द प्रीएम्बल ऑफ इंडिया. मैं बिल्कुल उसी लेवल पे प्रीएम्बल को डिस्कस करूंगा जहां पर आपके प्रीलिम्स के लिए एक फोकस्ड रिवीजन की ज़रूरत है. तो आपके जो भी क्लासरूम सेशंस आपने किए हैं प्रीएम्बल के ऊपर, या फिर जो भी आपको लगता है कि विच इज़ गोइंग टू बी अ गुड अंडरस्टैंडिंग कि एमसीक्यूज़ कैसे बन सकते हैं प्रीएम्बल से. पिछले 2 वर्षों में 3 वर्षों में हर बार एक प्रश्न एमसीक्यू आया है प्रीएम्बल के ऊपर, अलग अलग चीज़ों को परमिटेशन कॉम्बिनेशन में डाल के प्रीएम्बल. तो मैं जल्दी से प्रीएम्बल डिस्कस करूँगा. उसके बाद मैं शुरू करूँगा जो पहला भाग है कॉन्स्टिट्यूशन का, विच इज यूनियन एंड इट्स टेरिटरी. और इसमें मैं बस आपको उतना ही आर्टिकल्स बताऊंगा जिसमें से कि आपका कोई एमसीक्यू बन के निकल सकता है. ठीक है, तो हमारा फोकस ये रहेगा कि ज़्यादा से ज़्यादा जो एमसीक्यू की एबिलिटी वाले आर्टिकल्स हैं संविधान के अंदर, उनको एक बार जल्दी से रिवाइज कर लें, और उनके साथ अटैच्ड जो भी करंट अफेयर्स हैं या करंट अपडेट्स हैं उनको अपने साथ एक बार समझ लें कि उन करंट अपडेट्स के लेवल पे क्या डेवलपमेंट हुआ पिछले 1 से 1.5 साल के अंदर. ठीक है, तो जैसे फॉर एग्जांपल लेट्स से जब हम बात करते हैं किसी भी एक देश की या एक रिपब्लिक की, वी टॉक अबाउट व्हाट यू कैन कॉल इन प्रीएम्बल, we have of course a very simple understanding. The preamble is divided into 2 categories, or the information that is given in the preamble is divided into 2 categories. First, it talks about the nature of the state. It talks about the nature of the state. State का मतलब यहाँ पर जो हमको समझना है वो है राज्य. Okay, state not meaning the state मतलब जैसे कि प्रदेश, जैसे उत्तर प्रदेश या मध्य प्रदेश, बट राज्य मतलब जो राज्य करने वाली संस्था होती है एक समाज के अंदर, उसको स्टेट कहते हैं. और प्रीएम्बल में जो पहली चीज़ एक दे रखी है वो है कि हमारा जो भारत का गणतंत्र है, द रिपब्लिक ऑफ इंडिया, व्हाट इज़ द नेचर और द what you can call the specification of the Republic of India, what kind of a state is the Republic of India. ठीक है, तो इसमें जो पहली चीज़ दे रखी है प्रीएम्बल में, वी ऑब्वियसली नो, वी द पीपल ऑफ इंडिया हैविंग solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. ठीक है, बिल्कुल ही सिंपल सा एक इलेबोरेशन है. मैं इसके पीछे आपको बैकग्राउंड में नहीं जाऊंगा क्योंकि आपका ये ऑलरेडी जनरल स्टडीज़ की क्लास में पूरा हो गया है. बस मैं आपको इसमें 2-3 चीज़ें बता सकता हूँ जो कि प्रीलिम्स के लेवल पे आपसे क्वेश्चन में पूछी गई हैं पिछले वर्षों में. फॉर एग्जांपल, फर्स्ट थिंग वी अंडरस्टैंड इज दैट द इनिशियल ड्राफ्ट ऑफ द कॉन्स्टिट्यूशन एज इट वॉज मेड इन 1949 एंड विच केम इन टू इफेक्ट इन 1950 focused upon the 3 characters of Indian state. It was a sovereign, a democratic republic. ठीक है, SDR as we call it in an abbreviation. The Republic of India was initially granted as an SDR, the Sovereign Democratic Republic of India, and the idea was that the Indian, for example, if you take a look at your passport, it talks about the Republic of India, right? And if you talk about, for example, the nature of the Indian Republic, it can be understood that India is a sovereign republic and India is a democratic republic. तो कभी कभी प्रीलिम्स में ये प्रश्न आता है कि जो रिपब्लिक ऑफ इंडिया है उसके आगे जो विशेषण लगे हैं उनमें से कौन से सही हैं, राइट. सो व्हाट बेसिकली टॉक्स अबाउट इज व्हेन यू टॉक अबाउट सॉवरेन डेमोक्रेटिक रिपब्लिक, जो शब्द है सॉवरेन या जो शब्द है डेमोक्रेटिक, वो रिपब्लिक की विशेषता बताता है. वो ये बताता है कि हमारा रिपब्लिक विशेषकर किस प्रकार का रिपब्लिक है. तो इसका कहने का अर्थ है कि इंडिया इज अ सॉवरेन रिपब्लिक एंड इंडिया इज अ डेमोक्रेटिक रिपब्लिक. जैसे फॉर एग्जांपल हम थोड़ा सा कंपैरिजन करने के लिए कॉन्स्टिट्यूशन का थोड़ा समझ सकते हैं. जब हम बात करते हैं चाइना की फॉर एग्जांपल, तो चाइना का जो अब्रीविएशन है वो है पीपल्स रिपब्लिक ऑफ चाइना, PRC, राइट. यहाँ पर पीपल्स का जो एक अर्थ है वो है इट्स अ काइंड ऑफ अ कम्युनिज्म, कम्युनिस्टिक रिपब्लिक ऑफ चाइना. जो लोगों की, जो लोक शक्ति का एक रिपब्लिक है वो चाइना है. भारत के लिए जो विशेषण यूज किया जाता है, द एडजेक्टिव दैट इज यूज्ड फॉर इंडिया इज दैट इट इज अ सॉवरेन डेमोक्रेटिक रिपब्लिक. तो अगर मान लीजिए आपके सामने कोई प्रश्न आता है कि भारत का जो रिपब्लिक है, द रिपब्लिक ऑफ इंडिया, व्हाट काइंड ऑफ स्पेशल पॉलिटिकल नेचर does the Republic of India enjoy? And what we say is that it is a sovereign republic, which means that India as a republic is free to take decisions upon its international policy, upon its foreign relations. It has a free will to engage into friendly relations with foreign countries and not engage in foreign countries. Sovereign means a kind of a what you can call a swechhata or a swadhinta in matters of international relations. And democratic republic means that the republic in India follows a special form of political theory, which is democracy. Okay, so for example, you obviously understand by the point that democracy means it's a government of the people, for the people, and by the people, right? As famously described by Abraham Lincoln, the Indian state has its central authorities as the legislative organs. For example, you have the Union Parliament at the center, and you have the state legislative assemblies at the state level, and the power centers of the Indian polity are populated by popular elections or direct elections, which are held to the Lok Sabha and the Vidhan Sabha. So that in a way represents the democratic nature of the Indian Republic. Okay, and what we understand by the nature of republic, okay, a very simple understanding of the nature of republic or the definition of republic is that republic is any form of government where the head of the state, is directly or indirectly chosen by the people. Directly or indirectly chosen by the people, right? So the political science definition of the term republic is with the head of the state. हेड ऑफ द स्टेट का मतलब होता है जो आपका राज्य अध्यक्ष होता है या राज्य प्रमुख होता है. अगर गवर्नर एक हेड ऑफ द स्टेट होता है प्रदेश के लेवल पर, तो उसको राज्यपाल कहते हैं. तो द वेरी सिंपल पॉलिटिकल साइंस डेफिनेशन ऑफ अ रिपब्लिक इज दैट द हेड ऑफ द स्टेट इज डायरेक्टली और इनडायरेक्टली chosen by the people. Sometimes that method of choice can be through elections. Okay, a democratic republic का मतलब होता है कि not only the head of the state but even the government and every other political organization in the polity of India is elected by the people directly or indirectly, right? And therefore the adjective that we use to define India is a democratic republic. Okay, यहाँ पर मैं आपको एक और लगा हुआ एक एस्पेक्ट बता सकता हूँ जो डिफरेंस कभी कभी प्रीलिम्स में जो पुराने क्वेश्चंस आए उसमें पूछा गया है कि व्हाट इज द डिफरेंस बिटवीन हेड ऑफ द गवर्नमेंट एंड हेड ऑफ द स्टेट. ये प्रश्न है जो थोड़ा सा घुमावदार प्रश्न है जहाँ पर पूछ सकते हैं आपसे कि इन दोनों के बीच में क्या अंतर होता है. हेड ऑफ द गवर्नमेंट इज बेसिकली द प्राइम मिनिस्टर. Prime Minister is in the leadership of the Council of Ministers, and the Council of Ministers plus the Prime Minister together are referred to as the Government of India. Right? The simple definition as given under Article 12 of the Constitution is of the government is the Prime Minister and the Council of Ministers. Prime Minister as the head of the Council of Ministers, as the leader of the Council of Ministers. Head of the state, on the other hand, is President. So the way that the Indian polity is organized is that there is the president who is at the head of the state, and then there is the prime minister along with the council of ministers. Okay, and the president under Article 52 and Article 53 of the Constitution works on the aid and advice of the prime minister and council of ministers. ठीक है, तो इसका मतलब आप अपनी पॉलिटी के लेक्चर से याद कर सकते हैं कि जो व्हाट वी बेसिकली से इज दैट द इलेक्शंस ऑफ द प्रेसिडेंट ऑफ इंडिया आर undertaken by an electoral college, which is composed of the legislative assemblies of the state, the Lok Sabha and the Rajya Sabha, and only the elected members of these bodies can represent themselves in the election of the president. Therefore, the head of the state in India is indirectly elected through an electoral college, but the head of the state, the president, is the head of the republic, right? He is the head of the state, which is the Republic of India. But the head of the state in India is a nominal authority, is a body which does not have any actual real political powers. The real political powers are vested in India in the head of the government, and the head of the government is the Prime Minister, along with the Council of Ministers, which come out of the Parliament of India, right? So this kind of a simple distinction has been asked previously in a UPSC previous year question with regard to the distinctions which are related to who is the head of the state and who is the head of the government. So I'll repeat it again. The head of the state is the President of India, and the head of the government is the Prime Minister of India, along with the Council of Ministers, right? Pradhan Mantri, uske saath saath jo Mantri Mandal hai, that is known as the Government of India, and the Republic of India is represented by the President of India. Okay. At this point of time, let me also take the opportunity to identify 3 simple terms which you can remember. See, all of these little data points, little facts which are, I'm throwing out, for example, the distinction between head of the government, etc., etc. These are all coming out of a good analysis of the previous year questions of the UPSC. Okay, तो UPSC इन छोटे-छोटे concepts पे कभी confuse करके कोई MCQ बना देती है, तो I am going to clarify each bit of things as I move about, जहाँ पर कि छोटे-छोटे महीन areas में UPSC can create a question for the prelims examination. For example, let's say, if you talk about the fact, what do we know as Union of India? Okay. So when we think about Union of India, we think about the Parliament of India, which is the Union Parliament, which includes the Lok Sabha and the Rajya Sabha, and we include within it the Government of India. Government of India जो होती है उसके अंदर आपका आता है Prime Ministers along with the Council of Ministers. ठीक है? So the Parliament of India, the Union, Parliament at the Union level and the government at the Union level, both of them come together and form what is known as the Government of India. And as you know that the Indian Constitution follows what you can call a formula of checks and balances, which means that the Parliament of India holds the government of India to accountability. ये एक प्रश्न है जो बार-बार UPSC में पिछले 5 या 6 साल से आ रहा है, which is with regard to the accountability that the Parliament of India has towards the accountability that the government of India has towards the Parliament of India. ठीक है, तो हमारा जो सिस्टम है वो इस वेन डायग्राम से एक तरह से आइडेंटिफाई किया जा सकता है, जिसका नाम है checks and balances, the system of checks and balances, in which the Prime Minister and Council Ministers who are a part of the government of India are accountable to the Lok Sabha and the Rajya Sabha, who are the Parliament of India, and both of them collectively are referred to as Union of India. Let's say, for example, if you have a case in the Supreme Court which says XYZ versus Union of India, आपने कभी ना कभी कोई केस पढ़ा होगा इस तरह का, जहाँ पर लिखा होगा कि लेट्स से मान के चलिए कि अगर कोई श्याम दीवान वर्सेस यूनियन ऑफ इंडिया एक केस है, तो उसका मतलब है कि यूनियन ऑफ इंडिया इज़ अ पार्टी टू अ पर्टिकुलर मैटर. तो हम बात करते हैं कि यूनियन ऑफ इंडिया में क्या क्या इंक्लूड होता है. यूनियन ऑफ इंडिया में इंक्लूड होता है पार्लियामेंट और गवर्नमेंट. ठीक है, दोनों. उसके बाद हम कभी कभी बात करते हैं गवर्नमेंट ऑफ इंडिया की, GOI. गवर्नमेंट ऑफ इंडिया आई हैव ऑलरेडी आइडेंटिफाई फॉर यू, इज जनरली रेफर्ड टू एज द Prime Minister, the Council of Ministers, and then the various ministries under the Council of Ministers. So for example, आपका जो सारा मंत्री परिषद है, the मंत्रालय का जो आपका पूरा तंत्र है, you have the structure of the ministries, the Finance Ministry, the Home Ministry, the Defense Ministry, the International, the Ministry of External Affairs, etc. All of them plus the Prime Minister as the head of the government is known as the Government of India. But sometimes the Government of India also is referred alongside the Parliament. तो कभी कभी इसका कोई टेक्निकल आंसर नहीं है इस प्रश्न का कि गवर्नमेंट ऑफ इंडिया का क्या उत्तर होता है. कभी कभी गवर्नमेंट ऑफ इंडिया को आप यूनियन ऑफ इंडिया से इंटरचेंज कर देते हैं, लेकिन अगर आप बिल्कुल तकनीकी तरह से पूछें, इफ़ यू आस्क अ क्वेश्चन विच इज़ टेक्निकल इन नेचर, देन You can have the nature in which you are looking at the government of India is also the government of India includes the Prime Minister of India, the Council of Ministers, and the ministries and the administration which is working under the ministers respectively. ठीक है? Yes. So there's a statement made over here. Civil simplified. Of course, Parliament also consists of the President of India. Right. That is something that I was just about to point out. कि जब हम Parliament की बात करते हैं तो President of India. क्योंकि हम President of India की क्यों बात कर सकते हैं? क्योंकि यहाँ पर आप देखिए the Council of Ministers and the Prime Minister, both of them, as I pointed out, are working under the nominal leadership of the President of India. And since the Prime Minister and Council of Ministers are a part of Parliament, it is but natural that the President is also going to be a part of the Parliament. तो जैसे एक बार UPSC में प्रश्न आया था कि क्या भारत के राष्ट्रपति पार्लियामेंट का हिस्सा होते हैं कि नहीं, तो the correct answer to that is the President of India is a part of the Parliament of India. In fact, the Parliament of India has three components: the President of India, the House of the People, which is the Lok Sabha, and the Council of States, which is the Rajya Sabha. Right? So that's a correct observation over here. Okay. Now, moving on with this kind of a structure, I'll come back to some of the positions over here. Things that you can keep in mind. Number one, India is a sovereign, socialist, secular, democratic republic. The initial draft of the preamble with the Indian Constitution in 1949 and 1950 only use the term sovereign and democratic. The other terms, which is socialist and secular, were introduced into the Constitution by subsequent amendments made to the Constitution. तो पिछले से पिछले वर्ष एक प्रश्न आया था prelims examination में कि जो original draft है Constitution का, the original draft of the Constitution, which of the following adjectives were associated with the term republic in the original draft of the Constitution? And the correct answer was sovereign, democratic republic. Socialist and secular, with sovereign, socialist, secular, democratic republic, which is the current status of the Indian Constitution, was introduced in the Indian Constitution by subsequent amendments brought about by the Indira Gandhi government. Okay, so that's one part that we have to understand in the preamble with regard to the structure of the state. Okay, the second thing that we take a look at the preamble is, of course, the rights which are given to the citizens. Okay, what are the rights which are given to the citizens? Right, so जैसे मैंने आपको बताया था कि preamble है वो दो चीज़ों की बात करता है. एक तो बात करता है कि state की परिभाषा क्या है, what is the nature of the state in India. ठीक है, तो state की बात करता है what is basically the nature of the ruling power in India. Okay, the second thing that it talks about is, of course, that what is the rights given to the citizens of India. ठीक है, कोई भी एक पॉलिटिकल साइंस का डॉक्यूमेंट होता है, एनी काइंड ऑफ अ डॉक्यूमेंट विच इज अ डॉक्यूमेंट ऑफ पॉलिटिकल साइंस और पॉलिटिकल थ्योरी इज डिवाइडेड इनटू टू कैटेगरीज, द रूलर्स एंड द रूल्ड, the governor and the governed, right? And what we are basically looking at is that the preamble in a way gives the nature of the governor, the ruler, and the nature of the governed, and in a way it tries to balance the interaction between the two. तो जो second चीज़ जो preamble देता है वो देता है citizens के बारे में, the rights which are given with regard to the citizens of India, right? And the rights which are mentioned in the preamble are justice, liberty, equality, and fraternity. Right, a fraternity के अंदर ही you have two special rights which are given, which is unity of India, a balance between unity of India and a dignity of the individual. Unity of India and the dignity of the individual. ये दो rights दे रखी हैं आपकी, justice, equality, liberty और fraternity के साथ साथ unity of India and dignity of the individual. ठीक है, अगर हम justice की बात करें तो justice का जो elaboration है वो किया गया है into these three parts. The first kind of justice which the Constitution preamble talks about is social justice. The second kind of justice which the Constitution talks about is economic justice. And the third kind of justice which the Constitution talks about is political justice. कभी-कभी prelims के examination में ये order में पूछ ली जाती हैं. Now, for example, let's say a question can come in the prelims examination as to which is the correct order in which the justice principle in the preamble is organized. So they can give you one option, social, economic, political, option number 1. They can give you another option, economic, political, social, option number 2. Then they can give you another example, political, social, economical, option number 3. So, you know, for example, if this kind of a question is asked, you have to answer social, economic and political justice is the correct order in which the categorization of justice has been given in the preamble. Okay. So, for example, the question that we are asking, for example, is this, that when Ambedkar was putting the point of justice in the preamble, he very categorically made a point about it in the Constituent Assembly, that it is impossible to have political justice in a country like India without having social justice and economic justice, right? And that is why Ambedkar's name is very closely associated with the activities of social justice. For example, specifically the provisions in Article 15 and Article 16 about affirmative actions, right? So you have social, economic and political justice. अगर इस तरह का कोई प्रश्न आए तो आप इससे थोड़ा सा ध्यान में रखिएगा. उसी तरह से अगर हम बात करते हैं इक्वालिटी की, तो संविधान में जो इक्वालिटी के दो पार्ट दे रखे हैं, द टू पार्ट्स विच आर गिवन इन द कॉन्स्टिट्यूशन अबाउट इक्वालिटी आर इक्वालिटी ऑफ स्टेटस एंड इक्वालिटी ऑफ अपॉर्चुनिटी. ठीक है, अवसर की आज़ादी और औहदे की आज़ादी, इक्वालिटी ऑफ स्टेटस एंड इक्वालिटी ऑफ अपॉर्चुनिटी. Okay, to have samanta in status, there's kind of a that no one shall be discriminated on sociological grounds, on the race, on the nature of caste or color or creed or place of birth or descent or gender. Any kind of a discrimination on the basis of a sociological phenomenon is a violation of equality of status. And equality of opportunity entails that every person shall be given equal opportunity, specifically in matters of public employments. मतलब पहले क्या होता था कि जो भी व्यक्ति किसी भी तरह से जो स्टेट के नज़दीक रहता था, जो स्टेट के आसपास रहता था, स्टेट के चापलूसी में रहता था, उसी को सारे पब्लिक एम्प्लॉयमेंट्स में थोड़ा सा प्रमोट किया जाता था. इट कुड हैव बीन पीपल फ्रॉम अ सर्टेन रेस, सर्टेन कास्ट, सर्टेन कम्युनिटी एटसेट्रा, बट आर्टिकल द वैल्यू इन प्रियम्बल ट्राइज टू ब्रेक द शैकल्स एंड इट ट्राइज टू एस्टैब्लिश इक्वालिटी ऑफ अपॉर्चुनिटी इन पब्लिक एम्प्लॉयमेंट फॉर ऑल पीपल एंड नॉट have employment at the level of public administration and civil services be selected for a reserved few who were belonging from elite communities or castes or a group of people, right? तो ये दो बात करती है इक्वालिटी का. उसके बाद हमने फ्रेटर्निटी की बात कर ली, यूनिटी ऑफ इंडिया एंड डिग्निटी ऑफ द इंडिविजुअल. ठीक है, तो अगर आप इससे देखेंगे तो इससे आपके जो प्रीलिम्स के क्वेश्चन है वो कुछ इस प्रकार से आ सकते हैं. पहली कि जो भारत का जो स्टेट है उसके वो क्या है, विशेषण क्या है, what are the adjectives of the Indian state, right? And again I'm going to tell you that the term adjective means what is the visheshata of Indian state, right? So for example, Ram is a good boy. A good is a adjective to what a boy is, right? In a similar manner, India is a republic, but India is a sovereign, socialist, secular, democratic republic, and out of this, sovereign, democratic republic terms were used in the initial draft of the preamble, but later on it was changed to a sovereign, socialist, secular, democratic preamble in the subsequent amendments made to the constitution. ठीक है, तो preamble से आपके जो prelims के अभी तक के जो प्रश्न आए, मैंने वो almost सारे previous year के questions आपके जो मतलब जो प्रॉब्लम्स थे वो सारे हमने एक बार जो भी प्रीवियस ईयर के क्वेश्चन से प्रीएम्बल से मैंने हल्के से हाईलाइट करके आपको समझा दिया. मेरा फिर भी आपसे अनुरोध है, आई रिक्वेस्ट यू टू सिट विद अ पेन एंड पेपर एंड मेक श्योर दैट यू हैव द एबिलिटी टू जॉट सम ऑफ दीज थिंग्स डाउन, बिकॉज वी आर गोइंग टू मूव एट अ पेस विच इज़ नॉट ऑर्डिनरी. तो थोड़ा थोड़ा जल्दी अगर हो रहा है तो आप कुछ जॉट करते रहेंगे तो आपकी मेमोरी में कहीं ना कहीं चीज़ें कमिट होती रहेंगी. ओके, नाउ वी कम टू व्हेन वी हैव अंडरस्टूड प्रीएम्बल ऑफ द कॉन्स्टिट्यूशन. Let me, for example, say another thing which was asked in the prelims paper previously. Preamble is sometimes also known as the key to open the minds of the constitution makers. Okay? मतलब अगर ये बात सुप्रीम कोर्ट ने कही है कि if at any point of time the Supreme Court is not able to interpret the constitution, the Supreme Court's final role as a constitutional court is to interpret what is written in the constitution, which means that what is not written directly but what is indicated by the constitution. For example, the Supreme Court could interpret the basic structure doctrine from Article 368 of the constitution, Supreme Court has said that any point of time when Supreme Court finds it difficult to understand what the constitution makers would do in a position of a constitutional crisis, it looks at the values which are given in the preamble and it tries to read the mind of the makers of the constitution by reading the values given in the preamble. Therefore, it is also known, termed by the Supreme Court as the key to open the minds of the constitution makers. एक prelims का प्रश्न इस पे बन सकता है to verify, to in a way specify. For example, you can have a question, which of the following phrases specify the preamble? Key to open the mind of the constitution makers would be the correct answer. बाकी 3 आंसर्स आपको fictitious बना सकते हैं आपको कंफ्यूज करने के लिए. ठीक है, ठीक है. आपने जो बात कही थी वो लिबर्टी की थी. हाँ, लिबर्टी मैंने यहाँ पर आपको नहीं बताई थी, सॉरी मुझसे मिस हो गया लिबर्टी. हाँ, थैंक यू फॉर रिमाइंडिंग मी. Liberty which has been given in the preamble is an interesting value, and liberty in the preamble is given as thought, expression, belief, faith and worship. इसको आप अभी थोड़ा सा नोट करके रखिए. जब मैं आर्टिकल 19 पे आऊँगा तो मैं इस पर थोड़ा सा एलैबोरेट करके आपको एक याद करने का फॉर्मूला बताऊँगा. The kind of liberties which have been given in the constitution, sorry I missed out writing about the liberty part. The kind of liberty which has been given in the preamble includes a thought, expression, belief, faith and worship. By the time I come to article 19(1), I will take a relook at this part of the preamble. ठीक है, तो अभी बस मैं आपको इतने विशेषणों के साथ छोड़ देता हूँ. जस्ट प्लीज़ आप इस सेशन को ऐसे लीजिएगा कि आप कहीं भी कुछ भी कर रहे हो, आप कोशिश करिए कि आप अपने आप को इस सेशन के माध्यम से अपनी रिविजन को एक तरह से एम्पावर करें. द फैक्ट ऑफ दिस सेशन इज नॉट जस्ट टू गिव यू इन्फॉर्मेशन बट ऑल्सो टू यूज माई वॉइस एंड दिस एंटायर सेटअप एज अ एक्टिविटी टू रिवाइज थिंग्स इन योर हेड फ्रॉम द टॉप टू द बॉटम. वी आर मूविंग फ्रॉम द फर्स्ट पार्ट ऑफ द कॉन्स्टिट्यूशन एंड विल ट्राई टू गो एज फार ahead as possible for the prelims examination. ठीक है, तो अभी हमने जो रिविजन किया वो प्रियम्बल का किया. ठीक है, उसके बाद हम देखते हैं कि अब जब हमने प्रियम्बल एक बार कवर कर लिया, द फैक्ट दैट वी हैव सीन प्रियम्बल टू बी द की टू ओपन द माइंड ऑफ द कॉन्स्टिट्यूशन मेकर्स, what we are going to take a look at after the preamble is the what you can call the Constitution of India. Now one thing that we have covered is the preamble. ठीक है, now we take a look at the Constitution of India. ठीक है, यहाँ पर मैंने एक डॉक्यूमेंट है, बस एक ही डॉक्यूमेंट मैं आपको दिखाऊंगा, द कॉन्स्टिट्यूशन ऑफ इंडिया, which is something that I am going to refer to now and then to read certain articles of it. तो अगर हम मान लीजिए कॉन्स्टिट्यूशन ऑफ इंडिया के इंडेक्स में जाएं तो कभी कभी जो प्रश्न आते हैं कॉन्स्टिट्यूशन ऑफ इंडिया के इन चीज़ों से पूछ लिए जाते हैं. हालांकि आई विल बी वेरी क्लियर इन स्टेटिंग दैट इन द प्रीलिम्स एग्जामिनेशन नंबर ऑफ आर्टिकल्स आर नॉट आस्क्ड. ठीक है, नो क्वेश्चन हैज बीन आस्क्ड दैट हैज़ अ reference to which article does this kind of a thing apply under. So don't be under the obligation of remembering article numbers. Article numbers are not asked in the prelims examination. You can write article numbers in the mains examination out of your own willfulness to get better marks, but generally speaking in the polity examination the number of the article is not relevant. Okay, you can add relevance to the mains examination by memorizing some of them, but overall they are not relevant. Okay, so what we talk about basically in the Constitution of India is what are the essential components of a state. एक बार prelims में question आया था 2021 में, what are the essential components of a state, and generally we answer this question like this. A state must have the following components. Number 1, it must have a territory. ये आपका पॉलिटी का क्वेश्चन था 2021 का. State must have a territory, then it must have a population, then it must have the ability to take decisions of its own, basically what you can call a free foreign policy, right? And then it must have a structure of governance. These are the 4 components which are given in a political theory textbook as essential components of a state. It must have a territory, it must have a population, it must have a free foreign policy, meaning it can control its territory according to its own wills and control its populations according to its own wills without the obligations from an outside state, and it must have a structure of governance. Okay, now if we apply this very definition to the Constitution of India, we can find the Constitution of India being divided into these parts. Part 1 of the Constitution talks about union and its territory, right? तो मतलब ये आपको बताता है कि जो भारत उसकी भूमि कहाँ पर है, what is the territorial demarcation of India, right? That's basically what the part 1 of the constitution talks about, the territorial circumspection in which you call India, the land of India, the bhumi of India, right? And for example, you have within this the legendary article which is the name and the territory of the union, which is India, that is Bharat, is a union of states. That's given in article 1 of the constitution. Okay. Now, this particular part 1 of the constitution, which includes union and its territory, is just something that you can remember as the first part of the constitution. अगर कभी मान लीजिए पूछ लिया गया कि पार्ट जो है कॉन्स्टिट्यूशन का पार्ट 1 या आर्टिकल 1, क्योंकि इट्स अ बिट ऑफ अ लेजेंडरी आर्टिकल ऑफ द कॉन्स्टिट्यूशन, व्हाट डज इट से, यू कैन आंसर अ क्वेश्चन लाइक दिस, बट दो द आर्टिकल्स एज नंबर्स आर नॉट जनरली आस्क्ड इन द प्रीलिम्स पेपर. पार्ट 2 ऑफ द कॉन्स्टिट्यूशन talks about population, as it talks about the concept of citizenship. तो आपको मैं बस एक भूमिका बता रहा हूँ कि किस तरह से आप संविधान को आसानी से याद कर सकते हैं रिवीजन के तौर पे. पहले हमने बात करी थी प्रियम्बल की. प्रियम्बल का जो फिलोसॉफिकल डॉक्यूमेंट है, वैल्यू बेस्ड डॉक्यूमेंट विच डिस्क्राइब्स द नेचर ऑफ द स्टेट एंड द पीपल ऑफ अ सिचुएशन. आफ्टर दैट यू टॉक अबाउट व्हाट यू कैन कॉल द लैंड ऑफ इंडिया, राइट? एंड द लैंड ऑफ इंडिया is the territory of India, article 1 to 4, part 1 of the constitution. Once you have ensured for you the land of India, then you have to talk about the population of India, who are the people of India, and that is why you have article 5 to 11 as the second part of the constitution, which is known as population, or what you can generally understand is who shall be granted citizenship and what are the laws which are governing citizenship, right? So in this regard, obviously you have to reflect back from what you can call the Citizenship Act, which has been made by the Parliament and has been amended from time to time, which is, I'm sure, covered in your general studies, to get a look about what is the nature of citizenship which the Indian state grants. Okay, then we take a look at the next part, which is part 3 of the constitution. Now part 3 of the constitution talks about state, and let's say, for example, I'll just elaborate, because part 3 of the constitution is one of the most intensive parts from which questions are asked. So I'll just make an elaboration upon this. You have part 3 of the constitution. Okay, part 3 से डायरेक्टली क्वेश्चन पूछे जाते हैं. पार्ट 3 एक ऐसा पार्ट है जहाँ पर आर्टिकल के नंबर भी पूछे गए हैं कभी कभी, और कभी कभी उनकी कैटेगरीज में मिक्सचर करने की कोशिश की गई है. ठीक है. सो जब हम बात करते हैं इन चीज़ों की कि व्हाट आर बेसिकली द पार्ट 3 ऑफ द कॉन्स्टिट्यूशन, वी आर टॉकिंग अबाउट इन पार्ट 3 ऑफ द कॉन्स्टिट्यूशन आर्टिकल 12 विच डिफाइंस द स्टेट. ठीक है, मतलब आर्टिकल 12 विच डिफाइंस द स्टेट विच इज राज्य. ठीक है, दिस इज द ओरिजिन. मतलब फॉर एग्जाम्पल, इफ यू हैव अ क्वेश्चन इन द प्रीलिम्स एग्जामिनेशन एज टू फ्रॉम विच आर्टिकल कैन द डेफिनेशन ऑफ स्टेट बी ड्रॉन, you have article 12 of the constitution. Article 12 of the constitution defines a state, but also article 12 of the constitution is also the genesis of 2 concepts in the constitution of India. One concept from which the one of the basic feature of the constitution is derived is the article 12 of the constitution, separation of powers. If one, for example, asks a question ki jo which is the article in the constitution from which one can deduce that basic that India follows a what you can call model of a basic feature of the constitution, a model of separation of powers of the constitution, and the answer to that question would be article 12, which is the definition of state. Okay, and the other idea which is given in article 12 is the idea of a distribution of powers. ठीक है, तो बेसिकली आर्टिकल 12 क्या कहता है? आर्टिकल 12 कहता है कि जो भारत का राज्य है उसको आप इस तरह से समझ सकते हैं. यू कैन ड्रॉ काइंड ऑफ एक्स एक्सिस वाई एक्सिस फॉर्मेट टू अंडरस्टैंड द what you can call the nature of the government of the state of India. Okay, for example, over here you can write union, over here you can write state. State matlab you can write state over here as Pradesh. ठीक है, and union you can write over here as the Kendra, right? The union and the state. And over here you can write the legislative, and over here you can write the executive. ठीक है, तो आप देखेंगे अगर आप इस एक्स एक्सिस और वाई एक्सिस के स्ट्रक्चर को देखें तो आर्टिकल 12 की डेफिनेशन आपके सामने आ जाएगी. आर्टिकल 12 ये कहता है कि द स्टेट under Article 12 means the legislative organ at the union and the executive organ at the union. ठीक है, तो इन दोनों की बात करता है. That the state includes the legislative organ at the union and the executive organ at the union. ठीक है, ये बिल्कुल भाषा है इसकी जो मैं आपके लिए संक्षेप में, आई एम जस्ट ट्राइंग टू डिस्टिल इट डाउन. द स्टेट एट द यूनियन लेवल इंक्लूड्स द पार्लियामेंट ऑफ इंडिया and the government of India. Okay, the Parliament of India and the government of India. And similarly, the state at the state level, मतलब प्रदेश level, आप state के repeated use से confuse मत हो जाइएगा. State at the state level means the legislature at the state, which includes the Vidhan Sabha and the Vidhan Parishad. Yes, state legislative assemblies and the government at the state. तो फॉर एग्जाम्पल यहाँ पर हम लिख सकते हैं कि अगर हम बात करें मध्य प्रदेश सरकार की, द गवर्नमेंट ऑफ मध्य प्रदेश एंड विधानसभा ऑफ मध्य प्रदेश, तो यहाँ पर आ सकता है. तो आप देखिए, इफ यू टेक अ लुक एट दिस वेरी सिंपल एक्स वाई चार्टिंग आउट ऑफ द आइडियाज, यू हैव 4 concepts or 4 ideas which have been given. You have the concept of what you can call separations of powers between executive and legislative. ठीक है, जिसका बात करते हैं Parliament of India and the Government of India. And then you have the distribution of powers between the union and the state, which means that the union parliament and the union government and the state legislative assembly and the state government. ठीक है, तो ये जो इस मैट्रिक्स में कहीं पर भी कोई भी चीज़ अगर फॉल करती है तो उसको स्टेट की परिभाषा में इंक्लूड किया जाएगा. दिस इज व्हाट बेसिकली आर्टिकल 12 ऑफ द कॉन्स्टिट्यूशन से. जस्ट टू गिव यू अ रेफरेंस अगेन, आर्टिकल 12 ऑफ द कॉन्स्टिट्यूशन इज द जेनेसिस ऑफ द कॉन्सेप्ट ऑफ सेपरेशन ऑफ पावर्स, एज इट separates the powers between the legislative and the executive, and also it is the genesis of the concept of the distribution of powers, and in a way it lays down the structure in which the entire Indian network of state is identified. Okay, so for example, you have the states at the level of what you can call, you have the state government and the state legislature, and you have the union government and the union legislature. And all of these combined together are a part of what is known as state under Article 12 of the Constitution. Yes, of course, Shubham is correct, absolutely, to say that the union territories are also a part of the government of India and the Union of India. So the union territories generally, because they don't have an identification as a third form of the state, are included within the Union of India. The Union Parliament has the power over the union territories, and the Union government has the power over union territories. It can of course devolve certain powers to the union territories, but generally speaking, UTs are not a third entity of the state. They are not a third tier of the government. They are just basically what you can call extension to the powers of the union government. However, there is a third tier to the government, which is the local government. Okay, this is given in the Constitution. Local government, which is the 3 parts of local government are the cooperative societies, the panchayats, and the municipalities. ठीक है, so this was added into the Constitution by an amendment act in which the cooperative societies, panchayats and municipalities have been added into the structure of the state, which includes the local government and local authorities. Okay, we'll come to that and we'll discuss that as we proceed in that direction in the Constitution. ठीक है, तो Article 12, for example, let's take a look at Article 12 very quickly to get you a sense of it, क्योंकि Article 12 से पहले डायरेक्टली क्वेश्चंस पूछे जा चुके हैं प्रीलिम्स के पेपर में. इसमें जो जो चीज़ें पढ़ने लायक है हम एक बार इनको पढ़ लेते हैं. Take a look at this. In this part, unless the context otherwise requires, the state includes the government and Parliament of India and the government and legislature of each of the states and all local or other authorities within the territory of India under the control of the government of India. Take it, this includes the union territories, right? So you, for example, let's say if I have to identify this over here, the state includes the government and parliament of India. तो government का मतलब होता है executive branch, as I have pointed out earlier. Parliament का मतलब होता है legislative branch, और जो of India का मतलब होता है union. तो आप इसको मैट्रिक्स से अलाइन करके देख सकते हैं. The executive and the legislature of the Union of India and the executive and the legislature of each of the states. तो आपको मैंने जो x और y axis की जो premise बताई थी उससे आप देख सकते हैं. This is basically what it is referring to in terms of the indication of the states. ठीक है, तो ये this is basically what you can take a look at in terms of understanding the definition of state. उसके बाद हम आर्टिकल 13 पे पहुंचते हैं. आर्टिकल 13 is the genesis of articles of the concepts of two things which I will discuss very simply and very briefly. First thing is जुडिशियल रिव्यू. ठीक है, मैं आपको जुडिशियल रिव्यू की जो परिभाषा है बिल्कुल जल्दी से रिवाइज करा देता हूं, बिल्कुल पॉइंट बाय पॉइंट, कि जुडिशियल रिव्यू का अर्थ क्या होता है. स्टेट का काम होता है लॉ बनाना और पॉलिसी बनाना. ठीक है, द वर्क ऑफ द पार्लियामेंट इज टू मेक लॉ एंड द वर्क ऑफ द गवर्नमेंट इज टू मेक पॉलिसी, और लेट्स से द वर्क ऑफ द पार्लियामेंट इज टू मेक लॉ एंड पॉलिसी and the work of the government, which is the executive, is to implement a law and policy. Okay. Now, Article 13 of the Constitution talks about the fact that the law and the policy made by the government has to be subjected to certain review, a certain scrutiny. Okay. So, it basically very simply says that if any of the laws which are made by the state, if they are in violation of any of the rights mentioned in Part 3 of the Constitution, which are also known as the fundamental rights, they shall be subjected to the review by the judiciary. And if the judiciary finds out that the violation, or what you can call the subjugation of these rights is done by the state, it can strike down the law and the policy as unconstitutional. This power has been given to the judiciary by Article 13. So, for example, if you have a question as to does the Constitution of India explicitly define a judicial review, the answer is no. But does the Constitution of India indicate that there is judicial review? The answer is yes, and that article is Article 13 of the Constitution, because Article 13 of the Constitution states, and I am going to be specific about it, that any of the laws made by the state after the commencement of the Constitution, state meaning state as defined under Article 12 of the Constitution, any of the laws made by the state after the commencement of the Constitution, or made by the state which was existing before the commencement of the Constitution, they are going to be subjected to judicial review by the constitutional courts, which includes the High Court and Supreme Court, on the touchstone of them breaking the fundamental rights. So, if any of the laws are inconsistent or in abrogation with the fundamental rights, if there are any laws which are inconsistent with or in abrogation of fundamental rights, then they are going to be struck down by the judiciary as unconstitutional under the powers given to judiciary under Article 13 of the Constitution. Okay. So, one thing that you have to very specifically notice is that Article 12 defines the state and includes two organs of the states. In separation of powers, you have the legislative organ and the executive organ. But Article 12 does not include judiciary into it, indicating the independence of judiciary, right? Because judiciary is supposed to be independent from the state. It is not included in the definition of state under Article 12. On the other hand, because judiciary is supposed to be independent of the state and it is to scrutinize the activities of the state, it has the power to review the lawmaking, what you can call the laws made by the state and the policies made by the state. It has to be demarcated as separate, as independent of the state, and therefore the birth of judicial review comes under Article 13 of the Constitution. I'll repeat it again. Article 13 of the Constitution states that any law which is made in the territory of India, that is Bharat under Article 1, before the commencement of the Constitution or after the commencement of the Constitution by the state as defined under Article 12, shall be declared as unconstitutional if it is inconsistent or in abrogation with any of the rights mentioned in Part 3 of the Constitution. And from Article 14 onwards, you have the mention of the rights in Part 3 of the Constitution, right? So, before we move to the basic idea of fundamental rights, we have to understand two important elements which have to be described before we move into the quality or the nature of fundamental rights. One is the state, which is the law making and law implementing organ of the Union of India and the Government of India, and the Union of India and the Government of the states. And the activities of the states have to be reviewed by the judiciary, and the powers of the judiciary to review the activities of the state can be drawn from Article 13 Clause 1 and 13 Clause 2 of the Constitution of India. So, for example, if I have to represent it just very simply diagrammatically, you have the state over here, which is under Article 12. Okay, under Article 12 you have the state. Okay, then let's say, for example, you have the what you can call a judiciary. Which is under Article 13, and with judiciary you have what you can call a judicial review. Okay, and then after that, following on, you have the rights of the citizens or persons, you can call them. Okay, some rights are for citizens, some rights are for persons. So, for example, you have Article 14 to 18, which is the fundamental right of equality. Then you have Article 19 to 20, the fundamental right of liberty. Then you have Article 23 to 24, right against exploitation. And you have Article 25 to 28, rights of freedom of conscience, etc. These are rights which are given to individuals. Okay. So, for example, over here you have the ruler. Okay. Over here you have the ruled. And over here you have the custodian of the Constitution. And the role of the custodian of the Constitution, which is the judiciary, is to review the acts of the ruler. Let's say, for example, if there are certain acts of the rulers, which are, let's say, for example, if judiciary has made some law which is in contravention to the fundamental rights. Let's say, for example, if judiciary has made a law which is in contravention to the fundamental rights. This particular law can be annulled by the judiciary. If the state has made a law which is in contravention to the fundamental rights, this particular law can be annulled by the judiciary. If the state has made any policy or any decision which is against the fundamental right of an individual, the judiciary can annul these fundamental rights or these actions of the state. Right? तो आपको इसको इस तरह से देखना होगा कि स्टेट और इंडिविजुअल के बीच में इंडिविजुअल की फंडामेंटल राइट्स को प्रोटेक्ट करने के लिए जुडिशरी हैज बीन एस्टैब्लिश्ड. आर्टिकल 12, आर्टिकल 13 and article 14 onwards, which are a specification of the fundamental rights. Okay, clear? I hope I'm making this sense very clearly in terms of understanding the point about it. Okay? So let's say, for example, you have the question about what you can call the role of the judiciary, which is given under Article 13, is to review the decisions made by the state, either as laws or as policies or as orders or as regulations, etc., which can be subjected to a judicial review. Okay, clear? So this is basically what we're looking at Article 12 and Article 13. Another concept which is imbibed in Article 13 of the Constitution is known as the doctrine of severability. Okay, so the concept of judicial doctrines is somewhat relevant in the prelims paper some of the times. So we'll take a little bit of a look at some of the doctrines which are given with the context of polity. For example, we'll take a look at doctrine of severability, we'll take a look at doctrine of eclipse, we can take a look at the doctrine of harmonious construction. Very briefly, I will give you a sense of what these judicial doctrines imply. Okay, let's say, for example, when I talk about doctrine of eclipse or doctrine of severability, this is the first thing. Please be very quick about taking notes upon these. As soon as I'm just going to explain them very quickly. So as soon as you can, just take a note of them mentally or in a notebook. Okay. You have the question is what is the meaning of a custodian? Meaning of a custodian is someone who is in custody of something. For example, let's say if there is a bank and the custodian of the money which is kept in the bank is the bank manager or the branch manager, which basically means it is the responsibility of the branch manager to make sure that no money is stolen from the bank vault. Similarly, when we talk about custodian in terms of polity, a custodian in terms of the constitution, the custodian of the constitution is Supreme Court, which means that the intent and the essence of the constitution has to be kept alive and it has to be materialized in reality. That responsibility is given in the constitution to the Supreme Court of India. So what we basically say is that the custodian is the what you can call the final authority which is responsible for making sure that the spirit and letter of the constitution is implemented and realized. Okay, so the savior of the constitution, the custodian of the constitution, the guardian of the constitution, these are terms which are referred to for the Supreme Court. Also the final interpreter of the constitution. Okay, so you have for example, these bots, let's say if I take a look at what is known as the doctrine of severability. The doctrine of severability is given under Article 13. It simply states this, and I'm going to explain this very briefly to you. Let's say, for example, if a law has been made by the state, okay, if the state has made a law, which is basically, let's say, law has been made by the Union Parliament. Let's say, for example, you have the data protection law. Data protection law has been made by the state, by the Union Parliament. Let's say, for example, Section 5 and Section 11 of the data protection law are appearing to be in contravention to certain fundamental rights. Let's say, for example, they are in contravention with Article 21 of the Constitution. Article 21 of the Constitution, which includes the right to privacy. तो अगर मान लीजिए कोई लॉ बना है जो आर्टिकल 21 में इंक्लूडेड एक राइट टू प्राइवेसी के कॉन्ट्रवेंशन में है, और उस लॉ में सिर्फ सेक्शन 11 और सेक्शन 5 ही कॉन्ट्रवीन कर रहे हैं, बाकी सारे जो सेक्शंस हैं, द रिमेनिंग सेक्शंस विच आर गिवन इन द कॉन्स्टिट्यूशन, in the law, are all okay. They don't interfere or contravene the ideas of the constitution, of the fundamental rights. Then what is meant by doctrine of severability is that the court will not strike down the entire law as such. It will not holistically strike down the entire law, saying that the entire law is unconstitutional. It will sever. Sever means it will in a way cut out the portion which is cancerous in a law, and then it will just push that portion out, but it will retain or redeem the entire structure of the law, which is healthy. It's like surgery. Okay, if there's a part of the body which has been infected by a tumor, the idea for surgery is to just remove that tumor out but not hurt the entire body of the structure. So severance in English language means to take something out which is, let's say for example, undesirable, but leave the entire structure intact. So this is basically what is meant by doctrine of severability. Now this is what is basically an attachment with judicial review under Article 12. Article 12 judicial review states that if, let's say for example, a law has been made by the Parliament, Article 12, Article 13 says that if a law has been made by the Parliament and if that law is violating fundamental rights of an individual, then only the portion of the law which is violating the fundamental rights shall be struck down. And the judge should try to save the broader statute. It should not declare the entire statute is unconstitutional because a part of that is violating a fundamental right. Okay, so this is basically what is known as the doctrine of severability. I'll come to other doctrines as the connection between the concepts, etc. I hear you, doctrine of colorable legislation, etc. Please just wait for me as the suitable framework comes for it. I will explain to you in context as to what is meant by the doctrine of colorable legislation, eclipse, pith and substance, etc. So I'll try to finish as many doctrines as possible by the end of the session today. Okay, because this is a relevant concern in the prelims examination. The names of the doctrines can be directly asked. Okay. Right. Fine. Now we move on to the next part, which is we have understood Article 12, which is state. We have understood Article 13, which is judicial review and doctrine of severability. We are moving to the first set of fundamental rights, Article 14 and Article 18. Article 14 to Article 18, and I'll list it out very simply for you to get a sense of it. Okay. Sometimes a question is asked, for example, in the prelims examination in one of the previous years, a question was asked from the prelims, from the fundamental rights, about what you can take a look at. Let's say the categories of fundamental rights. So for example, let's say if I move to this part, the index, you can very clearly identify what I'm covering over here. You have part 3, which is fundamental rights. You have the definition of state that we have covered, and you have laws inconsistent with or derogation of the fundamental rights, which is judicial review that we have covered, right? So at this point of time, my intention is to make sure that you have, for example, let's say the structure of the constitution, the preamble, the land, which is territory, union and its territory, the citizenship, which is the people of India, and then you have the state. This is a component of a government, and along with state but separated from is the judiciary, right? So this part we have covered. So even if you're revising all your subjects in terms of etc., you should have a kind of a structural understanding of the constitution. This will help you. I will explain to you later as a part of a revision. Okay. So now we come to the next part, which is the fundamental rights given under Article 14 onwards. So the first category of fundamental right, this is a question which has been asked in the prelims examination. For example, a question can be asked in the prelims examination that abolition of untouchability falls under which category of fundamental right? Option A, they can give right to equality. Option B, they can give right to freedom. Option C, they can give right to what you can call freedom from exploitation. And option D, they can give right to conscience. Okay, the correct answer would be over here, the right to इक्वालिटी. तो इस तरह से थोड़ी सी चीज़ें हम एक बार रिवाइज कर लेंगे कि कौन सी राइट कौन सी कैटेगरी में आती है, कौन से हेड के नीचे आती है. तो फॉर एग्जांपल द फर्स्ट सेट ऑफ राइट्स विच आर गिवन फ्रॉम आर्टिकल 14 ऑनवर्ड्स आर आर्टिकल 14 इक्वालिटी बिफोर लॉ, विच इज ऑल्सो नोन एज द कॉन्सेप्ट ऑफ जनरल इक्वालिटी, राइट. अब इसको मैं बस बहुत जल्दी ही आपको प्रीलिम्स के बेसिस पे कौन से इंपॉर्टेंट कॉन्सेप्ट्स हैं उनसे थोड़ा सा रन थ्रू कर देता हूँ. कभी प्रीलिम्स में व्हाट वी आर नोटिसिंग इज फॉर अ वेरी लॉन्ग टाइम लॉट ऑफ कंसेप्चुअल क्वेश्चंस फ्रॉम द फंडामेंटल राइट्स पार्ट्स आर कमिंग. फॉर एग्जांपल लेट्स से एक क्वेश्चन आया था प्रीलिम्स में, आई थिंक इन वन ऑफ द ईयर्स 2019 और 2020, which said that which of the following is the best definition of liberty, and that question caused a lot of confusion in the UPSC. So the civil services is causing a lot of conceptual questions out of the fundamental rights. So let me elaborate them one by one to get a sense of what we can achieve through this kind of a discussion. When we talk about, let's say for example, equality, which is given under Article 14, when we talk about equality which is given under Article 14, we talk about two concepts of equality. Okay, one concept of equality is known as equality before the law. Okay, this is one concept of equality, and then it talks about and equal protection of the law. ठीक है, तो अगर मान लीजिए ऐसा कोई प्रश्न आता है, if there is a question which comes in the prelims examination as to which of the following categories or qualities of equalities are mentioned under the Constitution of India, what you have is two categories of equality: equality before the law under Article 14 and equal protection of the law. Okay, now basically the term which is used in terms of leading them to, in fact, let's say for example, I must substitute this not with and but or, which basically means that these are two very separate kind of equalities. And all I can say at this moment, for example, to give you a set of memorizing tips, is that equality before the law is a concept which has been borrowed from the British Constitution, from the English Constitution, right? It is a what you can call a concept which India has been inspired from the common law tradition, the English Constitution. Equality before the law, okay? And equal protection of the law is something that the Indian Constitution has taken from the American Constitution. तो इस तरह का आपका कोई prelims का एक question बन सकता है कि equality before the law is inspired from which constitutional scheme, because comparison of constitutions is a part of your main syllabus. Sometimes in the prelims examination, some questions can be asked with regard to the inspiration behind a certain conceptual idea. Equality before the law is taken from the English Constitution, and equal protection of the law is taken from the American Constitution, right? And the Indian Constitution, in a way, inherits both of them. The question which was there before the Constituent Assembly was, should we follow the American model of equality or the English model of equality? And eventually the answer came that we have to take both the models of equality and we should apply them as per the needs of the circumstances or conditions, right? So what we basically have is both sense of equality under Article 14 of the Constitution, equality before the law and equal protection of the law. Okay. Now we come to the next article, which is Article 15 and Article 16. These are two articles which are heavily important, and I am going to focus a significant amount of time in the next part upon these articles, and then I will lay out certain categories for you. So abhi humne Article 14 tak kar liya. Let's say I'll do a revision. Article 1 to 4 is the Union and its territory. Article 5 to 11 are citizenship. Article 12 is state. Article 13 is judiciary and judicial review and doctrine of severability. Article 14 is equality before law and equal protection of law. And Article 15 and 16 talks about what you can call equality of status and equality of opportunity. Just another thing which I can mention over here with regard to equality under Article 14 is that equality under Article 14 is granted to all persons, not only to citizens. So for example, if a person from USA is residing in India, but he doesn't have citizenship of India, he has citizenship of the USA. Therefore, what it means to say is that Article 14 grants that the equality before the law and equal protections of the law cannot be taken away even of a citizen of an outside country who is present in the territory of India and forms a part of the population of India, even though not as a citizen but only as a resident or a person. Okay, so this is something that I just want to specify as a bypass remark. Article 15 deals with equality of status. Article 16 deals with equality of opportunity, right? We have seen the presence of these two equality. We have seen the presence of these two equalities in the preamble, right? If we talk about preamble, we see equality of status and equality of opportunity. And the way that they have been elaborated in the Constitution is Article 15 talks about equality of status and Article 16 talks about equality of opportunity. So Article 15 says that there must be a prohibition of discrimination. Prohibition of discrimination in the society on the basis of gender, race, caste, creed, place of birth, etc., etc. Okay, and so basically it talks about prohibition of what you can call social discrimination. Clear? Article 16 talks about, as I mentioned previously, prohibition of discrimination in matters of public employment. Okay, you have to be very clear about it. For example, let's say if a person is trying to take some what you can call water from a well, okay, and that person has been told not to come near the well because he is a member of a certain caste, then it is a violation of his fundamental right under Article 15 because he has been discriminated from a social position. Okay, it can also be a violation of Article 17, which is the abolition of untouchability. But if he has violated article, if he, let's say, if he is asked for, if someone doesn't, recognize someone or disrespect someone or discriminates against someone within the society, then it is called a violation of Article 15 of the Constitution. For example, let's say the whole thing about Indians not being allowed into railway cabins of the first class during the colonial times is a violation of Article 15 of the Constitution. If any kind of a discrimination is subjected to a person on the basis of what you can call if any kind of a discrimination is made in the Constitution on the basis of caste or class, or class is not a point over here, sorry, race, gender, place of birth, etc., etc. These are discriminations which are going to be prohibited under Article 15 of the Constitution. If any discrimination is made to any person with regard to giving him a public employment means employment, which is, let's say for example, sometimes it is also known by a different term. Let me just replace this by saying the term in terms of offices under the state. Offices under the state. This is a better way of exposing it. It basically means that when you have state under Article 12, legislative, executive, union and state, any kind of a administrative position, any kind of a judicial position, any kind of a legislative position which is given in Sarkar, as you call it, Sarkari Naukari, if any discrimination is made in favor or against any person, it will be prohibited under Article 16 of the Constitution. So Article 15 talks about ohda, status, equality of status, and Article 16 talks about equality of opportunity. Okay. Now, Article 15 and Article 16 are easy to understand and revise, as I have given you the basics of how you can attempt some amount of prelims question from it. What I want to really focus upon in Article 15 and Article 16 is about the exceptions which are given in Article 15 and 16. And broadly speaking, we can have a kind of a understanding about this. Article 15 says that if the state makes any reservations for the upliftment of certain categories of people, it will not be considered a violation of right to equality. And Article 16 says, now basically Article 15 is more or less focused upon reservations in educational institutions. It is focused upon reservations in educational institutions. Question that was asked by Ambedkar was at some point of time, the question that Ambedkar asked was that what kind of a situation can you create for a person to uplift his status? What can you give a person so that the person's person's what you can call status in a society can be uplifted? Is what you can call the ohda in a society can be, he can be respected better. Right? And one answer which came unanimously to the entire Constituent Assembly was to provide that person with means of education. Okay? And therefore, Article 15 provides for the conditions of reservations which are made in the educational institutions. Incidentally, as we read the Constitution today, it talks about reservations both at the public level and at the private level. Right? So, both public and private institutions, at least from the reading of the Constitution, empower the state. Okay? The state, as mentioned under Article 12, can create a policy of reservations for reserving certain seats at educational institutions, both public and private, to uplift people of certain categories which are mentioned in the Constitution in certain schedules of the Constitution. And similarly, Article 16 talks about reservations in matters of offices of the state. Offices of the state. Reservation in matters of offices of the state. Okay. So, very simply, if I can elaborate this, it means this, that if there is a reservation policy which deals with giving reservations to people in educational institutions, it is springing out of Article 15 of the Constitution, which talks about the equality of status, and it talks about uplifting the status of people who have been historically marginalized by giving them access to education, both public and private, under Article 15 of the Constitution. If we talk about reservations in Sarkari Vibhag, in public employment in offices of the state, then we are talking about reservations which are given under Article 16, equality of opportunity. Okay. So, this point is something that we can remember for the prelims examination. Equality of status is associated with equality of what you can call opportunity for. Equality of status can be associated with what you can call educational institution reservations, and equality of opportunity can be associated with public employment or offices of the state reservation. Clear? This is one thing that I am trying to indicate. Now, I am going to just elaborate this part with some amount of current affairs which have developed. Okay. So, now I think we are coming at a position that we will be taking a look at some of the intricate developments in the current affairs in the recent years. Okay. Now, I am going to write briefly the name of the chapter, which is affirmative action. And these are the points that I will discuss in the name of the chapter called affirmative action. First point I will discuss, which I have discussed already, is Article 15 of the Constitution. Second that I have discussed is Article 16 of the Constitution. You see reservations in educational institutions and reservations in public employments. Okay. Third that I discuss is Article 338 of the Constitution. Fourth, I discuss Article 338A of the Constitution. Fifth, I discuss Article 338B of the Constitution. Sixth, I discuss Article 340. Seventh, 341. Eighth, 342. And ninth, 342A. Don't be intimidated by the number of these articles. As I am telling you, it's not very important to remember the number, and I am going to open up these articles as to what they stand for. Okay. So, for example, I have given you Article 15 stands for the right to equality of status, Article 16 stands for right to equality of opportunity, and Article 15 says that the state cannot be prevented from making any law in which equality of status can be violated. But if the state makes special provisions for the reservations of people in educational institutions, it will not be violative of Article 15 of the Constitution. And similarly, the state can make laws with regard to Article 16 of the Constitution, and any law which is made with regard to giving reservations to public employment, reservations in public employment to certain classes of people will not be violative of Article 16 of the Constitution. Okay. Article 338 talks about National Commission for Scheduled Castes. Article 338A talks about the National Commission for Scheduled Tribes. Okay, so I'm just going to write this: National Commission for Scheduled Castes, National Commission for Scheduled Tribes. Here I can write National Commission for Backward Classes. Article 35 mein again I can write of something similar, which is known as a Backward Classes Commission. For example, the Mandal Commission would be classified under Article 38 of the Constitution, 340 of the Constitution, and Article 341, 342 and 342A are powers to the Union to notify, powers to the Union to notify groups under scheduled caste, scheduled tribe and OBC/SEBC. So what I have done is, in a way I have laid out to you the entire amount of literature that you have to read in terms of identifying the relevant points within the Constitution of India with reference to the affirmative action. Okay. So, for example, Article 15, Article 16, Article 338 National Commission for Scheduled Castes, Article 338 National Commission for Scheduled Tribes, Article 338B National Commission for Backward Classes, Article 340 Backward Classes Commission, and Article 341, 342 and 342A with reference to the powers of the Union to notify groups under SC, ST and OBC, right. Now, just take a listing of this so that whenever you are revising, you can have one small piece of paper on which you can write the number of these articles, and the fact that you are writing the number of these articles with reference to what you are reading will be able to make you revise them properly again and again. Okay. So, let me give you a brief way in which you can take a look at what we are looking at. Right. With regard to reservations, we ask the following questions. Okay. The first question that we ask with regard to reservations is, how does the state get the power to provide reservations in educational institutions. If this is a question that we ask, then the answer that we get is under Article 15. The prelims question that can be framed out of this is under equality of status given by the Constitution. Okay, this is one question that we can ask as a frequently asked question. Okay. Second question that we can ask is, how does a state get the power? How does a state get the power to provide reservations in public offices? Answer to that question is under Article 15, equality of opportunity. Okay. Please take a note of this. This can be made to structure in a kind of a question in the prelims examination. Okay. Okay. The next question that we ask in reservation policy is, what are the categories in which reservations can be provided? Okay. Now, the answer to that is, number one, there is what is known as the scheduled caste. Number two, there is what is known as the scheduled tribe. Number three, what is known as the socially and educationally backward classes, sometimes also interchanged with other backward classes, SEBC. Okay, these are the three classes which have been envisaged in the original draft of the Constitution. Okay. Now, the important point that I am trying to come to is the fourth class, which is known as the economically weaker sections, EWS. Okay. This has been added to the Constitution only recently, and that is why you have a kind of a judgment by the Supreme Court of India recently, which is a Constitution bench judgment, a 5-judge bench judgment, which talks about certain ideas which are associated with this kind of a situation. Okay. So that's what I'm going to a little bit focus upon. If, let's say, for example, you have a question, which of the following categories were mentioned in the Constitution originally, you can have the answer as scheduled caste, scheduled tribes and SEBCs. However, the Supreme Court in the Indira Sani judgment, which I will take elaboration upon, stated that according to its power of interpretation, Supreme Court could also read the OBC to be a part of the Constitution. Okay. Again, I'll repeat the kind of question that you can get out of this. Question is, which of the following categories were a part of the original Constitution? Just like, for example, you have a question regarding Preamble, which of the adjectives to the Preamble were a part of the original Preamble? Okay. You can also get a question which states which of the part of the what you can call the categories for reservations were given originally in the Constitution, and the categories for reservations which were given originally in the Constitution were scheduled castes, scheduled tribes and the socially and educationally backward classes. Okay, the socially and educationally backward classes. This is given in the Constitution, right? Now, the concept of OBC was not given in the text of the Constitution. संविधान के अंदर शुरुआत में जो reservation policy लगी थी 1950 and 1951 में, it was not given originally in the draft of the Constitution. Okay, but it was interpreted to be in the Constitution by the Supreme Court in the Indira Sani judgment. Okay, and therefore it was understood as being a part of the constitution. But one category which is not mentioned in the constitution, which was introduced by a constitution amendment inside the constitution, is the EWS category, which is the economically weaker sections. So this is the recent addition to the categories which can avail reservations under Article 15 and Article 16 of the Constitution, right? So this is a part that you have to take a little bit of a look at. Okay, so let me just repeat to you again. What are the categories in which reservations can be provided? Now, the categories overall in today's terms are scheduled caste, scheduled tribes, SEBCs and EWS, and these three can be read in the original intent of the constitution makers. But EWS was not in the original intent of the constitution makers. It was introduced in the constitution by the constitution amendment, right? The constitution amendment which introduced the EWS is the 103rd Constitution Amendment Act, which was imposed in year 2019. Okay. नहीं, ये अच्छा क्वेश्चन. Invincible OBC वाला amendment से नहीं आया. There is no amendment made to the constitution to introduce the OBCs. OBCs were interpreted into the constitution, Article 15 and 16, by the Mandal Commission report, and the Supreme Court upheld the validity of the Mandal Commission report and said that if you read the intent and the logic of Article 15 and 16, you can interpret that OBCs can be a part of it. Okay, so it was not introduced. Even today, for example, if you look at the language of Article 15 and 16, it doesn't mention other backward classes. It only mentioned socially and educationally backward classes. But the Supreme Court said that the socially and educationally backward classes and what you can call the concept of backward classes can be read into the constitution. Okay? So that's what basically we are saying, that this was interpreted in the constitution. The only thing which was added into the constitution, which was not there in the original intention of the constitution, is EWS, and this is given by the 103rd Constitution Amendment Act made in 2019. Okay, so this is a point that I want to lay a little bit of a focus upon. Okay. The next question that we can ask with regard to reservations is that how does the government decide which groups of people can be notified as A, scheduled castes, B, scheduled tribes, C, SEBC/OBC, and D, economically weaker sections. Okay? Now let me give you the answer to this question. How does the government decide which groups of people can be notified? मतलब प्रश्न ये है कि मान लीजिए कोई एक group of people है, let's say there's a caste or a subcaste which is protesting by blocking the railway tracks about what is called the which is protesting which is blocking the railway tracks by giving a kind of a call for giving them reservations, right? So वो reservations के basis पे they are trying to protect and block out the railway tracks. Now, if the political party which is in power, they are being made demand to that this group or class should be given reservations to, how does the political party which is in power take this decision? Is it based upon any scientific basis? Is it based purely upon political agenda or political mobilization? मतलब राजनीति के अलावा क्या कोई और नीति है, कोई विज्ञान है, कोई ज्ञान है ये डिसाइड करने के लिए कि किसी को रिजर्वेशन दिया जाता है तो वो किस आधार पे दिया जाता है? And we can ask a question about what is the scientific basis upon which a particular group or a subgroup has been given reservation. The Constitution answers that question by creating what are known as constitutional bodies. आपके मेंस के पेपर के लिए एक हेडर दे रखा है जिसको कहते हैं constitutional bodies, राइट और एक जो कॉन्स्टिट्यूशनल बॉडी है जो कि बात करती है रिजर्वेशंस की, मतलब जो कि आधार बताती है कि किस बेसिस पर रिजर्वेशन दिया जा सकता है शेड्यूल्ड कास्ट को, उसको हम कहते हैं नेशनल कमीशन फॉर शेड्यूल्ड कास्ट, right? That is the articles that I am trying to refer to. For example, let me take you to the draft of the Constitution of India. If you go to the article 338 of the Constitution, it talks about a constitutional body which is known as the National Commission for Scheduled Castes. ठीक है, तो जैसे आपने जब अपने पॉलिटी के पेपर्स के बारे में पढ़ा होगा तो आपने कॉन्स्टिट्यूशनल बॉडीज के बारे में पढ़ा होगा. लेट मी गिव अ वेरी सिंपल डेफिनेशन ऑफ व्हाट अ कॉन्स्टिट्यूशनल बॉडी इज. अ कॉन्स्टिट्यूशनल बॉडी is a body which has been given birth to by the constitution. So for example, let me elaborate this a little bit as a note. Three kinds of bodies are something that we have to read in polity. Okay, one kind of body is constitutional bodies. For example, the example of constitutional body are, let's say, the Election Commission of India under Article 324, or what we have discussed as the National Commission of Scheduled Caste under Article 338, or for example, National Commission of Scheduled Tribes under Article 338A, right? Or let's say CAG or the Finance Commission under Article 280, 281. These are known as constitutional bodies. The point about constitutional bodies is that they are born by the what you can call the will of the constitution itself. Okay, they are born by the will of the constitution itself. They are not supposed to be altered by the parliament except by the provisions which are provided under Article 368 of the constitution. Okay, so for example, if you have the Finance Commission or the National Commission of Backward Classes or Scheduled Castes, it is something which has been made by the constitution itself, right? And therefore the parliament, the legislature, cannot unmake that constitutional body at its will. It requires a huge amount of power under Article 368 to, let's say, dismantle a body like the Election Commission or the National Commission for Scheduled Castes. Okay. The other kind of body which is something that we study in polity is what is known as statutory body. Okay. Statutory body is a body which is not made by the constitution but it is made by the parliament. So for example, let's say the instance of a statutory body is the Reserve Bank of India, which is made by the Act of the Parliament 1934. This is the Act of the Parliament which has given birth to Reserve Bank of India. Or for example, let's say Delhi University, or for example, let's say State Bank of India. These are bodies which are made by a statute. Statute implies a law made by the Parliament. This is basically what is made by the statute. And then you have the non-statutory bodies. For example, bodies which are made by an executive order or an administrative order. Right? For example, you have the Niti Aayog, which has been given birth by a cabinet approval, or before Niti Aayog you had another non-statutory body which was known as the Planning Commission. Okay, so this can be a simple conceptual understanding as to describe what is the meaning of constitutional body or distinguish between constitutional bodies and statutory bodies. A conceptual distinction between the two is that constitutional bodies can be amended or moved out of the constitution only by following the procedure under Article 368, and that too is subject to judicial review under the basic structure and doctrine. Okay, Article 368 can be used to amend or let's say disempower a constitutional body, but Article 368 is a strict procedure and it is also subject to a heavy inspection of judicial review under the basic structure doctrine, which effectively means that the parliament, if it wants, it cannot do away with National Commission of Scheduled Caste or Scheduled Tribes or Election Commission of India. Statutory bodies के लिए आपको Article 368 की जरूरत नहीं पड़ती. आप statutory bodies को ordinary law से बना सकते हैं और उनको मिटा भी सकते हैं, और इसमें judicial review बहुत limited लगता है. Ultra wires के level पे ही judicial review रख सकते हैं, otherwise इसमें judicial review नहीं लगेगा. ठीक है? And in non-statutory bodies, you don't even need the permission of the parliament. The cabinet itself, the government, at the union level and at the state level respectively can create and uncreate, make and unmake a statutory body, non-statutory body without the permission of the Parliament or the permission of the Constitution, which for example means the Planning Commission was made by a cabinet approval and the Planning Commission was dissolved by a cabinet approval. Okay, so this is a simple distinction that we can understand at this point between a what you can call a statutory body and a non-statutory body and a constitutional body. Now, coming back to our understanding, the decision, the science, or what you can call the data analysis, the sociological analysis of understanding who can be notified as a scheduled caste and what steps can be taken for the further advancement of scheduled caste is given as a power to a constitutional body under Article 338 of the Constitution, which is known as the National Commission for Scheduled Caste, NCSC, National Commission for Scheduled Caste. Okay, this is something that you can remember. Again, for example, let's say Article 338 of the Constitution, there shall be a commission for the scheduled caste to be known as the National Commission of the Scheduled Caste. Okay, and the jobs and the functions and the powers of the National Commission of Scheduled Caste don't need to be memorized. You just have to get a sense of what the basic idea of the National Commission of Scheduled Caste is, that it basically takes up the data, the sociological data, the anthropological data, and examines the data and gives recommendations to the government of India as to what steps can be taken to improve the conditions of the scheduled castes, and also what castes or what groups can be what you can call added into the category of scheduled castes and removed out of the category of the scheduled castes. So it's like a think tank which sends its recommendations to the government of India with regard to what is the nature and status of scheduled castes in India, with sociological, anthropological, and what you can call a kind of a knowledgeable aspect of what is supposed to be the real aspect of how to determine a particular caste as a scheduled caste or a tribe as a scheduled tribe. Similarly, under Article 338A, you have another constitution body which does the same thing exactly for the scheduled tribes, known as the National Commission for Scheduled Tribes. Okay, this was introduced into the constitution by an amendment, and therefore this kind of an activity is again the nature of the 338A is to produce a National Commission of Scheduled Caste which can give the government recommendations upon the status of scheduled castes in India and how the scheduled castes can be advanced, and also what groups of people can be identified as scheduled castes and what can be taken out of the categories of the scheduled castes. Then you have the SEBC and OBC for which the constitution was amended, and Article 338B had was inserted in the constitution to provide for what is known as a National Commission for Backward Classes. Okay, National Commission for Backward Classes was not there in the original constitution. Again, as a point that you can remember for the prelims examination, it was not the original intent of the constitution to have a National Commission for Backward Classes. Okay, the original intent of the constitution was only to have a what you can call a Backward Classes Commission. So I will just explain to you the difference between the two. This is going to be relevant to understand because the whole Indira Sahni judgment and the EWS quota judgment is ridden with this literature. Okay, कि मतलब जो भी हमारा reservations और affirmative actions में जो भी constitutional bodies है etc. उनके सारे नाम आपको याद करना important इस समय इसीलिए क्योंकि जो अभी EWS का judgment आया Supreme Court के 5 judge bench का, which is a bit of a landmark judgment, which is a landmark judgment which basically makes a huge exposition of all these activities which are happening under affirmative action. Okay, so basically अगर हम देखें तो Article 338B was introduced into the constitution by an amendment. Okay, and Article 338B also established is a constitutional body which is supposed to have the scientific and the anthropological basis on which the judgment about what is a backward class, which includes an OBC and an SCBC, can be identified as, right? So just take a look at Article 338B of the Constitution. Article 338B of the Constitution talks about National Commission for Backward Classes, introduced by the Constitution, 102nd Amendment Act 2018, right? 102nd Constitution Amendment Act 2018 introduced the constitutional body which is known as the National Commission for Backward Classes, okay, and it has exactly the same agenda as National Commission for Scheduled Castes and National Commission for Scheduled Tribes, just that it has it for the National Commission for the Backward Classes. Okay, matlab to identify who are the backward classes, to give recommendations to the government as to the upliftment of backward classes, and to make sure that the status and nature of backward classes is moving into a progressive direction, to do a scientific, sociological and anthropological research upon their identities and their what you can call upliftments, is the work of the National Commission for Backward Classes, which is introduced by the 102nd Amendment Act 2018. Okay, now before the National Commission for Backward Classes was in a way made a constitutional body by amending the constitution under Article 368, there was what is known as a Backward Classes Commission, right? This is under Article 340. For example, if you ask the question about what is known as the famous Mandal Commission, okay, so for example, if a question is asked in the UPSC about the nature of Mandal Commission under the Constitution, the Mandal Commission is not the National Commission for Backward Classes. Okay, Mandal Commission is something which is a part of Article 340 of the Constitution. A Mandal Commission was formed on first time in 1979, and it gave its report in 1980 onwards, and then it was implemented in 1990. Okay, but Mandal Commission was not a National Commission for Backward Classes. It was what is known as a Backward Classes Commission made by the Government of India under the powers given to the Government of India under Article 340 of the Constitution. This kind of a distinction is going to become relevant for the prelims examination this time, because the Mandal Commission report and the Indira Sahni judgment were in news again and again this time because of the EWS quota judgment. Okay, basically what we take a look at is the fact that the nature of Backward Classes Commission is slightly different from the nature of what you can call the, let's look at it. You have the Backward Classes Commission under Article 340, and you have the National Commission for Backward Classes under Article 338B. Right? You can have a question which compares the two in some way or the other in the prelims examination. Okay. Now, let's say for example, one of the differences that it was a part of the original Constitution, National Commission of the Backward Classes. Okay, and this, what you can say, became a part of the Constitution by amending the Constitution. It is not a part of the original Constitution. Okay. Number two, it leaves at the discretion of the government if a commission has to be appointed. Okay, so let's say for example, there are two Backward Classes Commissions which have been appointed in history. Okay, one is known as the Kaka Kalekar Commission, which is known as the first Backward Class Commission, which was established in 1953, and it gave its report in 1955. This was known as the first Backward Classes Commission. Okay, the second Backward Classes Commission was introduced way later, which was of course known as the Mandal Commission. Right, and the report of the Mandal Commission, was introduced, was established in 1979. It prepared its report in 1980, and the implementation of the Mandal Commission report was done in the year 1990. Okay, so this is what is known as, for example, in your reference books, you can write as the first Backward Class Commission, and this is known as the second Backward Class Commission. Okay. So, what you can see from this nature is that in under Article 340 of the Constitution, it says that the President may by order, and the defining feature over here is may, which is not shall. Okay. So, basically the first time that the President did establish a backward class commission was in 1953, and the second time it established was in 1979, which means that it leaves a room for the discretion of the President to appoint a commission under Article 340, which basically means that if a review has to be done as to which group of people should be identified as the SCBCs or the OBCs, that review can be done only when the President wants to appoint a commission for that. There is not a permanent commission which is appointed under the Constitution of India for the review of the status of the schedule of the other backward classes and the socially and educationally backward classes. Okay, this was the procedure which was given in the Constitution with regard to the commission for the backward classes. Now, with the introduction of Article 338B, in the Constitution, what you have is a permanent commission for backward classes. Sometimes it is also known as a permanent commission of backward classes, which is very different from Article 338A. Now, what you see in Article 338B is the fact that states there shall be a commission for the socially and educationally backward classes to be known as the National Commission of Backward Classes. Okay? So, sometimes it is also known as the permanent commission. It is not left at the discretion of the President to appoint a backward class. Okay? It is not left at the discretion of the President to appoint a backward class. It is something that must be appointed by the President, because the term over here is shall. Okay? So, this is the point that I am trying to clarify over here, which means that you have the government which may appoint a national commission, the commission for backward classes under Article 40, for example, the Mandal Commission. But over here it is mandatory for the government of India, the President, which says that it must or it shall appoint members to the National Commission for Backward Classes, and this is a commission which exists 24/7, 365 days, and any matter can be referred to it by the government, and the government will have an answer from this in terms of giving it a think tank ability to identify the backward classes in India. Okay. Yes, you're right in saying that Article 338A also made an amendment into the Constitution to insert about the National Commission for Scheduled Tribes. The National Commission for Scheduled Tribes was not in the original draft of the Constitution, it was introduced into the Constitution by the 89th Amendment Act 2003. So, anyone who is asking about what Amendment Act was passed in 2003 with regard to reservations, it was the 89th Amendment Act 2003, which was passed in reference to reservations. Okay. You get a sense about how this kind of a situation is arising. So, let me just do a kind of a recap about the entire reservation system before we get lost in the detail and specific points to remember at the prelims examination. You have Article 15, equality of status, Article 16, equality of opportunity, reservations in educational institutions, reservation in public offices. Okay. Then you have Article 338, which is the National Commission for Scheduled Castes, which was in the original Constitution. Article 338A, National Commission for Scheduled Tribes, which is from the 2003 Amendment Act. Then you have the National Commission for Backward Classes. This is also put in the Constitution by an amendment. So, this gives a list of castes which it thinks on a scientific basis to the government of India in terms of identifying if they are fit to be classified as scheduled castes, scheduled tribes and backward classes. These are the constitutional bodies, the scientific think tanks which are supposed to operation and assess the sociological and anthropological data in terms of assessing whether a particular group of people who are protesting to be included in the backward classes, etc., are eligible for such kind of a movement inside that category. Okay, so this is the next question that we answer. Then the question that we answer is, within the state as mentioned under Article 12 of the Constitution, okay, within the state, which organ of the state and which level of the state can identify groups into SC, ST, OBC, and then we'll talk about EWS. Please pay attention to the minute details of this discussion, because anything from here can be converted into a prelims question. As the EWS quota judgment was given only this year, you are going to see a lot of action in the prelims examination from this part. So I'm summoning your attention with some responsibility. Okay. So within the state, but basically the question I'm asking is, let's say if there's a caste called caste X. Okay. Now let's say the caste X is demanding to be included in the category of OBCs. Okay. You have the state as it is given, the union, the state, the legislative and the executive. Okay. So within the state, which of the organs does have the power to notify? Is it with the let's say the Prime Minister of India, who is a union executive, or is it with, let's say is it with the Prime Minister who is a union executive, or is it with the union parliament, the Lok Sabha, which is a union legislature, or let's say it is with the state executive, the chief minister, or it is with the state legislature, the Vidhan Sabha. Who has the power to notify a particular caste or a group of people who is trying to notify themselves under the other backward classes category? This is the question that we are asking. Okay. Now the answer to that question is very simply categorically put out over here. When it comes to the scheduled castes, what we have to refer to is Article 341 of the Constitution. Just let me put you out over there. Okay, and we'll read it together. And this is going to be important for us to memorize properly. This could be a little tricky if you have not been able to cover in your static portion. Now is a good time for having a clear understanding of them, and I'll go slowly about it. Okay. So for example, just like you have Article 340, 338, which talks about the National Commission for Scheduled Castes. National Commission for Scheduled Castes. Okay. Which is like a think tank, which suggests to the government as to what castes can be included in the category of the scheduled castes, right? Okay, it has what you can call a recommendatory power. Okay, now under Article 341 of the Constitution, it is said that the power to notify the scheduled caste is with the President of India, but of course, the President is only a nominal head. The President is working upon these powers on the aid and advice of the Prime Minister and Council of Ministers. Okay, so the recommendations are to be made to the President, who make under these recommendations or bypassing this recommendation, notify a particular caste X as an OBC. Okay, this is the point that we're trying to make. Again, I'll repeat it. With regard to scheduled castes, NCSC, which is a think tank, recommends to the President that a particular caste can be notified as a SC. Now, the President may look at the recommendations given by the National Commission of Scheduled Castes, but he is not obliged or bound by the recommendations. And maybe on the basis of the recommendation, or maybe upon his own political calculation, he can notify a particular caste under the category of the scheduled castes. This power is given to the President under Article 341 of the Constitution. But this power is not only given to the President. The list that is created by the President of the notification can be modified by the Parliament. Please listen to this very carefully. A very clever constructed prelim question can be asked on it. Okay, list is notified by the President, but the Parliament also has the powers of reviewing the induction of a caste as SC. Okay, so what I am trying to say is that the Parliament, if it gets a list as to the number of castes which have been inducted in the category of scheduled caste, the Parliament under Article 341 has the power to add another caste in this list or to strike out any caste in this list by passing a motion. Okay, you see the point? Let me just repeat it again slowly and clearly. I'll go through this again. Under Article 338 of the Constitution, the National Commission of Scheduled Caste is appointed, is established. It is a permanent commission. It is not at the discretion of the President that it is established, and it provides recommendations to the President to include a certain caste into the scheduled caste. The President may consider these recommendations and create a list of castes which are the part of scheduled caste now. Once this list has been created by the President, it can be reviewed by the Parliament, and the Parliament can add a name to the list and cross out to the name to the list, right? These are, for examples, the powers of the Parliament to check and balance the power of the executive, right? So a kind of a shared power is given to the Union Executive and the Union Parliament to notify the scheduled castes in the category given under Article 15 and 16 reservations. No power has been given with regard to scheduled castes to the state governments. That's a very simple prelims kind of a trick question. Has any power been given to the state governments with regard to inclusion of certain categories or certain classes of people under the scheduled caste category? No power has been given to the state government. राज्य की सरकारों को, प्रदेश की सरकारों को कोई भी पावर स्टेट गवर्नमेंट के अंदर नहीं दे रखी है, मतलब स्टेट गवर्नमेंट को नहीं दे रखी है. अगर कोई मध्य प्रदेश में कोई एक गुट है जो कि शेड्यूल्ड कास्ट में एंट्री करने के लिए प्रोटेस्ट कर रहा है, तो उस गुट को शेड्यूल्ड कास्ट में एंट्री देने की जो पावर है वो सिर्फ केंद्र सरकार के पास है, केंद्र एग्जीक्यूटिव के पास है, प्राइम मिनिस्टर और काउंसिल मिनिस्टर्स के पास, और उसके एक्शन को रिव्यू करने की पावर पार्लियामेंट के पास है. इस एक्शन को लेने से पहले केंद्र का जो एग्जीक्यूटिव और नेशनल कमीशन फॉर शेड्यूल्ड कास्ट की रिपोर्ट को देखकर अपने आप को सूचित कर सकता है. ही कैन इन्फॉर्म हिमसेल्फ ऑन द बेसिस ऑफ द रिपोर्ट विच इज गिवन बाय द नेशनल कमीशन फॉर शेड्यूल्ड कास्ट्स. ओके, बट ही इज नॉट बाउंड बाय दैट रिपोर्ट. इट इज ओनली recommendation in nature which is not binding upon the president, and no power is given to the state governments to notify scheduled caste. So even if I am staying in a particular state in India, if I have to ask for my rights as a scheduled caste, if I have to be asked for being included in the scheduled caste, I can only ask that from the central government. I cannot ask it from the state of Uttar Pradesh or Madhya Pradesh or Rajasthan, whichever state I am a resident of, right? That's one thing that we have to understand very clearly in terms of getting a clarity on the prelims part. Okay? Okay. Next we ask the question about scheduled tribes. Again, I'll make the same effort about it. Scheduled tribes are mentioned under Article 338A. You have the National Commission for Scheduled Tribes, NCST, National Commission for Scheduled Tribes, right? And the National Commission for Scheduled Tribes is, of course, what we have understood as a think tank, right, which is constituted as a permanent commission of scheduled tribes, and then the National Commission for Scheduled Tribes under Article 342 gives the recommendations to the President, which is again the President, but with the Prime Minister and Council of Minister aiding and advising. The President is bound by the aid and advice of the Prime Minister and Council of Ministers. They can notify a caste, a tribe, as a scheduled tribe. They can notify a tribe as a scheduled tribe. Clear? And the notification of a tribe as a scheduled tribe can then be reviewed by the Parliament, in which if a list is provided to the Parliament about the actions of the executive, that these groups have been identified as scheduled tribes, the Parliament can add another entry to the group or remove an entry from the group. The Parliament can add an entry to the group or remove an entry to the group. Okay, so the power to notify the scheduled tribes is finally shared between the President and the Parliament, and the 338A National Commission for Scheduled Tribes gives a kind of a think tank assistance, but the nature of this is only recommendations. It is not mandatory for the President to go with the recommendations of the constitutional body known as a National Commission for Scheduled Tribes. Okay. Now the next question is, what happens with regard to the other backward classes / the SEBCs? In the constitutional scheme of things, the OBCs and SEBCs are interchangeable terms. SEBCs. Okay. Again, let me put out very simply. You have Article 338B, which has a National Commission for Backward Classes, which gives the power to the constitutional body of National Commission of Backward Classes to create recommendations. Earlier, this power was enjoyed by the President, who could at his own time and discretion create a backward classes commission. But now this doesn't work. You have the 338B, National Commission for Backward Classes. Okay. For example, the National Commission for Backward Classes under Article 342A again follows the same pattern. The President can take cognizance of the report of the NCBC and then notify a list, and then the Parliament can exercise the powers of checks and balances to the power of the President to notify a caste as a other backward class or a scheduled socially and educationally backward class. Article 342A was introduced into the Constitution by a Constitution Amendment Act. Okay. Now, this is a point that I want to refer to it, and then I'll move to the judgment given by the Supreme Court in a famous judgment which is also known as the Maratha Reservation case, which came out only last year, and we take a look at the Constitution bench judgment. The Article 342A of the Constitution was introduced into the Constitution by the 102nd Amendment Act 2018. You can take a note of this. Okay. 342A was introduced in the Constitution by 102nd Amendment Act 2018. Now, with the introduction of this act, the modification that has been made is that earlier, while identifying the OBCs, before the Amendment Act was introduced in the constitutions, the identification of OBCs was shared between the union government and the state government. What I basically mean to say is that, let's say, if you have a job under a subject which is given under union list, let's say for example, let's say defense. Defense is a subject under the union list. So, to identify the other backward classes reservations, the classes for reservations as other backward classes in the defense sector or category is to be decided by the union government, because defense is a union subject. Okay, so who will become a other backward class in terms of getting a quota for reservations under the defense jobs which have come out in Article 16, public employment, will be decided by the union government, and correspondingly anything which is under the state government, let's say for example fisheries, which could be a state subject. If any kind of a job opens up, who will become an OBC, who will be able to avail the benefits of reservations in this sector if a public job is coming up, it will be decided by the state government. Similarly, for the universities who are central universities, for example, Delhi University or other universities which are central, केंद्रीय विश्वविद्यालय है, उनके लिए जो डिसाइड होता है कि कौन गवर्नमेंट ये डिसाइड करेगी कि इसमें किस ग्रुप ऑफ पीपल को ओबीसी का दर्जा दिया जाए, वो केंद्र सरकार करती थी. लेकिन जो स्टेट यूनिवर्सिटीज़ होती थी उसमें ओबीसी किस ग्रुप को दिया जाता था, वो राज्य सरकार होती थी. इसीलिए फॉर एग्जांपल यू मे हैव नोटिस दैट डिफरेंट कास्ट्स हैव बीन गिवन डिफरेंट आइडेंटिफिकेशंस in different states of the OBCs and the SEBCs. Okay, the question that we have now modified is that after the introduction of Article 342A into the Constitution since 2018, the power of the state has been taken away, and for all jobs and all educational institutions across the board, whether it is union or state, the power has been given to the union government. That's a modification that has happened, right? This is a recent modification under Article 342A of the Constitution, which became the crux of the Supreme Court judgment in the Maratha reservation case for the OBCs, right? Take a look at this. To answer your question, Shubham, just take a look at the Article 342A. The President may, with respect to any state or union territory, and where it is a state, after consultation with the government thereof, right? So the whole thing is that the President has the right to take a notification out of telling which group of people will be called an OBC with regard to a state and union territory, and it can only take a consultation with the governor thereof. Now, you know what it means. For example, let's say if there's a group of people in Haryana who are asking for the reservation as OBCs, right, and they are making the demand to the state government. Now, the state government, if it issues a notification saying that that group is a part of OBCs for all the universities which are under the Haryana government, which are under the state, and if the government of India issues a notification which says that that group is not a part of the reservations under OBCs, the reservation notification of the government of India will prevail over the state reservation notification. You see, that's the point. What it provides is that the President may make a notification of any state or union territory as a part of the OBC quota, and he may consult the governor. Now, all of you know, for example, governor is only a person who has been appointed by the President. Governor doesn't come from the legislative assembly or the government of the state legislature. He is a person who has been appointed by the President. So, in saying that the governor is going to be giving the consultation means that you're just in a way doing the same thing that you want. You're not taking any consultation from the state government or the chief minister, council of ministers, right? And this kind of an indication is what we are taking a look at in terms of we're getting a very clear sense that after the amendment made into the Constitution in in Article 342A, the power to notify OBC for the entire country of India has been given to the union government. Previously, it was with the state governments, but for the state universities and state employments and etc., etc. But recently, with the amendments in the Constitution, the entire power has been granted in the hands of the union government. Now, this became exactly the point of contestation in a case which is known as the Maratha reservation case. Okay? But I'll come to that in a point to get you a sense of what is basically happening in the background. So, at this point of time, I feel I have made a good coverage in making you understand the structure of reservation. Now, this is extremely relevant for the prelims examination. Article 15, Article 16, Article 338A, Article 338B, Article 340, Article 341, Article 342 and Article 342A. If you take a look at all of these articles in the Constitution of India, you will get a sense of all the information that is relevant in the Constitution which associates itself with the reservation policy. Okay. So, these articles I think have done right to equality of status, right to equality of opportunity, National Commission for Scheduled Caste, National Commission for Scheduled Tribes, National Commission for Backward Classes Commission, for example, the Mandal Commission, the powers given to the President in terms of notifying scheduled castes, the powers given to the President in terms of notifying scheduled tribes, the powers given to the President in terms of notifying the backward classes. This has been amendment to the constitution in the year 2018 and is going to be of some significance for you to understand in the current affairs. So for example, if a question comes that who has the final authority to decide OBC, is a state government or a union government, the answer is going to be the state government. If there's a contest between the union government and state government, one wants to give the status of OBC, doesn't want to give status of OBC to a particular caste, the will of the union government shall prevail, as it can clearly be read in Article 342A of the Constitution. Okay? Now, let me just put you in touch with one of the what you can call judgments which have been given by the Supreme Court Constitution Bench. This is a case which we are going to take a little bit of a discussion of. A Constitution Bench judgment from which a question can be possibly asked. Again, I am telling you this reference with current affairs because the question of EWS and the question of the OBC under Article 342A notification is a little bit of a relevant question in the recent times. A 5-judge Constitution Bench of the Supreme Court on Wednesday struck down the Maharashtra law granting reservation to the Maratha community in admissions and government jobs in the state. The court had framed 6 questions of law on the issue, right? So, one of the grounds on which basically the history of this is that the government of Maharashtra had notified the community of the Marathas as a other backward class for the, or let's say the socially and educationally backward class for the purposes of public employment and educational institutions with regard to subjects which fall under the state list for the state of Maharashtra. Okay, so for example, if there's a college, let's say there's a government college which has been established by the state of Maharashtra, the Marathas were given the status of an OBC community within that particular state. Okay, within that particular university for education institution reservations. Now, the Supreme Court said that after the introduction of Article 342A, the power cannot be exercised by the state government. The power has to be exercised by the union government. Therefore, if the state government makes a reservation on the other backward classes, then the state government is acting out of its authority, or what you can call ultra vires. Take a look at this. This is a point that I have to identify very clearly as a part of your current affair. The Constitution 102nd Amendment Act 2018 gives constitutional status to the National Commission of Backward Classes. The amendment also gives the President powers to notify backward classes, and several states raised questions on the interpretation of the amendment and argued that it curtails their powers. Okay? The bench unanimously upheld the constitutional validity of the 102nd Amendment, but differed on the question whether it affected the power of states to identify socially and educationally backward classes. Okay? So, now the first question that was raised in this particular judgment, which is known as the Maratha Reservation Judgment, or what is known as the Maratha SEBC Judgment, is that the constitutional validity of Article 342A was established to be perfect. There is nothing invalid with the introduction of Article 342A into the Constitution of India. Okay? And the majority bench in this judgment also held that. Take a look at this. In the task of identification of SEBCs, the President shall be guided by the commission set up under Article 338B. Its advice shall also be sought by the state in regard to policies that might be framed by it. If the commission prepares a report concerning matters of identification, such a report has to be shared with the state government, which is bound to deal with it in accordance with the provisions of Article 338B. However, the final determination culminates in the exercise undertaken by the President. Now, this is the judgment of the Supreme Court, which once and for all clarifies the idea that the right to notify any group of people, whether it is in Haryana or in Rajasthan or in Bihar or Uttarakhand or Goa, any group of people protesting to be included as a part of the category of OBCs can be given that kind of an induction by the President, not by the state government, after the introduction of Article 342A and Article 338B of the Constitution. Okay, so the President is supposed to be bound by is supposed to be in cognizance of the recommendations made by the National Commission for Backward Classes, but the final determination shall be made by the President with or without applying the theories or the what you can call the recommendations which are given in this particular category. Are we clear about it? Right? Okay, so this is what we are calling the Maratha judgment case. So let me just add another point that we are going to take a look at, the Maratha judgment case, the Maratha reservation case, which is a 5-judge bench Supreme Court judgment, in which the action of the Maharashtra government to notify the Maratha community as OBCs was declared as illegal ultra vires because the 342A Constitution Amendment Act made it the prerogative of this union government to identify OBCs. It is another thing to say that the union government may let the states identify it, but if it happens to be the case that the union government has identified certain people as OBCs, the state government cannot disidentify them. If there is a contest between the union list and the state list about OBCs, the union list will prevail. Let's say, for example, if you have been given the status of an OBC by a state government, but the union government has categorically said no to your inclusion as an OBC, then you will not get reservations even under the government offices which are under the administration of the state government, and public educational institutions or private educational institutions set up under the state. Okay, it cannot happen unless there is a a kind of a situation which has been given to the government of the central authorities. Okay, that's where we are. Fine. Now, so we are covering one by one the points that are going about reservations. Take it. So at this point of time, I've clarified to you a lot of structure about reservation. Article 15, Article 16 talks about scheduled castes, scheduled tribes, and the other backward classes. Let me give you a brief history of what is known as the other backward classes in terms of 2 or 3 points. What are the OBCs? Okay, so let's ask the next question. What are the OBCs? And how is the concept of OBCs becoming relevant in the Constitution of India? Okay. Now, as you can see under Article 342, in 1979, a backward classes commission known as the Mandal Commission was appointed by the President. This was done by the Morarji Desai government, and the Mandal Commission gave its reports in 1980. Okay, the Mandal Commission gave its report in 1980, and it called for reservations in public educational institutions and private educational institutions also, and what you can call public offices under the state, for a class of people known as the other backward classes. Okay, so it identified 3 categories of reservations can be given to the SCs, to the STs, and to the OBCs. Okay. In 1990, the reservations which was given to the OBCs was made a part of the reservation policy of the VP Singh government. Okay. So it is between the Narasimha Rao government and the VP Singh government that the reservation policy was issued, and OBCs were given a quota in both these aspects, right? So OBCs were given a quota of 22.5% in the what you can call the Mandal Commission report, and this policy was inducted, was made a part of what you can call the reservation policy formulated by the VP Singh government and the Congress government in 1991, which made a policy in which it is going to give reservations in public institutions and public educational institutions and government offices to the SCs, to the STs, and the OBCs, other backward classes. Okay. Now, the induction of the other backward classes in this reservation policy, let me just elaborate this a little bit. In 1990, the reservation policy that was made, it talked about SCs as a category, STs as a category, OBCs as a category, but is also introduced another category known as the EWS. Okay, so for example, if you have a question in the prelims examination that when was the first time that the category of EWS was introduced, it is not in the 2019 elections or in the amendments, right? The category of EWS has been introduced before in the constitutional scheme of things in the 1990 reservation policy, but it was not a part of the Mandal Commission. Okay, please be clear. EWS not mentioned in the Mandal Commission. These little bit of facts are important to remember for answering questions on the prelims, as I'm specifying that the EWS is a huge judgment by the Supreme Court this year, is not a part of the Mandal Commission but a part of the 1990-1991 reservation policy. So the government introduced the concept of EWS out of its own accord. It was not mentioned in the what you can call the reservation policy of the what is called the Mandal Commission, right? So for example, what we have in terms of the reservations which are given in this particular regard was 27% of the reservations were given to OBCs, 22.5% reservations were given to SCs and ST combined, and 10% reservations were given to the EWS category under the 1990 reservation policy. Clear? That's one part. This reservation policy was challenged before the Supreme Court in the landmark judgment of Indira Sahni. It was Indira Sahni versus Union of India, in which the constitutional validity of this policy was challenged before the Supreme Court, and we'll take a look at some of the aspects of the Indira Sahni judgments which came out as a result of the discussions which were made in this thing, and I'm going to underline for you the basic ideas about how the Indira Sahni judgment sought to in a way address some of the questions with regard to the OBCs. Okay, so you have Indira Sahni versus Union of India 1992. Okay, so I'm just going to elaborate upon the points about it. What is the main observations of the Indira Sahni judgment? What are the main observations of the Indira Sahni judgment? Okay, the first observation of the Indira Sahni judgment, or let's say for example, let me put it in a question answer format. Okay, question: is the category of other backward classes constitutionally valid under Article 15 and 16? Okay. This is the question, and the answer given by the Indira Sahni judgment, in the Indira Sahni judgment by the Supreme Court, is that yes, there is nothing unconstitutional about the category of other backward classes. It can be read into the Constitution because Article 15 and Article 16 both mentioned the term backward classes and socially and educationally backward classes. So combining these two terms, you can conceive the concept of other backward classes. तो जो मंडल कमीशन में जो other backward classes का जो concept था, वो Constitution Bench ने इंदिरा साहनी judgment में valid declare कर लिया. Okay, the bench declared the judgment made by the bench in this particular case said that the Constitution is a very clear, undertaking in which the backward classes under the constitution can be read to conceive the concept of the other backward classes. This was the first question which was given by the Indira Sani judgment. Okay. The second question which was to be decided was, is there a cap or a limit to the maximum percentage of reservations on the total number of seats. ठीक है, तो इसमें बोला था कि क्या रिजर्वेशन किसी भी परसेंटेज तक जा सकता है और इज रिजर्वेशन गोइंग टू बी लिमिटेड बाय सम फैक्टर somewhere or the other. The answer given by the Supreme Court in this was that yes, there has to be a cap, and the Supreme Court took 50% as a point in which this cap has to be realized. Okay, so it said, Supreme Court very categorically said that the total number of reservation, the maximum reservation percentage of the total number of seats cannot exceed beyond 50%, except, okay, subject to what the Supreme Court call exceptional circumstances. This was the second observation made by the Supreme Court in the Indira Sani judgment. Indira Sani versus Union of India, the judgment which was made by the Supreme Court. Okay. A third question that was asked of the Supreme Court was, do all OBCs qualify for reservation? This was the next question asked of the Supreme Court in the Indira Sani judgment, and the answer to that was that there has to be a distinction made within the OBCs. There has to be a distinction made within the OBCs between what is called as the creamy layer and non-creamy layer. Right, and later on a criteria was set out for creamy layer, which was 8 lakh annual family income plus some additional property requirements. Okay, so the judgment which was made over here said that all OBCs do not qualify for reservations. Reservations in OBCs have to be determined as a difference between creamy layer and non-creamy layer, and the criteria of 8 lakh annual family income will distinguish anyone who has 8 lakh and above annual family income will be called an creamy layer OBC, who will not have the privileges of reservation, and the others would be known as non-creamy layer. This kind of a thing was answered by the Indira Sani judgment. The third question was about what is now the important part which I want to develop for you, which is regarding this. Question number 4 in the Indira Sani was, does the Constitution provide for purely an economic, does the Constitution provide for purely an economic basis of reservation? This was the most important question made in the Indira Sani judgment, because as you can see that the reservation policy of the 1990-1991 government gave a point about the question of what you can call reservations on the basis of only economic criteria. Okay, so all the categories of reservations that we see today are based upon some kind of a social criteria. Okay, some kind of a social criteria that you have, for example, a group of people who have been marginalized historically, a group of people who have lived away from the urban life, a group of people who have been found to be backward because of the policies of reservations, etc., etc. So these are all sociological entities, but the constitution is not clear about mentioning any kind of a purely economic activity happening at the level of reservation. So the answer which was given by the Indira Sahni judgment over here was that no, the constitution does not provide for any purely economic reservation, and therefore it struck down the EWS. The constitution does not provide for any economic basis of reservation, and it struck down the EWS as unconstitutional. And it says that there is no provision of a purely economic basis of reservation. But also it implied that the constitution does not provide under Article 15 or Article 16 any specific category based upon only purely economic grounds of a person. Okay. So what you basically see is that the Article 15 and Article 16 do not provide for purely an economic basis of reservation, but it said that if it wants to make a case for it, the government can amend Article 15 and 16, and Article 15 and 16 can be amended to introduce EWS in the constitution. But unless it is introduced in the constitution by a Constitution Amendment Act of the government, it cannot be made a part of the reservation policy, because the constitution as it stood in 1990 did not provide for a purely economic basis of reservation. All the basis of reservation in terms of determining categories for reservations were made in sociological aspects. Clear? Those were the four important judgments made by the Indira Sahni case. I'll repeat them for you. It was in 1979 that the Mandal Commission, the concept of the OBC was used to collect all the backward classes which were mentioned in the constitution. The 1990 reservation policy gave effect to the Mandal Commission report, and it gave reservations the way that I had listed them over there. 27% to the OBCs, 22.5% to the SCs and ST combined, 10% to the EWS. But the EWS was not a part of the Mandal Commission. It was introduced by the government. Okay. Now the government policy was challenged before the Supreme Court in the Indira Sahni judgment. Okay. And the Indira Sahni judgment gave answers to 4 questions, and Indira Sahni is a landmark judgment. It's a 9-judge constitution bench judgment which can be overturned only by 11-judge constitution bench judgment, right? And in the Indira Sahni judgment, the constitution bench said that 4 questions can be addressed. Number 1, is the OBC a valid category under the constitution? It said yes. Under Article 15 and 16, OBC can be read. Then the second question was, is there a ceiling to the number of percentage of reservation that can be given maximum of the total seat? It said 50% of reservations can be given, but it is not a strict rule. In exceptional circumstances, the 50% mark can be breached, but more or less it has to be adhered to. Okay. The third question was, do the OBCs as a class all fall under the quota of reservations, or is there a distinction? It made the distinction between the creamy and the non-creamy layer, which I have later identified, that the 8 lakh rupee of family income was decided as a criteria for distinguishing the creamy and the non-creamy layer. And the fourth question, which was the most important question, which we are going to focus upon right now with regard to the EWS judgment, was whether the government has the ability to make a reservation policy purely upon economic basis. Let's say, for example, I am not given reservation because of the caste or the class that I belong to, but because of the economic status that I have only. There is no other contingency or condition which is required for reservation. Okay, and the answer that the Supreme Court gave in the Indira Sahni judgment, the 9-judge bench, was that EWS does not figure in the constitution. There is no clear mention of economic criteria as being the sole criteria for giving someone reservations, matlab to give reservations based only upon poverty. So it said that the policy cannot be made because the constitution cannot be read into providing for economic thing, and it struck down the policy, the parts of the policy using doctrine of severability till the part it gave the power to the state to create reservations for economic basis. Okay. These are the 4 elements of the Indira Sahni judgment which I am focusing upon because it is going to be relevant for the examination about the EWS judgment. Okay. So this I am moving forward now. Okay. Now, in what you call the Maratha judgment that we were discussing, let me just make you read through another thing. The Maratha judgment, as for example what our friend is saying over here, that Raghavendra is saying that in some state it is higher than 50%. Let's say for example the case of Maharashtra, in which after adding the quota for the Marathas in the OBC, it exceeded the 50% ceiling. The arguments made by the state governments before the court was that the Indira Sahni verdict must be referred to a 11-judge bench for reconsideration since it laid down an arbitrary ceiling which the constitution does not envisage, right. So the government of Maharashtra argued before the Supreme Court saying that the 50% ceiling does not have a scientific basis and it must be revisited by the Supreme Court of India. In a unanimous opinion, the court held that there is no need to revisit the case. The court said that the 50% ceiling, although an arbitrary determination by the court in 1992, is now constitutionally recognized. So the 5-judge bench in the Maratha judgment case reaffirmed the 50% rule of the Indira Sahni judgment and said that there is no way that it can be reconsidered, even if it does not it is not having a scientific basis to it. It is now become a part of the constitution. Okay. So on the basis of this, because it violated the 50% reservation criteria ceiling, the judgment which was made by the quota which was made for the Marathas by the Maharashtra government is struck down because it violates the 50% limit, and therefore as you are asking the question, it is possible that if some state governments having 50%, if the case goes to the court and if the politics can be sidelined, etc., the Supreme Court has recent history of striking the reservation policy which has more than 50% quota as struck down. Okay, so that's a part that I wanted to refer in the Maratha case also. Now this is again the case which has been given over here, which is the Maratha case, which is something that you can read over here, as you will find it in the document also that we have attached over there. Okay. All right. Take. Now we come to the current affairs which are immediately in our concern and vicinity, which is the EWS judgment. This is something that we have to pay some amount of clear attention to. EWS judgment. Okay. Let me take for example a reference to the Constitution of India and see Article 15 and 16 just briefly. In the Indira Sahni judgment, the Supreme Court had said that there is no basis for giving reservations purely on economic terms because the Constitution does not provide for only an economic criteria for getting reservations. Right? Clear? So what the Constitution, what the government did was, in Article 15 and Article 16 with regard to educational institution and with regard to what you can call government, with regard to educational institutions and government offices. For example, it introduced this clause. This is known as Article 16 clause 6. It says that nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any economically weaker sections of citizens other than the classes of mentioned in clause 4 in addition to the existing reservation and subject to a maximum 10% of the posts in each category. The 10% EWS policy, which was first introduced in the 1990 government order, was in a way made a part of the Constitution of India by amending the Constitution. You see the point? Supreme Court in Indira Sahni had said that there is no provision for making reservations based upon economy as a concept only because the Constitution doesn't provide for it. So what the Parliament did by this amendment in 2019 the Parliament started with the strong footing of making economic criteria introduced into the Constitution directly, right? Inserted in the Constitution by the 103rd Amendment Act 2019, economic criteria was made a part of the Constitution under Article 15 directly. Clear? So, the limitation which was given by the Indira Sahni judgment was overcome by the Parliament by giving a direct introduction of the thing, and therefore, of course, this kind of a thing became a little bit of a foolproof. But nonetheless, the EWS, there was a case which went to the Supreme Court, which is known as the EWS judgment. Again, a 5-judge bench of what is also known as a constitution bench. It considered the question, number 1, that is the EWS judgment constitutionally valid. Okay. The first argument which was made to prove its constitutional validity was that yes, the Indira Sahni limitation has been met because the Constitution Amendment Act has been legally passed. All the judges agreed with it. Now, the next question that was being asked with regard to EWS was, pay attention to this because this is going to be the basic crux of a question if it comes upon the EWS judgment, which is very likely to come because it made huge waves in the current affair department recently. Okay. The question that was asked by the 5-judge bench at this point was that when you talk about EWS quota for educational institutions under Article 15 and the public offices under Article 16, when you talk about the EWS quota under educational institutions in Article 15 and public institutions of offices in Article 16, it also mentions that anyone who has availed reservations as an SC, ST or OBC previously shall not be eligible for reservations as a EWS. Okay. This was a condition which was given under Article 15 and under Article 16 again. I'll repeat it. Anyone who has made, what the particular part says, that any person who has attained reservations as an SC, ST or OBC will not qualify under EWS. So, let us say for example, the criteria which was given by the Government of India for EWS was 8 lakh annual family income plus some property requirements. Okay. Any person who has a family income below 8 lakh rupees and also is not getting any reservations under these categories shall be eligible to get reservations as an EWS under Article 15 clause 6 and Article 16 clause 6, which have been introduced into the Constitution by the 103rd Constitution Amendment Act 2019. This is what Article 15 and 16 say. Now, the challenge to the constitutional validity was like this. A challenge was made that the provision of giving it not to these people is a violation of Article 14, which includes equal protections of the law and equality before law. So, this was a argument which was made before the court, that if you are saying that economy should not be a criteria, a caste should not be a criteria for reservations, there must be a purely economic criteria in terms of your poverty matrix, etc. Reservations can be given to you. The question that was asked for the Supreme Court is that why is caste becoming a disqualification? Let's say, for example, if a person is taking reservations as a scheduled caste, and what the government is saying that caste is not the only criteria for reservations, then why are you disqualifying people who have taken reservations as a certain particular caste from reservation under the EWS? Okay, it was a kind of a solid challenge made by the petitioners in this case, stating that giving a kind of a policy objective in which people are disqualified from getting certain benefits because of their caste is a violation of Article 15 of the Constitution. Okay, now what it basically says is that if you are giving only on the basis of economic conditions, nothing else is considered, nothing else is looked into, but only on the basis of economic conditions of a person. But if you are disqualifying people who are of a particular caste, then you are making a discrimination and violating Article 14 of the Constitution, right to equality before law and equal protection of the law. Right, this was a constitution challenge which was made to the EWS quota, but the bench with a 3:2 majority held that the ground which was made over here was not sustainable, and it held the constitutional validity of the 103rd Constitution Amendment Act 2019, and said that in no account does the exclusion of the SCs, STs and OBC amount to what you can call a reservation, a violation of Article 14 of the Constitution. Right, this was a judgment given by the majority bench, but the minority bench, which included the Chief Justice of India, held that the judgment given, the Constitution Amendment 2019 was in violation of the right to equality, and which was a basic structure of the Constitution of India, and therefore it ought to be struck down because it was making a discrimination and not giving economic advantages or economic reservations to everyone regardless of their caste, and therefore it was conducting a kind of a discrimination, and they wanted to declare it as unconstitutional. But since they were in a minority, the majority judgment had their way and said that the EWS reservations made by the Government of India in the 103rd Constitution Amendment Act is completely and comprehensively constitutionally valid. It does not suffer from any kind of a disqualification or any kind of a limitation in terms of its constitutional categories. Okay. Another question which was considered in the EWS case was that the 50% mark given by the Indira Sahni judgment is what you can call breached by introducing EWS as a category. As you can see that both for Article 15 and Article 16, the maximum percentage of reservations, both for Article 15 and Article 16, the maximum percentage of reservations was given in the EWS category up to a 10%, not more than 10%. It is constitutionally written there that the EWS reservation cannot exceed 10%, right? EWS reservation cannot exceed 10%. It was given in the what you can call the Constitution itself, Article 15 clause 6 and Article 16 clause 6. Just for your reference, please be sure about memorizing this. 10% is a cap which has been attached to EWS quota. But the introduction of the 10% EWS quota inevitably led the reservations to breach the limit of 50%. So another question which was posed before the Supreme Court was, does the EWS quota violate the Indira Sahni judgment of 50% ceiling, in which the court said that the 50% ceiling was not sacrosanct and it can be breached in certain cases, etc., etc. So what you have basically is that in 2 years you have two constitution bench judgment by the Supreme Court. One in the Maratha case, in which the Supreme Court had said that the 50% rule is an inherent part of the reservation policy. But another in the EWS case, in which the Supreme Court said that if the 50% mark is breached, it is not the unconstitutionality of that degree which is going to be very sacrosanct. Okay? And therefore, this kind of a judgment finally made the way for the EWS judgment. EWS as a Constitution Amendment Act, a firmly stated principle of the Indian Constitution under Article 15 clause 6 and Article 16 clause 6, Please remember that the maximum amount of a reservation which can be given under the EWS category is 50%. Not more than 50% can be given under the EWS category as reservation. Clear? Okay. Now, another question that we have to address at this point of time is that how does the government decide what group of people fall under the EWS, right? Let me go back to the structure. Okay, if I ask the question with regard to SC, you can make a very clear chart over here. You have Article 338, you have Article 341, right, which is the National Commission for Scheduled Caste and the Government of India at the Union. If we are asking with regard to ST, you have Article 338A and Article 342. With regard to OBCs and SEBCs, again the matter is sorted. You have Article 338B and Article 342A. These are two articles which are the crux of the Maratha judgment which we have discussed. Okay, but what happens with regard to SEEWS? The question is there a constitutional body which is governing the criteria for EWS? For example, we have the 8 lakh annual income criteria. We have the 8 lakh annual income criteria for the EWS, right? How do you determine this criteria? ये क्वेश्चन आ सकता है प्रीलिम्स में बहुत सिंपल तरीके से कि क्या ये क्राइटेरिया कॉन्स्टिट्यूशनली डिटरमाइंड है? क्या संविधान में जैसे नेशनल कमीशन फॉर बैकवर्ड क्लासेस है, नेशनल कमीशन फॉर शेड्यूल्ड कास्ट्स है, नेशनल कमीशन फॉर शेड्यूल्ड ट्राइब्स है, क्या नेशनल कमीशन फॉर EWS है क्या? For economically weaker section. Now, we have seen Article 338 to 342A, there is no such mention. The introduction which made Article, what you can call 16 clause 6 and 15 clause 6 a part of the constitution, did not make a subsequent corresponding introduction in the articles which refer to the national commissions. So, the simple answer is that there is no constitutional body yet in place which gives the power to the government of India to recommend or to have a kind of take recommendations from that constitutional body. Also correspondingly, there is no explicit power given to the president and the parliament for the allocation or the notification of who is going to be EWS. So, this is a little bit of a grey area which the government has not been able to give an answer to. First of all, how do you determine the 8 lakh criteria? Okay. Now, the current answer to that question which was submitted by the government before the Supreme Court. Supreme Court recently asked this question in the middle of the NEET counselling. Supreme Court said that how do you say that the 8 lakh criteria was, what kind of a scientific evidence have you referred to in terms of saying that the 50% criteria which is given by the EWS is, let's say for example, valid. Okay. So, for example, here you have this kind of a question comes in the NEET counselling every year, the medical entrance examination NEET, in which the government is supposed to give a kind of a percentage of reservation for the admissions into medical colleges. And since the EWS quota was in application, the government gave a 10% reservation for EWS. Now, a few people went to the Supreme Court filing an application and asking the question, what is it that makes the government determine 8 lakh as the criteria for determining who an EWS is? For example, some person would say that just because I am earning less than 8 lakh, or let's say 8 lakh 5,000, I am moved away from EWS. Someone has 7 lakh 99,000, he's moved into EWS. So, what is the basis of this rationality? What is the science behind this logic? Okay. So, this is the same question that the Supreme Court was asked by a petitioner, and the Supreme Court in turn asked this question to the Attorney General, to the Government of India. Okay. Okay, so this was a question that the Supreme Court had asked. Now, the The answer which was given by the government of India was that there is no constitutional body which is appearing in the picture which takes cognizance of what are the conditions under which a person can be given EWS criteria. मतलब 8 लाख को decide करने वाली कोई constitutional body नहीं है. Okay. The government gave the answer in this particular case that, which is again going to be important for your prelims examination, that the determination of EWS is to be done by a committee which is made under a Department of Social Justice. Department of Social Justice under the Ministry of Social Justice. So you have the Ministry of Social Justice, and within the Ministry of Social Justice you have a Department of Social Justice. Okay, we have Ministry of Social Justice and you have a Department of Social Justice, and the Ministry of Social Justice is in control of the Department of Social Justice, and the Department of Social Justice appoints a committee which is known as the EWS committee. So you can see this is a non-statutory body. It is appointed by the ministerial level, right? It is appointed at the mantri level. Neither the parliament nor the constitution has the power to appoint a body over here. It is the minister. Any prime minister can give a simple rule that this body is going to judge the criteria for determining 8 lakh annual income criteria, right? And currently the chairman of this committee is a person by the name of Ajay Bhushan Pandey, and therefore it is also referred to as the Ajay Bhushan Pandey committee. It is the Ajay Bhushan Pandey committee which has in a way identified the 8 lakh annual income criteria as a standard for the allocation of the category of EWS to any particular person. So this kind of a situation is what we are taking a look at in terms of getting a sense of how the entire EWS position and points are rotated. Okay, let me just repeat to you the entire structure. You have article, let me just draw it back again, reservations. I think this kind of a crash course upon this very important topic which was there in the current affairs would put you in better stead to solve the prelims based question on the reservations part. Okay. You have article 15, you have article 16, talks about education, reservations in educational institutions, reservations in what you can call economic government offices. Okay. Then you have after that article 338 and article 341. It talks about the National Commission for Scheduled Castes and the policies, the power of the President and the Parliament to notify scheduled caste on the recommendations of the National Commission for Scheduled Castes. Then you have article 338A and 342 with regard to scheduled castes, scheduled tribes, sorry. Then you have article 338B and 342A with regard to OBC and SEBC. Then you have, for example, the committee which is I have mentioned as the Ajay Bhushan Pandey committee. Okay, this can be a direct question in the prelims examination because sometimes the important committees are asked, and the Supreme Court has already given a judgment on the EWS, so this committee can be given. This gives recommendation to the Government of India, which currently notifies the EWS. But nonetheless, this reservation is not only at constitutionally is not given under what you can call the Government of India, which basically means President and Prime Minister is not given the constitutional power to determine who an EWS can be, and it is open for the states to stake a claim on determining EWS for their particular states. But that point is still under development. Okay. Apart from this, you've taken a look at the Mandal Commission, the recommendations made by the Mandal Commission, the challenging of the reservation policy based upon Mandal Commission in the 9-judge constitution bench known as the Indira Sahni versus Union of India 1992, and the observations made by Indira Sahni, 4 observations importantly, And then you've taken a look at the questions which have been asked with regard to the EWS amendments, right? The 2019 Constitution Amendment Act, which introduces the EWS, was challenged before the Supreme Court for constitutional validity, but the Supreme Court upheld the constitutional validity of the EWS, stating that there was nothing wrong with the way in which the Parliament had done it, and also it did not violate Article 14 of the Constitution, as it was a basic structure of the Constitution, just by not giving reservations to people who had already claimed reservations under the category of scheduled castes, scheduled tribes, and other backward classes. Clear? Okay. So I think this kind of a thing is one thing that we have covered, a very important part of the current affair, which I wanted to take a clear shot at. Take. You just have a glass of water. Okay, now let me for example give a kind of a little bit of a what you can call a revision of how what points are there that you can remember for your reference. Question to you: can a state government, let me see some activity on the chat box over here. I am asking certain questions with regard to what you've covered right now, and just give me an answer in yes or no. I'd like to see some activity in the chat group. Okay, my question is very simple. Can a state government determine the group of people who can be introduced in the category of a scheduled caste? Yes or no? What is the answer to this question? Can a state government determine the group of people who will be introduced in the category of scheduled castes? Yes or no? Let me see some activity here. Let me see if you can give the answer to this one. It was a very kind of a prelims based kind of a thing. Again, let me repeat it. Can a state government give introduction to a particular group of people as a scheduled caste? Yes or no? Great. Can you give me the relevant reasons for it? One reason is that there is a National Commission for Scheduled Castes, which is a constitutional body, and the other reason is Article 341 of the Constitution, which gives the power to the President and to the Parliament, but it does not give the power to the government of the state at all. Very good. Good to hear responses. Okay, next question. Think of this as a proper answer and tell me. Before 2018, could the state government give the allocation of other backward classes seats to groups within their states only in matters of educational institutions and public offices which were administered by the state government? Before 2018, could the state governments give matters with regard to OBC reservations to groups of people in public institutions, educational institutions and offices run by the state government? Yes or no? You see, a prelims question can be a little bit rounded off, which is before 2018, as I discussed, the power to notify OBCs was also given to the state government. It was only after the introduction of Article 338A, National Commission for Backward Classes, and introduction of Article 342A, a National Commission, the powers of the union government, executive and legislature, were these powers curtailed. Now, if, for example, if I ask you the Supreme Court judgment, which gives the power, which gives the authority, let's say, or gives a validation to the power of the union to notify the OBCs. Can you name the judgment for me, the Supreme Court judgment, which was recently passed? Let's say if a question is, which of the following recent Supreme Court judgments ascertained the powers of the union to notify OBCs for the entire territory of India? Can you give me the name of the judgment in the chat? Can you give me the name of the Supreme Court judgment which is relevant in this regard? Very good. The Maratha OBC reservation judgment. It was declared unconstitutional, the introduction of the Marathas into the other backward classes, as it violated the 50% ceiling limit, and also it was not under the control of the state government to notify OBCs anymore, because that power was given to the union government under Article 338A and Article 342A. Okay. ठीक है? Okay. Another question to you. With regard to, I'm just asking a question and then I'll give you an option and you tell me what can you write in that. With regard to the recent judgment given by the Constitution Bench of the Supreme Court in the EWS quota case, which questioned the constitutional validity of the 2019 Amendment Act. Which of the following grounds was the constitutional validity of the 2019 CAA challenged? Which of these are grounds upon which it was challenged? A, state could not make EWS policy by disqualifying SCs, STs and OBCs. Okay? SCs, STs and OBCs. And B, the Constitution explicitly prohibits, the Constitution explicitly prohibits a purely economic criteria for reservations. Okay? Out of A and B, which is a ground upon which the 2019 CAA was challenged? which is a ground upon which the 2019 CAA was challenged between A and B. What do you say? Between A and B, which was a ground upon which the CAA was challenged? Yes, that's the point, that now some of you are making an error. The Constitution does not explicitly prohibit purely economic criteria for reservation. The Constitution is silent. It does not provide, but it does not prohibit. Meaning, there is a vacuum. This is not a negative. इंदिरा सानी में कोर्ट ने कहा था कि यहाँ पर कुछ लिखा नहीं है इस तरीके का, तो जब तक आप लिख नहीं देते तब तक हम इस पे जजमेंट नहीं बना सकते. मतलब अनलेस यू राइट इट इन द कॉन्स्टिट्यूशन वी कांट गिव यू जब तक आप संविधान के अंदर इसको आप लगा नहीं देते तब तक आप पॉलिसी कैसे बना सकते. तो पहले आप संविधान में लगाइए. तो इंदिरा सानी की जो रिक्वायरमेंट थी वो पार्लियामेंट ने फुलफिल कर दी कि संविधान में डायरेक्टली लगा दिया उसको. इस वजह से उसकी कॉन्स्टिट्यूशन वैलिडिटी चैलेंज नहीं हो सकती थी. लेकिन संविधान में कहीं भी ऐसा लिखा नहीं है कि प्योरली इकोनॉमिक बेसिस पे कोई रिजर्वेशन नहीं दिया जा सकता. इट डजंट प्रोहिबिट दैट काइंड ऑफ अ थिंग, इट जस्ट डज नॉट प्रोवाइड फॉर इट. है ना, समझ रहे हैं ना आप इस बात को. इसको थोड़ा सा ध्यान में रखिएगा इस चीज़ को ना. ये इस तरह के क्वेश्चंस थोड़े घुमावदार क्वेश्चंस आपके बन के आपके सामने आ सकते हैं. ठीक है. अब आप लोग एक काम कर सकते हैं, जस्ट फॉर योर रेफरेंस सेक, जो हमने आर्टिकल्स लिखे हैं यहाँ पर, आर्टिकल 15, आर्टिकल 16, आर्टिकल 338, आर्टिकल 338 ए, 338 बी, 340, 341, 342, 342 ए. आपका थोड़ा सा भी टाइम अगर आपको मिले तो आप इन आर्टिकल को कॉन्स्टिट्यूशन के बेयर एक्ट से डायरेक्टली पढ़ लीजिएगा. कॉन्स्टिट्यूशन का बेयर एक्ट मैं आपको PDF के फॉर्मेट में आपके पोर्टल्स पे अपलोड करवा दूंगा. अगर आपको थोड़ा सा टाइम मिले, बहुत ज़्यादा मुश्किल नहीं है इन चीज़ों को पढ़ना. Just go to these article and try to read the language of these articles, है ना. और एक बार आप इसको पढ़ेंगे तो आपको पूरा जो reservations का खाका है, पूरा entire structure of reservations will be absorbed into your mind. Past and present and current any question from reservations, affirmative actions, you can take a look at these articles and you'll be satisfactorily able to answer them. ठीक है. Yes, so Anupama is absolutely correct in what she's pointing out, that there is no explicit prohibition in Article 15 and 16. But just for your sake of reference, I am telling you, go after this session sometime, you please go and read Article 15, 16, 338, 338A, 338B, 340, 341, 342, 342A, once from the Constitution directly. उसके बाद आपको किसी किताब को पढ़ने की जरूरत नहीं. और इंदिरा सानी पे और जो मराठा जजमेंट और EWS, 3 इंपॉर्टेंट जजमेंट्स हैं, उनके नोटिफिकेशन हमने ऑलरेडी ले लिए. अजय भूषण पांडे कमेटी का नाम मैंने आपको बता दिया. इससे बाहर से आपका रिजर्वेशन का कोई भी क्वेश्चन नहीं आएगा. डायरेक्टली फ्रॉम द व्हाट यू कैन कॉल द कॉन्स्टिट्यूशन और फ्रॉम द करंट अफेयर्स हमने सारा इसमें कवर कर लिया. ठीक. आशुतोष मिश्रा जी कह रहे हैं, सर डज स्टेट कैन नोटिफाई द लिस्ट ऑफ SC एंड ST? नो. आर्टिकल 338 and Article 341 read together gives all the power to notify SCs and STs to the union government, union parliament and the union executive. ठीक है. ठीक है. आप में से कुछ लोग आर्टिकल 105 की बात कर रहे हैं, तो मैं अमेंडमेंट ऑफ आर्टिकल 105 LD चरण, आई रिमेंबर यू फ्रॉम जयपुर. आप जो पूछ रहे हैं वो ठीक है. आई जस्ट टेक अ लुक एट इट, जस्ट बिकॉज यू आस्क, आई विल क्लैरिफाई अपॉन द 105th अमेंडमेंट एक्ट मेड इन द कॉन्स्टिट्यूशन. It's good to see some of the familiar names in this session. Sorry. Maybe this draft of the constitution doesn't have the updated version. Just give me a time in the break. LD, I'll get back to this question with regard to the 105th constitution amendment. Maybe it's not updated in this draft. Just let me pull it out during the break and I'll clarify upon that. And I'll be sure to tell you that it doesn't give the power to the state to identify the OBCs. It just kind of makes a very simple non-binding obligation on the union to consult the state in some kind of a manner. Okay, but all said and done, there is no power given to the state for any kind of identification. Okay. Garima has a question. Parliament voluntarily moved the motion to add caste to SC list, or it can only proceed after recommendations of the NCSE? It's a very good question. Parliament cannot initiate the process of identifying a caste as an SC or ST or OBC. Okay, that's the point. Very detailed reading of the articles will tell you that though the President and the Parliament have been given the same power of adding and removing the lists of SC, STs and OBCs, but the process can only be initiated by the President. It cannot be initiated by the Parliament. If the Parliament wants to add a particular person as an SC or an ST, it cannot be done by the Parliament unless the process of doing that is initiated by the President. So, President has to create the first list based upon the recommendations of the NCBC, NCSC, right. So, NCSC gives the recommendations to the President may or may not, based upon the recommendations, identify the caste as an SC or an ST and then give the list to the Parliament, and the Parliament can modify it then. But unless the President takes the initiative, the recommendation of the National Commission and the activity of the Parliament cannot have any value for him. The National Commission can give more and more recommendations to the President, but the President, if it is not willful for him to do it, he will not do it. So, the real power in this particular case lies with the Parliament, with the President. Yes, as you are pointing out correctly, Sayan, the Parliament has only a kind of a review power. It cannot initiate a process unless the President wants it. Clear? Chal, theek. Now, this is done under Article 15 and 16. Moving forward, I think you get a sense of the way in which I am giving agendas to this. Article 17 of the Constitution and Article 18 of the Constitution are more or less easy to understand. We'll just revise them once. Article 17 says that there has to be what is called the untouchability in all its forms is abolished, and its practice is an offence punishable by law. It's all that it basically says, right? And Article 18 talks about abolition of titles. Right? It gives a sense of what forms of titles are there and what are abolitions of these things. So, I think if you've covered classroom sessions with me, I've given you a very clear list which is going to be a point, a good understanding of how the abolition of title and abolition of untouchability work in India, right. So, just to give a structural clarity, you have Article 14 to Article 18 dealing with what is known as the category of right to equality. Let me repeat it again. You have Article 14 and Article 18, which we are dealing with the category of right to equality, and we have dealt with this specific reference to Article 14, equality before law, equal protections of the law, Article 15 and Article 16 with reservations, a huge chapter upon it, and Article 17, Article 18, I expect that you can read it upon yourself. Okay. Now, we come to the next category of fundamental rights, which is known as right to freedom. Very important category, right to freedom, and some amount of current affairs to be covered herein. Right to freedom. Right to freedom starts from Article 19, goes to Article 20, Article 21 and Article 22. Article 19 talks about freedom of speech and expression, etc. Freedom of speech and expression. Article 20 talks about freedoms from wrongful criminal action. Article 21 is the most important article in the Constitution, perhaps, provides for no person shall be deprived of life and liberty except by the procedure established by law. So here I will just give you a sense of what is the meaning of procedure established by law, because sometimes in the prelims you can have a question on the procedure established by law and the concept of the due process of law, the comparison between the procedure established by law and the due process of law. Okay, so this is a part that we can take a look at later on. So you have Article 19, 20, 21 and 22, which are known as the four freedoms. Okay, and 22 is of course some rights given to rights against detention, right, which basically includes the habeas corpus, etc., etc., and also includes the exception of the Preventive Detention Act. But my major focus is going to be upon Article 19 and Article 21 in terms of covering the current affairs. Now briefly let me take up Article 20 just to give you a sense of it. Article 20 clause 1 states that these are all four articles of freedom. Article 19 to 21 are articles which are known as right to freedom. The second category of fundamental rights after Article 14 to Article 18, which is the right to equality, in the first category of fundamental rights. Okay. Now, in the articles which are mentioned, I'll just give you a brief, very brief revision of Article 20. Article 20 basically talks about right to freedom against a criminal action. And it constitutes three forms of criminal actions against which one requires a constitutional safeguard. One is known as the ex post facto law. Okay, ex post facto law simply means ex post facto law. If this is a question in the prelims, you just have to understand ex post facto law simply means that one cannot be punished for a crime, or one cannot be punished for an act which he has committed today, but has not been described as a crime by a law on the date of its commission, but has only been described as a crime by the law after the date of its commission. So the retrospective impact of a law which determines something as a crime is something that no person can be subjected to. ओके तो अगर मैंने आज कुछ किया है लेकिन आज के दिन वो करने में आज किसी भी विधि के अनुसार वो गैर कानूनी नहीं है या फिर वो ऑफेंस नहीं है, मतलब पनिशेबल नहीं है, लेकिन मेरे करने के बाद मुझे पनिश करने के लिए विशेष रूप से मेरे को जेल में डालने के लिए उस एक्ट को क्राइम बनाया गया है, तो इसको कहेंगे प्रिवेंटिव एक्टिविटीज़ अगेंस्ट एक्स पोस्ट फैक्टो लॉ. जैसे ब्रिटिश साम्राज्य में ही होता था, कोई बहुत महान पॉलिटिकल लीडर अगर भारत में कुछ कर रहा होता था, जैसे बाल गंगाधर तिलक ने कुछ किया, तो ये है कि बाल गंगाधर तिलक ने कुछ किया मान लीजिए और वो कानून के अनुसार गलत नहीं है, लेकिन सिर्फ बाल गंगाधर तिलक को जेल में डालने भर के लिए ब्रिटिश सरकार वो कानून में गलत बता देगी और फिर रेट्रोस्पेक्टिवली मतलब पुरानी डेट बैक डेट करके उसको उसमें लगा देगी. तो इसको एक तरह से मतलब रोकने के लिए जो भारत का संविधान है उसने आर्टिकल 20 क्लॉज 1 में एक्स पोस्ट फैक्टो लॉ का प्रोविजन डाला हुआ था. ठीक है, तो ये एक जो पॉइंट है ये आप थोड़ा सा ध्यान रख सकते हैं. फिर दूसरा है डबल जेपर्डी. ठीक है, डबल जेपर्डी का क्या अर्थ होता है? डबल जेपर्डी का अर्थ होता है कि कोई भी एक व्यक्ति एक ही क्राइम के लिए 2 बार जेल सेंटेंस नहीं कर सकता है. ठीक है, नो वन पर्सन कैन बी punished twice for a similar crime. Clear? That's double jeopardy. एक बार पनिश कर दिया उसको, पनिशमेंट पूरा कर लिया तो दोबारा उसको नहीं किया जा सकता. और तीसरा है राइट अगेंस्ट सेल्फ इंक्रिमिनेशन. राइट अगेंस्ट सेल्फ इंक्रिमिनेशन का अर्थ होता है कि आप जैसे बिल्कुल सिंपल अर्थ ही होता है राइट अगेंस्ट सेल्फ इंक्रिमिनेशन का 20 क्लॉज 3 में कि नो पर्सन कैन, मतलब जैसे मान लीजिए आपने अगर पुलिस के सामने कोई बयान दिया, ठीक है, और पुलिस ने आपके बयान को आप जैसे मान लीजिए आपको पुलिस पकड़ने आई सामने आपके और आपको पुलिस ने पकड़ के डरा के आपसे कुछ लिखवा लिया या आपसे कुछ बुलवा लिया, रिकॉर्ड कर लिया मोबाइल पे कि आपने ये गुनाह किया है। अब आर्टिकल 20 क्लॉज 3 के अंदर क्या है कि अगर पुलिस ने आपसे कोई बयान लिया है तो वो बयान किसी भी कोर्ट के सामने एविडेंस की तरह मान्य नहीं होगा। खास तौर पे अगर उस बयान में आप कबूल कर रहे हैं कि मैंने कुछ किया है, क्योंकि एक बेनिफिट ऑफ डाउट दिया जाता है आपको कि पुलिस ने आपसे डरा धमका के, आपको डरा के आपसे कुछ उगलवा लिया होगा, इसीलिए उसको एविडेंस के रूप में नहीं मान्यता दी जाएगी। एनी काइंड ऑफ अ स्टेटमेंट मेड बाय यू बिफोर द पुलिस और एनी अथॉरिटी एक्सेप्ट द मैजिस्ट्रेट cannot be taken to incriminate your own self under Article 20 Clause 3, which is right against self-incrimination. That is the point that we are looking at over here. ठीक है, चलिए. Now, let me move on to the next important part, which is Article 19 of the Constitution. Article 19 1A. ठीक है, तो आर्टिकल 19 का थोड़ा सा इंट्रोडक्शन आप लोग ऑलरेडी ले चुके हैं पहले क्लासेस के अंदर कि आर्टिकल 19 इज फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन. ठीक है, आर्टिकल 19 का मतलब है फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन. एंड आर्टिकल 19(1)(a) कहता है कि एवरी पर्सन शैल हैव द फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन. सॉरी, इट इज गिवन एज अ राइट ओनली टू सिटीजन्स, नॉट टू पर्सन्स. ठीक है, फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन. और आर्टिकल 19 क्लॉज 2 क्या करता है, और फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन को कर्टेल करने की कंडीशंस बताता है. अंडर व्हाट कंडीशंस कैन द फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन ऑफ अ सिटीजन बी कर्टेल्ड. तो पहले तो आप देखिए कि अगर कोई बाहर देश का नागरिक इंडिया के अंदर रह रहा है तो उसके ऊपर कोई फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन नहीं लग सकती है. कारण यह है क्योंकि वो सिटीजन नहीं है. तो अगर उसको कोई अभिव्यक्ति की आज़ादी देने की बात होती है तो वो मना किया जा सकता है स्टेट के द्वारा, क्योंकि वो पर्सन है, वो सिटीजन नहीं है. ठीक है, तो आर्टिकल 14 जैसे सिटीजन्स पर लगता नहीं है, पर्सन पर लगता है. आर्टिकल 19 सिर्फ सिटीजन्स को दिया जाता है. ये एक इंपॉर्टेंट पॉइंट है आपके प्रीलिम्स के लिए. अब आर्टिकल 19(2) क्या बोलते हैं कि इसमें कुछ कंडीशंस दे रखी हैं जिसके अंदर फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन किसी एक व्यक्ति की कर्टेल की जा सकती है, उसको काट के रख दिया जा सकता है. फॉर एग्जांपल पब्लिक ऑर्डर, मोरालिटी, डिसेंसी. आप आर्टिकल 19 क्लॉज 2 में ये सारी चीज़ें पढ़ सकती हैं. यू विल गेट अ सेंस ऑफ व्हाट इट इज़ बेसिकली इलैबोरेटिंग अबाउट. मैं जो चीज़ इसमें आपको थोड़ा सा समझाने जा रहा हूँ उसमें 2-3 चीज़ें कवर करने की कोशिश करूँगा. ठीक है, एक मैं कवर करूँगा व्हाट इज़ नोन एज a very legendary judgment by a Supreme Court bench, which is known as the Puttaswamy judgment, which also is the judgment which talks about right to privacy. ठीक है, उसके अलावा मैं कवर करूंगा जो डेटा प्रोटेक्शन बिल संविधान में पिछले कम से कम नहीं तो 5 साल से इधर उधर हो रहा है, और अभी फिलहाल में ही सरकार ने इसकी एक नई कॉपी पब्लिक के संज्ञान के लिए एक्सेस करवाई है. तो एक पर्सनल डेटा प्रोटेक्शन बिल था जो पहले इंट्रोड्यूस हुआ था, फिर उसको खींच लिया गया वापस, उसकी जगह डेटा प्रोटेक्शन बिल लगाया गया, फिर उसको खींच लिया गया, अब उसकी जगह नया बिल लगाया गया. और एक कमेटी थी BN श्रीकृष्णा कमेटी. इनके बारे में थोड़ा मैं ऐतिहासिक रूप से आपको बताऊंगा कि इनका स्टेज इस समय चल क्या रहा है, मतलब ये पॉइंट किस पे पहुंचे हैं जहाँ पर कि पर्सनल डेटा प्रोटेक्शन लॉ जो प्राइवेसी को एक सिक्योर करता हुआ लॉ है उसका स्टेटस क्या है, और जॉइंट पार्लियामेंट्री कमेटी इसमें क्या रोल निभा रही है. क्योंकि ये पॉलिटी से आधारित क्वेश्चंस कुछ हैं जो न्यूज़ में हैं थोड़े समय से. There are some questions with regard to polity which are circulating in the news with regard to the personal data protection bill. I'm sure you must have seen some editorials upon this yourself. So this is something that we'll cover. And then with regard to this, we will also cover what is known as the information technology rules. Information technology rules. ये भी थोड़े से न्यूज़ में चल रहे हैं पिछले 2-3 साल से. पहला जो सेट था इन्फॉर्मेशन टेक्नोलॉजी रूल्स का वो आया था 2021 में. उसके बाद इसको अमेंड करके 2022 में कुछ रूल्स और लगाए गए थे, और अभी फ़िलहाल में ही 2023 में इन्फॉर्मेशन टेक्नोलॉजी रूल्स में कुछ और एडिशन करके कुछ अमेंड्स किए गए हैं. तो दिस हैज़ बिन इन न्यूज़ रिसेंटली एंड ऑल ऑफ दिस इज़ कमिंग आउट ऑफ आर्टिकल 19 which is 19(1)(a) freedom of speech and expression. ठीक है, along with this I will deal with certain aspects of the Information Technology Act. I will deal with certain aspects of the Information Technology Act 2000, which is the two sections that I will deal with are section 69A and section 79A. इनसे आपके प्रीलिम्स के कुछ क्वेश्चंस बनने की संभावना है, क्योंकि ये न्यूज़ में बहुत ज़्यादा सर्कुलेट हो रहे हैं, आज से नहीं, कम से कम 2-3 साल से, और पिछले वर्षों में जब इन पे न्यूज़ डेवलप हुई थी तो इन पे क्वेश्चंस नहीं पूछे गए थे, तो इसीलिए हम वी कैन मेक एन अजम्पशन दैट इन द कमिंग ईयर्स द क्वेश्चंस अबाउट द government of India, making these rules, etc., can come into picture over here. ठीक. Okay, let us begin the analysis over here. One of the most important judgments which was given by the KS Puttaswamy judgment is that privacy is a fundamental right under Article 21 of the Constitution. अगर आप इस एक स्टेटमेंट को पढ़ लेंगे तो आपको पूरा पुट्टास्वामी का जो जजमेंट है वो समझ में आ जाएगा. पुट्टास्वामी के पहले भी privacy was considered a fundamental right. It was not that privacy was not considered a fundamental right. But before the Puttaswamy judgment, privacy was considered a fundamental right under Article 19 of the Constitution. But if you have a fundamental right which is under Article 19 of the Constitution, the fundamental right given under Article 19 of the Constitution is a very weak fundamental right, because the restrictions which can be imposed upon Article 19 are easily applicable. Article 19 clause 1 A, B, C, D, E, etc. gives you the list of rights, but Article 19 clause 2 onwards gives you the restrictions which can be imposed upon those rights correspondingly. So Article 19 में जो rights दे रखे हैं weak rights दे रखे हैं, they are not very strong rights. State can take away your right to privacy in the case of a, let's say, public disorder or any kind of a what you can call any kind of a activity which is done to which can appeal to public morality or immorality, etc., etc. But once you put a right under Article 21, it is very difficult for the state to interfere in the exercise of that right, because Article 21 क्या कहता है? That no person can be deprived of their life and liberty except by the procedure established by law. There is only one condition under which a person's life and personal liberty can be deprived of, and that is a procedure established by law. Otherwise, a person has an almost absolute validity in terms of his life and personal liberty. Life means the right over one's body, and personal liberty means the right over one's mind. So the main argument made in the Puttaswamy judgment was whether privacy is a right as a fundamental right under Article 19 of the Constitution or under Article 21 of the Constitution. And the 9-judge bench held in the Justice Chandrachud judgment that privacy is a fundamental right. It is intrinsic to human life and it is intrinsic to human liberty, and it cannot be taken away except by a procedure established by law. And that procedure established by law is also reviewable under the Supreme Court, whether the Supreme Court can review the procedure established by law because of what is called the Maneka Gandhi case of 1978, in which the Supreme Court has said that a procedure established by law cannot be unjust, unfair or arbitrary. The Supreme Court can exercise a judicial review upon the question of whether a procedure established by the court, by the government, is just and fair and reasonable. Maneka Gandhi versus Union of India was a 1978 Supreme Court landmark judgment in which the Supreme Court said that the life and personal liberty of a person cannot be taken away by making an unfair, unjust or arbitrary procedure established by law. Okay, maybe if you've read this, all of this will come highlighting back into your revisionary memory. So the judgment in the Puttaswamy judgment very simply said that the fundamental right of privacy is a fundamental right under Article 21 of the Constitution. Okay. Now, when the Puttaswamy judgment was being, authored, the biggest question that was coming was the question of Aadhaar. It was actually the Aadhaar case only. That Aadhaar was collecting, the UIDAI was collecting the biometric information upon individuals, citizens, etc. And then the question became that, is it mandatory to give Aadhaar details to the government? And then this became the question of privacy. And then the question was whether privacy is a fundamental right under Article 19. If it is a fundamental right under Article 19, then the government can access the data without too much hassle, because there are reasonable restrictions to privacy if it is under Article 19. But the court held it is under Article 21, and the government cannot easily access the person's privacy or the Aadhaar card. The other issue which was coming together in this sense was the issue about what you can call the question of data privacy, which is becoming a big issue. Not only data collected by government, but also data collected by private organizations. As the quotation goes, data is the new oil, right? So that kind of a situation is something which the government wanted to, in a way, make data accessible, and private companies were taking data. So Supreme Court ने कहा, Puttaswamy judgment में ही, it directed the government to create a new framework of legislation which can be standard in terms of collecting data. मतलब अगर आप किसी का data collect कर रहे हो as a private organization or a public organization, you have to make sure that the data that you're collecting does not violate the newly invented right to privacy under Article 21 of the Constitution. तो आपको एक नया लॉ बनाना पड़ेगा जिसको कि आप डेटा प्रोटेक्शन लॉ कह सकते हैं, और वो डेटा प्रोटेक्शन लॉ एक स्टैट्यूटरी प्रोविजन क्रिएट करेगा जिससे कि किसी व्यक्ति का अगर डेटा चोरी होता है उसकी कंसेंट के बिना, तो उसकी राइट टू प्राइवेसी का वायलेशन माना जाएगा, और जो करता है उसको कॉन्स्टिट्यूशनल या फंडामेंटल राइट तोड़ने के बेसिस पे पनिशमेंट दिया जाएगा. ठीक है, तो ये जो जजमेंट था सुप्रीम कोर्ट का, इसमें सुप्रीम कोर्ट ने मिनिस्ट्री ऑफ इलेक्ट्रॉनिक्स एंड इंफॉर्मेशन टेक्नोलॉजी, MEIT, it gave recommendations to the MEIT, and MEIT then appointed what is known as the B.N. Sri Krishna Committee. In 2017, late 2017, early 2018, B.N. Sri Krishna Committee was appointed, and the B.N. Sri Krishna Committee gave a draft of what is known as a personal data protection law, and it submitted the draft to the ministry. Okay, so let's say for example how this kind of a thing works. The personal data protection bill was formulated by the B.N. Sri Krishna Committee. You can call it the BNS committee. This kind of a question can come in the prelims again. Which committee was responsible for drafting the personal data protection bill? And it submits the draft copy to the MEIT, which is the Ministry of Electronics and Information Technology. This is MEIT, right? And the ministry is then responsible for presenting this bill to the Parliament. Now, as you would have known from your readings of the Constitution, that the Speaker of the Lok Sabha or the Chairman of the Rajya Sabha has the power that at the time a bill is being introduced into the House, it can refer the bill to what is known as a parliamentary committee. And in that very activity, the Parliament, the Speaker of the Parliament or the Lok Sabha referred the personal data protection bill to a joint parliamentary committee for a review. And the joint parliamentary committee is supposed to give the recommendations upon this bill. And the joint parliamentary committee produced this bill before the Parliament, which was now translated not as personal data protection bill, but the data protection bill 2019. And data protection bill. Okay, so you have the PDP bill, which was introduced, PDP, let's say draft bill, which was introduced by the B.N. Sri Krishna Committee in 2018 to MEIT, and by 2019, by a review given by the Joint Parliamentary Committee, it had turned into data protection bill. The term personal data protection had been removed. Okay. Now, at the later turn of events, what we have seen is that in 2022, 2023, recently, the government of India has withdrawn this bill. the Data Protection Bill 2019 has been withdrawn by the Government of India and has been replaced by a new bill which is currently known as the new bill of 2023. Okay, and this is a kind of a thing that has been little bit of a news, and I'm going to only make some very initial advertisements about it. Okay, which is basically, let's take a look at the current affair development upon this. Take a look at this particular point and maybe just get a sense of what is it that we are trying to understand here in terms of memorizing certain facts which can be relevant for the prelims examination. In the KS Puttaswamy judgment, the Supreme Court of India ordered in 2017 that the right to privacy is an intrinsic part of the right to life and personal freedom guaranteed by the Indian Constitution. This is Article 21. In the light of this judgment and concerns around how large tech platforms are handling the personal data of its Indian users, the Centre in 2017 set up an expert committee chaired by the retired Supreme Court Justice B.N. Sri Krishna to formulate a regulatory framework for data protection. The Sri Krishna committee submitted its report and a draft for the data protection bill to the Ministry of Electronics and Information Technology on July 2018. Okay, just a few set of facts that you have to remember. For example, the KS Puttaswamy judgment you have to remember. For example, a question can come that the Personal Data Protection Bill is inspired with which of the following landmark judgments of the Supreme Court. You have to write the answer KS Puttaswamy. Of course, you have to remember the name of the B.N. Sri Krishna committee. It is a question that has been asked in the mains examination previously and can also be asked in the prelims examination to some extent. Okay. The bill that was tabled by the ministry in Parliament over a year was, however, criticized by Justice Sri Krishna for giving much more control to the central government over the data than envisaged in the committee's draft. The government had changed its nature of the bill, and the changes were made in the bill by the Joint Parliamentary Committee. Its report in 2021, the provision that enables government agencies, etc. We don't have to go into this kind of a detail, but just know that the bill was then referred to the Joint Parliamentary Committee. And now at this point of time, the bill has been withdrawn and a new kind of a bill has been introduced in its overhaul, as a kind of a new bill has been introduced in its overhaul. So the important points that we can remember about this particular instance is that there is a Supreme Court judgment which has in a way redefined the nature of privacy that is existing in India. Okay, the first thing that it says is that right to privacy is a fundamental right under Article 21. Second, on the basis of that, the committee was appointed which has given a kind of a draft bill, but the government has taken this draft bill to 2 or 3 layers, and still the government has not been able to pass the draft bill. So that is a kind of a conundrum which brings back the questions around KS Puttaswamy, Article 21 and right to privacy, and the B.N. Sri Krishna committee relevant. So these are things that you can remember from the respect of the current affairs. Okay? Right to privacy not a fundamental right under Article 19 but under Article 21. Now the next important part that we are going to deal with regard to the government assertions are the information technology rules. Again, given in 2021, 2022 amended and 2023 re-amended. ठीक है, तो इसको थोड़ा सा हम अच्छे से categorically समझेंगे क्योंकि I have a very strong feeling this can be a question in the prelims examination this time. Okay, because it is in news for the last 3 years and this year it is extraordinarily in news because of some compliances default made by WhatsApp and Facebook and some court cases which are going in this particular sense. ठीक है, तो अब इसमें क्या है कि let me just give you a sense of it. Currently, the privacy of data or any kind of an activity which is happening on a computer in India is governed under the इंफॉर्मेशन टेक्नोलॉजी एक्ट 2000, ठीक है। तो अभी जो पर्सनल डेटा प्रोटेक्शन बिल अभी पावर में नहीं है, उसके एब्सेंस में भारत के अंदर जो भी कोई कंप्यूटर रिलेटेड चीज़ होती है, इंक्लूडिंग द ब्रीच ऑफ प्राइवेसी और अ साइबर क्राइम, it is covered under the Information Technology Act 2000, which has been amended from time to time. ठीक है। Now, let me just draw a bit of a background to give you a sense of understanding about how the Information Technology Act is moving in a sense. Let me get a sense of that. Okay. So the Information Technology Act 2000 is the parent legislation currently which deals with all forms of issues related to a computer. Okay, and that is why the need for overhaul of the Information Technology Act is a kind of a impending need, because it is considered by many as outdated, because it was first drafted in 2000 and it has obviously not been able to catch up with the technological development which have happened. But the processes in the Parliament with the Personal Data Protection Bill have been stuck, so this is still the parent legislation under which everything is covered. Now, let me just tell you a story about an interesting fact which happened in the Information Technology Act. In 2005, in the year 2005, there was a case in India which is known as the Bazi.com case. This case just went to the Delhi High Court and the Supreme Court. Listen to this carefully and listen to it with the intent of making sure that you are able to answer some of the questions from the prelims examination in sense. So in 2014, in 2005, the case which is known as the Bazi.com case, what was the facts of the case was that the social media platform known as Bazi.com was a platform on which auctions were made of certain objects. Let's say, for example, if you have, let's say, a glass or an antique thing or anything, you can post a picture of that particular thing upon the website Bazi.com, and then another person who wants to buy some amount of goods from Bazi.com, they can bid on buying that particular product, and therefore you can make that kind of a payment. So Bazi.com was like a social media platform from which products can be bought and sold between two people upon a bidding kind of a format. Matlab, they had to make a kind of a auction upon this thing. That is why the name which was given to this particular thing was known as the Bazi.com. Okay. Now, one of the incidents which happened in 2005 with regard to Bazi.com was that a person from New Delhi had posted a pornographic clip of another person on the Bazi.com website, and the Bazi.com website was not able to filter it out for some reason. It didn't have the checks and balances around it, and another person in an auction bought that kind of a pornographic clip and downloaded it and circulated it. Now this matter went to the Delhi police. Delhi police filed an FIR against both the person who was putting the clip, the person who was buying the clip, but also the Delhi police filed an FIR against the CEO of the Bazi.com for letting this kind of an activity happen upon the social media platform. Okay. Now, the question that was now before a Delhi High Court, मतलब Delhi High Court के सामने जब मैटर गया, तो Delhi High Court के सामने Bazi.com के CEO ने ये अपील रखी कि I should not be the one to face FIR over here, because I am merely providing a platform for other people to use. I don't have any movement in and out of the products. I just give a kind of a standard standing place over which people can give this kind of activity. So I just own the market, but I don't own the activities of the products which are exchanged in the market. So I should be exempt of this kind of a criminal charge that I was involved in creating pornographic material. The charges were framed under the Information Technology Act. Okay. The Delhi High Court said to the Bazi.com CEO that nothing doing, you have to be responsible for this kind of an activity, and the Delhi High Court sentenced the three of them for some amount of imprisonment for cyber pornography, etc., etc. Okay. So in this kind of a judgment of the Delhi High Court, it was held by the court that the intermediary, the social media intermediary, is equally responsible for the exchange of information on the platform that they are owning. Let's say, for example, if you are Amazon.com and if you're selling some amount of thing which is illegal, and if that kind of a thing breaches or breaks a certain law, अगर उसमें कानून व्यवस्था में कोई मतलब if it breaks a law somewhere or the other, then the argument which is made over here is that the Amazon.com is equally responsible as a person who's selling some illegal product and who's buying some illegal product in terms of breaking a particular law in reference to the Constitution, okay, in reference to the Indian Penal Code or something like that. Now, the Delhi High Court judgment in 2005 took about 7 years in 2012, in which the judgment of the Delhi High Court was appealed before the Supreme Court of India. The judgment of the Delhi High Court was appealed before the Supreme Court of India, and before the Supreme Court of India, the petition was made that the social media intermediary cannot be held responsible for the content which is exchanged. Social media intermediary cannot be held responsible for the content exchange on the platform. Cannot be held responsible for the content exchanged on the platform. And in 2012, the Supreme Court agreed with this proposition and released the CEO of Bazi.com. Saying that the platform should not have the responsibility or the criminality of hosting a certain particular kind of a content. It is merely a place where people interact with each other, and therefore the responsibility of the content should be limited to the people who are exchanging the content, not upon the social media intermediary. Okay? So in this sense, the Supreme Court made a kind of a judgment which radicalized and revolutionized the IT sector in India. And it was only after this judgment of the Supreme Court did it become possible for social media intermediaries like Facebook, WhatsApp, and whatever we were seeing in the day, Amazon, Reddit, all of these things to come and have great market access into the Indian IT sectors, because then they got the immunity from the Supreme Court of India that anything which was happening upon their platform will not invite any kind of a criminal activity against them. In pursuit of this, the Parliament of India added a article, a section to the Information Technology Act, which is known as Section 79A. Now, this is a part of your questions, जहाँ पर आपके prelims में question आ सकते हैं, which is known as a safe harbor provision. Okay, safe harbor provision. Let's just take a look at Section 79A of the Information Technology Act to make the point clearly to you. Please read this, and read this as a sense that you may have to answer a question like this directly in the prelims examination. Under Section 79A of the Information Technology Act, what it is saying is that one second, just let me open. Yeah, sorry, just a little bit of a correction. This is not section 79A, section 79 of the Information Technology Act. Section 79 of the IT Act. This was introduced into the Information Technology Act after the judgment of the Supreme Court in 2012, in which the provision said exemption from liability of an intermediary in certain cases. Okay, so what it basically says that, you read this part, an intermediary shall not be liable for any third party information, data or communication link made available or hosted by him. Okay, now this is a section which is at the fundamental root of the success of the social media companies in India. Because what is basically it is meaning to say is that after the 2012 judgment, it became possible for the social media companies in India to have data move on the platform which is given by the social media companies without inviting any criminal complaint against themselves. Let's say, for example, if I am Twitter and if someone posts something pornographic on Twitter or something defamatory on Twitter, I have as Twitter a immunity which is given to me under section 79 of the Information Technology Act. It says that an intermediary shall not be liable for any third party information, data or communication link made available or hosted by him. ठीक है, तो मतलब किसी भी तरह से अगर मान लीजिए कोई व्यक्ति कोई गलत तरीके की बात करता है सोशल मीडिया प्लेटफॉर्म पे, फेसबुक पे, ट्विटर पे, तो ट्विटर को एक इम्यूनिटी मिली जाती है जिसको कि सुप्रीम कोर्ट ऑफ इंडिया ने कहा था safe harbor provision. इसको you can also remember it as a name clearly. A safe harbor provision. This is an immunity which is given to social media intermediaries in India under section 79 of the Information Technology Act. Immunity given to the social media intermediaries in India under section 79 of the what you can call the Information Technology Act, which allows them to operate without getting any criminality over them with regard to the content which is generating on the social media. ठीक है, अब ये बेसिकली एक पॉइंट हमारा कवर हो गया. ठीक है, तो सेक्शन 79A आप ढंग से याद रख लीजिएगा क्योंकि ये करंट अफेयर्स में डायरेक्टली आपके इंफॉर्मेशन टेक्नोलॉजी रूल से पूछा जा सकता है. नाउ इन द स्पेस ऑफ इंफॉर्मेशन टेक्नोलॉजी रूल्स मैं आपको थोड़ा सा समझाना चाहता हूँ, एंड द नोट्स दैट आई हैव अटैच्ड टू दिस आर अगेन गोइंग टू बी इंपॉर्टेंट फॉर यू टू रिमेंबर टू रीड. Okay, information technology rules. Now, in India, a very simple assessment and assertion can be made about a particular fact. There are two kinds of institutions, or public institutions. जैसे हम बात करते हैं कि एक प्रश्न अगर हम आपसे पूछें कि मीडिया को इंडिया में कौन रेगुलेट करता है? Who regulates media in India? Right? If that's a question that we ask, then the सिंपल आंसर इज दैट मीडिया इज सेल्फ रेगुलेटरी. मतलब मीडिया अपने आप को खुद को रेगुलेट करती है ना. मैं जैसे फॉर एग्जांपल अगर हम एक बात करते हैं कॉन्स्टिट्यूशन के अंदर, वी टॉक अबाउट अ कोड ऑफ एथिक्स, समथिंग दैट यू मस्ट हैव रेड इन एथिक्स सम टाइम और द अदर, एंड व्हाट इज नोन एज अ कोड ऑफ कॉन्डक्ट. ओके, कोड ऑफ एथिक्स एंड अ कोड ऑफ कॉन्डक्ट. अब कोड ऑफ कॉन्डक्ट का मतलब होता है कि मान के चलिए ये कोई पब्लिक ऑर्गेनाइजेशन है, जैसे कि मान लीजिए मीडिया है. नाउ लेट्स से दिस इज द गवर्नमेंट. नाउ इफ द मीडिया is trying to do something which is, let's say, in violation of certain ethics or laws. Let's say, remember that example of what you can call the Sudarshan News. There was a media channel, satellite media, which had displayed certain aspects of certain things. For example, they had said about some, coaching institutes doing certain things, etc., etc. So that kind of a publication by a media house is supposed to be a violative of a lot of laws in India and a lot of ethics in India. When the matter of Sudarshan News went to the Supreme Court said that we don't want to put media under state regulation. India has a kind of a principle in which media is self-regulated. मतलब media की क्या होता है कि जैसे for example you have the Press Club of India or the Press Trust of India. These are bodies made of the media houses themselves. These are bodies made of the media houses themselves who are trying to in a way regulate the conduct of the media. You have for example the Editors Guild of India. Right? So it is supposed to be a kind of a self-regulated, all the major media houses come together and form a body, and that body releases a code of ethics which has to be applied to all of them. It's a self-regulated kind of an activity that media is in India. A question which came in UPSC Prelims once was whether media is regulated by the state or is self-regulated. The answer is self-regulated. It is not regulated by any law. There are censorship laws on movies and cinematographic acts, etc., etc. But there are no censorship laws upon the media in India. Okay. Similarly, when we talk about social media, there are no censorship laws upon social media also. Okay, the social media is not what you can call regulated by the state at all, at least up until the point of 2021. So let's say for example, if someone posts something on Twitter which is offensive, which is also of a profane nature, okay, and let's say you find it offensive and of profane nature and you complain to Twitter. How do you complain it? You have an option of report abuse or something like that, and that kind of a data goes to Twitter. And then maybe Twitter takes a look at that data, maybe Twitter doesn't, maybe Twitter removes that account, maybe it doesn't, maybe the action is taken, it's not taken. You don't get any accountability as to what Twitter or Facebook or WhatsApp have done with regard to that particular data. Okay. So there is no what you can call enforcement or a law upon Twitter to take account of whatever has offended you and give you a response within this period of time. Right? If you have had any experiences of reporting abuse of anything, you don't know how and why and where these companies take their decisions of putting some content online or putting some content out of the picture. For example, Twitter, when it was very famous, had suspended the account of Donald Trump by the end of his presidential candidature because he was inciting riots in the Capitol building in the United States of America. Okay, so the question which was being asked over there was, how does Twitter take a decision of suspending an account of a person? At some point of time, there was a BJP spokesperson whose account Twitter has suspended and whose content Twitter has qualified as fake news, unverified content. So question ये पूछ रहे थे सब लोग कि Twitter अगर किसी एक अकाउंट को सस्पेंड करती है, किसी एक अकाउंट को टर्मिनेट करती है, किसी एक अकाउंट को बार बार गलतियों करने के बाद भी टर्मिनेट नहीं करती है, तो ट्विटर के पास क्या स्टैंडर्ड और क्या पॉलिसी जिसको फॉलो करके वो डिसीजंस ले रही है. और ट्विटर का आंसर ये था कि सोशल मीडिया इन इंडिया इज़ अ सेल्फ रेगुलेटेड एंटरप्राइज. नंबर 1, तो जो कंटेंट आ रहा है जा रहा है उसको हम अपने हिसाब से मैन्युफैक्चर करके, मतलब उसको अपने हिसाब से हम ट्रैफिक को ऑर्गेनाइज कर लेते हैं, हमारे खुद के कोड ऑफ एथिक्स हैं. ठीक है. और दूसरा, द सेकंड पॉइंट वाज ऑफ कोर्स समथिंग इनक्रिमिनेटिंग. अगर कोई क्रिमिनल एक्टिविटी ट्विटर के माध्यम से हो रही है, जैसे मान लीजिए किसी ने किसी का वीडियो बना के व्हाट्सएप पे डाल दिया, तो सेक्शन 79 ऑफ द इंफॉर्मेशन एक्ट के अंदर व्हाट्सएप को तो कोई टेंशन नहीं लेनी ना. They don't have to worry about anything under section 79 of the IT Act, because section 79 of the IT Act gives immunity to the social media platform from any kind of an activity which is happening upon their platform. So it was a very comfortable position for the social media companies. Number 1, they had no accountability about the content which was passing on their platforms. Number 2, they did not reveal to the world the standards that they were using to qualify and disqualify a content which was circulating on their platform. तो कभी भी किसी का अकाउंट सस्पेंड हो जाता था, किसी का सस्पेंड नहीं होता था, है ना. कभी किसी का ब्लू टिक निकाल लिया, कभी कुछ कर लिया, ऐसे ऐसे होता था. सो दिस बेसिकली लेट द गवर्नमेंट इन द एंड to change the landscape of social media from self-regulatory to government regulatory, right? And this began the introduction of what you can call the information technology rules from the year 2021, which has now seen additional amendment. तो सरकार क्या करती है? Under the powers given to the Ministry of Electronics and Information Technology. Okay, again this is a question that can be asked. which is the nodal agency for issuing the information technology rules. It is Ministry of Electronics and Information Technology. Under the powers given to the Ministry of Electronics and Information Technology by the Information Technology Act 2000, the MeitY has issued what is known as the rules, which are known as the IT rules. And the objective of the IT rules is to set out the procedure for regulation of social media intermediaries. This is the objective of the information technology rules. Regulation of social media intermediaries. मतलब प्रश्न ये है कि सोशल मीडिया इंटरमीडियरीज किस आधार से अपने कंटेंट को रेगुलेट करते हैं, किससे उसको बैन करते हैं, किससे किसी चीज़ को फेक न्यूज़ बोलते हैं, किसी चीज़ का अकाउंट सस्पेंड करते हैं. ये अब सोशल मीडिया कंपनीज के हाथ में नहीं छोड़ा जा सकता है. इट हैज़ टू बी टेकन इन द हैंड्स ऑफ द गवर्नमेंट एंड द गवर्नमेंट इज गोइंग टू गिव देम सम प्रिंसिपल्स based upon which they will regulate the content coming and going out of their media platforms. Okay, in very short and precise terms, this is the objective of information technology rules. So if a question comes whether social media enterprises, social media intermediaries in India, are they governed by the government or they governed by themselves like the media in India? The answer today to that question is that after the introduction of the information technology rules, the social media enterprises in India are governed by the IT rules 2021 as amended in 2022 and 2023. Okay. Now, for example, what does the government do in 2021, 2022, 2023 rules? It says that every social media intermediary, basically what it says is every significant social media intermediary has to appoint certain officers. For example, there is going to be a chief grievance officer. Then there is going to be a chief nodal officer. These officers have to be, let's say for example, there is a Twitter. Now Twitter has to appoint a person at these roles who will be directly reportable to the Ministry of Electronics and Information Technology for the activities that they are doing to regulate the content on Twitter. मतलब एक अगर मान लीजिए किसी व्यक्ति ने अपना कोई ट्वीट, किसी का ट्वीट कोई ऑफेंसिव पाके उसको रिपोर्ट अब्यूज किया है. Okay, if a person is let's say asking for a report abuse of a particular activity or in Twitter, etc. Then now at this point of time, if Twitter does not respond to that person's report abuse in time, MeitY will start questioning the chief grievance officer and chief nodal officer as to what have you done about the reports which have been made by people in your company. मतलब अगर आपके सामने कोई रिपोर्ट लेके आया तो अब आपको उसकी पूरी फाइल रखनी और उसकी फाइल पे आपने उनके क्या उत्तर दिए और उन रिपोर्ट्स को किस तरह सॉल्व किया. That has to be submitted to the government of India under the information technology rules. A set of compliances have to be check-boxed by every significant social media intermediary. Significant social media intermediary means media intermediary which is having what you can call a audience base of more than 50 lakh. That is the definition which is given in the information technology rules. तो मतलब मान लीजिए कोई बहुत बड़ा ट्विटर या फेसबुक या व्हाट्सएप है जिसके पास 50 लाख से ऊपर वो हो सकते हैं, मतलब people who are using it can be called a significant social media intermediary. Every significant social media intermediary has to check a box as to what are the compliances which are mentioned under IT rules that they have to report to the government now. Now here's a trick about it. If any social media intermediary fails to check box a compliance, जैसे मान लीजिए किसी social media intermediary ने अपना चीफ कंप्लायंस ऑफिसर नहीं अपॉइंट किया या चीफ ग्रीवियंस ऑफिसर नहीं अपॉइंट किया, सरकार को जवाबदेही नहीं दी, सरकार के पास फाइलें नहीं भेजी कि उन्होंने किस डिस्प्यूट में क्या डिसीजन लिया, उसकी क्या रीजनिंग है, तो द IT रूल्स से दैट for the non-performance of the compliances under the IT rules, a social media intermediaries immunity under section 79 shall be suspended. A social media intermediaries immunity under section 79 will be suspended, which basically means that any social media intermediary, if it does not agree to what the government wants it to do in terms of regulation of the content, then the government can pass an order, the MeitY can pass an order that the immunity which is enjoyed by that social media intermediary can be suspended by passing the information, suspended by the suspending of the section 79, and the FIRs can be made against the CEOs of the company. So at some point of time what had happened was, let's say for example, take a look at this. This is an example of how it started developing in the current affairs, and now it becomes important and necessary for you to understand with reference to the current affairs. Take a look at this. The government has said that the social networking platform Twitter has lost the immunity granted to intermediaries under the IT Act 2000, the government told the Delhi High Court on Monday. This was because of its failure to comply sorry, it's just acting up. So the news article basically said this, that the social media intermediaries, for example, what Twitter had done was, Twitter has in a way rejected the government's said, and for the longest time it did not appoint any chief nodal officer or chief grievance officer, and as a result of this, what the government of India, MeitY, issued a notification that the immunity which is given to Twitter under section 79 acts suspended because it has not been able to comply with the regulating guidelines under the information technology rules. Okay. So what this basically specifies is that the punishment, now this is a question for the prelims, a directly pointed question for the prelims. What is the punishment which is given in the information technology rules for non-compliance of the Information Technology Rules 2021 as amended in 2022 and 23? And the answer is that the safe harbor provision / section 79 of the Information Technology Act, the immunity which is given to social media intermediaries from criminal liability of the content which is circulating on the media shall be suspended. You know what that means? What that means is that as soon as this immunity is suspended, then for example, an organization like Twitter can, let's say if someone posts an incorrect map of India on Twitter, and that posting of incorrect map of India on Twitter is a crime under certain laws in India, then the FIR will not only be registered against a person who has posted it from his account, but also the CEO of Twitter in India, because the company does not enjoy the immunity which has been given to Twitter under section 79 of the Information Technology Act. Right? This is a part that becomes a relevant discussion under Article 19 and under Article 19(1)(a) of the Constitution with regard to freedom of speech and expression of social media intermediaries and people on social media intermediaries with relation to section 79 of the Information Technology Act. Okay, so we have taken a look at this particular aspect of the current affairs. We have given you an understanding of the Personal Data Protection Bill and the laws which are associated with the KS Puttaswamy case and the B.N. Sri Krishna committee, but also the information technology rules which have been given by the government of India, which it has amended time and again. The provisions of that you can read from the notes that we are circulating, but the important things that you would want to remember for this is section 79A, section 79 of the Information Technology Act and the relevant sections with regard to what is known as a safe harbor provision which is given under section 79, and the information technology rules which are now bringing a transformation in the self-regulated nature of social media to a government regulated one, and anyone who is not complying with these government regulations, immunity is being suspended under section 79. Though the immunity which was suspended for Twitter did not remain suspended for a very long time, it was able to, of course, paralyze the activities of Twitter for some time, unless they had completely regained the position of what you can call making that kind of a thing happen again. Okay, all right, take it, chalo. I think it's a good time for us to take a break. We'll come back with the remaining articles. There's a lot of material that I want to dispense before the day ends today, so please come prepared, have your snacks and a little bit of a rest, and we'll begin with the next part. When we're going to discuss, I'll just number out what are the things that I want to discuss. I want to discuss disqualification of MPs with the current case of MP from Congress who has been disqualified under the Representation of People's Act section 8. Okay, this is the first thing that I want to discuss. Then the second thing that I want to discuss is the anti-defection law, which has been heavily in news since the formation of the Maharashtra government under Eknath Shinde as a leader of the Shiv Sena, and a lot of complications happening in that regard because of the judgments which have been given by the Supreme Court. So after the break, these are the two important things that I will start up with. So I will see you on the other end. Thank you. Okay. Right. So welcome back, all of you. We are back online. Okay. So please just take out a pen and a notebook. And I'll just give you some amount of just very simplistic notes about both of these documents that we're dealing with. Okay, we'll take a look at the data protection law, some amount of notes that you can just scribble down so that you can have some amount of understanding in terms of creating pointers about it, and also the okay. This is an article that I'm going to attach with the notes that we have to distribute you. This is a Hindu explainer page on the Information Technology Rules 2021. Okay, so I'm just going to highlight a few points, just read them barely, and you keep a note of things as you write a certain. If you put down these points in the notebook at this point, it will come in handy for you to find them at one place where I have explained everything correspondingly. Okay, here we go. The Ministry of Information, Electronics and Information Technology, MeIT, has notified amendments to the Information Technology Intermediary Guidelines in Digital Media Ethics Code Rules 2021, which are also known as the IT Rules 2021. In June 2022, MeIT had put out a draft of an amendment and solicited feedback from the relevant stakeholders. The draft generated considerable discussion and comment on the regulation of social media in India. Okay, so this is after the news had developed that amendments were made to the Information Technology Rules 2021. Okay, so what you can take down in your notebooks is this part. This is the full name of the law, in case you want to remember it. Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules of 2021, as they are amended in 2022. As amended in 2022. Now, let me repeat the significance of these rules again. These rules are the method by which the social media in India is moving from a stage of being self-regulatory to being government regulated. Okay, so that's the point about it. This is a move by which the social media in India, the social media intermediaries in India, are moving from being self-regulated to being government regulated. Okay, so that's the point that you can take it out from here. And after that, this is the part that you can read in the given article. It compares the Information Technology Rules 2021 and the changes which have been made in these rules in 2022. Okay, this part of the article, that how is the first draft of the rules different from the most recent draft of the rules. Okay, for example, let's say The original IT rules 2021 obligated the SMIs. SMIs are the social media intermediaries to merely inform its users of the rules and regulations, privacy policy and user agreement that govern its platforms, along with the categories of content that users are prohibited from hosting, displaying, sharing, etc. on the platform. This obligation on the SMIs has now been extended to ensuring that its users are in compliance with the relevant rules of the platform. Okay. Further, SMIs are required to make reasonable efforts to prevent prohibited content being hosted on its platform by the users. Okay, just take a look at this. If, for example, we want to understand the changes which have been made in the information technology rules from 2021 to 2022, you can take a look at this paragraph which I have underlined over here. The earlier version of the information technology rules obligated the social media intermediaries to merely inform its users. It's kind of a notice, intimation of what is rules and regulations in privacy policy and user agreements. Okay, but now the rules have changed of ensuring that the users are in compliance with the relevant rules of the platform. Okay, so now users have to, in a way, make sure that not only are they aware of the rules, but they agree to the rules. Let's say, for example, if a kind of a notification has been issued by a social media intermediary that a kind of an activity, if you perform or involve yourself into a certain kind of an activity, it will be a violation of the code of conduct of the user on a social media platform. If he does not agree to that fact, then he may not be allowed to use that social media platform, right? So the focus has shifted from just making aware. Focus has shifted from mere awareness to making the users compliant. Okay, that's the first part. Second thing which has been given in the new IT rules, in case it emerges as a kind of a multiple choice question, is that the social media intermediaries have to respect all the rights accorded to the citizens under the Constitution, including in the Articles 14, 19 and 21. Okay, the social media intermediaries, SMIs, have to keep in mind the rights which are given to the citizens of India under Article 14, 19 and 21 as they are undertaking their operations. Okay. Clear? This is the next part that you can remember. Okay. Now, these are the 2 points that you can remember in which the 2 rules have changed over the last year. Then the next part that you can take a note of, which has been introduced in the IT rules 2022, again can be asked as a question, is that the government has instituted a grievance appellate committee. The committee is styled as a 3-member council, out of which 1 member will be a government officer, while the other 2 members will be independent representatives. Users can file a complaint against the order of the grievance officer within 30 days. Importantly, the GSE is required to adopt an online dispute resolution mechanism which will make it more accessible to the users. Okay, this is a very MCQ-like literature that you may want to remember at this stage. Okay. Now, this is what basically is one of the important points about the information technology rules, that it has instituted something which is known as a grievance appellate committee. So earlier we talked about the CGO, Chief Grievance Officer. If you have, for example, certain complaints against a social media platform or intermediary or content hosted upon it, you have to file a complaint to the social media intermediary, whose Chief Grievance Officer is supposed to take that complaint up and in a way tell you that your complaint is being acted upon, etc., etc. But now, because of the 1 year of looking at the practicality of the grievance complaint officer not working properly, the information technology rules have instituted what is known as a grievance appellate committees, GACs. Grievance appellate committees, which is styled as a 3-member council, out of which 1 member be a government officer, while the other 2 members will be independent representatives. So user can file complaint against the order of the grievance officer within 30 days. Importantly, the GSC is required to adopt an online dispute resolution mechanism which will make it more accessible to the users. ठीक है, तो इसको आप थोड़ा सा याद कर लीजिए. What are the very probable things which can be asked from the information technology rules 2022 as current affairs? Okay, this is not even 1 year before the examination, and it's going to be a relevant part of the UPSC prelims examination. Okay. Yeah, so you can take a look at this article. I think this article would be sufficient for you to read anything about the IT rules. I'll be attaching this article at a portal that we are going to replace. We are going to place all the documents for your review. Okay. Here's a document similarly that I want you to read upon the personal data protection law. What is the relevance of this particular document in terms of creating a information base upon the personal data protection law? Right now, this is the point at which we can take a look at the history of the personal data protection law. That would be sufficient. I told you that recently a 4th draft, or let's say a 4th iteration of the data protection law in India was introduced before the Parliament. The first draft of the law of the personal data protection was proposed by the Justice Shri Krishna Committee, set up by the Ministry of Electronics and Information Technology. This we have covered, with the mandate of setting out a data protection law for India. The government made revisions to this draft and introduced it as a Personal Data Protection Bill 2019 in the Lok Sabha in 2019. On the same day, the Lok Sabha passed a motion to refer the PDP Bill 2019 to a joint committee of both the houses of Parliament. Due to delays caused by the pandemic, the joint committee on PDP Bill submitted its report on the bill after 2 years in December 2021. The report was accompanied by a new draft bill, namely the Data Protection Bill 2021, that incorporated the recommendations of the JPC. However, in August 2022, citing the report of the JPC and the extensive changes that the JPC had made to the 2019 bill, the government had withdrawn the bill. Just take a look at this. Very simply, if you want to take some notes out of it, which you feel are relevant for the prelims examination, you can take a look at it. This is what you call the journey to and fro of the Personal Data Protection Bill from the KS Puttaswamy judgment till 2022. Okay. If you want, you can take a screenshot. Otherwise, I'll be attaching this document anyway for you to take a look at. Right, so the 2019 bill, the government was withdrawn by the government, and the latest news in this is that the latest development in this is that the draft of the data protection law, which is known as the Digital Personal Data Protection Bill 2021, has now been made open for public comments, and the government is expected to introduce in the Parliament in this budget session of 2023. It was not introduced in the budget session of 2023. It will likely be introduced in the monsoon session. Right, so just remember the name of the bill, because the name of the bill has changed so much and so often. The name of the bill that you can remember over here, which is currently the functional bill on the protection of personal data, is Digital Personal Data Protection Bill 2022. Okay, Digital Personal Data Protection Bill. This is the name of the bill. ठीक है, इसका इतना इतिहास कॉम्प्लिकेटेड हो गया है कि इस चीज़ पे क्वेश्चन बन के MCQ की तरह UPSC पूछ सकता है. तो इसको अगर आप याद कर लेंगे तो थोड़ा आसान हो जाएगा काम. Digital Personal Data Protection Bill. First it was Data Protection Bill, then it was Personal Data Protection Bill, then it was a Digital Data Protection Bill. Now it has become Digital Data Personal Protection Bill. Because of the confusion, it can be exploited as a MCQ that you can prepare. Okay. Okay, so that's the kind of thing that I would want you to take a look at simply and easily. All right. Fine. So we are comfortable with this part of Information Technology Rules, Section 79 of the Information Technology Act, Safe Harbor Provision, the Bazi.com case, the 2005 and 2012 judgments of the Delhi High Court and the Supreme Court, and the Information Technology Rules and the penalties for Information Technology Rules breaches, Section 79 of the what you can call the Information Technology Rules, right? I think I was showing you a set of news articles. Here, for example, I was referring to this news article. Something wrong. Yeah. You can take a look at this briefly. UP Police files an FIR against Twitter Inc. India unit over a viral video, right? So all the immunities that were enjoyed by companies like Twitter, etc., they were now lost into oblivion because of the suspension of Section 79 of the Information Technology Rules, Technology Act, which had given all forms of governments the ability to strike a FIR kind of an activity against the officials of the Twitter, because the immunities was now getting lost. Okay. Right, so now we move on to the next one. Right. Okay, so now the next important things that I'm trying to do is basically related to what you can call, I've already made you understand what is the nature of Article 21, which is life and personal liberty cannot be taken away of any person. No person's life and personal liberty can be taken away except by the procedure established by law. Except by the procedure established by law. Okay. Now, just a kind of a revision of Article 21. Life under Article 21 means the body of a person, and personal liberty under Article 21 means the mind of a person. Life means body and personal liberty means mind. Okay. Now, what it says is that no one can be deprived of their body or their mind except by a procedure established by law. Clear? And later on, for example, in the what you can call the A.K. Gopalan case, in the A.K. Gopalan case, 1951, Supreme Court had said that Supreme Court cannot exercise judicial review. Supreme Court cannot exercise judicial review over the procedure made by the Parliament. Supreme Court cannot exercise judicial review over the procedure made by the Parliament in pursuit of its powers to take away the life and personal liberty of any person. To take away the life and personal liberty of any person, comma, even if it violated rules of natural justice. Okay, this was a famous judgment by the Supreme Court in which it had refused to bring the activities of the Parliament under Article 21 when it creates a law for depriving a person of his life and personal liberty, even if that law breaks down the the rules of natural justice. This is A.K. Gopalan case 1951. The A.K. Gopalan case was overturned by the Supreme Court in the famous Maneka Gandhi case. Maneka Gandhi versus Union of India 1978, in which the Supreme Court had held that a procedure established under Article 21 must be just, fair and reasonable. Okay. A procedure established under Article 21 must be just, fair and reasonable, and if the procedure is not just, fair and reasonable, the Supreme Court can exercise judicial review. Also, the Supreme Court held that rules of natural justice, must be employed. While taking away the liberty of a person under Article 21. A very simple comparison between two landmark judgments which were given over here by the Supreme Court. One in 1951. In 1951, the judgment of the Supreme Court said in the A.K. Gopalan case that the procedure established by law is something that the Supreme Court cannot interfere in. Just please listen to what I am saying. Questions will be formed exactly in the same language. So even if you have to memorize at this point of time, it's going to be worth it. Okay. Article 21 says life and personal liberty of any person cannot be taken away except by the procedure established by law. Supreme Court in the A.K. Gopalan 1951 case said that the procedure established by law is entirely as a concept under the control of the legislature, and therefore the Supreme Court cannot review the procedure by which a person's liberty has been taken away. On the other hand, with the due process of law, for example, as a concept which was available in the American Constitution, okay, I'll just mark it out. India had taken the concept of procedure established by law from the Japanese Constitution. Okay, and India did not take the concept of a due process of law, but which was available under the American Constitution. In the procedure established by law, there is no room for judicial review. on a procedural law. In due process of law, there is room for judicial review. Okay, may not be in line with principles of natural justice. May not be in line with principles of natural justice. Are always in line with principles of natural justice. These are very simple points which you can just memorize in context of your prelims examination to answer any kind of a one sentence question on the due process of law and procedure established by law. Okay, a very simple and categorically tabular comparison between the two concepts. Procedure established by law drawn from the Japanese constitution, due process of law present in the American constitution. India prescribes to this. No room for judicial interpretation, judicial review on a procedural law. There is room for judicial review. May not be in line with the principles of natural justice, is always in line with principle of natural justice. Let me bring out the two elements of principle of natural justice. No person shall be a judge in his own case. This is the first principle of natural justice. Second principle of natural justice is no person shall be punished without being given a right to be heard. Okay, no person shall be punished without being given a right to be heard. These are two principles of natural justice. They may not apply in the procedure established by law, but they do apply in due process of law. As a last minute point, if you want to remember how to answer questions in due process and law and procedure established by law, just memorize them. I don't think we have the time in which I will make you understand the conceptual background of it, but if you can, just draw this table and all your questions from procedure established in due process can be answered by the reference to these tables. Okay, also keeping in mind that India has adopted it from the Japanese constitution, procedure established by law. Okay, it has not adopted the due process of law. But in article in the Maneka Gandhi judgment, the Supreme Court started giving interpretation that the procedure can be just, fair and reasonable, and the Supreme Court can exercise judicial review. So this is over here that the Indian constitutional thinking started moving towards the direction of judicial review under what is known as due process of law. Okay, so today India is not a strictly procedure established by law country, but it has elements of due process of law because the Maneka Gandhi case allowed the judges to interfere into interpreting certain procedural laws made by the parliament. Okay, take. Now let me just go and change the tone a little bit and come to a kind of a relevant hot topic which is in news recently, and we'll have some fun, engage some momentum and energy of the class to discuss one of these issues. So now brace yourself for a very, very fascinating event developing in the current affairs as we speak, sure to be a very favorite for the UPSC for creating an exam out of it. Let's take a look at what is known as the disqualifications of MPs under the Constitution. I'm going to categorically and step by step make a case about what it means to have this entire chapter covered every little bit of piece of information that you would need for the prelims examination will be covered under this header. Okay, disqualifications of MPs under the constitution. Okay, let me just give a brief understanding of what is happening over here. Parliament of India is governed by articles 79 to 123 of the constitution. Okay, article 79 to 123 of the constitution is where you have the articles with reference to the union parliament. Okay, it provides for the two houses which is the Lok Sabha and the Rajya Sabha. That is also known, the Indian system of having two houses is also known as a bicameral legislature. Bicamera means two chambered or dual chambered, bi means two, camera means chamber. Okay? Then of course we have the conditions on which you have qualifications for being an MP. Okay, so what are qualifications given in the constitution? For the Lok Sabha you have to be a minimum of 25 years and for the Rajya Sabha you have to be a minimum of 30 years. This is the first qualification given in the constitution, plus you have to be a citizen of India. These are two qualifications which are given for a person to become a member of parliament in the Constitution of India. Okay, and in addition to this, if there are any other qualifications which are required, it will be given in the Representation of People Act 1951. Right, so a simple question as to what law made by the parliament governs the qualification and disqualification of member of parliament? The answer to that is Representation of People Act 1951. Two conditions, however, are given in the constitution directly. 25 years is going to be the minimum age for the Lok Sabha MP and 30 years is going to be the minimum age for the what you can call the Rajya Sabha MP. Over and above that, the conditions for qualifications are given in the Representation of People's Act. Okay. Now let's take a look at a bit of a understanding of what is happening over here. Article 102 of the Constitution, let me just give you a clear understanding of it. Article 101 of the Constitution deals with vacation of seats at the Lok Sabha and Rajya Sabha. Okay. It says in what manner can seats be vacated from the Lok Sabha and the Rajya Sabha. किस तरह से लोक सभा और राज्य सभा से सीट्स को खाली किया जा सकता है. That's the point that the Article 101 of the Constitution makes. I'll just put out the grounds of vacation. ठीक है, what are the grounds which are given in? आप इनको copy कर सकते हैं, directly MCQ की तरह आ सकता है. Grounds. First ground which is given for vacation of seats in the Lok Sabha and the Rajya Sabha is what is known as if a person is a member of both the Lok Sabha and Rajya Sabha simultaneously. मतलब अगर कोई एक व्यक्ति दोनों ही सदन का मेंबर्स है, लोकसभा और राज्यसभा का एक ही समय में, तो उसको डिस्क्वालीफाई किया जा सकता है unless he resigns from one of the members. Okay, members of both the Union Parliament and स्टेट लेजिस्लेचर. अगर कोई व्यक्ति यूनियन पार्लियामेंट और स्टेट लेजिस्लेचर का साइमल्टेनियसली मेंबर है, if a person is a member of the union parliament and the state legislature at the same time, he can be disqualified from both the houses unless he is गिविंग रेजिग्नेशन फ्रॉम वन थिंग, ठीक है। तो ये दो ग्राउंड्स हैं वेकेशन के, कि अगर बोथ लोकसभा और राज्यसभा का व्यक्ति है तो उसको वेकेट करनी पड़ेगी अपनी सीट, और राज्यसभा और यूनियन पार्लियामेंट और स्टेट लेजिस्लेचर का व्यक्ति है तो उसको एक जगह अपनी सीट वेकेट करनी पड़ेगी, राइट। दिस इज द ग्राउंड्स फॉर वेकेशन। तीसरा जो ग्राउंड है वेकेशन का, दैट इज डिस्क्वालिफिकेशन। ओके, दैट इफ अ पर्सन इज डिस्क्वालिफाइड under Article 102 and the Representation of People Act 1951. These are the two statutes which deal with disqualification. Okay, if a person is disqualified from a membership of the Lok Sabha and the Rajya Sabha under Article 102 and the Representation of People's Act 1951. This is what I am going to deal with the case of the Member of Parliament with Wayanad, who's been disqualified by the Lok Sabha Secretariat recently. Okay, and the fourth ground for vacation is by resignation, that a Member of Parliament can resign from his seat. Okay, but the resignation can be rejected by the speaker / chairman. Okay, so the very simple MCQ kind of a question which can come this time. What are the grounds on which Lok Sabha can be, or Lok Sabha and the Rajya Sabha seats can be vacated? The Lok Sabha and Rajya Sabha simultaneously, if a person is member, he has to vacate one of the seats. If he is a member of the Union Parliament and the state legislature, he will have to vacate one of the seats. C, disqualification under Article 102 of the Constitution and and the Representation of People Act 1951, which talk about the grounds of disqualification and resignation, but can be rejected by the Speaker and Chairman. This is a simple setup of how MCQ can be drawn, right? Now, I want to take up this particular part, which is regarding disqualification, and I want to stretch it out. Okay, starting with the next point over here. Article 102 of the Constitution, in succession to Article 101, talks about grounds for disqualification. Again, I am putting it in a very MCQ format for the reason that disqualification of an MP is all over the news recently. And if you have any care about your prelims examination, you will listen to everything that is being talked about over here, because it is going to be a very, very probable question. Disqualification of an MP is all in the news. Okay, so Article 102 takes out grounds for disqualification. I'm putting it in an MCQ format again. The grounds of disqualification mentioned under Article 102 are: A, a person is holding an office of profit. Okay, disqualification of an MP, Member of Parliament of Lok Sabha and Rajya Sabha, if a person holds an office of profit. Okay, B, if a person is of unsound mind. Okay, C, if a person is an undischarged insolvent. The person who has been declared a Diwaliya. Please take note of these. If you want to memorize them, do it now. D, if a person is not a citizen of India. Or has given up the citizenship of India to acquire the citizenship of a foreign state. And E says, under Section 8 of the Representation of People Act 1951. Under Section 8 of the Representation of People Act 1951. Please take note of these things. Okay, if you have a question about what are the grounds of disqualifications given in the Constitution of a Member of Parliament, I have set it out in a very perfectly styled MCQ format. Okay, Grounds for disqualification of an MP: A. Office of profit, B. Unsound mind, C. Undischarged insolvent, D. Not a citizen of India, and E. Under Section 8 of the Representation of a People's Act. Okay, UPSC Gyan is asking the question. If office of profit is not a ground for vacation, let's go to it again. Disqualification is a ground for vacation, and a person will be disqualified if he is holding an office of profit. So by default, a person who's holding an office of profit who will be disqualified will eventually have to vacate. Vacation means someone is moved, someone is leaving his chair. Vacation by the means of disqualification means someone is leaving his chair that he's been asked to leave. He is not eligible to sit on the chair anymore. So C is a ground for disqualification. Okay, and C is what you can call a ground for vacation, or what you can call a example of vacation, and office of profit is an example of disqualification. So if you put a syllogism over here, you have office of profit under disqualification and disqualification under vacation. Therefore, you are correct. Holding an office of profit is a kind of a vacation, but not directly, mediatively. Okay? So grounds for disqualification of an MP, this is what we have taken a look at. So now I want to elaborate upon the Section 8 of the Representation of People's Act as to what it is basically trying to say. But before that, let me take a look at, and we can go to the Section 8 of the Representation of People's Act. We're coming close to what is the current case over here. Now, the Indian Penal Code, again please be aware about the information that I am laying out on the board. 1860 is a code which gives punishment for offences. Okay, it's what you can call, Indian Penal Code is a criminal law. Right? It is a criminal law, and the what you can call the objective of the Indian Penal Code is to fold. Let's say first is to convict a person of committing an offence. That you have to determine, for example, that X has committed murder. By conviction, one means that the judge is convinced. See, conviction in English language means convinced, that you have completely arrived at the conclusion that it is X who has committed murder. Right? So this is the first thing that is decided in the Indian Penal Code. And then the second thing that is decided in the Indian Penal Code, that according to the circumstance of the case, the judge sentences the person for committing an offence. Now see, all this is going to be important for the prelims examination. Only last year there was a question in the prelims examination with regard to the difference between judicial custody and parole, judicial custody and arrest. Okay, which means that the UPSC is going beyond the mandate of only asking questions from polity, but it is also venturing out in law and Indian Penal Code, etc., etc. That's why I'm trying to indicate this to you. Conviction of a person is that a judge is satisfied that a person has committed the crime. Sentence of a person means that what kind of punishment does judge want to give to the person. Let's say, for example, if a person is found guilty of having committed a murder, it's a conviction of murder, that he is guilty of committing the murder. But let's say if he has committed murder under some kind of a force, some kind of a pressure, some kind of a social distress, then that kind of a factoring in would be taken into account before punishing him for the conviction of murder. And let's say if he's living under a lot of social distress or economic distress, then you can take a look at, for example, what is known as the sentence of a person for committing an offence is basically reduced if he is under emotional and social distress. But if the person is completely fine and he is not under any emotional distress, then the sentence would be higher. So sentence means to give him punishment. Conviction means to be convinced that he has committed the crime. You can convince yourself that he's committed the crime, but nonetheless his sentence may vary according to the conditions under which he has committed the crime. Higher sentence for not unreasonable conditions, and lower sentence for unreasonable conditions, right? That kind of a thing is given as what you could call a conviction and a sentence. Now, I want to take a look at what is known as section 499 of the Indian Penal Code. Section 499 of the Indian Penal Code and section 500 of the Indian Penal Code. Section 499 is the definition of what is known as defamation, manhani as it is called. Okay. Section 499 of IPC is the definition of defamation. Okay, this is how defamation is defined under section 499. And section 500 of the Indian Penal Code gives the punishment for defamation. Again, this is going to be important because the case that we are dealing with in terms of disqualification of member of parliament is with regard to defamation only, right? So what is the punishment for defamation is a question that we can ask ourselves. Ashutosh, you're absolutely correct. The 10th schedule is a ground for disqualification. I wanted to write it later on because I was trying to deal with anti-defection all of its own. But yes, if you say, we can put it over here. Article 102, clause 2, 10th schedule, or what is known as the anti-defection law. 10th schedule, or what is known as the anti-defection law, is a ground, or what you can call ground or fifth ground for disqualification. We'll read the 10th schedule in elaboration in a bit because of the recent upheaval which has been happening in the Maharashtra Legislative Assembly because of the governments changing from one port to the other. Okay, so we'll come to that 100%. But okay, because we wanted to write it right now, we can do it. Article 102, clause 2. The punishment which has been given for defamation under the Indian Penal Code is as follows. Okay, the maximum punishment that a person who is convicted of committing defamation can be punished to the maximum of 2 years of imprisonment. Plus fine. Okay, let's say this is the harshest punishment, point number A. Second harshest punishment would be, let's say, 2 years of imprisonment without the fine. Okay. Third harshest could be, let's say, reduce the term of the punishment. 1 year punishment plus fine. Okay. Then let's say, for example, no punishment. No imprisonment. I don't mean to say punishment, I mean to say imprisonment. No imprisonment, only fine. Okay. And the most lenient of this thing, most lenient would be no imprisonment plus no fine. So this is the range in which defamation can be punished under section 500 of IPC. The least is no imprisonment plus no fine. Then fourth is only fine. Then third is 1 year imprisonment plus fine. Second is 2 years of imprisonment minus fine. And maximum punishment is 2 years of imprisonment plus fine. If you are convicted of criminal defamation under section 499 of the Indian Penal Code, then the maximum that you can be punished for is 2 years of imprisonment and some fine. Okay, and the second worst that could happen to you is that your fine can be relaxed, but your imprisonment is taken to the maximum period of 2 years. Okay, let me, for example, let's say open up the copy of the Indian Penal Code to make you read a little bit about the criminal defamation part, because I think this is going to be an important chapter in the mains examination this time because of what is happening in the current affairs. Okay, take a look at this. Just a simple definition that you can read of defamation over here to get a simple sense of what defamation means. Defamation, as defined under the Indian Penal Code, is that if any person by words either spoken or intended to be read, मतलब अगर कोई व्यक्ति कुछ बोल के या फिर कुछ ऐसे शब्द जो लिखता है जिससे कोई पढ़ सके, या फिर by signs or by visible representations makes or publishes any imputation concerning any person intending to harm or knowing to having reasons to believe that such imputation will harm the reputation of such a person is set to defame that person. इसका कहने का सिंपल मतलब ये इस परिभाषा का कि अगर कोई व्यक्ति मौखिक शब्दों से, लिखित शब्दों से या विजिबल रिप्रेजेंटेशन और साइन लैंग्वेज से किसी व्यक्ति की रेपुटेशन को हार्म करता है, तो उसको कहा जाएगा कि उसने दूसरे व्यक्ति को डिफेम किया, उस व्यक्ति की मानहानि करी। ये सिंपल सी परिभाषा है डेफेमेशन की सेक्शन 499 के अंदर। उसके नीचे काफ़ी सारे ऐसे एक्सेप्शंस दे रखे हैं जहां पर कोई एक्टिविटी होगी तो उसको डेफेमेशन नहीं कहा जाएगा। जैसे फॉर एग्जांपल, अगर मान लीजिए किसी व्यक्ति ने किसी पब्लिक अथॉरिटी के बारे में कोई सच्ची बात बोली जो कि समाज के लिए जानना ज़रूरी था, तो उसको डेफेमेशन की डेफिनेशन में इंक्लूड नहीं करेंगे। व्हाट आई एम ट्राइंग टू से इज दैट द सेक्शन ऑफ द IPC 499, it defines defamation, but then after that it lays out certain things or certain ideas which cannot be held as defamation. They are exceptions to defamation, but nonetheless you're not concerned about the exceptions, you're only concerned with the rule. And then we come to section 500 of the Indian Penal Code, which states that the punishment for defamation is a maximum term of 2 years of simple imprisonment with fine. This is the maximum amount of punishment that can be given to a person of defamation. ठीक है, चलिए अब हम क्या करते हैं, अपने करंट अफेयर्स के पॉइंट पे आ जाते हैं. Our story starts at a point where a member of parliament from Kerala in the 2019 elections, the campaigning for the 2019 elections, was found to be saying certain things about a particular group or a caste or a community. Okay, and in 2019 FIR was registered against the person charging section 499 and 500 under the IPC in Surat, and the matter was taken up by Judicial Magistrate First Class. The matter was taken up by Judicial Magistrate First Class of Surat in 2019. But nonetheless, matter did not proceed to any kind of a speedy movement. It just went completely still. Okay. Now in 2023, the matter of the Surat Sessions, the Judicial Magistrate First Class, which is the what you can call the first point of lower judiciary in criminal law. क्रिमिनल जस्टिस सिस्टम में जो सबसे पहला पॉइंट होता है जुडिशरी का, उसे कहते हैं जुडिशियल मजिस्ट्रेट फर्स्ट क्लास. उसके सामने क्रिमिनल डेफेमेशन का केस हुआ था, लेकिन उस पर कुछ कार्रवाई खास विशेष तौर से नहीं हो रही थी. अब 2023 में क्या होता है कि ये वाला जो मैटर है ये सामने आ जाता है दोबारा से, और सूरत का ये जो जुडिशियल मजिस्ट्रेट फर्स्ट क्लास है वो इस एमपी के इस बयान को सेक्शन 499 और सेक्शन 500 के वायलेशन में मैक्सिमम जो इम्प्रिजनमेंट था वो अवॉर्ड कर देता है. तो द imprisonment of 2 years, which is the maximum imprisonment, is awarded to this particular person, the MP, for using defamatory, what you can say, derogatory statements against a community or a group of people. ठीक है? And he is imprisoned, मतलब first of all he is convicted and then he is sentenced for the maximum punishment of 2 years minus a fine. बस फाइन ही नहीं लिया. तो जो ये जो दूसरा पनिशमेंट है ना इसमें, मतलब the gravity of the act was considered to be so huge that the punishment which was given was maximum punishment of 2 years, nothing less than that. Okay, that's here. Now, so this kind of a part is clear to you. Now we go back to what is the point that we were dealing with in terms of a disqualification. जो ये है 102 में जो क्लॉज 1 है, उसका जो सब क्लॉज ई है वो बोलता है कि अगर कोई व्यक्ति सेक्शन 8 रिप्रेजेंटेशन ऑफ पीपल्स एक्ट के अंदर डिस्क्वालीफाई हो जाता है तो उसको डिस्क्वालीफाई, मतलब अगर कोई व्यक्ति सेक्शन 8 के अंदर की कंडीशन पूरी करता है तो उसको डिस्क्वालीफाइड माना जाएगा. ठीक है. सो नाउ आई विल शो यू द नेक्स्ट एक्ट विच इज रेलेवेंट इन द मैटर, विच इज रिप्रेजेंटेशन ऑफ पीपल्स एक्ट इन 1951. ठीक है. अब इस एक्ट को मैं आपके सामने खोल के प्रस्तुत करना चाहता हूँ. इस एक्ट में जो हमारी रेलेवेंट आर्टिकल है वो सेक्शन है, वो है सेक्शन 8. Okay, take a look at this. Just 1 second. Something wrong with the documents. Just wait a minute. Just let me resume in 1 minute to get this problem fixed about the computer. तो यार आज के तो ठीक करके रख देते अगर इतनी इंपॉर्टेंट क्लास है तो।
सर वो इसका कोई
Okay, we are back. Sorry for the glitch here. The server was acting up a little bit. Okay, so this is what I'm in a way referring to. We are talking about Section 8 of the Representation of People's Act. Okay, so just let me redraw the whole story for you again from the start. There is Article 101 which talks about vacation of seats by an MP. Under what conditions can a seat be vacated? Now there are several grounds for vacation of seat, and one of them is by disqualification, that he can be disqualified. Then this ground of disqualification is further elaborated under Article 102, and then it has certain grounds which are given in the Constitution directly. For example, office of profit, for example, unsoundness of mind, undischarged solvent, and a citizen who's not in India, or a person who's not a citizen of India. Fifth ground which is given is Representation of People's Act 1951. Right, and the sixth ground, as pointed out by one of our friends over here, is anti-defection law under the 10th schedule. Okay, so I am taking the program from here, Representative People Act, and elaborating Section 8. And within Section 8 also, what I have to read is Section 8 subsection 3. Okay, and this is what I say. Section 8 of the Representation of People's Act, which you have to very clearly give a very good amount of weightage and gravity to, says that disqualification on conviction for certain offences. A person, or what you can call an MP, can be disqualified on conviction for certain offences. Okay. Disqualification on conviction of certain offences is basically the point which has been given to the what you can call disqualification conviction of certain offences. A member of parliament can be disqualified from the parliament if he is convicted for certain offences. Okay. Now take a look at this. Section 8 subsection 8 talks about all the offences. Whenever we talk about the conversation about the criminalization of politics, for example, if we are asking the question as to why is there a rising number of people in the parliament or in state legislative assemblies who have criminal backgrounds. So the power which has been given to the parliament under the constitution is to create the Representation of People Act 1951, and within that notify what are the laws which if you break you will not be allowed to contest elections, or if you have contested elections and have won and taken over the party or taken over the political leadership, then you will not be allowed to what you can call retain the seat of the member of parliament. Okay, let's say for example one of the laws which has been introduced in Section 8. Now, Section 8 is like a compendium in which all the laws, all the actions which are done by people which are breaking certain laws, let's say for example rape, murder, let's say loot, or outraging the modesty of a woman. If a person has been convicted and sentenced for any of these laws or any of these punishments or any of these criminal charges, he shall be disqualified from becoming a member of parliament. And that is what Section 8 subsection A does. It takes out, for example, let's say if anyone who has been imprisoned under Section 498A of the Indian Penal Code, which is offence of cruelty towards a woman by husband or relative or a husband, then a person who has been convicted and sentenced for this particular thing will be disqualified as an MP. Similarly, for example, the Protection of Civil Rights Act 1955. This is an act which governs untouchability. Okay, if a person is found to be convicted and sentenced for untouchability, if a person is found to be let's say in commission of untouchability, he will be disqualified from being a MP. If he is a sitting MP, he will be thrown out, and if he is electing or he is fighting the elections for becoming an MP, he will have to make sure that he will not be able to qualify for the elections of the member of parliament. Okay, that's the point which has been given over here. Now, in pursuit to that, what you basically mean to understand is that these are the sections of different laws. For example, the Commission of Sati Prevention Act, the Prevention of Corruption Act, the Prevention of Terrorism Act. If a person has been charged and he has been convicted in any of these, he will lose his seat. But you don't have to remember all these offences, just get a sense of what section 8 of the Representation of People's Act talks about. What you have to remember is section 8 subsection 3 of the Representation of People's Act. Now please, I invite you to read this part of the Constitution, of the Representation of People's Act, section 8 subsection 3 of the Representation of the People's Act. It says that a person convicted of any offence and sentenced to imprisonment for not less than 2 years, other than any offence referred to in subsection 1, shall be disqualified from the date of such conviction and shall continue to be disqualified for a further period of 6 years since his release. This is a point that I am trying to make emphatically again. Then let's say, for example, the case that we are dealing with currently is that there is a case of defamation, which under section 499 of the Indian Penal Code and 500 of the Indian Penal Code gives a maximum punishment of 2 years imprisonment, okay, and which has been given to the Member of Parliament in concern. Okay. Now what we see alongside that is that there is a section in the Representation of People's Act 1951, section 8 subsection 3, which says that if any person has been convicted of an offence in which the punishment, the imprisonment is of 2 years or more, that person is going to be what you can call disqualified from being a Member of Parliament. Right? Now you can maybe join the dots and complete this entire storyline. An FIR is registered against the Member of Parliament. The FIR is heard by a judicial magistrate first class, and the result of the FIR, the hearing, is that the person has been convicted for 2 years of imprisonment, the maximum punishment which can be granted under the law. In further, the Representation of People's Act section 8 subsection 3, which lists out the ground for disqualification as one of the grounds, which says that if a person is not, let's say, if a person is convicted or is imprisoned for a period of 2 years or more, then by that condition being fulfilled, he will be disqualified from being a Member of Parliament. Do you understand this? And that is basically how these two laws, section 499 and section 500 of IPC and section 8 subsection 3 of the Representation of People's Act, come together into effectuating the disqualification of the Member of Parliament from the Wayanad constituency in Kerala. Right? That's the point that we have to, in a way, keep in notice. Right? So you have, for example, the coming together of section 499 and a section 500 of the Indian Penal Code plus section 8 subsection 3 of the Representation of People's Act. Okay, and section 8 subsection 3 is driven by article 102 clause 1 clause E, which are grounds for disqualification made by Parliament under the Representation of People's Act. Right. So on one end, as soon as the Surat magistrate, the judicial magistrate first class, gives a 2-year imprisonment under the punishment of section 499 of the IPC, on the other end, the Lok Sabha Secretariat notifies the operation of section 8 subsection 3 and disqualifies the Member of Parliament from the House. Right? This is a circumstance which has led to the effectuation of this particular situation. Okay? So I feel that this has become somewhat clear to you. Now in the next course of action, what the Member of Parliament does is, the Member of Parliament takes an appeal of the judgment of the JMFC the Judicial Magistrate First Class, the judgment of the Judicial Magistrate First Class is taken by the Member of Parliament to the Sessions Court. In the form of an appeal. Appeal to suspend the conviction. And the Sessions Court of the Surat district has also agreed to the appeal made by the Member of Parliament and has agreed to suspend the conviction. The order of suspension of conviction will be released on 20th April 2023. Okay. The order of suspension of conviction has been granted by the Sessions Court, in which the Member of Parliament who was sentenced and convicted by the Judicial Magistrate First Class has been now released in a way. He has been declared to be not guilty under the defamation or whatever you is saying, and in a way it has reversed the order of the Judicial Magistrate First Class, but the details of the reversal of the order will be released to the public on 20th April 2023. Okay, so we have covered, for example, in the case of polity, 3 parts. One is Article 101, one is Article 102, Article 101 vacation, Article 102 disqualification, and within Article 102 you have Section 8, subsection 3 of the Representation of Peoples Act. Along with that, we have covered Section 499 and Section 500 of the IPC. This is an entire structure that you can memorize, reading directly from the Constitution and the Indian Penal Code. Any question which is coming from this can be answered directly by this kind of a reading. In further understanding, we talk about Article 103 of the Constitution in continuation with Article 102. Okay. Now, Article 103 of the Constitution states that if any question arises, okay, Article 103 of the Constitution states that if any question arises with regard to the disqualification of an MP under Article 102, if any MP is disqualified by the operation of Article 102 of the Constitution, then the Member of Parliament, if any Member of Parliament is disqualified by the operation of Article 103 of the Constitution, then the question which is arising out of that disqualification or about that disqualification shall be referred directly to the President of India. Okay, and the decision that the President will make in this regard shall be final. But there is one more proviso to that. The President, while he is making the decision, will refer the matter to the Election Commission, who will give the opinion to the President, and this opinion of the Election Commission shall be binding upon the President. Okay. So, I am getting a bit of a point across over here. What it means to say is that the government, which is the Lok Sabha Secretariat, which has given the order of notification of the suspension, the disqualification of the MP, if this order has to be raised as a question, if the MP wants to raise an appeal or a kind of a objection to this order, the authority for raising that objection is going to be the President of India, okay, under Article 103 of the Constitution. And the President, whatever decision he makes about the disqualification, whether it is correct or incorrect, agreeing with it or disagreeing with it, will then be making the final decision upon the matter. There is no other authority which can make a decision on the matter except the President of India. But the decision of the President of India can be taken only with consultation of the Election Commission of India. The President of India must seek the opinion of the Election Commission of India, and the President of India must be bound by the opinion of the Election Commission of India. So, in all said and terms category, If a question comes like this, that which of the following constitutional bodies has the final authority in terms of deciding a question with regard to disqualification of an MP? The answer would be President plus the Election Commission of India. Okay, President will take the final decision, but he would be bound by the opinion of the Election Commission of India. Okay, do we understand this? Right? So this is what we are talking about in terms of what is going to be the constitutional provisions that you have to understand with reference to the terms that we are taking a look at in Article 101, vacation of seats, Article 102, the what you can call Article 101, vacation of seats, Article 102, disqualification of member of parliaments, and Article 103 is what we call the powers of the President to refer the last questions for his disposal with the opinion of the Election Commission of India. These are articles that you can take a look at in tune with all of this. Just adding the last bite to this entire thing so that our current affairs upon this matter are full, square and complete. Take a look at this. Section 8, subsection 4. Okay, now this is where I want to introduce a judgment by the Supreme Court which has been in the news recently. This judgment is Lily Thomas versus Union of India, 2013. Lily Thomas versus Union of India, section 8, subsection 4. Now, just briefly go through the articulation of section 8, subsection 4 of the Representation of People's Act. Section 8, subsection 4 of the Representation of People's Act stated that if any person who has been disqualified as an MP because he has been punished for a period of at least 2 years of imprisonment as mentioned under section 8, subsection 3, then if he files an appeal within 3 months of such sentence, if he files an appeal within 3 months of such sentence, he shall be liable to get his disqualification annulled by the way of him filing an appeal. कहने का अर्थ ये है कि अगर मान लीजिए कि मैं एक मेंबर ऑफ पार्लियामेंट हूँ और मेरे को सेक्शन 8 सबसेक्शन 3 की कंडीशन के तहत डिस्क्वालीफाई कर दिया गया क्योंकि जो मुझे इम्प्रिजनमेंट मिला है वो 2 साल का या 2 साल से अधिक है, लेकिन कम से कम 2 साल का अधिक चाहिए मुझे, ठीक है। अब मान के चलिए कि सेक्शन 8 सब सेक्शन 4 के अनुसार मैंने अगर उस इम्प्रिजनमेंट के विरोध में अगर अपील दायर कर दी है किसी भी कोर्ट में 3 महीने के अंदर उस कन्विक्शन आने के, तो मेरे जो डिस्क्वालिफिकेशन है उसको कैंसिल कर दिया जाएगा, भले ही वो अपील डिसाइड हुई हो चाहे ना हुई हो, वेदर कोर्ट अहेड और हायर would have given me any kind of a relief or not. Regardless of that, just by the fact that I have drafted and filed an appeal in a higher authority will make me immune from getting disqualified from the parliament under section 8 subsection 3. This is what is meant in section 8 subsection 4. Please take a look at this section. पढ़िए एक बार इस सेक्शन को. Right? It says that a disqualification shall not take place until 3 months have elapsed from the date. Okay, you understand the point? Now, this obviously section 8 subsection 4 of the Representation of People's Act is obviously a draconian kind of a thing. It's absolutely defeating of the spirit of the non-criminalization of politics. And what the Supreme Court received in 2013 was a PIL by a person called Lily Thomas, an advocate in the Kerala state. Lily Thomas filed a PIL with the Supreme Court asking the Supreme Court to declare section 8 subsection 4 as unconstitutional. And in this very case, Lily Thomas versus Union of India, again remember the name of the case, it has been in news ever since the controversy about the MLA being disqualified is happening. In this particular news, the government, the Supreme Court has struck down the section 8 subsection 4 of the Representation of People's Act, calling it ultra vires, saying that the Parliament does not have the competence or the authority to make a law like this. Okay, so in today's date, section 8 subsection 4 of the RPA stands invalidated, unconstitutional as declared by the Supreme Court. Now, one of the things that happened with regard to this entire development was in 2013, when the Supreme Court gave the judgment striking down this particular law, then the Manmohan Singh government wanted to, in a way, give this kind of a law a kind of a extension. There was a case about the case of Lalu Prasad Yadav in the fodder scam, in which he had filed an appeal, but he was not able to get out of the jail because of the section 8 subsection 3 of the RPA being declared unconstitutional. So the Manmohan Singh government had brought an ordinance to remedy the actions done by the Supreme Court. And what the MP from Wayanad had done was, he had taken the ordinance in the public domain in the media briefing, and he had torn the ordinance publicly and thrown it out, which was a kind of a very kind of a very spectacular kind of a thing that was a part of that particular kind of politics, and it's coming up for the repetition now also. Now the point that is being made in the media a long time is that if the Member of Parliament from Wayanad had not tore up that notification ordinance, and if the government would have been able to place that ordinance, then today he would have been able to prevent his disqualification, because he would have been covered under the immunity provided under section 8 subsection 4. That is the reason this entire saga was coming in the news again and again, of the Member of Parliament tearing up the documents. And also maybe you must have heard about this kind of a thing, that if those ordinance would have been placed, he would not have probably lost the membership in the Parliament. Okay, but currently, as we have seen, that the Surat court has given, Sessions Court has given some relief to the person, and therefore you can see some kind of a thing. But nonetheless, this court judgment is going to be taken to appeal by the government again to higher authorities, or by the petitioner against to higher authorities, and the appeal, etc., will be moved around on that. So this is going to move from one court to another in a matter of appeal, until there's a kind of a political settlement of the issue, which is the main condition of the dispute. Okay. Right, let me take up the questions from here. Okay, give us some glimpse about the office of Secretariat of Parliament. Okay, I'll take up some parts about the Lok Sabha and the Rajya Sabha Secretariat. Also with reference to the Lily Thomas case of the Union of India, we can take a look at the recent activities which are happening with regard to the Lok Sabha Secretariat, which is in the news. Okay, do section 8 apply for MLA? Yes, MPs and MLAs alike. Is there judicial review for President's order? Yes, there's a judgment by the Supreme Court in which it has said that the judiciary can review the President's order, but nonetheless the Constitution says that the President's order shall be final. So judiciary does not have a lot of room, but nonetheless in extreme cases of incongruency, judiciary can interfere in the matter and pass a review upon this. Samiksha Devi Singh, so which means that President's decision pending in case of the recent disqualification of the MP? No. Interestingly, the recent MP of disqualification has not filed a question before the President as of yet. He has not reached out to the President. But the reason that I'm teaching you this is that he may perhaps reach out to the President. And if he doesn't reach out to the President, UPSC certainly will maybe want to ask a question in this regard. Okay, a disqualified member can become a member of Rajya Sabha? No, he cannot become a member of Rajya Sabha. A member of Parliament who is disqualified for any of these things become eligible for any kind of movement into the Parliament, either with elections or with nominations. Okay, clear? right? So here we have taken a look of complete clarity of the things which are happening in one of the most interesting cases which is developing in the current affairs. Okay, I'll repeat it again. What all you have to read directly from the Constitution to take a revision of this. Okay, first thing that you take is Article 101, vacation. 102, disqualification. 103, questions to be addressed to the President. Okay, and the President's address to be taken a look at by the Election Commission, whose decision, whose opinion on the President's address shall be final. Okay. Take a look at Article 103 of the Constitution just for your own self. Article 103 says, a decision on questions as to disqualification of members. If any question arises as to whether a member of either House of Parliament has become subject to any of the disqualifications mentioned in Clause 1 of Article 102, the question shall be referred for the decision of the President and his decision shall be final. This is Article 103, Clause 1. Okay? And Clause 2 of 103 says, before giving any decision on any such question, the President shall obtain the opinion of the Election Commission and shall act according to such opinion. Okay? ठीक है? Clear. So this is one part that we have taken clearly a look at. Now the next current affair that I wanted to deal with, again a very interesting development of events in the polity paper, is the anti-defection law, right? Anti-defection law. Okay, so let me give you a brief sense of how to collect the literature upon it. Under Article 102, we have seen the grounds for disqualification. And one of the last grounds, in fact, the last ground for disqualification under Article 102, Clause 2 is what is known as anti-defection, or what is known as the 10th schedule. Okay, let's take a look at it in the Constitution. If you go to Article 102, Clause 2, you see that the 10th schedule of the Constitution has been mentioned under Article 102, Clause 2. A person shall be disqualified for being a member of either House of Parliament if he is so disqualified under the 10th schedule. Right? This we have taken a clear look at. Okay. Now, Sangamitra, disqualification rules are same for Council of Ministers too. Council of Ministers are necessarily supposed to be member of Parliament. Okay, and therefore, if you're not a member of Parliament, you cannot be a Council of Minister. So what it entails is that a Council of Minister cannot be disqualified as a Council Minister, but if she loses to be a member of Parliament, she cannot be a Council Minister, right? So it, in a way, the answer to your question is yes. Okay, and no precedent switch involved in that. A person shall be disqualified for being a member of either House of Parliament if he is so disqualified under the 10th schedule. This was not there in the original Constitution. This was added into the Constitution by the 52nd Constitution Amendment Act 1985. Please take a note of this. 10th schedule plus Article 102, Clause 2, plus Article 191 Clause 1 for the state legislatures, this was added in the Constitution by the 52nd Amendment Act 1985. Right, this was the Rajiv Gandhi government which had added the 10th schedule plus 102 clause 2 plus 191 clause 1 in the 10th schedule of the Constitution. Right, now the question that we are in a way basing ourselves to understand is that what is the nature of anti-defection law, for which we'll have to take a reference to the 10th schedule. This is the 9th schedule. Here, take a look at 10th schedule, and slowly and steadily we'll cover some important paragraphs of 10th schedule, and then I'll start developing a set of current affairs which are relevant in terms of understanding important recent developments about anti-defection. The case that I'll be dealing with is the Maharashtra government, MLAs moving from one political party to another political party, etc., etc. So this is what we can take a look at in terms of that. Right, take a look at this. Paragraph 2 of the 10th schedule says that disqualification of an MP on the grounds of defection. Okay, paragraph 2 of the 10th schedule lays out the grounds upon which a MP can be disqualified if he has committed a kind of a defection. Defection simply moves Ayaram Gayaram, which basically means that if a person is moving from one political party to another political party, this kind of a thing is known as defection. And in 1985, the movement of a person from one political party to another political party, which is going to be a kind of a movement of opportunism. Let's say, for example, if I am a person who becomes a member of parliament from one political party, let's say from BJP, but whilst I'm inside the parliament having won from the BJP ticket, I move my allegiance from one political party to another political party, then what I have done is defection. And under schedule 10 paragraph 2 paragraph 4, the movement of me from one political party to another political party is a event of defection, which is a ground or ground for disqualification. Okay. Just can we just take a break for just 5 minutes? There's a technical thing that may need addressing. 5 minutes. 5 minutes we resume again. Just got a message. Please wait for 5 minutes and we'll be back again. Okay, I hope we're back. Right. Okay, so here we are. We're taking a look at the disqualification on the ground of defection. Okay. Now, under the, let me just point it out properly. The 10th schedule is what is known as the anti-defection law. As we have seen that it has been added into the Constitution by the 52nd Constitution Amendment Act. Anti-defection law, the 10th schedule, right? Now, when we talk about the 10th schedule, what we see is it is divided into paragraphs. And we talk about paragraph 2. Paragraph 2 defines 2 conditions under which an MP can be disqualified if he has defected. 2 conditions which can be considered under the definition of defection. Okay, under the 10th schedule. Okay, 2 conditions. First condition is that if a member of Parliament voluntarily gives up membership of the political party. If he voluntarily gives up membership political party from which he entered the house. Okay, this is the first ground or condition for disqualifying someone of having committed defection. Second is, he may not voluntarily give up the membership, but he acts in contradiction to. The line, or let's say for example, the position of his political party. Position of his political party in voting behavior. These are the 2 grounds, only 2 grounds, which are considered to be what you can call the conditions under which defection can be ascertained, that a person has committed defection. Paragraph 2 of the 10th schedule. एक तो कि अगर कोई व्यक्ति अपना खुद का मेंबरशिप छोड़ देता है जानबूझकर, तो उसको डिफेक्शन के अंदर पार्लियामेंटेरियन के पोजीशन से डिस्क्वालीफाई कर दिया जाएगा. और दूसरा, वो वॉलंटरीली एक्सप्लिसिटली अपनी मेंबरशिप नहीं छोड़ता है, ठीक है, लेकिन वो वोट देता है इस तरह से कि अपनी पार्टी की जगह दूसरी पार्टी को फ़ायदा दिलाने के लिए वोट देता है. जैसे मान लीजिए कि अगर मैं भारतीय जनता पार्टी से मेंबर ऑफ पार्लियामेंट बन के आया और कांग्रेस ने मुझे बोला कि आप हमारे साथ आ जाइए, आपको जो भी मतलब पोजीशन है या जो भी पावर है वो दे देंगे. अब मैं बोलता हूँ कि मैं वॉलंटरीली मूव करूँगा तो मैं डिफेक्शन के अंदर लपेटा जाऊँगा. तो मैं क्या करता हूँ कि भारतीय जनता पार्टी के अंदर रह के मैं भारतीय जनता पार्टी जिन मुद्दों पर वोट देना चाहती है, मैं उनको छोड़ के कांग्रेस जिन मुद्दों पर वोट देना चाहती है या जिस पोजीशन पे वोट देना चाहती है, मैं उसके साथ खड़ा हो जाऊँगा. तो भले ही मैंने औपचारिक रूप से अपनी जो मेंबरशिप है वो चेंज नहीं करी है, लेकिन मेरे एक्शन से ये प्रतीत होता है कि मैं दूसरी पार्टी का जो है वो समर्थन ज़्यादा कर रहा हूँ अपनी पॉलिटिकल पार्टी से. तो अगर इस तरह का कोई बिहेवियर मेरे उसमें दिख गया एक्शंस में, तो मुझे डिफेक्शन के अंदर डिस्क्वालीफाई कर दिया जाएगा. दिस इज गिवन अंडर पैराग्राफ 4. Yes, as Raksha is pointing out, against the whip of the political party. The whip of the political party in a, what you can call parliament is, or any kind of a legislature, is basically a person who is supposed to be appointed by the political party, who is supposed to keep the entire political party in one group, and they have to vote for only one position. ऐसा नहीं हो सकता कि एमपी अलग अलग वोट करें सब लोगों को. तो अगर एमपी ने अलग अलग वोट करना शुरू किया, पॉलिटिकल पार्टी लाइन से उसके मतलब प्रतिकूल वोट नहीं किया, तो फिर जो आपका पॉलिटिकल पार्टी का जो विप है वो आपको एक तरह से वार्न कर सकता है कि हम आपको डिफेक्शन के अंदर डिस्क्वालीफाई करा सकते हैं। और अगर आप इस पॉलिटिकल पार्टी के विप की बात नहीं मानते हो तो इवेंचुअली आप डिस्क्वालिफिकेशन आप डिफेक्शन के अंदर डिस्क्वालीफाई हो सकते हो, क्योंकि आप देख सकते हैं कि ग्राउंड दूसरा यही है। अगर आप एक बार इसको पढ़ना चाहें तो पढ़ लीजिए। If you want to take a look at this, please take a look at this now. Disqualification on the ground of defection. Okay. If he votes or abstains from voting in such house contrary to the direction issued by the political party to which he belongs, then such person shall be liable to lose his seat on the basis of defection. अगर अपनी पॉलिटिकल पार्टी के कॉन्ट्रेरी पोजीशन पे वो वोट करता है तो उसको डिफेक्शन के अंदर लपेटा जा सकता है। ठीक है, चलिए, ये तो हो गया आपका पैराग्राफ 2 विच इज ग्राउंड्स फॉर डिफेक्शन। जल्दी जल्दी रिवाइज करना है इस चीज़ को। उसके बाद हम देखते हैं कि क्वेश्चन ये कि अगर इतने स्ट्रिक्ट ग्राउंड फॉर डिफेक्शन दे रखे हैं कॉन्स्टिट्यूशन के अंदर, इफ देयर आर वेरी क्लियर लेट्स से प्रोविजंस मेड टू स्टॉप डिफेक्शन विद इन द कॉन्स्टिट्यूशन ऑफ इंडिया, व्हाई इज इट दैट डिफेक्शंस हैपन सो ऑफ्टन? व्हाई इज इट दैट देयर इज सो मच ऑफ अ मूवमेंट of MLAs from one party to another party? Especially at the state legislative assembly, we hear this almost every month with some state legislative assembly that MLAs are moving from one particular political party to another political party, right? The answer to that question is the exemptions which are given with regard to the defection. The answer to that is the exemptions which are given regarding defection in paragraph 4 and paragraph 5. So we'll take a look at paragraph 4 of 10th schedule. ठीक है, पैराग्राफ 4 में एक एक्सेप्शन दे रखा है कि कहां पर अगर कोई पॉलिटिकल पार्टी का एक व्यक्ति दूसरी पॉलिटिकल पार्टी में जाता है तो उसको हम डिफेक्शन नहीं मानेंगे, मतलब उसको डिफेक्शन के अंदर हम डिस्क्वालीफाई नहीं करेंगे। ये एक्सेप्शन है। और जो भी ये मूवमेंट होते हैं एमएलएस के एक पॉलिटिकल पार्टी से दूसरे पॉलिटिकल पार्टी की तरफ, वो इसी दौरान और इसी एक्सेप्शन के अंदर होते हैं। तो आप इसको समझिए ज़रा, मैं आपको समझाता हूँ इस चीज़ को बोर्ड पे। पैराग्राफ 4 में लिखा हुआ है कि मान के चलिए कि ये एक पॉलिटिकल पार्टी है, ठीक है। इस पॉलिटिकल पार्टी के मान के चलिए 60 मेंबर ऑफ पार्लियामेंट्स हैं, 60 एमएलए हैं सदन के अंदर, ठीक है। अब पैराग्राफ 4 में लिखा है कि अगर आप अगर आप 60 के अंदर में से 2/3, इफ यू कैन टेक 2/3 members of the legislative assembly from the political party and make those 2/3 members join another political party, ठीक है। जैसे मान लीजिए ये है पॉलिटिकल पार्टी नंबर 2 और ये है पॉलिटिकल पार्टी नंबर 1। अब इसमें क्या हुआ कि इस पॉलिटिकल पार्टी नंबर 1 के जो 60 एमएलए थे, इसमें से from 60 MLAs in this political party, 2/3 of MLAs from this political party move from PP1 to PP2. If it is at least a number of what you can call, if it at least a number of what you say the political party moving from one political party to another political party, if it is at least 2/3 of the MLAs, then it will not be subject to defection। ये बात है कहने वाली जो हम कहना चाह रहे हैं, ठीक है। अगर एक पॉलिटिकल पार्टी से दूसरी पॉलिटिकल पार्टी में 2/3 लोग चले जाते हैं, 2/3 ऑफ द नंबर ऑफ इलेक्टेड रिप्रेजेंटेटिव्स इन अ हाउस, दोज रिप्रेजेंटेटिव्स ओनली, इलेक्टेड रिप्रेजेंटेटिव्स, अनइलेक्टेड रिप्रेजेंटेटिव्स का कोई दायित्व, कोई उनका अस्तित्व नहीं होता पॉलिटिकल पार्टी के सिस्टम में, ठीक है। तो अब अगर पॉलिटिकल पार्टी के 2/3 मेंबर यहां से वहां चले जाते हैं तो उसका जो पैराग्राफ 4 में नाम दे रखा है उसे कहते हैं मर्जर, और मर्जर इज गिवन एज एन एक्सेप्शन अंडर पैराग्राफ 4 ऑफ द 10th schedule. So for example, if a question comes, what are the essential conditions for merger under the anti-defection law? You can see the essential condition for merger is a 2/3 of 60. A question can come, which of the following is a valid ground for exempting yourself from getting defected? Then you can give merger as the correct answer. Paragraph 4 talks about merger. and merger implies that 2/3 of the legislative assembly members move from political party 1 to political party 2. अगर 2/3 से कम है तो फिर वो डिफेक्शन का लॉ लगेगा, लेकिन अगर आपने 2/3 की संख्या टच कर ली है, उससे ऊपर जा रहे हैं, तो डिफेक्शन के लॉ से आप एग्जेम्प्ट हो सकते हैं. इसका अर्थ है कि जो हम देखते हैं कि एक पार्टी से जो दूसरी पार्टी में डिफेक्शन हो रहा है, और उसमें जहाँ पर भी आपको लगता है कि जैसे बिहार में होता है, कर्नाटक में होता है, गोवा में होता है, जहाँ पे एमएलएस कई महाराष्ट्र लेजिस्लेटिव असेंबली में या फिर जैसे गोवा के लेजिस्लेटिव असेंबली में एक पॉलिटिकल पार्टी के 5 एमएलए हैं, तो 5 का 2/3 कितना होता है, उतने चले गए, 3 एमएलए चले गए, तो उससे भी बात बन जाती है. ठीक है, तो ये इस तरह से आप एक जो एंटी डिफेक्शन लॉ है उसको एक तरह से बाईपास करके पॉलिटिकल पार्टी के चेंजेस को कर सकते हैं. और इसी पॉलिटिकल पार्टी के चेंज के हिसाब से पीपल आर मूविंग फ्रॉम वन पॉलिटिकल पार्टी टू अनदर पॉलिटिकल पार्टी. क्लियर? दैट्स द पॉइंट दैट आई वांट टू ले अ लिटिल बिट फोकस अपॉन. ठीक है, सो दिस इज व्हाट इज गिवन इन पैराग्राफ 4. उसके अलावा जो हम बात करते हैं वो है पैराग्राफ 5 की. पैराग्राफ 5 में एक और एक्सेप्शन दे रखा है. पैराग्राफ 5 में एक और एक्सेप्शन दे रखा है इसका, डिफेक्शन का. पैराग्राफ 5 कहता है कि मान लीजिए अगर कोई स्पीकर है और स्पीकर के ऊपर आरोप लगता है पक्षपात करने का. इफ दिस एन एलिगेशन ऑफ अ स्पीकर और अ चेयरमैन ऑफ द राज्यसभा और द स्पीकर ऑफ द लोकसभा, इफ the speaker or the chairman of the Lok Sabha Rajya Sabha is under the allegation that he is being, let's say, in favor of the ruling party from which he is coming, that to prove himself as non-partisan, one of the methods by which he can prove himself as non-partisan is by resigning from the political party that he is a member of. एक statement होता है ना, once a speaker always a speaker. So one way in which he can prove his allegiance to non-partisanship is that he can resign from the political party in the duration of which he is a speaker. Now, paragraph 5 of the 10th schedule says that as long as a speaker is a speaker or holding the office of a speaker, and if he resigns from a political party, this resignation or voluntarily giving up the membership of political party does not amount to defection. He will not be disqualified from the house because of defection, provided that once the speaker is completed his duration, he joins back the same political party from which he entered into the house. एक बार स्पीकर अपना जो सत्र है वो खत्म कर लेता है तो उसके बाद उसको उसी पॉलिटिकल पार्टी का हिस्सा बनना पड़ेगा जिससे वो निकल कर आया था, जिससे वो सदन के अंदर आया था. अगर वो किसी और पॉलिटिकल पार्टी का हिस्सा बन जाता है तो उसको डिस्क्वालीफाई किया जा सकता है. तो ये 2 एक्सेप्शंस है. अब आप बहुत सिंपल तरीके से इसको याद कर सकते हैं. आर्टिकल 102 क्लॉज 2 में 10th शेड्यूल का मेंशन किया गया है. 10th शेड्यूल में पैराग्राफ 2 है ग्राउंड्स ऑफ डिफेक्शन, 2 ग्राउंड्स हैं. पैराग्राफ 4 में एक्सेप्शन टू डिफेक्शन है. पहला एक्सेप्शन जो मर्जर का एक्सेप्शन था मैंने आपको बता दिया 2/3 वाला, और उसके अलावा जो दूसरा एक्सेप्शन है वो है स्पीकर का एक्सेप्शन पैराग्राफ 5 में. ठीक है, इसके अन्यथा the next point about it we will take a look at paragraph 6 of the anti defection law. paragraph 6 of the anti defection law says कि अगर मान लीजिए डिफेक्शन के रिलेशन में अगर कोई भी प्रश्न उठता है कि किसी का डिफेक्शन की जो प्रोसीडिंग्स है वो सही हुई है कि गलत हुई है, अगर डिफेक्शन के बेसिस पे किसी के ऊपर भी प्रश्न उठता है कि किसी व्यक्ति का डिफेक्शन सही है या गलत है, तो उस प्रश्न का जो फाइनल उत्तर है वो स्पीकर देगा और स्पीकर का डिसीजन फाइनल होगा. This is what article paragraph 6 says, that any question which arises with regard to a matter of defection shall be referred to the speaker whose decision shall be final. But the Supreme Court has in what is known as the Nabam Rabia judgment, the Supreme Court has in the Nabam Rabia judgment held that the Supreme Court has in the Nabam Rabia judgment held that the powers of judicial review of the Supreme Court cannot be ruled out by paragraph 6. तो मतलब अगर स्पीकर का डिसीजन सही नहीं है तो सुप्रीम कोर्ट उसके अंदर जुडिशियल रिव्यू की पावर असर्टेन कर सकता है। ठीक है, ये नाबम रेबिया का जजमेंट है। आपके प्रीलिम्स के लेवल पे क्वेश्चन आ सकता है क्योंकि ये सारी चीज़ें न्यूज़पेपर में बार बार पाई जा रही हैं। एक बार आप पैराग्राफ 6 पढ़िए। पैराग्राफ 6 में यू विल गेट अ सेंस ऑफ व्हाट इज रिटन। Or any question arises as to whether a member of a house has become subject to disqualification under this schedule, the question shall be referred for the decision of the chairman, or as the case may be, to the speaker of such house, and his decision shall be final. ठीक है, ये प्रश्न है कि अगर किसी भी तरह किसी भी क्वेश्चन को मतलब अगर देखा जाए तो अगर किसी व्यक्ति का जो डिसीजन है डिस्क्वालिफिकेशन का अगर वो चैलेंज होता है तो उसका जो डिसीजन है वो स्पीकर ले सकता है। ठीक है, और इसी के साथ मैंने आपको बताया कि सुप्रीम कोर्ट का जजमेंट है नाबम रेबिया में, जिसमें कि सुप्रीम कोर्ट में जुडिशियल रिव्यू एक्सरसाइज कर सकता है। तो ये क्वेश्चन आ सकता है आपके सामने कि क्या इसमें हो रहा है। तो मैं एक बार दोबारा से आपके सामने अलाइन कर देता हूँ चीज़ें। आर्टिकल 101, आर्टिकल 101 डिफेक्शन, एंटी डिफेक्शन, आर्टिकल 102 क्लॉज 2, 52nd कॉन्स्टिट्यूशन अमेंडमेंट एक्ट 1985, 10th शेड्यूल, उसमें हमने देखा पैराग्राफ 2 है which is about the grounds for defection. ठीक है, उसके बाद पैराग्राफ 4 बात करता है, what does paragraph 4 talk about? The exemption of defection which is merger and the condition for merger is 2/3. और पैराग्राफ 5 बात करता है exemption कि स्पीकर या चेयरमैन अपना त्यागपत्र, चेयरमैन तो त्यागपत्र नहीं दे सकता क्योंकि वाइस प्रेसिडेंट है, बट स्पीकर कैन गिव हिज रेजिग्नेशन फ्रॉम पॉलिटिकल पार्टी. And 6 is the power of the speaker or the chairman to take the final decision on the matters with regard to defection. ठीक है, this is something that we'll take a clear understanding of in terms of what is it. हाँ, तो the Holohan case है जो, that is exactly also the same case in which the Supreme Court has said that the powers of the speaker under paragraph 6 of the anti-defection law are subject to judicial review. Power of the speaker cannot be a singular power which has no amount of review by the judiciary. तो यही बोला था इस वाले केस में. ठीक है, तो वो नाबम रेबिया और दोनों का जजमेंट का जो रेशियो डिसिडेंडा है, the essence of this both the judgments is exactly the same. ठीक है, चलिए अब ये वाला हमारा एंटी डिफेक्शन का पूरा सिस्टम खत्म हो चुका है. तो हम अब एक जो करंट अफेयर है उसमें थोड़ा सा इसको ब्लेंड करके देख लेते हैं. ठीक है, जो करंट अफेयर हम कवर करेंगे यहाँ पर वो होगा शिवसेना की जो महाराष्ट्र में सरकार बनी है उसके ऊपर आधारित. ठीक है, तो आप थोड़ा ध्यान के दीजिएगा. इससे 2-3 चीज़ें जो हम समझ के कवर कर सकते हैं. क्वेश्चन आ सकता है इससे प्रीलिम्स में किसी तरीके का, क्योंकि इसमें एंटी डिफेक्शन के कुछ प्रोविजंस लगे थे और सुप्रीम कोर्ट के पास मैटर गया था. तो इट इज़ मतलब रीजनेबल दैट वी कैन कवर इट इन सम सेंसेस. ओके, यहाँ पर ज़रा देखिए, इन चीज़ों को हम लगा के थोड़ा सा वी कैन टेक अ लुक एट व्हाट इज़ बेसिकली हैपनिंग विद द रेलेवेंस ऑफ द एंटी डिफेक्शन लॉ इन डिफरेंट क्वार्टर्स. जो आप ये सामने देख रहे हैं 2019 के महाराष्ट्र जो लेजिस्लेटिव असेंबली उसके चुनाव के रिजल्ट्स हैं. ठीक है, तो यहाँ पर देखिए कि भारतीय जनता पार्टी को 2019 में 105 सीटें मिली, शिवसेना को 56, नेशनलिस्ट कांग्रेस पार्टी एनसीपी जो शरद पवार की पार्टी उसको 54, and the Indian National Congress got 44 seats, 105, 156, 54 and 44. And then there is independent party candidates who got 13, and you have other parties which got some singular seats, etc., etc. ठीक. Now the question is this: the majority needed to make the government in Maharashtra is, I'm not sure about the exact number, but it is something about 145. कि आपको 145 सीट्स चाहिए. There are 145 seats that we need for forming the government in Maharashtra, but no one single party has a clear majority of forming the government in Maharashtra. Okay. Now, the 2019 elections end up creating a coalition government between these three parties. Shiv Sena with the highest number of seats within the coalition, then followed by the Nationalist Congress Party, and then the Indian National Congress. These three parties come together to form a coalition government. And the Shiv Sena, Uddhav Thackeray, becomes the chief minister of the coalition government. I'm sure at this point of time I don't need to explain to you the what you can call the effects, or the what you can call the exigencies of what is known as a coalition government, right? तो यहाँ पर इन लोगों ने कोalition government डिक्लेयर करी अपने साथ, एक दूसरे के साथ, और इस कोalition government के आधार पर जो कि इस coalition government के आधार पे they formed the government, मतलब they claimed the roots of the government. Now what happens is that in Maharashtra, in Shiv Sena, which has 56 MLAs, Shiv Sena starts dividing into two factions. एक तरह से शिव सेना के दो टुकड़े होने लगे. One was known as the Uddhav Thackeray faction, and the other was known as the faction on the name of the current chief minister. एक तरह से शिव सेना के अंदर भिड़ंत होने लगी. There's by kind of a kind of a division of political party lines started erupting within the Shiv Sena, right? Now, when this kind of a thing was happening, then it was noticed that about 40 MLAs from Shiv Sena, along with Eknath Shinde faction, had moved from Mumbai to Guwahati, and they had locked all these 40 MLAs in a resort in Guwahati. Okay? Now, this is basically that people were now speculating that the 40 MLAs from Shiv Sena are now going to form government with the BJP and withdraw their membership from the Shiv Sena. ठीक है. तो looking at this kind of a movement, जब शिव सेना को लगा कि उनके 40 MLA बस में बैठ के गुवाहाटी फ्लाइट लेके गुवाहाटी चलेगा, गुवाहाटी में एक रिजॉर्ट में बैठे हुए हैं, they got a very clear indication that the 40 MLAs are going to leave Shiv Sena. As soon as they started moving away from the center, which is Mumbai, the political leader of Shiv Sena in the Vidhan Sabha of Maharashtra, he invoked the powers of the speaker under paragraph 5. Under paragraph 6 of a 10th schedule, he wrote a letter to the speaker saying that they should be disqualified. Okay, so the 40 MLAs, including Eknath Shinde, were disqualified by the speaker. What was the ground of disqualification? Paragraph 2, voluntary giving up of membership. इस बेसिस से स्पीकर ने डिस्क्वालिफिकेशन का ग्राउंड दे दिया. ठीक, ध्यान से सुनिएगा इस चीज़ को, बहुत रोचक चीज़ है, आपको समझ में आ जाएगी एक बार. इससे प्रीलिम्स के क्वेश्चन बन जाएंगे आपके आराम से, क्योंकि इस ताने बाने में कॉन्स्टिट्यूशनल प्रोविजंस का यूज़ होता है और इस तरह से आप याद भी कर सकते हैं आसानी से. ठीक, तो अब क्या होता है, 40 MLA जो हैं वो यहाँ से चल जाते हैं और स्पीकर उनको डिस्क्वालीफाई कर देता है, स्पीकर डिस्क्वालिफिकेशन के पेपर साइन कर देता है. नाउ व्हाट हैपेंस इज, नेक्स्ट स्टेप इज दैट एकनाथ शिंदे, who is the leader of the what is known as the rebel MLAs, he reaches out to the Supreme Court और सुप्रीम कोर्ट को वो नाबम रेबिया जजमेंट के अंदर अपील करता है कि सुप्रीम कोर्ट स्पीकर के ऑर्डर पे स्टे लगा दे. Supreme Court should put a stay upon the order of the speaker. Okay, this is what the Eknath Shinde faction goes and says to the Supreme Court. जब Supreme Court उसने प्रश्न पूछता है कि आप डिस्क्वालिफिकेशन में क्यों नहीं आते, तो एकनाथ शिंदे बोलता है कि जो पैराग्राफ 4 है उसके अंदर जो एक्सेप्शन दे रखा है उसके अनुसार हमारे पास 2/3 ऑफ 56 हैं और हम इन 2/3 को लेके भारतीय जनता पार्टी का पार्ट बनना चाहते हैं, और अगर हम ऐसा करते हैं पैराग्राफ 4 के अंदर तो दिस विल नॉट अमाउंट टू डिस्क्वालिफिकेशन. राइट, दिस इज क्लियर टू यू? दैट इफ द गवर्नमेंट, if the paragraph 4 is read, 2/3, 40 out of 56 is certainly higher than 2/3. If they move from one political party to another political party, then under the provisions of merger, they cannot be disqualified from the position of the member of legislative assembly. Clear? So Supreme Court के पास जाके बोलता है कि please stay our disqualification because we are moving from one place to another under a provision of law and we will not be subject to disqualification under 10th schedule, marking the exception under paragraph 4 of the 10th schedule. Okay? Supreme Court उनकी बात मान लेता है. Supreme Court बोलता है कि आप ठीक कह रहे हैं, आप अगर आपके पास 2/3 मेजॉरिटी है तो आप डिस्क्वालिफिकेशन में नहीं आएंगे, और सुप्रीम कोर्ट जो स्पीकर का जो वो होता है डिसीजंस उस पर स्टे लगा देता है और उनका डिस्क्वालिफिकेशन रद्द कर देता है. लेकिन उसके बाद सुप्रीम कोर्ट एक और चीज़ करता है. सुप्रीम कोर्ट उनको बोलता है, महाराष्ट्र लेजिस्लेटिव असेंबली के लोगों को, महाराष्ट्र के गवर्नर को वो एक तरह से ऑर्डर देता है कि अभी तुरंत की तुरंत प्लीज कंडक्ट अ फ्लोर टेस्ट. Floor test is a kind of a what you can call a no confidence motion. Okay. Now, let's say for example, if the floor test is to be conducted, he said that without wasting any time, as soon as possible, please conduct a floor test. Floor test का मतलब होता है, let's say in the government you have 56 from Shiv Sena, 54 from NCP, 44 from Indian National Congress and let's say 105 from BJP. ये मान लीजिए this is the composition of your Maharashtra Legislative Assembly. Out of this, let's say if 56 members, out of 56, 40 are of the rebel faction. मतलब they don't want to stand the ground of the political party. But the curious thing is this, that if you read, for example, paragraph 2, it says that if a member of a political party votes contrary to any direction issued by the political party to which he belongs, then he can be suspended for disqualification. Okay? You get the point? So, in this sense, let's say for example, if all these people have gathered in front of the Maharashtra Legislative Assembly Speaker, and these are political parties, let's say if 40, अगर जैसे मान के चलिए कि इनसे पूछा जाए कि क्या आप उद्धव ठाकरे की सरकार को समर्थन देते हैं कि नहीं, 44 MLAs over here are asked the question, do you give the what you can call the support to the Uddhav Thackeray government? Okay, If that kind of a question is asked of these MLAs, they would say yes, we give support. Fine. So 44 MLAs recorded Indian National Congress. Then the 54 MLAs from the National Congress Party are asked the question, do you give the support to the Uddhav Thackeray government? And they say yes. Okay. So you have these number of MLAs from the National Congress Party. Okay. Now, if the Shiv Sena is asked a question, do all of your 56 members vote in support of the Uddhav Thackeray government? Let's say if these 40 rebel MLAs says that we don't vote and only 16 are left in support of the government, then it is possible that the government will have a no confidence, right? The government will not be able to demonstrate its confidence. The figure of 145 cannot be achieved and the government will possibly fall. But the trick over here is this, that if they don't agree with the party line, let's say if Uddhav Thackeray, being the leader of this political party, tells all of these 56 people that you cannot have independent decision making with regard to this, you will have to beat the party line. Okay. And if, let's say for example, Uddhav Thackeray doesn't beat the party, if the 40 MLAs don't vote according to the official position of the political party, then they are subject to disqualification. So it could be possible that these 40 MLAs don't show confidence with the Uddhav Thackeray government, but the moment the government collapses, the very next moment what will happen would be a disqualification application made to the speaker with regard to the disqualification of the 40 MLAs from the member of Legislative Assembly, which means that the Maharashtra government would be in a situation in which it can say that if we don't make a government, 40 MLAs from the member of Legislative Assemblies from the Vidhan Sabha will be suspended and you will have to conduct by elections on these 40 seats. Clear? Now, in the absence of 40 MLAs, it is impossible for the Bharatiya Janata Party to make a government, because if it is 105 plus 16, which are favor of Maharashtra, and you obviously know that the Congress and the NCP will not support the BJP, there will not be a clear majority in the House and eventually the House will also collapse. So, when in the absence of a kind of a majority coming into the House, no one can create a kind of a Gathbandhan or a Gathjod in terms of answering the questions about the House, then the majority collapses and the House will have to be forced for a re-election, which is something that the Maharashtra government can do by getting the 40 MLAs disqualified under the grounds mentioned in paragraph 2 of the 10th schedule. I hope you are able to see it clearly. Yes? Okay. So, the government is preparing itself for the floor test, etc., etc. But very curiously enough, Uddhav Thackeray, as the Chief Minister of Maharashtra, even before appearing for the floor test, he resigns from the position of the Chief Minister. Okay. He resigns from the position of the Chief Minister and he does not participate in the floor test. At this point of time, Eknath Shinde, who is the head of the rebel faction of the Shiv Sena, Eknath Shinde, who is the head of the rebel faction of the Shiv Sena, what he does is he takes this opportunity and rather than merging with the BJP, let's say for example, this is Shiv Sena. Okay. Now, the leader of Shiv Sena is, let's say, Uddhav Thackeray. He is also the CM of Maharashtra. But he resigns from the position of the CM of Maharashtra. Okay. Now, the rebel faction of Shiv Sena, which is composed of, let's say, Eknath Shinde, who is trying to take 40 MLAs from Shiv Sena and merge into the BJP. Now, instead of merging with the BJP, what he does is, he files an application with the Election Commission of India. He files an application with the Election Commission of India, and under the Election Commission order symbols, rules made by the government giving powers to the Election Commission. in this particular set of rules, these are important for your prelims examination, right? 1968 Election Commission rules, as they are known as. Okay. In the 1968 Election Commission symbols order, the Election Commission has the power to decide in the matters of political dispute between political parties. जैसे मान के चलिए कि एक कोई political party है, उस political party में दो खेमे बन गए और दोनों खेमे political party की leadership के लिए लड़ाई कर रहे हैं. They are fighting or contesting with each other for the political leadership of the political party. ठीक. तो अब अगर मान लीजिए कि एक खेमा और दूसरा खेमे के बीच में डिसीजन हो रहा है कि पॉलिटिकल पार्टी का जो चुनाव चिन्ह है, द इलेक्शन सिंबल ऑफ द पॉलिटिकल पार्टी और द प्रॉपर्टी ऑफ द पॉलिटिकल पार्टी और द फंड्स ऑफ द पॉलिटिकल पार्टी, द रिसोर्स ऑफ द पॉलिटिकल पार्टी, वो किस व्यक्ति के पास जाएंगे, हु विल बी द लीडर ऑफ द पॉलिटिकल पार्टी. तो अगर पॉलिटिकल पार्टी आपस में समन्वय करके इस प्रॉब्लम को सॉल्व नहीं कर सकती है तो ये चीज़ें दोनों पॉलिटिकल पार्टी लेके इलेक्शन कमीशन के पास चली जाती है. इलेक्शन कमीशन हैज़ अ पावर टू डिसाइड हु इज द ट्रू ऑथेंटिक लीडर ऑफ अ पॉलिटिकल पार्टी. Okay, and so the Eknath Shinde faction goes to the election commission and says that we are the real leaders of political party called Shiv Sena, and therefore the symbol of Shiv Sena, the bow and arrow, the properties of Shiv Sena, everything with regard to the leadership of Shiv Sena shall be given to us, not to Uddhav Thackeray. And the election commission asks them the reasons why they think that they are the leaders of Shiv Sena. So the Eknath Shinde faction of the political party says that we have 40 out of 56 MLAs in our support. 40 out of 56 MLAs are in our support, and 13 out of 18 MPs, both in the Lok Sabha and the Rajya Sabha, are standing in our support. So what Eknath Shinde faction does is, he brings all of these people in front of the election commission and he says that 13 out of 18 MPs both from the Rajya Sabha and Lok Sabha are standing in our support, and 40 out of 56 MLAs are standing in our support. And this is where the election commission applies what is called a test of majority. Again, an important term for identifying a prelims question, a test of majority, by which it can identify the real leader of a political party. By the application of the test of majority, the election commission gives an order in favor of the Eknath Shinde faction, stating that the real political leadership of Shiv Sena shall go to the Eknath Shinde faction. It takes away the political leadership of Shiv Sena, the sign, the symbol, the electoral representation, etc. All of these it takes away from the Uddhav Thackeray faction and transfers it to the Eknath Shinde faction. Now what happens is that Eknath Shinde becomes a political leader of Shiv Sena. Now let's say, how does the House act? You have 56 members over here with Shiv Sena, right? Now you have 40 under the Eknath Shinde faction who own Shiv Sena, and you have 16 now who are not in line with the political party. Okay. So now what he does is 56 over here and 105 over here, both of them, at least 40 plus 105, they reach the magic number of 145 and they form the government. But also you would understand at this point of time, if these 16 MLAs don't beat the party line given by Eknath Shinde, now they can be subject to disqualification. Right? They can be subjected to disqualification. Clear? You see how it turns around completely. Earlier the 16 were trying to disqualify the 40, but now because of the intervention made by the election commission, the 40 are now in a position to disqualify the 60. Under paragraph 2 of the 10th schedule, which says that if a person does not vote in line with the political party in a particular house, they can be subjected to disqualifications under anti-defection law. Clear? Now the government in Maharashtra has been formed between the BJP, which has 105 seats, and the Maharashtra Shiv Sena, which has 40 seats, and Eknath Shinde faction, which is in lead, and slowly some members of the 16 seats also start joining the Eknath Shinde faction, eventually leading the chief ministership of Maharashtra government to come to a point. Okay? Clear? Do we understand this? right? So you can, in reference to this, for example, remember the role of the Election Commission, the role of the Supreme Court in disqualifying, staying the order of disqualification, the relevance of part 4 and paragraph 4 and paragraph 5 and paragraph 2 of the 10th schedule. Okay? This entire current affairs structure is a good way to understand the points which are basically coming out over here in terms of what is happening in the Maharashtra State Legislative Assembly. Okay? Okay? So now what you have to do is read Article 102 of the Constitution, read paragraph 2 of the 10th schedule directly from the Constitution, take up the bare act of the Constitution and read it directly from the Constitution. Then read paragraph 5 of the 10th schedule, read paragraph 6 of the 10th schedule, and combine together, read the documents that I will provide with regard to the Maharashtra Shiv Sena case, and you will have a good understanding of how anti-defection law, any kind of question on anti-defection is going to come on this, because this is what happens in every case in which there is a movement of MLAs from one party to another party. This is the formula, that you have to move at least 2/3 of MLAs and you have to merge them in your political party. Now, in this case, as the events turned around curiously, the Maharashtra Shiv Sena first wanted to merge into BJP, but it got a better opportunity to control its own political party once Uddhav Thackeray had himself resigned and sidelined away. Okay, and therefore it made not a government by merger but by coalition, which is a different thing altogether. Okay, I hope this is becoming properly understandable by you. Okay, so this is another part that I wanted to take in the current affairs. Good, we are moving steadily. Right. Now let me take the another part with this regard, which is the constitutional provisions with reference to current affairs. In the same vein, we can take a look at Article 105 of the Constitution. Article 105 of the Constitution deals with a concept which is known as parliamentary privileges. Okay, parliamentary privileges, Article 150 of the Constitution. Now, Article 105 can be divided into two specific clauses, and I am going to give you in a very detailed kind of format about how this is happening. Article 105 clause 1 says that in Parliament there shall be freedom of speech, which means that the parliamentarians should be allowed to say whatever they want in the Parliament without any fear of any sort. Okay. Now, basically, when we talk about the rights of freedom of speech, they are given to a normal citizen under Article 19, Clause 1, Clause A. Right? This is the point at which freedom of speech exists within the Constitution. Article 19, Clause 1, Clause A, Subclause A. This is where freedom of speech exists within the Constitution. But the freedom of speech that exists within the Constitution is also very heavily restricted by Article 19, Clause 2, which provides for reasonable restrictions on the freedom of speech and expression. In comparison to this freedom of speech and expression, which is given by the Constitution to a normal citizen, the freedom of speech which has been given to member of parliaments is extraordinarily strong and less liable to be restricted when that member of parliament is exercising that freedom of speech within the parliament. It's a very important thing to understand. Okay. So Article 105 Clause 1 gives freedom of speech to the member of parliament, and it is not as heavily restricted as the freedom of speech and expression of a particular individual is restricted outside the parliament. Let's say, for example, if a person has said something, let's say the member of parliament from the Wayanad constituency who has been punished under the defamation case by the what you can call the Surat court. Okay. If he had said the things that he had said inside the parliament, then he would not have punished by, he could not have been punished by any law. I think this kind of a thing makes sense to you when I'm trying to say that. Right. So Article 105 Clause 1, with regard to freedom of speech, it shall exist in parliament subject to the provisions made of the constitution. But all said and done, you have a more amount of freedom of speech in parliament as compared to Article 19(1)(a). A parliamentarian is freer to say things that he wants, he likes in his mind in front of the entire parliament inside the session. Okay, that's number one. Then the number two is that an MP inside a parliament has two basic actions. First, he speaks inside the parliament, and second, he votes inside the parliament. A member of parliament has two basic actions. Number one, he speaks inside the parliament, and number two, he votes inside the parliament. And what Article 105 Clause 2 says is that with regard to anything said by a member of parliament and with regard to any vote given by the member of parliament, he shall not be, or the reasons for saying something or reason for casting a vote on a particular manner, it cannot be inquired by any court. Which basically means that no law which applies on a individual citizen of the country will apply on the power to speak and power to vote of a member of parliament when he is speaking or voting inside the parliament. Let me give you an example of Article 105 Clause 2. It states that, let's say for example, there is a bill being debated in the parliament. The bill being debated in the parliament is, let's say, dealing with nuclear technology. Okay. Now, one of the member of parliament goes to the parliament to vote upon that bill. And while he is voting upon that bill, he takes out what you can call a religious scripture from his bag. And then he closes his eyes and he reads a religious scripture. And then according to what he is reading in the religious scripture, he casts his vote upon the bill, as if he is taking inspiration from a religious book as to what can be done about this thing. Someone from outside can say that this man is superstitious or irrational, okay? That he is doing a kind of a non-reasoned exercise in deciding as to what vote has to be given to a law which is inherently determined by science and technology. Right? So a question can be raised, what is the basis on which the vote has been made? But Article 105 Clause 2 says that if any person is making any vote in the parliament, the method that he is using to make that vote cannot be questioned by any court of law. So if a person, for example, does a kind of a Jyotishi Shastra before he votes upon a particular matter in the parliament, he cannot be complained against by any court. He cannot even be made fun of by any media channel, etc., etc. You see the point? This is what is the next set of privileges known as the parliamentary privileges. Article 105 Clause 1, freedom of speech. In Article 105 Clause 2, right to vote, and the way in which whatever decision a member of parliament takes in the parliament with regard to his party line structures, etc., etc., cannot be questioned upon because his information or his reasoning on that decision is superstitious or anything else. Okay, because the parliament is supposed to reflect the true nature of India as it is. Okay. This kind of a situation becomes what you understand as a relevance understanding of parliamentary privilege. Third kind of a parliamentary privileges which has been given to the member of parliament is that, this is one which you can have an MCQ out of, is that, let's say for example, if this is an MP and this MP is involved in some case in which, let's say, there is an act known as the Negotiable Instruments Act. In the Negotiable Instruments Act, there is a provision which says that if you submit a check and if the check bounces, then you will be liable for certain, what you can call compensation. You will have to pay certain compensation to the bank and to the party that you have given the check. Now let's say for example there is a member of parliament who has given a check to some person, but the check bounces. Okay, if the check bounces and the person who has taken the check in the bank, they go to a civil court and they say that this person's check has bounced, the civil court says that this person has to pay an amount of 50,000 as a compensation for causing trouble to these people, and if he does not pay this amount, he shall be arrested. Let's say the member of parliament does not pay this fine. Okay, he refuses from paying this fine. Now what the parliamentary privileges basically say is that if, let's say, this is the session of a parliament, let's say for example you have the budget session or the monsoon session starting on, let's say, 15th of June and going on till, let's say, 20th of July, imagine. Okay, this is the monsoon session which is going on from this period to this period. Now what the parliamentary privileges say is that in the duration of this session, okay, 40 days before this session and 40 days after this session, okay, within the duration of this session, 40 days before this session and 40 days after this session, this member of parliament cannot be arrested, okay, for any wrong which is civil in nature. If there is some kind of a civil complaint against this person, then this person cannot be arrested for the period of time as it is mentioned above, 40 days before the session, during the time of the session and 40 days after the session, he cannot be arrested. Alright, makes clear? Okay. Now, this kind of a immunity that a person enjoys in civil cases does not extend in criminal cases. If there is a warrant against a person in a criminal matter, then he can be arrested even during the duration of the house. But for civil matters, if there is a warrant of arrest, then he can skip that arrest the duration of the house. Not only in the duration of the house, he can also skip the arrest in the time when he is attending the meetings of a parliamentary committee. So when, for example, you read about parliamentary committees is of course composed of parliamentarians, right? Parliamentary committee is composed of parliamentarians. Now the parliamentary committee की meeting है कोई, अगर उसके ड्यूरेशन के दौरान उसके 40 दिन पहले और उसके 40 दिन बाद the person cannot be arrested for a warrant for violating a civil law in the country of India. This is one of the aspects of what is known as the privileges which are given to the parliamentarians. So I'll count 3 privileges which can be transformed as a multiple choice question. First privilege is that he can speak anything in the parliament. He shall not be liable to defamation, restrictions under Article 19, Clause 2, etc., etc. He can overcome these restrictions. Number 2, he can vote about anything in the parliament according to whatever logic he suits fit. Okay, he can do a akkad pakkad Bombay and vote in front of the entire world, and no law can be applied against him. Okay, and third, he is immune from civil arrests for the period which is mentioned in this particular phase. If you understand these three things, the person who is being given a kind of a privilege of the parliament membership can actually realize them. Right? Now, in continuation with this concept of parliamentary privilege, let me discuss a subsequent concept, which is breach of privilege motion. Breach of privilege motion. Now, basically what it says is that, let's say for example, I'll give an example of it. Let's say this is a member of parliament. Member of parliament has stood up in the parliament to speak something. Okay, let's say for example, this member of parliament is representing the transgender community in India, right? And he has been elected by a constituency which has gotten overwhelming support by people who stand for the transgender or LGBTQ rights. And let's say for example, she makes a speech in the parliament, but let's say for example, some person somewhere who's watching the speech on the Lok Sabha TV or the Rajya Sabha TV, he takes that speech and makes a spoof out of it, create memes out of it, or does some kind of a profanity with it, etc., and circulates it in the social media, making fun of a person. Okay. Now, the question of parliamentary privilege entails that there is nothing in this country that can stop a parliamentarian from speaking his mind in the parliament. It's the most radical form of freedom of speech and expression. Okay, and it's obviously due, because if you cannot have the debate about what you want to feel correctly about, etc., if you can't speak your heart out in the parliament, then where do you have discussions about the society or the social problems or the social issues? Now, let's say when the transgender person, she goes back home and looks at all the social media full of her videos which are circulating, which are making fun of her, spoofing her, etc. This can be constructed by the parliament as a breach of its privilege under Article 105. You see the point? If any person inside or outside parliament tries to do some actions by which a member of parliament is dissuading or is dissuaded from speaking out freely or voting freely, okay? Let's say if there's a media channel which is broadcasting the parliament debate and they're looking at the parliamentarians and they're telling the people कि आप देखिए अपने अनपढ़ नेताओं को, इनको कुछ भी नहीं आता, इनको न्यूक्लियर टेक्नोलॉजी के बारे में A to B नहीं आता और लोग बिल पे डिस्कशन कर रहे हैं. Try to mock them, try to in a way create a situation in which you feel, make them feel inferior. Those member of parliaments, because of this kind of a public consciousness, may feel discouraged to stand up and speak in the parliament next time. They will not feel the confidence to do it. And they will not be able to represent the people who have sent them inside the parliament, right? Which would be a problem with the constitutional spirit. And therefore, in this particular case, let's say for example, if I am the speaker of the parliament, of the Lok Sabha, and I see this video which is making fun of this person, what I can do as a power is, I can take cognizance of a breach of privilege motion. Okay, I can do, what the power that I have is that I can punish, or I can start the proceeding for punishing the person who is breaching my privilege, breaching the privilege of the member of parliamentarian in my house. Okay, so for example, let's say what I can do as speaker is, I can ask the person to file a written complaint with me, and I can set a breach of privilege motion into order. A breach of privilege motion is a motion in which an investigation or an inquiry can be conducted. And if the investigation and inquiry is conducted by the parliament and it is found that the person who has made the video is in breach of parliamentary privileges, he can be arrested. he can be arrested is number one as an option. The second, he can be reprimanded. For example, let's say if he's a journalist or something, his license can be cancelled. If it is a media house, its license can be cancelled. Okay? Or he can be made to publicly apologize to the parliament. Or he can be warned and let go of with saying that this should not repeat again. So this is one of the few instances in which the Parliament of India has powers of the judiciary. There are certain judicial powers which are given to the Parliament under Article 105 of the Constitution, which means that Parliament can act as a judge over matters which it considers are a breach of its privilege. Okay? So, one way in which a breach of privilege motion can work is that, let's say for example, the speaker looks at some particular person's privilege being breached, the speaker can take up the matter and send it to the privilege committee. Now, both the Lok Sabha and the Rajya Sabha have something called a privilege committee. I'm sure you've read about the parliamentary committees by now, and one of the departmentally related standing committee in the Lok Sabha and one in the Rajya Sabha is a privilege committee. The Lok Sabha privilege committee has 15 members and the Rajya Sabha privilege committee has 10 members. And the speaker, upon taking a cognizance of an action in which parliamentary privilege has been breached, can refer that application to the privileges committee of that particular house, the speaker to the Lok Sabha privilege committee and the chairman to the Rajya Sabha privilege committee. And the privilege committee can investigate into these actions and then subscribe punishment and keep the report about its investigations in front of the house. And the house can pass a motion by simple majority, and by that passing of the motion, the house has the power to punish the person who has breached the privilege of the member of parliament to speak or utilize their privileges under Article 105 of the Constitution. Okay? And it can also lead to arresting the person. You understand the point? So what is one of the basic impacts of the breach of privilege motion is that Parliament all of a sudden becomes a judge of a matter of its own accord. Okay? And Parliament has been given very clear judicial powers, and judiciary cannot interfere with the parliamentary powers. Okay? For example, let's say the procedure which has to be adopted by the parliamentary committee or the parliament to investigate into the crimes or the what you can call the act of punishing a person shall not be investigated into by the courts. Article 122 of the Constitution of India. This is something that you can understand and read carefully. Article 122 of the Constitution of India states that courts not to inquire into proceedings of Parliament. The validity of any proceeding in the Parliament shall not be called in question on the ground of any alleged irregularity of procedure. Let's say for example, while the parliamentary committee or the parliament itself is investigating the actions of a person who is blamed for breaching the privileges of the parliament, and if the evidence against that person has not been taken according to the principles set down by the Supreme Court to collect evidence, the court cannot interfere in the decision-making process of the parliament by saying that the procedure that you have followed to come to this conclusion is incomplete or invalid or unscientific. That is given under Article 122 of the Constitution. Please read it and try to learn it right now. You can have a very clear question coming out of it under Article 122, which is regarding the powers of the court not to inquire into the proceedings of the parliament. Okay? The validity of any proceedings in the parliament, मतलब कोर्ट पार्लियामेंट से ये नहीं कह सकता है कि तुमने जिस तरह से इन्वेस्टिगेशन करी है वो हम जिस तरह से इन्वेस्टिगेशन करते हैं उससे बहुत ढीली है, साइंटिफिक कम है, उसमें प्रिकॉशंस कम लिए गए हैं, उसमें आपने एविडेंस को जल्दी से आकलन नहीं किया, इसलिए हमको तो हम इन्वेस्टिगेशन करेंगे, या क्योंकि आपका जो इन्वेस्टिगेशन है वो स्टैंडर्ड से सेट नहीं है इसलिए आपकी इन्वेस्टिगेशन को हम रद्द करार कर देते हैं. ऐसी कोई भी पावर सुप्रीम कोर्ट के पास नहीं है. Eventually, if the parliament is not able to conduct inquiry completely scientifically, but the parliament feels that this person has done wrong, it can still punish that person, and the court cannot interfere in the decision of the parliament saying that the procedure that you have followed is incomplete or irregular. Article 122 of the Constitution. Okay. Achal, absolutely correct. Article 122 is the same as procedure established by law. If the Parliament has established a procedure for investigation of any kind of a fault against itself, it is something that the courts cannot interfere in. Yeah, you're correct. So India is following procedure established by law in terms of, India is following due process of law in terms of acts made by the Parliament which is applicable on the citizens of India. But with regard to the internal regulation of Parliament, there is no due process of law. Courts cannot dare touch the procedure of a Parliament or the way that the Parliament comes to a particular answering of a question. As we have seen, for example, if a member of Parliament votes upon a particular matter reading a religious text, the court cannot interfere in that procedure. Neither can the court interfere in the procedure by which the committee is investigating evidences for coming to conclusions on certain matters. Neither can court interfere into the procedures which are taken by the Parliament while discerning whether the breach of privilege motion applies to a particular person or not. You're absolutely correct. We are not moving towards a due process of law in the procedure established by the Parliament for its own regulation, but by Parliament to the regulation of the country as at large. But within the Parliament is a sacrosanct. It does not have any obligation to listen to any person telling it that this process is unfair, unreasonable, unjust. You please rectify it. The Parliament is not bound to listen to anyone. Yeah, that's obviously an example, as Shubhi is pointing out very clearly, of separation of powers, right? So I'm just referring to Article 105 of the Constitution over here. Okay, now let me just add a current affair event to the point which is being mentioned right at this stage. Okay. Recently in the Rajya Sabha, during the budget session, there was a huge what you can call uproar. The budget session was a very disruptive session of the House this time. Okay, so the government and the opposition were having a kind of a tough time talking to each other and letting the House function as one entity. Now, what was happening in the Rajya Sabha was that the ministers, I'll just refer to an article to you within the Parliament part. If you take a look at Article 88 of the Constitution, just as a revision, because we are now revising some of the important aspects of Constitution, and I hope that this kind of a thing makes, I'm sure all of you know all of these things, but while we are doing it together, it is consolidating back again. Okay, so when we take a look at Article 88 of the Constitution, under Article 88 of the Constitution, we identify that let me just give you a better sense of making an answer of a question from this particular perspective. Okay. Now let's say sometimes you see that a member of Parliament from Lok Sabha is the finance minister. You know, of course, that to become a minister in the union or the state cabinet, you have to be a member of the Parliament or the state legislative assembly or council, right? Now, the point about what you can call the member of Parliament being a minister, let's say for example you have the Home Minister who is a member of Parliament from Lok Sabha. But as we see that the parliamentary democracy works, that both Rajya Sabha and Lok Sabha are equal in footing and both of them can a certain accountability from the government or the ministers regarding their actions, right? Now, sometimes we observe that the minister who is a member of parliament from Lok Sabha is also addressing the Rajya Sabha. How does he get the powers to do so? Okay, if he is not a member of Rajya Sabha, sometimes you see Prime Minister in the Lok Sabha, sometimes you see him in the Rajya Sabha. Okay, he gets his powers to address any house in the parliament from Article 88 of the Constitution. Take a look at this. Article 88 of the Constitution. Rights of ministers and attorney general as respects houses. Okay, take a look at this. Every minister and the attorney general of India shall have the right to speak in and otherwise to take part in the proceedings of either house, any joint sitting, and any committee of parliament of which he may be named a member. But he shall not have the right to vote by the virtue of Article 88. Right? तो अगर मतलब मान लीजिए आपसे प्रश्न पूछा जाए कि does the constitution provide that any person who is a member of parliament from one particular house can only address that particular house? This statement is correct or incorrect? This statement is incorrect. Because Article 88 says that a minister and an attorney general can be present in either house of the parliament to speak, even if he is not a member of that house of parliament. Attorney general is not a member of any house of parliament. But when he is speaking in such a house, he cannot exercise the right to vote. He can only exercise the right to vote as a member of parliament within the house from which he is, in the house in which he is elected by the people, either Rajya Sabha or the Lok Sabha. So, you can just make sure that if the UPSC creates a kind of a creativity out of this question somewhere or the other, you're able to deal with that without facing too many difficulties. Okay? Make sense? Take. Now, in addition to this, what was happening was that the Prime Minister and some other ministers were addressing the Rajya Sabha under Article 88 of the Constitution, and some of the members of the Rajya Sabha sitting towards the other benches, they were constantly uproaring in a way, entering the well, creating a bit of a mood, and etc. etc. These are the normal things which happen inside a democratic forum. Now, the Rajya Sabha chairman, who is a vice president, you know the vice president is the ex-officio chairman of the Rajya Sabha, he took notice of this kind of a thing which was being done by the member of parliaments. Now, the Rajya Sabha chairman issues what is known as a breach of privilege motion to these member of parliaments. It's a very interesting case story, which is a current affair that is developing, which I wanted to draw your attention towards, which is the reason why you can have a question from the breach of privilege motion. Yeah. I'm sure by now you understand what is the nature of a breach of privilege motion. Okay. So what he says is that because of the constant disruption of these, what you can call member of parliaments of the Rajya Sabha, this member of parliament who is a minister is not able to exercise his right to freedom of speech under Article 105 clause 1. And on account of this, he takes a suo motu cognizance. I hope you understand the meaning of suo motu. He takes a suo motu cognizance. A suo motu का मतलब होता है on its own accord, on his own accord. So what he does is he takes a suo motu cognizance of the fact, matlab without anyone having complained to him, he takes the matter up by his own volition and he refers this complaint to the Rajya Sabha departmentally related standing committee on privileges to investigate and prescribe a proper punishment to the member of parliament who have been disrupting the house and not letting other member of parliament speak. Okay, and this is why this kind of a thing has become relevant in the current affairs. Now, an interesting constitutional question which is arising out of this is basically the point that can the member of parliament be charged for breaching the privilege of another member of parliament? And if the member of parliament is being asked not to talk by issuing a breach of privilege motion, is that itself not a breach of privilege of that member of parliament? This is a constitutional question that is being asked in the newspapers. Now, currently, the parliamentary committee is taking a consideration of it and the answers are not coming out correctly, but nonetheless, you have the ability to understand the way in which parliamentary privileges work. Parliamentary privileges, for example, a question comes. Breach of parliamentary privileges motion can only be applied against people who are outside the parliament, who are non-parliamentarians. Is this statement correct or incorrect? It's a typical UPSC kind of a question. UPSC always plays upon these facts from current affairs. The question that the UPSC will state in a sentence somewhere would be, can breach of privilege motion under the provisions of Article 105 be made only against non-member of parliaments or non-members of the house from which the breach of privilege motion arises? Is this statement correct or incorrect? And as we have seen it in the case of the 12 MPs from the Rajya Sabha having been served the breach of privilege motion, it is obviously clear that a breach of privilege motion can arise against the members of a house also from which it is originating. Clear? Okay? You get the point? Let me see if I can pull out a news article to get you a sense of it. This is a news article that I developed February 20, 2023, fresh of the current affairs, ready recipe for the prelims examination. Take a look at this. Rajya Sabha chairman asks privilege panel to investigate disorderly conduct of 12 opposition MPs. Okay. This is the Vice President of India, Jagdeep Dhankar, who is also the chairman of the Rajya Sabha. Take a look at this article to get a sense of it and also the question that can come out of it. Out of the 12 MPs, 9 MPs were from the Congress party and 3 MPs were from the Aam Aadmi party. Right, so you see, this is the what was made was the point. In violation of the rules and etiquette of the Rajya Sabha, by repeatedly entering the well of the council meaning Council of States, shouting slogan, persistently and willfully obstructing the proceedings of the council, compelling the chair to repeatedly adjourn the sitting. Right? Shraddha has an interesting question. What can be a valid alternate punishment for constant hecklers then? The Speaker has been empowered by the rules of the Parliament, Lok Sabha and the Rajya Sabha, both to take actions against the what you can call the people who disrupt the parliamentary proceedings. But all said and done, the speaker has to use these powers very judiciously, because as you can see, parliament is a ground of free exchange of ideas and debate. It's supposed to be a little chaotic. But nonetheless, the powers to take disciplinary actions are there with the speaker in cases of heckling, etc., etc. This is one of the courses by which discipline can be handed down, and there are other simpler powers which are not given in the constitution but given in the rules and procedures of the Lok Sabha and the Rajya Sabha, which empower the speaker to take actions against the what you can call non-compliant member of parliaments. Has any disciplinary action been taken yet, Sayan? No, not yet. This is still under consideration of the standing committee. The standing committee is currently under the consideration of the nature, but in some time you will see the matter develop, and as you see the matter develop, you can update yourself from the newspaper articles itself. Okay? Clear. So this is one thing about the parliamentary privileges which I wanted to cover. Check. Now let's move on. Let me just give you a brief gist of the articles that I have covered of the Constitution, and to get a sense of what I am trying to say. We have Article 105 of the Constitution, which talks about parliamentary privileges. Along with this, I have discussed Article 88 of the Constitution, which allows for a minister of one house who is a member of that house to go into another house and speak out. And the parliamentary privileges will apply to him not only in his own house, but also into another house, and even from the members of parliament. So this ये prelims का question बन सकता है कि अगर एक किसी व्यक्ति की parliamentary privilege breach करी जा रही है, it can be only applicable by the actions of people outside the parliament, but also by the application of people inside the parliament. And the correct answer, as you can see in the recent case of the Rajya Sabha, it's coming out very clearly in front of our eyes that even member of parliament can be disciplined by the use of the parliamentary privileges given under Article 105 of the Constitution. Let's take a look at Article 105 of the Constitution directly. Take a look at this. Article 105 Clause 1. Subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. Okay? So, subject to the rules made by the House. The House can make its own rules to say, for example, there is something called a parliamentary language, that there are terms which you cannot use in the Parliament. So, Parliament has the ability to make the rules for its own regulation inside the House कि कौन सी भाषा बोली जाएगी, कौन सी भाषा नहीं बोली जाएगी. उस चीज़ को ध्यान में रखते हुए, उस चीज़ को ऑब्लाइज करते हुए पार्लियामेंट में हर व्यक्ति के पास फ्रीडम ऑफ स्पीच रहती है. ठीक है. No member of parliament shall be liable to any proceedings in any court. No member of parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in parliament or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of either house of parliament of any report, paper, votes or proceedings. तो अगर पार्लियामेंट में कोई व्यक्ति कुछ बोलता है, कुछ छापता है, कुछ सर्कुलेट करता है और अगर किसी प्रकार का वोट देता है, तो उसके बेसिस पे कोई भी क्वेश्चन ऊपर नीचे हो, वो किसी भी अदालत के सामने पेश नहीं किया जाएगा, which basically means that he cannot be subject to any law of the land and will be given a immunity from that kind of a prosecution. As again, I'll repeat it out. If Rahul Gandhi had done what he had done inside the parliament, he would not have been subjected to the case of defamation under section 499 because he would have been covered under the clauses of parliamentary privileges. Okay? Okay. So with this regard, I've also covered with you the nature of parliamentary privileges. Don't forget the 40 days wala clause over here. And also with this edition, I have covered what is known as the, what you can say, a breach of privilege motion and the points which are associated with it. Breach of privilege motion. इसके कुछ आर्टिकल्स हैं जो मैं आपके साथ शेयर कर दूंगा क्लास के बाद या कल तक. ठीक? This is some material that you can read in addition to these things. ठीक? Now we come to the next important current affair which is developing, which is with regard to the officers of the parliament. ठीक है, तो जनरली जब हम पार्लियामेंट की बात करते हैं तो उसमें पार्लियामेंट के चैप्टर में एक चैप्टर होता है पार्लियामेंट के अंदर, मतलब कॉन्स्टिट्यूशन के अंदर, जिसको हम कहते हैं ऑफिसर्स ऑफ द पार्लियामेंट. ठीक है, officers of the parliament. Now in officers of the parliament basically we include three parts. One is the chairman and the deputy chairman of the Rajya Sabha. इसमें ना बहुत महीन questions निकल आते हैं prelims के, तो we'll go through this part a little bit, what you can call delicately, so that you have the ability to make sure that you are in tune with the possible trapped question that can be asked from this part. तो थोड़ा ध्यान से इसको हम कवर करते हुए चलेंगे, क्योंकि इन चीज़ों से ना छोटे छोटे आर्टिकल से कॉन्स्टिट्यूशन के क्वेश्चंस बना के घुमा के दिए जाते हैं, थोड़े से फिरकी मार के. ठीक है, तो चेयरमैन एंड डेप्यूटी चेयरमैन ऑफ द राज्यसभा, ठीक है. सेकेंड यू हैव correspondingly the speaker and deputy speaker of the House of the People. And you have what is known as the Lok Sabha plus Rajya Sabha Secretariat. इसको हम दिल्ली में केंद्रीय सचिवालय कहते हैं. Okay. Now this is basically what is covered under the part of the constitution which is known as officers of the parliament or offices of the parliament. Okay. Now तो अभी हम लोकसभा राज्यसभा सेक्रेटेरिएट को थोड़ा अलग से कर लेंगे, लेकिन हम अब एक प्रिसाइडिंग ऑफिसर्स की लिस्ट ले लेते हैं. ठीक है, जो आपके प्रिसाइडिंग ऑफिसर्स होते हैं हाउस के, और सिर्फ पार्लियामेंट के ही क्यों, वी विल टेक अ लिस्ट ऑफ द मेंबर ऑफ लेजिस्लेटिव असेंबलीज आल्सो, राइट. तो पहला हम इसके बारे में समझते हैं चेयरमैन के बारे में. जो राज्यसभा का चेयरमैन होता है उसके बारे में क्वेश्चंस घुमा के दिए जाते हैं कभी कभी प्रीलिम्स में. लेट्स से फॉर एग्जांपल, now please take a look at what I'm trying to say and try to learn it alongside with the classroom. Okay, when we talk about the chairman of the Rajya Sabha, it's a very distinct entity from all the presiding officers. All the presiding officers, प्रिसाइडिंग ऑफिसर मतलब किसी सदन का कोई जो प्रेसिडेंट होता है, मतलब जो चेयर होती है प्रेसिडेंट की. ठीक है, इसको स्पीकर कहते हैं हम लोकसभा में, और चेयरमैन कहते हैं राज्यसभा में, और डेप्यूटी चेयरमैन और डेप्यूटी स्पीकर, और फिर स्पीकर आपका लेजिस्लेटिव असेंबली में और डेप्यूटी स्पीकर आपका लेजिस्लेटिव असेंबली. इनको सबको प्रिसाइडिंग ऑफिसर्स ऑफ द हाउस कहते हैं. अब इसमें से प्रिसाइडिंग ऑफिसर जो होता है चेयरमैन, वो थोड़ा विशेष होता है. विशेष मतलब और किसी चीज़ में विशेष नहीं होता, लेकिन उस पर क्वेश्चन विशेष आ सकते हैं क्योंकि उसकी थोड़ी क्वालिटी अलग होती है. ही इज़ द ओनली प्रिसाइडिंग ऑफिसर who is not elected from the house, okay, because he is the vice president of India. तो ये क्वेश्चन प्रीलिम्स में आ सकता है. इनफैक्ट कुछ पहले के टाइम में प्रीलिम्स में क्वेश्चन आता था थोड़ा घुमावदार, कि विच ऑफ द फॉलोइंग प्रिसाइडिंग ऑफिसर्स इज नॉट अ मेंबर ऑफ द हाउस विच ही इज प्रिसाइडिंग. अब आप देखिए, लोकसभा का स्पीकर होता है वो भी हाउस के अंदर से ही इलेक्ट होता है, राज्यसभा का स्पीकर होता है वो भी हाउस के अंदर से इलेक्ट होता है, लेकिन जो राष्ट्रपति होता है या उपराष्ट्रपति होता है वो हाउस के अंदर से इलेक्ट नहीं होता है, वो होता है इलेक्टोरल कॉलेज के द्वारा इलेक्ट, है ना. यू गेट द पॉइंट. तो ये एक छोटी सी चीज है कि बिकॉज ही द चेयरमैन ऑफ द राज्यसभा इज द चेयरमैन ऑफ द राज्यसभा इन द कैपेसिटी ऑफ एक्स ऑफिशियो। एक्स ऑफिशियो मतलब कि अगर आपने एक पोस्ट मिली है आपको तो उसी पोस्ट की वर्च्यू से आपको कोई और पोस्ट मिल जाती है। जैसे फॉर एग्जांपल कि द गवर्नर ऑफ अ स्टेट इज ऑल्सो द चांसलर ऑफ अ यूनिवर्सिटी। तो जो इस प्रदेश का राज्यपाल होगा वो ही इस यूनिवर्सिटी का चांसलर होगा। इसको एक्स ऑफिशियो कहते हैं, है ना। तो इस पोजीशन में अगर कोई व्यक्ति चेयरमैन है राज्यसभा का तो वो इसीलिए क्योंकि वो प्रेसिडेंट है। तो ही इज नंबर 1 नॉट इलेक्टेड बाय द हाउस इन विच ही इज प्रिसाइडिंग। दिस इज नंबर 1, ठीक है। नंबर 2, अब ये मैं आपको क्यों बता रहा हूँ, क्योंकि अभी जो हम जगदीप धनखड़ की बात कर रहे थे, ही हैज़ बिन इलेक्टेड द चेयरमैन ऑफ और वाइस प्रेसिडेंट ऑफ इंडिया ओनली रिसेंटली इन योर एग्जाम ईयर। मतलब वो आपका करंट अफेयर का पार्ट बनता है, तो इसीलिए हम थोड़ा सा चेयरमैन के बारे में पढ़ सकते हैं, क्योंकि करंट अफेयर में अभी ही उनका इलेक्शन हुआ है, ठीक है। नॉट इलेक्टेड बाय द हाउस इन विच ही इज प्रिसाइडिंग, ही इज द ओनली वन, अदरवाइज ऑल दिस प्रिसाइडिंग ऑफिसर्स आर देयर। तो इसका घुमा फिरा के क्वेश्चन बन सकता है, ठीक है। एंड द सेकेंड थिंग इज दैट he is not a member of the house, which he is presiding. He is not a member of the house which he is presiding, ठीक। This one thing about the chairman. उसके बाद हम आ जाते हैं दूसरी चीज़ पे जिसको कहते हैं प्रिसाइडिंग ऑफिसर्स इन जनरल, ठीक है। जो प्रिसाइडिंग ऑफिसर्स अपार्ट फ्रॉम चेयरमैन होते हैं, इनके बारे में कुछ कुछ कॉमनैलिटीज़ हैं जो हम साथ में कवर कर सकते हैं, ठीक है। जैसे फॉर एग्जांपल एक जो कॉमनैलिटी है प्रिसाइडिंग ऑफिसर्स, मैं लिख देता हूँ प्रिसाइडिंग ऑफिसर्स कौन से हैं। डेप्यूटी चेयरमैन ऑफ द काउंसिल ऑफ स्टेट्स, ठीक है। स्पीकर ऑफ द लोकसभा, डेप्यूटी स्पीकर ऑफ द लोकसभा, then you have speaker of the legislative assembly and deputy speaker of the legislative assembly, ठीक है। ये आपके हो गए विधानसभा, ये हो गया लोकसभा, ठीक है। राज्यसभा, okay. Now to make a point about it over here, it means that the deputy chairman, speaker, deputy speaker and speaker, deputy speaker of Lok Sabha have one kind of a thing in common, ठीक है। इनके बारे में कॉन्स्टिट्यूशन ने कॉमनैलिटी रखी है एक चीज में, वो ये है कि कॉन्स्टिट्यूशन सेज दैट the house to which they belong respectively shall choose one of its members ठीक है। उसके बाद शब्दावली है as soon as may be, as 1, 2, 3, 4 and 5, ठीक है। मैं इसीलिए बता रहा हूं आपको कि करंट अफेयर में है ये इशू। अभी कुछ दिन पहले ही सुप्रीम कोर्ट के पास एक PIL फाइल करी गई है, जिसमें सुप्रीम कोर्ट के सामने इस मैटर रखा गया है कि लोकसभा का डेप्यूटी स्पीकर एब्सेंट है और 5 राज्यों का डेप्यूटी स्पीकर एब्सेंट है। मतलब इन राज्यों में और लोकसभा के अंदर डेप्यूटी स्पीकर मौजूद ही नहीं है। इसी चीज़ पे पिछली बार UPSC के मेंस एग्जामिनेशन में प्रश्न भी आया था, द इलेक्शन प्रोसीजर ऑफ द डेप्यूटी स्पीकर। This is a matter which is in current relevance. That is why I'm trying to give you the background about what is happening in this particular area. Okay. Now, एक हमारा जो सबसे पहला प्रश्न आता है वो ये है कि if you talk about the chairman, speaker, deputy speaker, लोकसभा speaker, deputy speaker, विधानसभा, the constitution does not give two things. Okay? Constitution दो चीज़ों के बारे में कुछ नहीं बोलती है. पहला तो मेथड क्या होता है इन लोगों के चूज करने का. देखिए, जहाँ भी संविधान कुछ लिखता है अपने अंदर, वो उसका मेथड दे देता है. जैसे फॉर एग्जाम्पल, द प्रेसिडेंट शैल बी इलेक्टेड बाय द इलेक्टोरल कॉलेज, द मेंबर ऑफ पार्लियामेंट शैल बी इलेक्टेड बाय द इलेक्टोरल कॉलेज, द कंट्रोलर और अटॉर्नी जनरल शैल बी अपॉइंटेड बाय द प्रेसिडेंट. Okay, the Election Commission of India shall be appointed by the President. The chairman of the National Commission for Scheduled Caste shall be appointed by the President. संविधान लिख देता है कि elected है, appointed है या nominated है. If a person has, मतलब निर्वाचन से आया है, नामांकन से आया या नियुक्ति से आया है, लिख देता है. लेकिन स्पीकर एक अकेला पोजीशन है कॉन्स्टिट्यूशन के अंदर, इसमें से ना तो निर्वाचन लिखा है, ना ही इलेक्शन लिखा हुआ है संविधान में, ना ही अपॉइंटमेंट लिखा हुआ है, ना ही लिखा है नॉमिनेशन. व्हाट इज रिटन इज चूज, दैट्स इट. इसका मतलब है कि द पार्लियामेंट इज लेफ्ट टू डिसाइड अपॉन द मेथड बाय विच अ स्पीकर कैन बी चोजन. फॉर एग्जाम्पल, लेट्स से द पार्लियामेंट कैन डिसाइड ऑल ऑफ अ सडन दैट द एल्डेस्ट मेंबर ऑफ द हाउस विल बी द स्पीकर, एंड दैट इज एज गुड अ क्राइटेरिया टू अपॉइंट और fulfill the position of the speaker. You see the point? The question, if it comes, that does the constitution provide the method by which the speaker's position has to be filled? The answer is no. Okay, what the constitution says is that the house shall, as soon as may be, choose one of its members as a speaker. ठीक है, एक बार देख लेते हैं आर्टिकल को इसके कॉरेस्पॉन्डिंगली, जिससे आपको बात समझ में आ जाएगी, जिससे कि क्वेश्चंस को आप डील कर पाएंगे आराम से. जैसे हम आर्टिकल 93 पे जाते हैं, स्पीकर की बात करता है. ठीक है, इस आर्टिकल को आप ढंग से पढ़िए और इससे जो घुमावदार प्रश्न आएंगे आप उनको उत्तर देने में थोड़ा सक्षम अपने आप को महसूस करेंगे अगर इसको समझ लिया थोड़ा सा. ठीक है, ये देखिए, फॉर एग्जाम्पल लेट्स से द हाउस ऑफ द पीपल शैल एज सून एज मे बी चूज. ठीक है, अब चूज का मतलब होता है कि पार्लियामेंट के पास संविधान ने पावर दे दी है कि वो कैसे डिसाइड करेगा उसका स्पीकर कैसे आएगा. या तो पार्लियामेंट इलेक्शन करा सकता है, या तो पार्लियामेंट जिसके हाथ में पॉलिटिकल पार्टी के, वो अपने मन से अपॉइंटमेंट कर सकती है उसका, और या फिर वो नॉमिनेट हो सकता है, या फिर कोई एक क्राइटेरिया लगा दिया जाता है, जैसे कि मैंने आपको बताया कि स्पीकर इज गोइंग टू बी द एल्डेस्ट मेंबर, और लेट्स द एल्डेस्ट the eldest member of the what you can call the eldest woman member of the Lok Sabha will be decided as the speaker. ये भी एक क्राइटेरिया लगा सकता है पार्लियामेंट के पास पूरी छूट है. तो अगर ऐसा कोई स्टेटमेंट आता है that the constitution provides the method by which the speaker's position is fulfilled, the deputy speaker's position is fulfilled, the deputy chairman's position is fulfilled, the speaker and deputy speaker positions at the legislative assembly is fulfilled, the answer is incorrect. This decision has been given by the constitution to the house in which the presiding officer has to be taken out. Okay, clear? Now, second thing, the question is, does the constitution provide the time within which the speaker has to be appointed? ठीक है, क्या संविधान के अंदर स्पीकर को नियुक्त करने का कोई समय दे रखा है? द आंसर टू दैट क्वेश्चन इज नो. What has been given in the constitution is the phrase as soon as he may be. मतलब जल्द से जल्द, जब वो चाहे, जितना, मतलब अगर द प्रेसिडेंट, द हाउस ऑफ द पीपल, मतलब द हाउस शैल एज सून एज मे बी, मतलब जितना जल्दी उनसे हो सकेगा उतना जल्दी वो स्पीकर को चूज कर लेंगे. लेकिन द टाइम लिमिट विच इज देयर सपोज टू बी फॉर द स्पीकर हैज नॉट बीन गिवन बाय द Parliament. Again, neither a time limit has been given for the Speaker, nor the Deputy Speaker, nor the Deputy Chairman, nor the Deputy Speaker and Speaker of the Vidhan Sabha. इन लोगों के लिए कोई टाइम लिमिट नहीं थी. ये भी पार्लियामेंट अपने आप खुद, या फिर जिस सदन का प्रिसाइडिंग ऑफिसर है वो अपने आप खुद डिसाइड करेगा इस चीज़ को. द डिसीजन ऑफ दिस पर्टिकुलर थिंग हैज़ टू बी टेकन बाय द गवर्नमेंट, बाय द पार्लियामेंट इटसेल्फ. ठीक है. नाउ दिस इज वेयर वी बिकम अ क्वेश्चन ऑफ रेलेवेंस. इन द पार्लियामेंट, the Parliament of India, for example, has decided through the rules of procedure. जो पार्लियामेंट ने अपने आप को गवर्न करने के लिए जो प्रोसीजर बनाए हैं, the Parliament has decided through the rules of procedure. Parliament has decided through the rules of procedure that the Speaker shall be chosen by elections. Okay? The Speaker shall be chosen by elections. Now, just pay attention to this. The date of the election of the Speaker shall be प्रिस्क्राइब्ड. इसको नोट करके लिख लीजिए, इस पे MCQ आएगा. बाय द प्रेसिडेंट. ओके. द डेट ऑफ द इलेक्शन ऑफ द स्पीकर शैल बी प्रिस्क्राइब्ड बाय द प्रेसिडेंट. क्योंकि कोई डेट का प्रावधान उसमें नहीं दे रखा है संविधान में, इसलिए प्रेसिडेंट के पास पावर है कि स्पीकर के इलेक्शंस कौन से दिन में होंगे उस दिन को अलॉट करना. वेरी गुड संदीप. ठीक है. अभी आपका एक MCQ बन जाएगा इस चीज़ पे बहुत आसानी से. अब इसके आगे बढ़ के क्या है, द डेट ऑफ द इलेक्शन ऑफ द डेप्यूटी स्पीकर, द डेट ऑफ द इलेक्शन ऑफ द डेप्यूटी स्पीकर of the Lok Sabha shall be prescribed by the speaker. कौन से दिन चुनाव होगा डेप्यूटी स्पीकर का भी जो फिलिंग ऑफ द पोस्ट है वो चुनाव के माध्यम से होती है. ठीक है. अब इसको आप अंडरलाइन करके याद कर लीजिए. इस पे एक बहुत इजी MCQ बन सकता है, क्योंकि लोकसभा में अभी तक डेप्यूटी स्पीकर के चुनाव नहीं हुए. 2019 के इलेक्शंस हुए थे लोकसभा में. द पार्टी केम इनटू पावर इन लोकसभा इन 2019, राइट? एंड सिंस 2019 till 2023, it's almost the completion of the term of the Lok Sabha, the deputy speaker elections have not been notified by the speaker, and therefore it becomes relevant to understand what authority is in charge of notifying the election date of the deputy speaker. The answer is the speaker. What authority is in charge of notifying the date of the election of the speaker? The answer is the president. Analogously, what authority is responsible for describing the date of the election of a speaker of the Vidhan Sabha? The answer is the governor. And what authority is in charge of appointing the date of election of a deputy speaker? The answer is the speaker of the Vidhan Sabha. Right? This kind of a analogy makes a clear repetition in these cases. Clear? तो अब जो हमारे सामने करंट अफेयर है वो ये है. मैं आपको दोबारा से इसमें जो पीसेस ऑफ इंफॉर्मेशन है वो याद कराने की कोशिश करता हूँ कि जो लोकसभा है या राज्यसभा का डेप्यूटी चेयरमैन, लोकसभा का स्पीकर, ये सब है, विधानसभा का स्पीकर, डेप्यूटी स्पीकर, इन लोगों के बारे संविधान के अंदर ना तो मेथड दे रखा है इलेक्शंस का या अपॉइंटमेंट का, ना ही टाइम लिमिट दे रखी है। ये सारी चीज़ें पार्लियामेंट के ऊपर छोड़ी गई हैं। पार्लियामेंट अपने रूल्स बना के इस डिसीजन पे आ सकता है कि किस बेसिस पे किसको क्या पदवी देनी है, और इलेक्शंस कब होंगे वो भी पार्लियामेंट ने पावर दे रखी है प्रेसिडेंट को, और स्टेट लेजिस्लेटिव असेंबली ने पावर दे रखी है गवर्नर को। ठीक है, सो द पावर हैज़ बीन एक्सरसाइज्ड एट द डिस्क्रेशन ऑफ द गवर्नर and no time limit has been given. So the question that is now standing before the Supreme Court in a public interest litigation, let me show you the comments made by the Supreme Court in this particular aspect. It's a very recent current affairs which are coming out over here. ठीक है, ये सब फरवरी 2023 के करंट अफेयर्स। ठीक है, जस्ट टेक अ लुक एट दिस पर्टिकुलर पार्ट। Supreme Court issues notice to center on plea that no polls were held to posts of deputy speaker in parliament and 5 state assemblies. ठीक है, चलिए सुनिए, इसको एक बार पढ़िए इस पर। एंड दिस इज व्हाट बेसिकली आई एम पॉइंटिंग आउट टू एज अ करंट अफेयर। यू कैन सी द डेट ऑफ दिस करंट अफेयर इज एब्सोल्युटली recent, February 13, 2023, in the jurisdiction of the current affairs for the polity paper. Okay, the Supreme Court on Monday asked the union government to respond to a plea that no elections have been held to the posts of deputy speaker in parliament and 5 state legislative assemblies. A bench led by the Chief Justice of India, D.Y. Chandrachud, issued notices to the union and requested the Attorney General of India to be present in court when the case comes up for hearing. Now, this is something that you can also remember just for a fact check information about your current affair. The 5 legislative assemblies which do not have a deputy speaker are Rajasthan, Uttar Pradesh, Madhya Pradesh, Jharkhand and Uttarakhand. ठीक है, एक बार आप चाहें तो इसको नोट कर लीजिए। द 5 legislative assemblies which do not have a deputy speaker today are given as on the board: Rajasthan, Uttar Pradesh, Madhya Pradesh, Jharkhand and Uttarakhand. Okay. Right. Now, let's read forward. The petition said that Article 93 हमने पढ़ा है, स्पीकर के बारे में है, स्पीकर और डेप्यूटी स्पीकर। Article 178 है डेप्यूटी स्पीकर और स्पीकर, स्टेट लेजिस्लेटिव असेंबली। Mandated the House of the People in Parliament, it said, to choose 2 of their members to the office of the speaker and deputy speaker when the posts fall vacant. Okay. Now, this is one part. Supreme Court later on had made certain observations in listening to this PIL. Take a look at this. This is about the disqualification under anti-defection. Sorry, so this is still the judgment which the Supreme Court is keeping under consideration. It has not brought about a judgment upon this. ये आप एक बार पढ़ सकते हैं, और डेप्यूटी स्पीकर का जो प्रोविज़न है आर्टिकल 93, उसको आप पढ़ सकते हैं। इससे आपके प्रीलिम्स में अगर एक आधा क्वेश्चन कोई बनता है तो वी कैन टेक अ लुक एट दैट। अगेन पार्ट ऑफ व्हाट यू कैन कॉल द रेलेवेंस एनश्राइंड इन द करंट अफेयर्स। ठीक है, चलिए लेट्स मूव फॉरवर्ड। Now, one of the things that I can at this point of time introduce is an important current affair of Prevention of Money Laundering Act. the PMLA. It has been in news for a lot of reasons. Prevention of Money Laundering Act and the provisions of the amendments which have been made to the Prevention of Money Laundering Act have been brought about under certain considerations. ठीक है, तो अब बात यह है कि प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट क्या है. अब it's a good point and you point out, I missed it out. दो डेप्यूटी स्पीकर के ना अपॉइंट या इलेक्ट होने का एक जो बहुत बड़ा कारण, थैंक यू फॉर रिमाइंडिंग मी दैट पॉइंट, डेप्यूटी स्पीकर के ना इलेक्ट होने का एक जो बहुत बड़ा कारण है वो ये है कि एज अ कन्वेंशन ऑफ द पार्लियामेंट मोरारजी देसाई के समय से 1969 से 1979 ऑनवर्ड्स the deputy speaker of the parliament was always supposed to be from the opposition party, kind of a convention of the parliament. ऐसा कोई कॉन्स्टिट्यूशनल नियम या कुछ ऐसा नॉर्म नहीं है, पर एक तरह से एक प्रथा बन गई थी कि स्पीकर की पोजीशन रूलिंग पार्टी को जाती थी और डेप्यूटी स्पीकर की पोजीशन ऑपोजिशन पार्टी को जाती थी. तो कई लोग बोल रहे हैं कि जो आज के समय रूलिंग पार्टी और ऑपोजिशन पार्टी के बीच में जो पूरी तरह से तालमेल टूट चुका है, उसका एक नतीजा है कि अभी तक कोई डेप्यूटी स्पीकर किसी भी तरह से चुनाव करके बाहर नहीं निकाला जा रहा है. तो ये एक आपने अच्छा पॉइंट बनाया, थैंक यू फॉर रिमाइंडिंग मी सो दैट आई कुड एलैबोरेट अपॉन इट. ठीक है, ओके. प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट PMLA. ठीक है, अब इसमें ना जो हमारे पास मतलब इसको पढ़ने के लिए जो रीज़न है वो है कि अभी फ़िलहाल में ही सुप्रीम कोर्ट ने एक अच्छे खासे जजमेंट में कुछ चीज़ें बातें करी हैं प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट को लेके. ठीक है, तो मैं आपको एक एडिटोरियल के माध्यम से इसको थोड़ा सा समझाना चाहूँगा. ये अच्छा खासा इंपॉर्टेंट डेवलपमेंट है. ठीक है, नाउ हियर इज़ अ पॉइंट दैट यू वांट टू मे बी रिमेंबर. Take a look at this. Outcomes in matters of constitutional law disputes depend on the values that the constitutional court choose to emphasize over those it chooses to discount. सुप्रीम कोर्ट का एक डिसीजन आए, डिसीजन का आप नाम लिख लीजिए प्लीज. आई वुड रिक्वेस्ट यू टू take a copy and a pen and just note a set of things about the PMLA. अगर आप if you take a half page note about the PMLA, it can serve you good at the last moment revision of the questions that can come from the PMLA. ठीक है, just if you can take a set of notes upon this. The case that we are referring to is a case decided by the Supreme Court of India and the name of the case is Vijay Madan Lal Chaudhary versus Union of India. Okay, Vijay Madan Lal Chaudhary versus Union of India, or you can also give it the name of the PMLA case. I'll repeat it again. The case name is the Vijay Madan Lal Chaudhary versus Union of India, also known as the PMLA case. ठीक है. All right. Now, the PMLA is an act which was enacted by the Parliament in the year 2002, and it has been amended from time to time. The act has been amended, I think, as recently as 2019 itself. Okay. Now, the point about PMLA is this: the Prevention of Money Laundering Act is specifically enacted in 2002, but it came into force in 2005, right? And the real reason, the intention behind enacting the Prevention of Money Laundering Act was to give a kind of a special focus on crimes which involve extraction of money. and to deal with that extraction of money in an expedited manner. For example, I'll explain to you. Let's say, this is a very simple conceptual thing that you can take a background understanding of and then grasp it very clearly. Let's say, for example, if I sell drugs and I get some cash out of it, okay, then what I am doing is getting money out of selling illegal substance, which is an offense which is punishable under the Indian Penal Code. Or let's say I steal someone's cash from ATM and keep it in my pocket. And the allegation, the charge that would be made against me would be the charge of theft. This is a charge under which I can be prosecuted. Theft. Clear? Now let's say, for example, after I have been charged of theft, an FIR has been filed against me before the police station, and then the criminal law will be set in motion and I will have to be presented before a magistrate within 24 hours if I am arrested, and the things will go on as much as possible. Now, while all this kind of a thing is happening to me in terms of my criminal prosecution, I am protected by the rights mentioned under Part 3 of the Constitution. Part 3 के अंदर जो rights हैं, for example, specifically rights under Article 20, under Article 21 and under Article 22. These are the three freedoms which are given under Article 20, 21 and 22. I have the protection of these rights, which basically means that we have discussed. Article 20 clause 3 बोलता है कि self incrimination नहीं कर सकता है व्यक्ति. Article 21 बोलता है कि life and personal liberty cannot be taken away except by the procedure established by law, and Article 22 states that every person has a right to be produced before magistrate within 24 hours of his arrest. So if a criminal law is being applied against me, at the same time, to not let me be subjected to any brutality by the police or other administrative forces, it is necessary for me to also have the safeguard of the constitutional provisions. Take. So the point that we may want to at this point of time highlight in terms of getting a sense is that the thing that I have committed is something that I will be punished for, but I can't be punished prematurely, or I can't be punished twice, or I can't be punished without the procedure established by law. Clear? So the agency which is prosecuting me, the police, is supposed to take its best steps to get evidence against me, but also it has to make sure that it does not violate any of my rights. Now, in, let's say for example, cases of money laundering, 2002 Act, I take some amount of money from somewhere, I steal money from an ATM, but now what I do is, rather than keeping the hard cash with myself, what I do is I layer the money, right? What does it mean by layering the money? What it means is that I send the money to a tax haven outside India, and in tax haven, the money gets invested into some company, and then that company starts buying stocks in some company which is registered in India, a Bombay Stock Exchange, and that company which is buying stocks in Bombay Stock Exchange, is giving returns to me in some or the other manner. So, agar मान लीजिए I create cash and I start layering it, buying property, making that property a registered office of a company, leasing that registered office and trailing the money 1, 2, 3 layers, then it is a little difficult for the police to catch hold of that money, and for that reception of the money back, which has been made more sophisticated by economic and financial planning, a separate act has to be introduced in addition to the Indian Penal Code, etc., which deals with what you can call offences regarding money, which is known as the what you can call the Prevention of Money Laundering Act. Okay. Now, this is a special act which has been made in addition to the crimes of theft and stealing and burglary which have been alleged against the people. तो अगर कोई चोरी हुई है सिंपल, तो पुलिस उसको निपटा देगी, लेकिन अगर चोरी के बाद उस पैसे को लेयर कर दिया गया है, जिसकी पुलिस के पास that police doesn't have that kind of resources to deal with that sophistication. You have to create a special act and a special agency within that act who has the expertise and resources and a focus to deal with situations only like this. And for this, the Prevention of Money Laundering Act was enacted. And the special agency which is supposed to be acting in the cases of money laundering under the PMLA is the Enforcement Directorate, ED. Okay. Now, since the enactment of PMLA, the PMLA has been amended multiple times. And the recent amendments to the PMLA have created certain provisions which have become subject to certain constitutional controversies. We'll take a look at those provisions. But let me give you a sense of it. The provisions in PMLA say that Enforcement Directorate is not bound by the constitutional safeguards which are applicable over an action of a police. Okay? Since the start, PMLA has been projected as a kind of a special law, a special expedited manner of getting things done, of dealing with sophisticated economic offenders. Okay? And therefore, it was not, the recent amendments to the PMLA suggest that the limitations or the what you can call the responsibilities which are given to the police to not violate certain fundamental features of the Constitution. For example, let's say Article 20 Clause 3, that police, anything that you say to the police cannot be taken as an evidence against yourself. This kind of a fundamental right is not supposed to bind the prosecution or investigation done by the Investment Directorate. मतलब ये मतलब एक्ट कहता है कि इन्फोर्समेंट डायरेक्टोरेट के सामने अगर आपने कुछ कबूल कर दिया तो उसको आपके अगेंस्ट एविडेंस की तरह इस्तेमाल कर लिया जाएगा. ठीक है, तो ये सारी चीज़ें तो थी पीएमएलए में. एक तरह से एनफोर्समेंट डायरेक्टोरेट को एक तरह से एक अलग स्पेशल कैटेगरी ऑफ ऑर्गेनाइजेशन बता रही थी जो पुलिस जैसी नहीं है, और उस पर जो पुलिस के ऊपर सीमाएं लगती हैं संविधान के अंदर वो एनफोर्समेंट डायरेक्टोरेट के ऊपर नहीं लगेंगी. ऐसे अमेंडमेंट्स करके इस लॉ को थोड़ा सा पावरफुल बनाने की कोशिश की गई थी. इन अमेंडमेंट्स को सुप्रीम कोर्ट के सामने चैलेंज कर दिया गया ये कहते हुए कि दिस लॉ इज इन वायलेशन ऑफ आर्टिकल 13 ऑफ द कॉन्स्टिट्यूशन. मतलब आर्टिकल 13 के अंदर सुप्रीम कोर्ट कैन रिव्यू द लॉ बिकॉज इट इज इन वायलेशन ऑफ फंडामेंटल राइट्स 20, 21, 22 एटसेट्रा ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया. तो सुप्रीम कोर्ट के जजमेंट ने कहा है, जो विच इज द करंट अफेयर विच इज डेवलपिंग ओवर हियर, दैट द law which is made by the parliament in this particular matter is not violative of any fundamental right, and the Supreme Court has upheld the fact that the enforcement directorate within the PMLA is a special body which is not limited the same way in which the police is limited by the constitutional provisions. You see the point? This is one point that has been given as a judgment by the Supreme Court, a very important judgment which is forming a part of the current affairs recently. Second thing which was also a contention before the Supreme Court was that the amendments made to the PMLA were done by the route of the money bill under Article 109 and Article 110 of the Constitution of India. The money bill was used as a method to bypass the Rajya Sabha and get it passed only by the Lok Sabha. This also became a subject of challenge to the power of the Speaker of the Lok Sabha to determine a bill as a money bill when it is not falling under the conditions of Article 109 which defines the definition of money bill. तो ये दो चीज़ें थी जिसके बेसिस पे चैलेंज हुआ था सुप्रीम कोर्ट में पीएमएलए, लेकिन सुप्रीम कोर्ट ने दोनों चैलेंजेस को दरकिनार करके जो कॉन्स्टिट्यूशनल वैलिडिटी है उसकी स्थगित मतलब उसकी स्थापित कर दी है. इट इज़ नॉट सेइंग दैट एनी ऑफ दीज इश्यूज आर कॉन्स्टिट्यूशनली गोइंग टू बी अ प्रॉब्लम फॉर द वैलिडिटी ऑफ अ लॉ. ठीक है, दिस इज़ वाई द पीएमएलए हैज़ बीन इन न्यूज़. मे बी आई एम श्योर यू मस्ट हैव टेकन अ लुक एट सम ऑफ दीज एस्पेक्ट्स ऑफ द पीएमएलए. ठीक है, तो मैं आपको ना थोड़ी बहुत चीज़ें अब यहाँ पर धीरे धीरे लिखवाने की कोशिश करूँगा जिससे कि आप इसको थोड़ा समझ सकें. ये वाला जो आर्टिकल है इसमें काफ़ी संक्षेप में बिल्कुल उतना ही दे रखा है जितना आपको किसी एमसीक्यू को सॉल्व करने के लिए यूज़ करना पड़ेगा. जैसे फॉर एग्जाम्पल मैं यहाँ से धीरे धीरे पढ़ना शुरू करता हूँ. द मेजर डेविएशंस इन द पीएमएलए स्कीम ऑल ऑफ विच ऑपरेट टू द डेट्रीमेंट ऑफ द अक्यूज एटसेट्रा, वो ये है कि अब जैसे फॉर एग्जाम्पल जैसे एफआईआर होती है उसी तरह से पीएमएलए के अंदर जो इन्वेस्टिगेशन रिपोर्ट फाइल करती है ईडी उसको कहते हैं ईसीआईआर. ठीक है, तो इसको याद कर लीजिए थोड़ा सा, है ना. आप एक इसमें लिखिए और आप लिखिए मेजर प्रोविजंस ऑफ द पीएमएलए, मेजर प्रोविजंस ऑफ द पीएमएलए। इसको अभी याद कर लेंगे तो तुरंत याद हो जाएगा, इससे एक आधा क्वेश्चन अगर आया तो बन जाएगा आपका, इसको बात के लिए मत छोड़िए। मेजर प्रोविजंस ऑफ द पीएमएलए, ठीक है। इसके आगे लिखिए अंडर कंसिडरेशन ऑफ कॉन्स्टिट्यूशनल वैलिडिटी, मेजर प्रोविजंस ऑफ द पीएमएलए अंडर कंसिडरेशंस ऑफ कॉन्स्टिट्यूशनल वैलिडिटी, ठीक है। एक टाइटल डाल दीजिए और इसके नीचे लिखिए नंबर 1, नॉन सप्लाई ऑफ द ECIR enforcement case information report to the accused / arrested person। मैं ये ना उसी कंटिन्यूएशन में बोल रहा हूं इस चीज को कि जहां पर इन्फोर्समेंट डायरेक्टोरेट को पुलिस से अलग बताया गया है और पुलिस के ऊपर जो लिमिटेशंस हैं संविधान के प्रिंसिपल्स की, वो ईडी को थोड़ा सा उनसे राहत दिलाती है, जैसे कि ईडी अपना काम जल्दी कर ले और प्रॉपरली इंसाफ दिलाते, ठीक है। लेकिन इसी वजह से ये कॉन्स्टिट्यूशनल मतलब वैलिडिटी के लेवल पे चैलेंज हो चुका था, क्योंकि ये बोल रहे थे कि आर्टिकल 13 में जुडिशियल रिव्यू के अंदर सुप्रीम कोर्ट शुड स्ट्राइक दिस नाउ। तो पहला पॉइंट लिख लीजिए, नॉन सप्लाई ऑफ एनफोर्समेंट केस इंफॉर्मेशन रिपोर्ट ECIR टू द अक्यूज्ड / अरेस्टेड पर्सन। Okay, non-supply of the enforcement case information report to the accused / arrested person, ठीक है। ECIR is exactly the same thing as an FIR। अब ECIR के ऊपर क्वेश्चन आ सकता है कि फॉर एग्जाम्पल विच ऑफ द फॉलोइंग एजेंसीज इज रेफर्ड और इज कनेक्टेड टू द टर्म ECIR विच वॉज रिसेंटली इन न्यूज। पहला आ सकता है CBI, दूसरा आ सकता है RBI, तीसरा आ सकता है विजिलेंस ब्यूरो, चौथा आ सकता है एनफोर्समेंट डायरेक्टोरेट। करेक्ट आंसर इज ED। Okay, so just in your mind take note of how MCQs can be created out of this kind of a complicated activity. Okay, right, next point लिखिए, power to make any person state the truth on oath even though it may amount to self incrimination। ठीक है, अब मैंने आपको बताया था कि आर्टिकल 20 क्लॉज 3 के अंदर सेल्फ इनक्रिमिनेशन पर अगर कोई क्वेश्चन आया तो वो यही आएगा कि जो PMLA है वो बोलता है कि अगर मान लीजिए पुलिस किसी व्यक्ति से साइन करा लेती है किसी पेपर पे कि मैंने चोरी करी और मैंने चोरी करके प्रॉपर्टी खरीदी है, तो उसको उसके अगेंस्ट एविडेंस की तरह यूज किया जा सकता है। इट विल नॉट बी सब्जेक्टेड टू आर्टिकल 20 क्लॉज 3 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया। The power to make any person state the truth on oath even though it may amount to self-incrimination। ठीक है, उसके बाद तीसरा लिखिए, राइट डाउन द थर्ड वन, राइट डाउन द थर्ड वन। Once a person is accused of committing the offense of money laundering, the burden of proving that proceeds of the crime are untainted property shall be on the accused। ठीक है, जनरली क्या होता है क्रिमिनल लॉ में कि अगर आप किसी पे एक्यूजेशन लगाते हैं तो जो एक्यूजेशन प्रूव करने का जो भार होता है ना, एक्यूजेशन प्रूव करने की जो रिस्पॉन्सिबिलिटी होती है, जो जिम्मेदारी होती है, वो होती है प्रोसिक्यूटर पे, मतलब वो होती है पुलिस के ऊपर। लेकिन इसमें जो बर्डन ऑफ प्रूफ है कि मतलब आप, जनरल प्रिंसिपल ऑफ क्रिमिनल लॉ इज दैट द पर्सन हु इज गिल्टी is considered innocent unless he is proved guilty। The person who is charged of a particular crime is considered innocent unless he is proved guilty। बट इसमें इसको उल्टा कर दिया गया, इसमें उसी के ऊपर रिस्पॉन्सिबिलिटी दे दी गई अपने आप को इनोसेंट प्रूव करने की। ये भी एक क्वेश्चन था जहां पर कि सुप्रीम कोर्ट के सामने इस चीज को लाया गया था। ठीक है, तीसरा पॉइंट। ठीक है, तो ये जो 3 पॉइंट है ये आप एक तरह से देख सकते हैं जो थोड़ा सा कंट्रोवर्सी के घेरे में आ गए थे और इन पे किसी ना किसी से जोड़ तोड़ कर कोई क्वेश्चन ये लोग बना सकते थे। ठीक है, और इसके बाद जो एक बहुत बड़ा पॉइंट था वो ये था कि जो इसके अंदर अमेंडमेंट्स पास किए गए थे वो अमेंडमेंट्स मनी बिल की तरह निकाल के दिए थे। तो मैं थोड़ा सा बस इसमें यहाँ पर आपको एक रिवीजन के तौर पे जो मनी बिल है उसके बारे में कुछ बता के इस चीज़ को आगे बढ़ाता हूँ, ठीक है। अब जैसे अगर हम देखें तो जो संविधान के अंदर आर्टिकल्स हैं विच इज़ बेसिकली आर्टिकल्स 107 to Article 117. These are articles within the Constitution which deal with what is known as the parliamentary procedure. मतलब प्रोसीजर कि पार्लियामेंट में किस किस तरह की चीज़ें आप किस किस तरह से करा सकते हो। तो जनरली ये 4 चीज़ों की बात करता है, ठीक है। पहली चीज़ की जो ये बात करता है आर्टिकल 107 से लेकर आर्टिकल 117, दैट इज ऑर्डिनरी बिल। अगर कोई सिंपल बिल है तो उसको पास करने का क्या तरीका होता है, ठीक है। ऑर्डिनरी बिल को पास करने का तरीका होता है सिर्फ बहुत सिंपल सा कि एन ऑर्डिनरी बिल कैन बी इंट्रोड्यूस्ड इन बोथ द हाउसेस, दोनों हाउसेस में इंट्रोड्यूस किया जा सकता है ऑर्डिनरी बिल को, राज्यसभा और लोकसभा में। जैसे फॉर एग्जांपल मनी बिल के साथ एक कंडीशन है कि उसे सिर्फ लोकसभा में ही इंट्रोड्यूस किया जा सकता है। फाइनेंशियल बिल के साथ भी एक कंडीशन है कि उसको सिर्फ लोकसभा में ही इंट्रोड्यूस किया जा सकता है। लेकिन जो ऑर्डिनरी बिल होते हैं, ऑर्डिनरी बिल की परिभाषा है कि जो मनी बिल और फाइनेंशियल बिल नहीं है वो ऑर्डिनरी बिल है। ऑर्डिनरी बिल्स अंडर आर्टिकल 107 कैन बी इंट्रोड्यूस्ड इन बोथ द हाउसेस, ओके, एंड दे हैव टू बी पास्ड बाय बोथ द हाउसेस। They have to be passed by both the houses. That's another important aspect. जैसे फॉर एग्जाम्पल मनी बिल राज्यसभा पास करे चाहे ना करे उससे कोई फर्क नहीं पड़ता है। द पावर्स ऑफ द राज्यसभा इन मनी बिल्स आर ओनली recommending powers. So even if it does not, even if it gives recommendations and the recommendations are rejected by the Lok Sabha, then the Rajya Sabha cannot do anything about it. But not the same for ordinary bills. ठीक है। बट एक चीज़ है कि ऑर्डिनरी बिल्स में अगर लोकसभा चाहे तो जॉइंट सिटिंग करा के राज्यसभा की विल को ओवरराइड कर सकती है। लोकसभा कैन ओवरराइड द विल ऑफ द राज्यसभा थ्रू अ जॉइंट सिटिंग, ठीक है। तो ये 3 पॉइंट्स अगर आप ऑर्डिनरी बिल के बारे में लिख देंगे तो आपको थोड़ा सा इसमें एमसीक्यू से डील करने का एक पॉइंट मिल जाएगा। दे कैन बी इंट्रोड्यूस्ड इन बोथ द हाउसेस, दे हैव टू बी पास्ड बाय बोथ द हाउसेस। उसमें कोई एक हाउस को आप बाईपास नहीं कर सकते हैं। लेकिन अगर मान लीजिए आपको लोकसभा को राज्यसभा को बाईपास करना है ऑर्डिनरी बिल के लेवल पे, तो उसको जॉइंट सेटिंग करानी पड़ेगी। जॉइंट सेटिंग का जो आर्टिकल है वो है आर्टिकल 108। और आर्टिकल 108 जॉइंट सेटिंग में क्या होता है कि आपके पास 543 मेंबर होते हैं लोकसभा के और 250 मेंबर होते हैं राज्यसभा के, और आप उन दोनों को मिला के एक ग्रुप कर लेते हो। और अगर आपको इसमें से 2/3 ऑफ प्रेजेंट एंड वोटिंग लेना है तो जाहिर सी बात है कि लोकसभा के पास ज़्यादा लोग हैं, और अगर आप लोकसभा में हावी हो, राज्यसभा में हल्के हो, और राज्यसभा आपका बिल पास नहीं कर रही है, तो आप लोकसभा की मेजॉरिटी की स्ट्रेंथ को लेके राज्यसभा को जॉइंट सिटिंग में माइनॉरिटी बना के अपना बिल पास करा सकते हो जॉइंट सिटिंग में। तो जो एक तरीका है, फॉर एग्जाम्पल इफ यू हैव अ क्वेश्चन इन द प्रीलिम्स पेपर, व्हाट इज वन वे बाय विच the Lok Sabha can override the will of the Rajya Sabha in matters of ordinary legislations? The answer is a joint sitting. Okay, that's the point I want to make you a little focused upon with regard to giving any kind of a answer to the prelims questions in this sense. ठीक है, that's one part. Okay, second part, Article 109 and Article 110 deal with what is known as money bill. ठीक है, तो आर्टिकल 109 में दे रखा है प्रोसीजर ऑफ पासिंग अ मनी बिल, और जिसको कहते हैं स्पेशल प्रोसीजर ऑफ पासिंग अ मनी बिल। इस पर थोड़ा सा एक बार हल्का सा एक बुलेट पॉइंट्स का रिवीजन कर लेते हैं। आप किताब पढ़ के भी रिवीजन करोगे, इससे अच्छा आप बोर्ड देख के रिवीजन कर लो। स्पेशल प्रोसीजर फॉर पासिंग अ मनी बिल, स्पेशल प्रोसीजर फॉर पासिंग अ मनी बिल। ठीक है, मैं आपको बस पॉइंट में लिख के देता हूँ, मैं बोलता जाऊँगा, साथ साथ में आप इसका रिवीजन कर लो, क्योंकि प्रश्न इंपॉर्टेंट है। अगर मनी बिल अगर आपको पास करना है तो किस प्रोसीजर से कर सकते हो। ठीक है, बता देता हूं उसका एक पॉइंट. कैन ओनली बी इंट्रोड्यूस्ड इन लोकसभा. ठीक है, मनी बिल कैन ओनली बी इंट्रोड्यूस्ड इन लोकसभा, मतलब इट कैन नॉट बी इंट्रोड्यूस्ड इन द राज्यसभा. पॉइंट नंबर बी, if it is transmitted to the Rajya Sabha can only give recommendations on the bill. It cannot make amendments to the bill. It can give only recommendations on the bill. ठीक है. C, if the Rajya Sabha does not give recommendations in 14 days of its transmission, then it is deemed that the Rajya Sabha has passed the bill. ये वाली बात है ना, आपको समझ में आ रही है? अगर 14 दिन में उसने अगर अपनी recommendations नहीं दी लोकसभा को वापस, तो ये मान के चला जाएगा कि राज्यसभा ने अपनी recommendations नहीं देनी है, उनको बिल से कोई आपत्ति नहीं है. तो 14 दिन में अगर लोकसभा को बिल वापस नहीं मिलता तो लोकसभा मान के चलती है कि राज्यसभा ने बिल पास कर दिया है. ठीक है. जो recommendations राज्यसभा से जाती हैं लोकसभा में, they are of only persuasive value, मतलब उसकी कोई बाइंडिंग ऑब्लिगेशन नहीं होती है. they are only of a persuasive value, they don't have a binding obligation on this particular regard. get the sense? ठीक है. तो लोकसभा चाहे तो उन रिकमेंडेशंस को एक्सेप्ट कर ले, चाहे उनको छोड़ दे, उसे कोई फर्क नहीं पड़ता. ठीक है. तो ये जो इसमें पार्ट है कि जहां पर 1, 2, 3, 4 में आप लगातार देख रहे हैं कि लोकसभा डायरेक्टली और सिंगल हैंडेडली मनी बिल के लिए रिस्पॉन्सिबल है. राज्यसभा की कोई भी पावर लोकसभा के सामने किसी हाल में टिक नहीं सकती है. ठीक है. सो दिस इज बेसिकली वेयर द पॉइंट अबाउट द मनी बिल is becoming the special procedure which has to be passed by the Lok Sabha without giving any kind of a leeway to the Rajya Sabha. This is Article 109. अगर आप ये 4 पॉइंट याद कर लेंगे तो आपका आर्टिकल 109 में जो भी एस्पेक्ट है वो एक तरह से क्लियर हो जाएगा. ठीक है. द स्पेशल प्रोसीजर फॉर पासिंग ऑफ द मनी बिल. उसके साथ ही हम देख लेते हैं आर्टिकल 110 में व्हाट इज द डेफिनेशन ऑफ मनी बिल. मनी बिल की परिभाषा क्या है? अब मनी बिल की परिभाषा में ना मैं आपको बस एक बहुत सिंपल सा ट्रिक दूंगा जिससे कि आप समझ जाएंगे कि मनी बिल के बारे में क्या बात करते हैं. हाँ, ये जो प्रेसिडेंट का एसेंट का पॉइंट है, मैं भी आगे आऊँगा इस चीज़ पे. प्रेसिडेंट का एसेंट किस चीज़ पे हो सकता है, मनी बिल और फाइनेंशियल बिल, इन सब चीज़ों पे. दैट्स अ गुड पॉइंट रोशन, आई विल कम टू दैट. नाउ व्हाट इज द डेफिनेशन ऑफ मनी बिल. मैं आपको एक सिंपल सा लॉजिक बताता हूँ ये समझने के लिए कि किसी भी बिल को मनी बिल कब कहा जाएगा. अगर आप गौर से देखें तो आर्टिकल 110 जिसमें डेफिनेशन दे रखी है मनी बिल की, और आर्टिकल 117 जिसमें डेफिनेशन दे रखी है फाइनेंशियल बिल की, वो ऑलमोस्ट सिमिलर, मतलब उनकी जो आर्टिकल की शब्दावली है इट्स मोर और लेस सिमिलर. बहुत ज़्यादा डिफरेंस नहीं है उन दोनों आर्टिकल्स के अंदर, है ना. इसमें लिखा हुआ है फॉर द पर्पसेस ऑफ दिस चैप्टर, ये आर्टिकल 110 है, डेफिनेशन ऑफ मनी बिल. For the purposes of this chapter, a bill shall be deemed to be a money bill if it contains provisions dealing with all or any of the following matters. इसका मतलब है कि क्या? मैं आपको बताता हूँ सिंपली मनी बिल होता क्या है. इसमें लोकसभा को इतनी एक्स्ट्राऑर्डिनरी पावर्स दे रखी हैं. अगर आप कोई काम अपने जीवन में सिर्फ पैसे के लिए करते हो, मतलब जैसे मान के चलिए कि आपने कोई नौकरी ढूंढी या आपको कोई मतलब एक प्रोजेक्ट करना है, और आपसे कोई पूछता है कि आप ये प्रोजेक्ट क्यों कर रहे हो, तो आपसे कोई कहता है कि आर यू डूइंग दिस प्रोजेक्ट फॉर फन, इज दिस प्रोजेक्ट एडिंग मीनिंग टू योर लाइफ, इफ दिस सम काइंड ऑफ अ पर्पस बिहाइंड फुलफिलिंग द एम्बिशंस ऑफ दिस प्रोजेक्ट, डज दिस प्रोजेक्ट मेक एनी इमोशनल सेंस टू यू. ठीक है. आप कहते हो, इसका उत्तर मान लीजिए आप देते हो कि मेरे पास इसको करने का कोई मोटिवेशन नहीं है, सिर्फ एक ही मोटिवेशन है, मुझे पैसा कमाना है. ठीक है. यू सी द पॉइंट. सो व्हेन अ गवर्नमेंट, लेट्स से फॉर एग्जांपल, आई विल गिव एन एग्जांपल ऑफ व्हाट अ मनी बिल इज. व्हेन द गवर्नमेंट सेज दैट, लेट्स से it wants to put a excise duty on alcohol. Okay, that's it, put 10% excise duty on alcohol. Now the question that is asked to the government is that why are you putting excise duty? डू यू वॉन्ट टू लेट्स से डेटर द पीपल फ्रॉम कंज्यूमिंग अल्कोहल? क्या आप लोगों के बीच में अल्कोहल को लेके एक वो लाना चाहते हो, मतलब छोड़ दें अल्कोहल, पैसा बहुत महंगा खर्च होता है अल्कोहल वगैरह देने में, तो आप एक सामाजिक बदलाव लाना चाहते हो, ठीक है? या फिर आप मान के चलो कि आप अल्कोहल के प्राइसेस को स्टेबलाइज करना चाहते हो, जिससे उस पर ड्यूटी लगा दी तो कुछ और है, मतलब क्या आपका ऑब्जेक्टिव है? तो अगर सरकार बोलती है देखो भाई मेरा कोई ऑब्जेक्टिव नहीं है एक्साइज ड्यूटी लगाने में, मुझे इस समय कोई इंटरेस्ट नहीं है लोगों की जीवन शैली में परिवर्तन लाने के लिए, आई डोंट हैव एनी इंटरेस्ट इन मेकिंग पीपल बेटर एट दिस पॉइंट, व्हाट आई वांट टू डू इज आई हैव अ फिजिकल डेफिसिट in which I have to put on some money, and I am putting excise duty on alcohol only because I want some money. There is no other motivation behind it. Only when I am looking for something which is basically to draw money out of it. You see the point? So when, for example, the government makes a bill or makes an act only to draw money out of a certain thing, nothing else, or only to give money to someone, nothing else. जैसे फॉर एग्जाम्पल डायरेक्ट बेनिफिट ट्रांसफर्स में या किसी और चीज़ में अब ये पूछा जाता है कि आप किसी व्यक्ति को पैसा देना चाहते हो सब्सिडीज़ के तौर पे, पर आप उसको पैसा क्यों देना चाहते हो? आप चाहते हो कि उससे उसका व्यवहार चेंज हो जाए, वो कंजम्पशन अच्छा कर ले, वो पढ़ाई लिखाई में खर्च करे, तो कोई बोलता है कि देखो वो सब उसका डिसीजन है, आपका डिसीजन नहीं है. इफ़ यू गिव अ पर्सन सम काइंड ऑफ अ सब्सिडी इन कैश, यू जस्ट गिव हिम द मनी, right? Don't try to change his behavior, don't try to make him invest in a particular thing. You give him the money and you trust his decision whatever he wants to do with the money. तो अगर कोई एक्ट ऐसा बनता है जिसमें सरकार कैश लेके लोगों के हाथ में रखना चाहती है और फिर बोलती है कि तुमको जो करना है करो, खर्च करो, we have the faith in you that you will take the right decisions without putting any XYZ conditions कि आप सिर्फ राशन पे खर्च कर सकते हैं या फिर आप सिर्फ मतलब एजुकेशन पे खर्च कर सकते हैं. अगर ये पॉलिसी काम नहीं कर रही है तो आप सामने वाले के हाथ में सिर्फ पैसा रख दो. सो एनी एक्ट विच इज डन बाय द गवर्नमेंट, बाय द यूनियन पार्लियामेंट, in terms of getting only money out of a certain thing and putting only money in the hands of certain people without any corruption, without any ulterior motive कि आप मतलब जैसे कि आपको इसमें से environmental clearance चाहिए या environmental clean चाहिए, climate change चाहिए, ये होगा तो वो भी हो जाएगा, ये सारे confusions के बिना बिल्कुल clearly certainly आपको सिर्फ एक चीज़ से पैसा निकालना है और या फिर किसी और चीज़ में पैसा डालना है. ये सारी बातें बात की है ना. जैसे फॉर एग्जाम्पल अगर किसी ने डीजल व्हीकल्स पे एक ड्यूटी लगा दी कि 15 साल से पुरानी जो गाड़ियां हैं उनको इतना ड्यूटी देनी पड़ेगी, तो आप इसको मनी बिल नहीं कह सकते. हालांकि इसमें पैसे का आदान प्रदान है, देयर इज अ ट्रांजैक्शन ऑफ मनी विच इज हैपनिंग अंडर हियर, बट यू कैन नॉट कॉल दिस अ ट्रांजैक्शन बेस्ड ऑन ओनली ऑन मनी, बिकॉज वॉट यू आर इंटेंडिंग टू डू बाय द यूज ऑफ मनी इज टू चेंज द बिहेवियर ऑफ पीपल, राइट? So just because for example you have exposed people with a diesel vehicle of more than 15 years of age to a particular duty, right? What it will do is it will dissuade people from traveling in that diesel vehicle. So your objective is not to get money. In fact, you would want less and less duty to be collected because that indicates that more people are switching to better combustion engines, okay? But to dissuade them to use a particular thing, you are using money as a tool. Or for example, if you punish someone for smoking and you charge a penalty upon them, or spilling the road, or dirtying the streets, etc. You're not doing it for money, but you are using money as a means to achieve social ends. In a money bill, you are not achieving any social ends. Money is the end in itself. And that is why, for example, under Article 109, okay? Under Article 110, you see, for the purposes of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with any or all of the following matters. ठीक है? Imposition, abolition, remission, alteration or regulation of any tax. ठीक है? मतलब आपने कोई टैक्स लगाया और टैक्स लगाने के पीछे आपका कोई और मोटिवेशन नहीं है, सिर्फ टैक्स लगा के पैसे निकालना है. There's a term only which is written over here. That is the characteristic definition of what is a money bill. You see the point? When a government or a union parliament does anything only for getting money out of it. अब for example अगर हम चलेंगे आर्टिकल 117 में जहाँ पर फाइनेंशियल बिल की डेफिनेशन दे रखी है. Take a look at this. A bill or amendment making provisions the matter specified in subclause A to F of clause 1 of article 10 shall not be introduced or moved except on the recommendation of President, and a bill making such provision shall not be introduced. Now basically what it says is that a bill or an amendment making provisions for any of the matters specified in आर्टिकल 110, तो मतलब इसका कहने का अर्थ है कि जो फाइनेंशियल बिल की जो डेफिनेशन है वो भी वही है जिसकी जो आइटम्स आर्टिकल 110 में दे रखे हैं. मतलब अगर मान लीजिए फाइनेंशियल बिल का मतलब होता है कि अगर आपने किसी एक पर्टिकुलर चीज़ पे ड्यूटी लगाई तो उसमें आपको कुछ पैसे का आदान प्रदान करना है, लेकिन उस ड्यूटी लगाने का जो ऑब्जेक्टिव हो वो पैसे का आदान प्रदान ही करना नहीं है, उसके अलावा भी कुछ आपको करना है, जैसे कि सोशल बिहेवियर करना है, इकोनॉमिक की स्टेबलाइजेशन करना है, कुछ और करना है, तो उस बिल को हम फाइनेंशियल बिल कहेंगे. तो यहाँ पर आप देखिए व्हाट इज रिटन ओवर हियर इज अ बिल और अमेंडमेंट मेकिंग प्रोविजन फॉर एनी ऑफ द मैटर्स, और ऊपर क्या लिखा है, ओनली मैटर्स स्पेसिफाइड इन आर्टिकल 1110 क्लॉज 1 क्लॉज A to F. ठीक है, मैं आपको दोबारा दिखाता हूँ द डिफरेंस बिटवीन अ मनी बिल एंड अ फाइनेंशियल बिल. यहां पर लिखा है आर्टिकल 101 में, फॉर द पर्पसेस ऑफ चैप्टर बिल शैल बी डीम टू बी अ मनी बिल इफ इट कंटेन्स ओनली प्रोविजंस डीलिंग विद ऑल और एनी ऑफ द फॉलोइंग मैटर्स. उसमें लिखा है कंटेन्स प्रोविजंस डीलिंग विद ऑल और एनी ऑफ द फॉलोइंग मैटर्स. ठीक है, you see the point? So this is basically what we find as a difference between a money bill and a financial bill. A financial bill is a bill which may be using money but as a means to an end. A money bill is a bill which is using money as an end in itself. The only thing that it is wanting is to make money transactions out of it, nothing more or nothing less. Okay, you see the point? Now, in addition to this, let's take a look at some of the provisions which have to be given over here. दिस इज आर्टिकल 110 क्लॉज 3. तो आप समझ गए बेसिकली संविधान में जब मनी बिल को दे रखा है तो संविधान मनी बिल के लेवल पे क्या चीज एस्टैब्लिश करना चाहता है. यू सी द पॉइंट, व्हाट इज द गवर्नमेंट ट्राइंग टू क्रिएट एज एन एस्टैब्लिशमेंट इन टर्म्स ऑफ द मनी बिल. And what it wants to establish is that it wants to give the Lok Sabha, the people, the complete power to do whatever they want to make sure that they can do things only for the money of it. Right? राज्यसभा का उसमें इंटरफेरेंस संविधान ने पूरी तरह से हटा रखा है. अब ये डिसाइड करना कि कोई एक बिल मनी बिल है कि नहीं, ये तो खैर हमने देख लिया कि मनी बिल का जो टच स्टोन है वो क्या है ना. इससे आप एक तरह से बिल्कुल प्रॉपरली आप खुद समझ सकते हैं कि ये बिल मनी बिल है कि नहीं है. ठीक है, अब आप समझ लीजिए वो अलग बात है, लेकिन आर्टिकल 110 क्लॉज 3 में दे रखा है दैट इफ एनी क्वेश्चन अराइजेज एज टू वेदर अ बिल इज अ मनी बिल और नॉट, द डिसीजन ऑफ द स्पीकर ऑफ द हाउस ऑफ द पीपल देयर ऑन शैल बी फाइनल. अगर कोई भी प्रश्न ऐसा आता है कि कोई बिल मनी बिल है कि नहीं, तो उसका जो डिसीजन होता है वो लोकसभा की स्पीकर का फाइनल होता है. उसके बीच में ज़्यादा हस्तक्षेप या ज़्यादा लॉजिक नहीं लगाया जा सकता. हालांकि द कॉन्स्टिट्यूशन इज गिवन वेरी क्लियर conditions of a bill to be qualified as a money bill. But if any question arises whether a bill or a money bill is or not, the decision of the Speaker of the House shall be final. Okay, that's one point. Now, in relation to this point also is the question that can the court, a constitutional court, exercise judicial review upon the decision of the Speaker? Can a court exercise judicial review upon the decision of the speaker given under article 110 clause 3? And the answer to that question is yes. Okay, the recent answer to that question has been given in the KS Puttaswamy judgment only. Okay, in the Puttaswamy judgment, which is also known as the Aadhaar judgment, one of the questions which was dealt by the people sitting at the bench, the constitution bench of the Aadhaar Act, it said that it cannot be questioned that the judiciary has the power to review the decision of the speaker. But nonetheless, जब आधार एक्ट को पास किया गया था तो आधार में बेसिकली बिकॉज it was supposed to be, what we are basically saying is that because Aadhaar was supposed to be a kind of an activity which was being done of exchanging some money. For example, what the argument in the Aadhaar Act was, that what Aadhaar will do is it will enable direct benefit transfer to beneficiaries, because you can link your Aadhaar account to your bank account, and identifying unique identification numbers will allow your bank account to be better be managed, and the activities can be directly given out. The what you can call welfare scheme measures, etc., can be directly given out. Okay, so in this case, the Supreme Court said that the Speaker's decision to decide of it as a money bill is fine. We don't want to interfere into it, but we have the power to interfere into it. That is what the Supreme Court said. Okay, but we choose not to interfere into it. The Speaker shall decide whether it is a money bill or not. In the Aadhaar Act, the dissenting judgment was written by the Chief Justice of India, the current Chief Justice of India, D.Y. Chandrachud. He wrote the dissenting judgment in the Aadhaar Act, and he said that the Speaker's decision to pass the Aadhaar bill as a money bill is a fraud on the Constitution of India. Okay, that's the judgment that the Justice Chandrachud basically gave in the Aadhaar judgment. Now, in the PMLA also the same case applied. Prevention of money laundering has some amount of money into it. The Speaker of the Lok Sabha passed the amendment to the PMLA as a money bill, bypassing the Rajya Sabha under Article 109 of the Constitution. Okay. Now, the question which was before the Supreme Court was again the same question, that does the Supreme Court have the power to review the judgment of the Speaker? And the Supreme Court said, yes, we have the power, but we choose not to exercise it. Okay, let the Parliament take its own procedure, etc., etc. Let's not interfere into it. And by and large, Supreme Court said it seems that the decision of the Speaker is correct, and therefore the Supreme Court also did not take consideration of the second ground of appeal which was made to challenge the constitutional validity of the PMLA, that whether the bill which has been passed as a money bill, the amendment to the PMLA, can be challenged on the basis of it not being a money bill and incorrectly identified so by the Speaker. The Supreme Court dismissed this argument and said that this is done by the Speaker, etc., etc. However, the question of what constitutes a money bill and the power of the Speaker with regard to the money bill has now been referred to a 7-judge bench of the Supreme Court. So, in the coming times, what you will see is the constitution of a 7-judge bench of the Supreme Court, which will take the final decision on what are the major powers which are given to the Speaker with regard to money bill, in what cases can the Supreme Court exercise judicial review. These kind of constitutional questions have been referred to a 7-judge constitution bench, and which the current Chief Justice of India, who himself wrote the dissenting judgment in the matter of K.S. Puttaswamy, saying that the passing of the Aadhaar Act as a money bill is a fraud on the Constitution, himself is responsible for creating this constitution bench. So, one can see a lot of fireworks in terms of contestation between the judiciary and the government with regard to the decision-making power upon the money bill. If the government's decision-making power, the union's government Speaker's decision-making power of the money bill is regulated or guidelined by the Supreme Court, it can lead to a closer contestation between the two already disturbed organs of the state in India, which is the state on one hand and the judiciary on the other hand, right? So, this concludes our discussion upon PMLA and the background of what is known as, what you can call the passing of the money bill and the positions of the money bill. Okay. Chale. Now, in relation to this, assent to bills is also an article. So, for example, let's say if I just draw a very simple structure of this, you have under Article 107 ordinary bills, right, which has to be introduced in the Rajya Sabha and have to be passed by the Rajya Sabha. Article 108, you have the provision of joint sitting by which the Rajya Sabha can be bypassed. Article 109, you have what is called the procedure for passing a money bill. Okay, if you can read these articles as a source of revision of your basic content. Okay. Article 110 is the definition of money bill, focusing upon the term only. Definition of money bill. focusing upon the term only. Article 111 deals with the provisions of assent of the President to the bills. Assent of the President. Right. Article 112 deals with annual financial statement, which is the budget. Article 113 deals with demands for grants. Article 114 deals with appropriation bill. Article 115 deals with additional grants, and Article 116 deals with exceptional grants. I'm sure you must have covered in your own sense about how this particular movement happens within the procedure established by the Parliament. So just take a look at Article 111 to finish off this entire portion of revision. When a bill has been passed by the House of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill or that he withholds assent therefrom. You know, for example, the powers of the President or the discretionary powers of the President are most acutely highlighted in Article 111 of the Constitution. This discretionary power of not granting assent to a will is sometimes also known as a pocket veto. Okay, let me, for example, elaborate for you what a pocket veto means. Okay, a pocket veto is basically simply this. What is a pocket veto? It says basically, let's say, for example, if let's say the President has been given a bill which has been passed by the Parliament. Article 111 say that the President must give his assent before the bill can be passed. Now, what the President can do is that upon receiving the bill, let's say if he disagrees personally with the objectives of the bill or with something like that, he can sit upon the bill and not sign it endlessly. By this, what he can do is he can frustrate the purpose of the bill. You see the point? Now, this kind of a situation is what is referred to as pocket veto. Now, in this one specific thing remains, kind of significant, that a pocket veto is not exercised by the aid and advice of the Council of Ministers and the Prime Minister. It is exercised by the President as his own discretion upon a matter, which makes the President in India finally have a say in terms of legislative power. Right? It has happened. For example, Gyani Zail Singh has exercised pocket veto because he has found some legislations made by the Indira Gandhi government to be a little off the track. So what you can do is you can give him the bill to assent, and what he can do is he can sit upon the bill and not sign it, and by not signing it for some time, he can frustrate the objectives of the bill and therefore in a way veto the bill. That is a power given to the President under Article 111 of the Constitution, withholding without any time frame. Okay. Now, with regard to a money bill, provided that the President may, as soon as possible after the presentation to him of a bill for assent, return the bill if it is not a money bill to the Houses with a message requesting that they will reconsider the bill or any specified provisions therefrom, in particular, will consider the desirability of introducing any such amendments as he may recommend in his message, and when a bill is so returned, the Houses shall reconsider the bill accordingly. And if the bill is passed again by the Houses with or without amendment and presented to the President for assent, the President shall not withhold assent therefrom. Very simple, aspect of it. Basically, if a bill goes to the President, he can do three things: give assent, withhold assent, or return the bill for reconsideration. Now, mind you one thing, let's say if a President gets a bill which is passed by both the Houses of the Parliament, and if he withholds, let's say if he gets a what you can call a bill from both the Houses of the Parliament, and if he, let's say, returns the bill for the reconsideration of a Parliament, first of all, he cannot return a money bill. Money bill can only be subjected to two provisions. Either it can be assented to, or it can be withheld in the pocket veto. It is actually possible for the President to withhold a money bill. Do you imagine? The pocket veto of the President applies also to the money bill. Okay. What the President cannot do with the money bill is return it to the Parliament. Okay. But for any other bill other than the money bill, so President has three exclusive choices. If he gives assent, he can't do anything else. If he returns, and when he returns for the reconsideration of the House may reconsider or may not reconsider and give the bill back to him. But upon the return of the bill from the House, the president has to mandatorily give the assent. Neither can he withhold once he returns back the bill, once the House returns back the bill to the president, nor can the president return it back to the House for a kind of again reconsideration. And if he is withholding the bill, then he can sit upon the bill and give assent at a later date. Right? But one thing very important to remember with regard to the multiple choice questions in which this kind of a context can be turned around a little bit is that the president cannot return a money bill, and the president, once returned an ordinary bill, can neither return the ordinary bill again nor withhold the ordinary bill from giving an assent. This is also one addition over here in the Constitution Amendment Act under Article 368. The President shall necessarily give assent to a bill. Under Article 368 for a Constitution Amendment Bill, the President can neither return the bill nor withhold the bill. So, pocket veto does not apply for Article 368 Constitution Amendment Acts. If you can remember this, you can answer all questions with regard to the assent of the President. Okay. Now, I think we are drawing to a close of the session. So, if you have certain questions which I have missed out, you can start pasting them in the chat box. And if you have any more questions, maybe the chat has moved along without me taking a lot of questions. So, if you have some questions, please make sure that you repeat them in the chat box and I can start addressing them, because we are moving towards the final points of the session. Please paste in your questions, lest I move on to the last points that I am trying to discuss. If you have any questions, otherwise I have one or two topics. Okay, you want, okay, fine. Give me a list of things that you want to discuss. If I have the convenience of accessing these things, I can discuss of these things. Okay. So, Kanti says that they want to discuss, Karan says discuss Office of Profit. Okay, okay. Anything else if you want me to discuss, I'll take it up very quickly from the prelims perspective, so that we can cover things which are possibly questions from the prelims examination perspective. Office of Profit is one thing. Anything else that you want me to cover, please put it out in the chat box. I can see it and I can take it up. Okay, Aditya has a question. Article 105 clause 2 and Article 122 seem exactly similar in meaning. Is there any difference between the two? What if an MP complains of the right of freedom of speech and expression to Supreme Court? No, it's not similar. Article 105 clause 2 says that the difference between the two is the difference between substantive and procedural law. Okay, the substantive law of let's say, for example, if a vote has been made by a member of parliament by using a logic which is not scientific, okay, then the Supreme Court or High Court can interfere into the activities of the Parliament, except that it is saved from doing so by the application of Article 105 clause 2. This is a substantive activity of the parliamentary procedure, the parliamentary activity of the reason by which you are voting. In Article 122, what you are saying is that the court cannot interfere in the procedure of the Parliament. So, first of all, Article 105 clause 2 saves a member of Parliament from the court. Article 122 saves the Parliament as a whole and the procedure by which it functions from the court. You see the point? That's one important distinction which in a way clearly identifies the two. यहाँ पर एक member of parliament की अपनी खुद की करने की, जैसे for example let me say this, अगर कोई member of parliament बोलता है सुप्रीम कोर्ट पार्लियामेंट के अंदर कि इस व्यक्ति ने 50,000 करोड़ का घोटाला किया है ना, और अब मान के चलिए कि वो 50,000 करोड़ नहीं है, असल में 10,000 करोड़ है, ठीक है। अब मान के चलिए कि सुप्रीम कोर्ट के पास कोई चला गया डेफेमेशन का केस लेके इसके ऊपर कि आप इस पे डेफेमेशन का केस लाओ, इसने 10,000 को 50,000 करोड़ बैठा है, तो सुप्रीम कोर्ट बोल देगा आर्टिकल 105 तो दिखा के कि इस मेंबर ऑफ पार्लियामेंट की जो पावर है इसके बीच में हस्तक्षेप नहीं कर सकता हूं क्योंकि आर्टिकल 105 क्लॉज 2 के हाथ मेरे हाथ बंधे हुए हैं। तो आपने कुछ अगर बोला है उससे आपको डेफेमेशन नहीं मिल सकता है। आर्टिकल 122 व्हाट आर्टिकल 122 सेज इज दैट, मान के चलिए कि अगर पार्लियामेंट की किसी, जैसे मान लीजिए पार्लियामेंट ने किसी सुप्रीम कोर्ट के जज का इंपीचमेंट किया और मान लीजिए सुप्रीम कोर्ट के जज के इंपीचमेंट में पार्लियामेंट ने प्रॉपरली हर एविडेंस का बहुत ध्यान से बारीकी से फॉरेंसिक एग्जामिनेशन नहीं किया जैसे कोर्ट करते हैं, है ना। अब मान लीजिए सुप्रीम कोर्ट इस चीज पर गुस्सा हो गया कि आपने बिना पूरी एविडेंस लिए सुप्रीम कोर्ट के जज को इंपीच कर दिया। अब इस पोजीशन में अगर सुप्रीम कोर्ट पार्लियामेंट को आके शिक्षा देता है कि तुम्हारा जो फोरेंसिक प्रोसीजर है वो बिल्कुल फ्लॉड है, तो पार्लियामेंट के पास आर्टिकल 122 के अंदर इम्यूनिटी है दैट सुप्रीम कोर्ट पार्लियामेंट को चीज़ों करने की शिक्षा ना दे। मतलब किस तरह से प्रोसीजर, किस मेथड से आप साइंटिफिक एनालिसिस वगैरह करोगे वो सुप्रीम कोर्ट अपने तक ही रखे। पार्लियामेंट को आर्टिकल 122 में दे रखा है कि द सुप्रीम कोर्ट कैन नॉट इंटरफेयर इनटू द एक्टिविटीज ऑफ पार्लियामेंट मियरली ऑन द ग्राउंड दैट योर प्रोसीजर ऑफ डूइंग समथिंग इज इनकरेक्ट। कि आपने बारीकी से एक एक चीज़ नहीं देखी, जैसे हम कोर्ट में देखते हैं आपने ऐसी इंपीचमेंट कर दिया, इस चीज़ में पार्लियामेंट को सुप्रीम कोर्ट की एक्टिविटीज से इम्यूनिटी मिलेगी। दिस इज अ वेरी स्टेबल एंड अ सस्टेनेबल डिस्टिंक्शन बिटवीन द पार्लियामेंट एंड द सुप्रीम कोर्ट इन टर्म्स ऑफ आर्टिकल 105 एंड आर्टिकल 122। ओके, just give me 1 second, I'll get the questions properly on a pad, please. Whatever we can discuss, we'll discuss in the time remaining for us. आपके पास टाइप सी का चार्जर है? Please put in the questions. I would like to collect all the questions and then address them as much as I can. Okay. Right, so I have a bunch of things that I can explain. Okay, Aditya, I think I answered the question. If it feels that it's a good question, but maybe I was able to address some of your concerns here. ठीक है. Okay. No, Sandeep, 10th schedule में president cannot decide the questions on qualifications of members of parliament. It is the speaker who decides it. President decides it under Article 105. Under Article 102. Any kind of a disqualification which is done under Article 102, which is with regard to Article 102, Clause 1, Clause E, which is about the Representation of People's Act. It's a good point. I'll just highlight this. Under disqualifications, let me just give you a sense of this. It's a good point that you've raised. Under disqualification, I'll just make a kind of a diagram to get you a sense of what I'm trying to say. Under disqualification, by the virtue of Article 102, you have disqualification made under Article 102, Clause 1, Clause E, which is Representation of People's Act, 1951. And you have disqualification made under Article 102, Clause 2, which is the 10th schedule. Okay? Do you hear me? Now, under this, the final authority to decide the question under this is the President plus the Speaker. President plus the Election Commission. Okay, the final authority to decide the matter is the President plus the Election Commission. Okay, and in this, the final authority to decide in anti-defection is the Speaker plus what you can call the final authority to decide is Speaker plus the judicial review, which can be exercised by the Supreme Court. This is a way that you can probably chart it out to answer the question, right? ठीक है. I'll deal with a little bit of what is known as the Lok Sabha and Rajya Sabha Secretariat. I think that's a part that was also important in the current affairs recently. Okay, Secretariat of the Parliament, Article 90 of the Constitution. Article 98 of the Constitution deals with, as I mentioned out, the Secretariat of the Parliament. ठीक है, मैं इसमें ना आपको इंपॉर्टेंट पॉइंट्स बता देता हूँ जो कि आपको याद रखने एग्जाम के लिए, जो प्रीलिम्स में क्वेश्चन आ सकते हैं। पहला जो है इसमें वो है कि द आर्टिकल 98 सेज दैट ईच हाउस ऑफ पार्लियामेंट which is the Lok Sabha and Rajya Sabha shall have a separate secretarial staff। मतलब ये बोला गया कि राज्यसभा और लोकसभा के बीच में एक सेक्रेटेरियल स्टाफ नहीं हो सकता, अलग अलग सेक्रेटेरियल स्टाफ होगा। दिस इज गिवन डायरेक्टली इन द कॉन्स्टिट्यूशन इटसेल्फ। ओके, सो सेपरेट सेक्रेटेरियल स्टाफ, this can be a MCQ in the prelims examination। Second, it says that the terms of conditions terms of recruitment and conditions of service terms of recruitment and conditions of service of the secretariat staff is decided by the president, by making rules, ठीक है। इसमें 1955 के रूल्स बने हुए हैं लोकसभा और राज्यसभा सेक्रेटेरिएट को गवर्न करने के लिए प्रेसिडेंट के द्वारा, जिससे कि उनकी जो ऑर्गेनाइजेशंस में उनमें रिक्रूटमेंट किए जाते हैं और उनके जो ऑर्गेनाइजेशंस में ऑफिसेस हैं, जो स्टाफ हैं, जो सेक्रेटरी जनरल, उनके नीचे जॉइंट सेक्रेटरी और उनके नीचे जो पार्लियामेंट का पूरा स्टाफ है, उनकी कंडीशंस ऑफ सर्विसेज को वो किया जाता है, मॉनिटर किया जाता है। ठीक है। थर्ड इज अबाउट व्हाट इज कॉल्ड द क्वेश्चन ऑफ डिस्क्वालिफिकेशन ऑफ एमपी अंडर सेक्शन 8 सबसेक्शन 3। अब इस चीज़ पे ना लोकसभा का सेक्रेटेरिएट इज इन न्यूज़ रिसेंटली, सो यू कैन एक्सपेक्ट वन क्वेश्चन फ्रॉम द लोकसभा सेक्रेटेरिएट इन द न्यूज़, विच इज़ दिस दैट for example, what we can say in this particular matter is that in 8 subsection 3 it is written that the member shall be disqualified, and agar if he is, let's say, violation of the provisions given under section 8 subsection 3 which is 2 years, he shall be disqualified। तो इसमें क्या कि लोकसभा सेक्रेटेरिएट ने जैसे ये हुआ, आपने देखा था कि लोकसभा सेक्रेटेरिएट ने डायरेक्टली डिस्क्वालिफिकेशन का नोटिस निकाल दिया ना। यहाँ से दो स्कूल ऑफ थॉट्स निकल के आ रहे हैं। एक कहता है कि लोकसभा सेक्रेटेरिएट के पास पावर है, power to issue disqualification notification. The Lok Sabha Secretariat has the power to issue a disqualification notification. This is one school of thought which is emerging. Power to issue disqualification notification under the provisions of section 8 subsection 3. This school of thought is also getting the evidence of saying it under the case decided by Lily Thomas versus Union of India 2013. I have already discussed this case with you to some extent. और Lily Thomas versus Union of India में क्या लिखा है कि as soon as a member is disqualified under article 8 subsection 3, he shall be immediately notified as disqualified, which basically means that it is the Lok Sabha Secretariat which will sign the decision of disqualification. एक जो दूसरा thought आ रहा है वो ये कह रहा है, school of thought which says that it is the president under article 103 who shall take the decision of disqualification and not the Lok Sabha Secretariat. So these people are saying that the Lok Sabha Secretariat should have referred the matter to the President and President should have consulted the Election Commission of India and then found a way to disqualify it. Okay, so there's two schools of thought in which the constitutional question of disqualification. तो ये question आ सकता है, for example, MCQ के level पे कि under the Representation of People Act, which of the following bodies have the power to notify the disqualification of a member who is disqualified under the Representation of People's Act. And one of the answers which can be given on the basis of the Lily Thomas judgment is the Lok Sabha Secretariat. तो इसको आप थोड़ा सा इस क्वेश्चन आंसर के हिसाब से अपने आप को आप प्रिपेयर कर सकते हैं, क्योंकि जो डिस्क्वालिफिकेशन का नोटिफिकेशन है वो जारी किया था लोक सभा सेक्रेटेरिएट ने immediately after the person was what you can call imprisoned, sentenced. Okay, and therefore this seems correct that it is the job of the Lok Sabha Secretariat itself to make the disqualification happen. So this kind of a thing is something that you can take a look at. Okay, this is one point I think I should have been clearly made you understand. Okay. Okay, Sandeep. Sir, can President decide on questions as to disqualification of members of the Parliament under the 10th schedule? No. No. The answer is no. The President cannot. Okay, Nisha and Abhijit both have questions from Article 117. One has question from 117 clause 1. One has question from 117 clause 3. So let me take a look at Article 117 over here. Okay, Article 117 clause 1 is a question. Okay, a bill or amendment making provision for any of the matters specified in subclause A to F of clause shall not be introduced or moved except on the recommendations of the President, and a bill making such provision shall not be introduced in the Council of States. इसमें amendment कहाँ लिखा है? आप क्या बोल रहे हैं इसमें amendment के लिए? Where is amendment written in Article 117 clause 1? रिकमेंडेशन लिखा है, अमेंडमेंट कहाँ लिखा है? अच्छा, इसकी बात कर रहे हैं बिल और अमेंडमेंट मेकिंग प्रोविजन. इसका मतलब ये हुआ कि अगर आप कोई एक फाइनेंस बिल है जो आपने पहले पास करा रखा था और उसमें आप दोबारा अमेंडमेंट करा रहे हैं, मतलब उसमें कुछ आप मान लीजिए आपने पहले 50,000 करोड़ का टैक्स लगाया था, अब आप 70,000 करोड़ का टैक्स लगा रहे हैं, तो वो फिगर आपको इनपुट करने के लिए अमेंडमेंट करना पड़ेगा. तो बिल के लिए और अमेंडमेंट के लिए भी सेम प्रोसीजर है. ये लिखा है आर्टिकल 117 क्लॉज 1 में. डज इट मेक सेंस अभिजीत? ओके. Article 117 clause 3. A bill which if enacted and brought into operation would involve expenditure from the consolidated fund of India shall not be passed by either house of parliament unless the president has recommended to that house the consideration of the bill. ठीक है, ये मैं समझा सकता हूँ. देखिए, मैं इसके पीछे का लॉजिक आपको समझाता हूँ. मान के चलिए कि लोकसभा है. ठीक है, imagine that this is the लोकसभा and this is the राज्यसभा. Okay, this is the Lok Sabha and this is the Rajya Sabha. Clear? Now, let's say, for instance, the political party, ध्यान से सुनिएगा इस चीज को, the political party in power has a majority in the Lok Sabha, but does not have a majority in the Rajya Sabha. Now let's say, for example, if it has to pass a bill which is a financial bill, where it has to impose a taxation upon the consumption of cigarettes. Okay, let's say it's a financial bill. Now, because it has a majority in the Lok Sabha, we can see that a financial bill can only be introduced in the Lok Sabha. तो वो क्या करेगा? वो लोक सभा से इंट्रोड्यूस करा के इसको पास करके रख लेगा. Okay, and let's say, for example, within 1 year, the composition of Rajya Sabha will change so that this political party, after 1 year, will attain a majority in the Rajya Sabha. You see the point? So once this political party has attained the majority in the Rajya Sabha, the president, who is the nominal head of the government, will take this money bill and then introduce it into the Rajya Sabha. You see the point? So this kind of a provision has been given under Article 117 Clause 3, which says that a bill cannot be introduced in either house of the parliament without the recommendation of the president. मतलब directly जैसे यहाँ से पास हुआ वो राज्यसभा में नहीं जाएगा. It gives the power to the government of the day to introduce the bill into the Rajya Sabha at a time of its own choosing, and that is why a kind of a nozzle has been introduced to make sure that the president at some point of time has the power to say about when this kind of a bill is moving into the Rajya Sabha. You see the point? अगर तुरंत पास होती लोकसभा से राज्यसभा में चला जाएगा, राज्यसभा कॉम्पोजिशन नहीं है आपके मतलब कैलकुलेशन का, तो बिल हो सकता है कोलैप्स कर जाए. आपने लोकसभा से पास करके बिल रखवा लिया है और अब आप धीरे धीरे वेट करो, राज्यसभा का कॉम्पोजिशन चेंज होगा. जैसे कॉम्पोजिशन चेंज हुआ आपने उसको राज्यसभा में इंट्रोड्यूस करा दिया और अब राज्यसभा में जाके वो पास हो गया क्योंकि अब मेजॉरिटी आपकी है. नाउ लुक एट व्हाट आई एम ट्राइंग टू से एंड देन अगेन रीड आर्टिकल 117 clause 3, all of you. A bill which if enacted and brought into operation would involve expenditure from the consolidated fund of India shall not be passed by either house of parliament unless the president has recommended to that house the consideration of that bill. ठीक है, तो इसमें क्या है ना, प्रेसिडेंट को एक ब्रेक लगाने का मौका दिया है फाइनेंशियल बिल में कि वो डायरेक्टली राज्यसभा नहीं जाएगा, वो सिर्फ तभी जा सकता है राज्यसभा में जब प्रेसिडेंट ने उसको राज्यसभा की कंसिडरेशन के लिए फॉरवर्ड किया होगा, अन्यथा वो राज्यसभा में नहीं जा सकता है. ठीक है, आई होप दिस आंसर्स सम ऑफ योर डाउट्स. निशा, ठीक है. Should I explain the finance bill again? अच्छा, you wanted to discuss, some of you wanted to discuss this part, na? Article 105 of 105 Constitution Amendment Act. Just let me get a sense of it. I saw Charan and I was remembered about it. Okay. Right. So in Article 338B of the Constitution, the clause 9, the following provision shall be inserted, provided that nothing in this clause shall apply for the purposes of clause 3 of Article 342A. In Article 342A of the Constitution, the words socially and educationally backward classes, which shall for the purposes of this Constitution, the words socially and educationally backward classes in the central list, which shall fall for the purposes of the central government, shall be substituted. This is the part. Here. Notwithstanding anything contained in clause 1 and clause 2, every state or union territory shall by law prepare and maintain for its own purposes a list of socially and educationally backward classes, entries in which may be different from the central list. This is a question that a few of you had, right? I looked at the comment by LD Charan and I'm reminded of that. Now see, let's say, take an example to understand what it means to say. It does not mean that the state has the power. Just to be sure about the question or answer to this, it does not mean that the state has the power to enact or notify OBCs under its authority. The power is with the central government. That's sure. This amendment was brought into the Constitution. Let's say, for example, if I am a Chief Minister of Bihar, right? अब सुनिएगा ध्यान से इस चीज़ को ना कि आर्टिकल 105 कॉन्स्टिट्यूशन अमेंडमेंट 2021 का उसने जो 342A में जो अमेंडमेंट किए हैं उसमें क्या स्टेट को पावर मिलती है ओबीसी को नोटिफाई करने के लिए? आंसर है नहीं. मैं आपको समझा देता हूँ क्यों नहीं, उसमें क्या लिखा है. नाउ अब देखिए, मान के चलिए कि अगर लेट्स से if I am the Chief Minister of Bihar and I have promised the people of Bihar, a certain group of Bihar, that I will give them reservations under OBC. ठीक है. But now my power to give them reservations under OBC has been taken away by the union government. जो केंद्रीय पॉलिटिकल पार्टी है वो ओबीसी नोटिफाई करेगी, ठीक है। तो अब जो जिन व्यक्तियों को मैंने प्रॉमिस किया था कि मैं ओबीसी की पावर आपको दूंगा, वो व्यक्ति अब मेरे ऊपर प्रश्न उठाएंगे कि आप किस काम के, राइट। नाउ सिंस द पावर ऑफ मी नोटिफाइंग द ओबीसीज हैज बीन गिवन टू द यूनियन गवर्नमेंट, I still want to create I still want to keep a political, what you can say, currency with myself, जिसमें मैं अपनी एक लिस्ट बना के रखूँगा और उस लिस्ट का काम ये होगा कि मैं अपने लोगों को बता सकता था कि अगर मैं केंद्र में चला जाता हूँ तो मैं तुमको ओबीसी नोटिफाई कर दूंगा। डू यू अंडरस्टैंड सर व्हाट आई एम ट्राइंग टू से? If a chief minister of a state is maintaining his list and he says that this is my official list, I stand by it. If you give me power, I will notify the people in this list as the OBC. Now, it happens to be the case that the power has been taken away from me and has been given to the union. But if you give me power to go in the union, I will notify you as an OBC. You see the point? So, the amendment which was made under Article 342A by the 105th Constitution Amendment Act did not necessarily make changes to the constitutional powers of the state to, notify OBCs, but allowed them to maintain an official list of themselves to talk to their constituencies, right? And ensure them that if I were in power, either that the power from the union comes back to the state, I will notify you as OBC, or you send me to the Lok Sabha and I will notify you as OBC. So, there is a possibility of a political connection that the people can still maintain with their constituencies, even if they have lost the power. This was a demand made by the states. If the government cannot give the OBC status notification back to the state government, at least it should allow the state governments to not completely lose the constituencies of backward classes to the politics of the central government, right? And also it allows them to then find ways to either get the laws from central government back to the state governments or get the politicians from the state governments to the central government. Okay, therefore the answer is that it does not give, the maintaining of a list does not give the power to the state governments to enlist or notify their own OBCs. It is only a sense of political actions that they can take under it. ठीक है, all right. ठीक है. And doctrine of eclipse I can explain. What is doctrine of eclipse? It's the most interesting thing. Think about it very simple and categorically, and you will get it in one instance. Let's say if there is an Article 14 of the Constitution, or actually let's take this. If there is Article 19 of the Constitution which says that freedom of association is a fundamental right. Freedom of association is a fundamental right. ठीक है? Now let's say the state is trying to deal with the problem of gambling associations. ठीक है? Gambling associations. मतलब people have created huge associations in which gamblers come together and play, games which are lottery based, etc., etc. ठीक है? And these people have become so powerful and they have so much money that they are also vouching for saying that give us legal recognition. Gambling should not be against the law, etc., etc. The state wants to, deal with the menace of a gambling association. But the moment that the state tries to dismantle gambling associations, they go to the court under Article 19 and say that the state is interfering with my freedom of, association under fundamental right. Now, of course, you can take the course that state has the provisions under Article 19 clause 4 to restrict the fundamental rights, but the argument थोड़ा लंबा ही चला जाता है. अब let's say for example, if the state हैज़ अ पार्लियामेंट विच इज़ वेरी पावरफुल, एक ही पार्टी का पार्लियामेंट है, एक आत्मता से पार्लियामेंट इस चीज़ को काम कर रहा है कि वो गैमलिंग एसोसिएशन को ख़त्म करना चाहता है। आपने गैमलिंग एसोसिएशन को तोड़ना शुरू किया, गैमलिंग एसोसिएशन ने कोर्ट जाना शुरू किया आर्टिकल 19 के अंदर, ठीक है। अब मान के चलिए कि आपके दिमाग में ये आ गया कि अगर आपको 2 महीने दे दिए जाए, इफ़ यू गेट 2 months, you will finish the problem of gambling associations in India once and for all. For 2 months, you will finish, if you are given a free hand, without any restriction, you will finish the problem of gambling association in India for once and for all. Now, the moment you try to touch gambling association, पुलिस जाती कुछ करती है, आप उनका डी लाइसेंस करते हो, डी रजिस्टर करते हो, तो वो पहुंच जाते हैं सुप्रीम कोर्ट के पास। सुप्रीम कोर्ट फिर आपके ऊपर हाथ पैर मारना शुरू कर देता है। यू आर गेटिंग इरिटेटेड बाय ऑल ऑफ दिस। तो आप क्या करते हो, पार्लियामेंट से एक लॉ पास कराते हो जिससे कि आप आर्टिकल 19 को सस्पेंड कर देते हो, मतलब यू जस्ट रिमूव आर्टिकल 19 ऑफ द कॉन्स्टिट्यूशन। 2 महीने तक आप आर्टिकल 19 को सस्पेंड कर देते हो, तो गैमलिंग एसोसिएशन के पास कोई आर्टिकल नहीं है जिसके बेसिस पे वो आपको सुप्रीम कोर्ट लेके चले जाए। और जैसे ही आपने गैमलिंग एसोसिएशन को अच्छे से निपटा दिया, आप जो सस्पेंडेड आर्टिकल है उसको दोबारा रिस्टोर कर देते हो। दिस इज नोन एज डॉक्ट्रिन ऑफ एक्लिप्स। डॉक्ट्रिन ऑफ एक्लिप्स का मतलब ये होता है कि अगर ये कोई फंडामेंटल लॉ है और अगर ये कोई पॉलिसी है, अगर स्टेट ने कोई पॉलिसी बनाई है और अगर स्टेट की बनाई हुई पॉलिसी इसीलिए इंप्लीमेंट नहीं हो पा रही क्योंकि वो पॉलिसी फंडामेंटल लॉ के विरोध में है और स्टेट बार बार कोर्ट कचहरी के चक्कर में पड़ जाता है, तो इसका मतलब क्या होता है कि जो ये पॉलिसी है ना, इस पे इस फंडामेंटल लॉ का एक एक्लिप्स पड़ रहा है, right? Now what the state can do under doctrine of eclipse is, for some time when it wants to create a policy, it can skip the fundamental law out, and the time that it gets without the fundamental law is a free hand when it can create matters of policy and that bring the fundamental law back. This is known as the legislative activity of removing a law for some time, getting things done and then restoring the law back. Like for example, if land reforms have to be done in India, 1950s, but everyone is going to the court under Article 19, right to property. Under doctrine of eclipse, what can happen is that you can remove the, what you can call, the Article 19 right to property for some time, take 5 months and do all the land reforms. No one can go to the court because the parliament has amended the constitution of removing Article 19 away from the constitution. राइट तो अब आप क्लेम कहाँ से करोगे? आप कहोगे आर्टिकल 19 में हमको फ्रीडम है राइट टू प्रॉपर्टी की, लेकिन पार्लियामेंट ने तो आर्टिकल 19 हटा रखा है, और हटा रखा है जिससे कि आपका जब तक तिया पांचा नहीं हो जाता, टिल द पॉइंट दैट दे हैव टेकन केयर ऑफ यू, दे विल नॉट रिस्टोर आर्टिकल 19, right? And once you have taken care of you, article 19 is returned back, right? So the article 19 is casting an eclipse upon the law. Either you can keep fighting with the Article 19 through a court, or what you can do is, if you have enough power in the parliament, you can create a constitution amendment act, remove Article 19, and once it's done, you can bring Article 19 back. This is what is known as, this kind of an activity, when it is done by the legislature, is known as a doctrine of eclipse. Does it make sense? Do we understand this? Cool. ठीक है, what is another doctrine that is remaining over here? Doctrine of eclipse, doctrine of severability, doctrine of what other doctrine did I say that we'll do? A doctrine of harmonious construction. हाँ ठीक है. A simple one, doctrine of harmonious construction. Basically what it means is this, that let's say you have the union list, या फिर लेट्स से आई विल टेक एन एग्जांपल ऑफ डॉक्ट्रिन ऑफ हार्मोनियस कंस्ट्रक्शन. इसी एग्जांपल से आपको समझ में आ जाएगा कि अब फंडामेंटल राइट्स दे रखी हैं पार्ट 3 ऑफ द कॉन्स्टिट्यूशन में, और डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी DPSP, डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी आर गिवन इन पार्ट 4 of the constitution, right? Now a huge debate which came before the Supreme Court, for example in the Minerva Mills case. The prelims में question ये आ सकता है, in which of the following cases was the doctrine of harmonious construction established to settle the dispute between fundamental rights and directive principles of state policy? In the Minerva Mills case 1980, in which the question that was asked is that among the directive principles and fundamental rights, which of them have been given superiority over by the constitution? अब सुप्रीम कोर्ट बहुत समय तक कह रहा था कि fundamental rights are superior, और directive principle of state policy के लिए state कह रहा था कि these are superior. Now in the Minerva Mills case, the Supreme Court has said that the constitution doesn't envisage any of them to be superior, but the fact that the interaction between directive principles and state policies must happen in the society without any constraint made by the state or the court, and eventually the society will decide which is superior. Okay, so harmonious construction means that you don't interfere in deciding something positively, leave two things as they are. They will have a juggling with them, and eventually sometimes the society will decide the directive principle is superior, sometimes the society will decide the fundamental right is superior. This is known as harmonious construction, that the harmony is constructed by their free floating interaction between the two, and the state or the Supreme Court should not try to hold one into superiority. It's a kind of hands-off approach in terms of making sure that the question of declaring something to be superior than another is written off. A similar doctrine was used by the Supreme Court in deciding matters between the union list and the state list, which is a superior list among the two, and the whole idea was that it should be left off completely. So harmonious construction is basically a judicial doctrine which says that the judiciary or the state should not declare something to be superior and something to be inferior. Superiority or inferiority shall be assumed by the harmony of their interactions with each other. So it basically entails that the superiority of something, the superiority, for example, of executive over the legislature, or judiciary over the executive, or executive over the judiciary, this kind of a language should not be applied. All of them should be left as they are, and the harmony between them will eventually decide what is superior and inferior. At different times, you will construct different superiorities and inferiorities. This is known as the doctrine of harmonious construction. I've explained doctrine of severability in the previous part of the video. You just have to go to the rewind of it and you'll find it somewhere. Okay. Yes, Shubhi, you are correct. Absolutely. It's a brilliant observation that doctrine of eclipse does violate the basic structure of the constitution. Yes, it does. But remember, a basic structure of the constitution was only invented by the 1973 Keshwananda Bharati judgment. Before that, doctrine of eclipse could have been applied because nothing like basic structure existed, and that is where the doctrine of eclipse became a kind of a relevant activity in the parliament, where it could actually move things about to push policy decisions, right? Article 31A, 31B, 31C are examples of doctrine of eclipse in the Constitution of India, where they expel judicial review under certain cases. For example, the 9th schedule. Can amendment in Article 342A be considered a centralizing? Of course, yes. That's a very acute observation. It is a centralizing tendency where the government union has not only taken the responsibility of scheduled caste and scheduled tribes notification to union government के हाथ में थे. OBCs are very indigenous to communities. You see what I mean? अगर एक स्टेट में कोई एक कास्ट अगर जनरल में है तो अगले स्टेट में वो OBC में आ सकती है, right? So OBCs are generally always in all commission reports attributed as best defined by the state in which they exist. So taking away this power from the state and giving it to the center is a little bit sociologically and anthropologically unclear, is a good observation to say that it is an act of centralizing a tendency. Okay. See, citizenship I can't explain in the time that I have. You just have to read the Citizenship Act 1955 के कुछ चीज़ें हैं. That maybe will be enough. If you want to, for example, read citizenship for the prelims examination, I can refer to you in the Durgadas Basu, D.D. Basu book, Shorter Constitution of India. Shorter Constitution of India. You have a chapter, I think it is the third or the fourth chapter on citizenship. Just read that chapter and everything that you will have from the prelims perspective will be given in that chapter. Citizenship Article 5 to 11 and the Citizenship Act 1955. These are given very properly in the D.D. Basu Shorter Constitution of India. It's a book that you get for the preparation of the IAS examination. Okay. Okay, let me just at the brief finale of this discuss another important issue that I've been meaning to make sure that can be becoming a part of the prelims kind of a thing. The case is about the bail which has been given in what is known as the Bilkis Bano case. Right now, this case has become a little bit relevant because of the remission powers which are given under the CRPC, Criminal Procedure Code. So I'll just explain to you the facts about what basically is this happening. I think I'll be able to cover it in 10 minutes, and I feel कि थोड़ा बहुत इस पे prelims के question बन सकते हैं क्योंकि remission जो एक concept है, it is becoming more and more relevant in terms of the prelims paper. Now, see, the idea of remitting or commuting an offence is given as a power to the President and the Governor. We all know that, and I think you've covered that to declare that a sentence cannot be reduced or pardoned is a sovereign power which has been given to the President and the Governor. Clear? But you would be surprised to know that the power of remission is also given to the government, basically to the union government and the state government. Right? The requisite article, the requisite section for describing the power of remission is section 432 of IPC. We'll take a look at section 432 of IPC, and we will take a look at section 433A of IPC. This is something that you may not have heard about. Remission का मतलब होता है किसी का सेंटेंस कम कर देना, और गवर्नर और प्रेसिडेंट के पास तो पावर होती है कॉम्यूटेशन की, रेप्राइव की, रेमिशन की, ये सब आप लोगों ने पढ़ा होगा. पर इसके अलावा गुड कॉन्डक्ट के आधार पे स्टेट गवर्नमेंट और यूनियन गवर्नमेंट के पास भी, मतलब स्टेट काउंसिल ऑफ मिनिस्टर्स और प्राइम मिनिस्टर, चीफ मिनिस्टर और यूनियन काउंसिल ऑफ मिनिस्टर और चीफ प्राइम मिनिस्टर के पास भी पावर होती है किसी के ऑफेंस को रेमिट करने की. And that is given under section 432 of the did I mention IPC? No, it is 432 of the CRPC, the Criminal Procedure Code. Let me just pull it out, the copy of the Criminal Procedure Code, and I can maybe finish up the whole entire thing about the Bilkis Bano case and the Supreme Court judgment upon the matter and the Supreme Court bench which is being formed upon the case. Just give me 1 second, I can get to it. Here, this is an article, a section that is going to be a little bit relevant, I feel, for the Bilkis Bano judgment to understand it, right? You have the power to suspend or remit sentences. ठीक है? इसको एक बार पढ़िए. When any person has been sentenced to punishment for an offence, the appropriate government may at any time without conditions or upon any conditions which the person sentenced accepts, suspend the execution of a sentence or remit the whole or any part of the punishment to which he has been sentenced. You just take a look at this to get a legal clarity as to how it was possible for the government of India and the government of Gujarat to remit sentences of certain offenders who were serving a jail imprisonment under some charges of the Indian Penal Code. Okay? Right, so this is basically the power to suspend or remit a sentence. Okay, this is article 432. Again, let's read it. When any person has been sentenced to punishment for an offence, the appropriate government may at any time without conditions or upon conditions, any conditions which the person sentenced accepts, suspend the execution of a sentence or remit the whole or any part of the punishment to which he has been sentenced. Section 432 is a section under which the government of Gujarat had issued the instructions of the remission of the sentence of what is known as the Bilkis Bano gang rape case. And with the reference to section 432, we will also read section 433A. Take a look at this, section 433A. Please just read this. We'll be able to make some good about some 1 or 2 marks in the prelims just at the point of our departure. Please एक बार पढ़ लीजिए इसको 433A को. Notwithstanding anything contained in section 432, where a sentence for imprisonment of life is imposed on conviction of a person for an offence for which death is one of the punishments provided by law, or where a sentence of death imposed on a person has been commuted under section 433 into one of imprisonment for life, such person shall not be released from prison unless he had served 14 years of imprisonment. इसका कहने का अर्थ ये है कि अब सेक्शन 432 में दे रखा है that the appropriate government, which means that the state government or the union government, whoever has the schedule, let's say for example, if someone is doing economic offences and he has been changed. Now, if that economic offences falls under the subject of the union government, a subject of the union government, the question is decided by the union government of remission, and if it is in the state government, then it is decided by the state subject. ठीक है, तो अब इसमें ये है कि if let's say a person who has been convicted of an offence for which the penalty is a life imprisonment. Life imprisonment is imprisonment until death. जो उम्र कैद की जो सज़ा होती है वो होती है punishment until death. लेकिन अगर किसी व्यक्ति का कॉन्डक्ट अच्छा है तो उस लाइफ इम्प्रिजनमेंट को रेमिट किया जा सकता है, लेकिन वो रेमिशन तभी हो सकता है जब उस व्यक्ति ने 14 साल की इम्प्रिजनमेंट कर ली हो. डू यू अंडरस्टैंड द पॉइंट? इफ अ कोर्ट हैज सेंटेंस्ड मी फॉर अ लाइफ इम्प्रिजनमेंट फॉर एन एक्ट दैट आई हैव डन, देन if I am to apply for remission under section 432, it is necessary that I must have undertaken at least 14 years of imprisonment. इसीलिए कभी कभी what we hear in popular references that उम्र कैद is 14 years, क्योंकि 14 साल के बाद कई बार आप अपने अच्छे कॉन्डक्ट के बेसिस पे अपनी imprisonment unto death को रेमिट करा लेते हो सरकार के द्वारा. The appropriate government, which means the union government or the state government. That is why this kind of a little misunderstanding sometime arises that life imprisonment is imprisonment of 14 years, but no. Life imprisonment is imprisonment of life, but if it is conditioned to section 432 and 433A, then a person's life imprisonment can be cancelled after he has completed 14 years of imprisonment. ठीक है. अब in the Bilkis Bano case, in the Bilkis Bano case, there was a kind of a series of events which happened. For example, the person, I think it was Radhesham Shah, who was the main accused in the Bilkis Bano gang rape case, he had filed a, what you can say, application at the Gujarat High Court for remission under section 432 of the CRPC, and also the Gujarat government had created a remission policy. Okay. The Gujarat government, I'll just give you a set of ways in which you can understand. In May 2022, Radhesham Shah, who was the main accused in the Bilkis Bano gang rape case, he had filed a petition in the Gujarat High Court. It filed a petition in the Gujarat High Court in which what he had said was that under section 432 of CRPC and what is known as the Gujarat remission policy, गुजरात सरकार ने एक अपनी रेमिशन पॉलिसी बनाई थी कि किन किन ग्राउंड्स पे आपको रेमिट किया जा सकता है. तो जैसे फॉर एग्जांपल जो सारे के सारे गुड कॉन्डक्ट्स के ग्राउंड हैं उन पे आपको रेमिट किया जा सकता है. मतलब इफ़ यू आर वेल बिहेव्ड इन द प्रिजन, इफ़ यू आर शोइंग साइंस ऑफ रिफॉर्म्स एटसेट्रा अंडर दिस पॉलिसी, ऑल दोज कंडीशंस वर गिविंग अंडर विच यू कैन लेट्स से what you can do is you can take a kind of a recourse of remission in this sense, right? Now the Gujarat remission policy in 1992, what basically we were taking a look at was that the Gujarat High Court में ये चला गया Radhesham Shah, but the Gujarat High Court said that a remission cannot be granted. Remission cannot be granted. Okay. This was the judgment of the Gujarat High Court. Then this person went to the Supreme Court of India. And Supreme Court in its judgment, in its order, said to the Gujarat government that the application for remission of this person shall be considered. Consider the application of remission. In a way, the petition was filed, a writ petition was filed by him in the Supreme Court of Mandamus, in which the Supreme Court commanded the Gujarat government to consider his application of remission. Okay. And then later on what happened was that by 15th of August 2022, the decision was given by the Gujarat government that this person shall be remitted. Okay. The crime for which he was serving sentence was of rape and murder, for which he was imprisoned for a life imprisonment, into jail until life. Okay. And the imprisonment was, I think, executed in the year 2008. Right. And so 2008 till 2022, he had completed 14 years. I think 15 years, yeah. 15 years he had completed. So he had become eligible under section 432 of section 433A of the CRPC, in which he was filing the petition for remission. 15 years it had completed, right? So these are some facts which maybe you can use in answering some question. अगर कहीं आ जाता है remission के आसपास का कोई question इस चीज़ पे लेके, ठीक है? Now, the next point that is now raised is that some people have petitioned the Supreme Court. Because there is a problem with the order of the Gujarat government. The problem of the Gujarat government order is that the court which sentenced him to imprisonment was a CBI court in Maharashtra. And therefore, the petition which has been made into the Supreme Court by activists say that the Gujarat government does not have a jurisdiction as the appropriate government under section 432 of the CRPC. The appropriate government in this particular case should be the Maharashtra government. What basically had happened was that because of the some application filed by the petitioners in the Bilkis Bano case, they had said that they fear that in the Gujarat High Court or they will not get justice. So they asked for the permission of the High Court and the Supreme Court to transfer the matter out of Gujarat to Maharashtra. So the trial of this person in this gang rape case was conducted in Maharashtra. And the decision of life imprisonment was also given in Maharashtra. So the petition which is now lying before the Supreme Court is basically asking the question whether a CBI court in Maharashtra which has sentenced a person who is residing in Gujarat and the crime was committed in Gujarat, can the Gujarat government have the authority under section 432 of the CRPC to remit a sentence? So this is the kind of a thing that is now at this point before the Supreme Court, where the Supreme Court is trying to create a bench to hear this matter. So इसमें कुछ ना कुछ development आगे होगा, but nonetheless things that you can remember from this particularly and specifically prelims is that the power of remission is not only given to the president and the governor, the power of remission is also given to the government, which is the prime minister and the council of ministers at the union, or the chief minister or the council of ministers at any state. The section of 432 says appropriate government. Okay, so both the union government and the state governments have the power to remit a sentence under section 432. Okay, and the proviso over here is that in case of what you can call sentences which are given for life imprisonment or death penalty, which have been converted to life imprisonment, a person cannot be remitted unless he has completed the 14 years timeline inside the prison. Only after 14 years can he be remitted. And in pursuit of this kind of a remission, activity given under Article 4, under Section 432, governments of various states have made their own remission policies. The Gujarat government has 2 remission policies, which can be asked as questions. Okay, the remission policy, because it was in news, so I'm just laying it out before you. Remission policy of 1992. And remission policy of 2014. These were circulating in the news, and therefore I'm just in a way laying out before you remission policy of 2014. Okay, so ये इस पे क्वेश्चन जैसे ये आ सकता है कि रेमिशन की और रेप्राइव की और जो सारी पावर्स हैं जब आप प्रेसिडेंट की पढ़ रहे होंगे तो उसमें बस आप एक बार ना सीआरपीसी का सेक्शन 432 और सेक्शन 433 ए भी पढ़ लीजिएगा. अ काइंड ऑफ अ क्वेश्चन फ्रॉम द बिल्किस बानो केस कैन बी आस्क्ड इन टर्म्स ऑफ मेकिंग दिस अ लिटिल बिट ऑफ अ हाईलाइट. ओके, ठीक है. एनी लास्ट डिस्कशंस दैट यू वांट मी टू डू इफ इट्स प्रेसिंग? वैसे तो बहुत कुछ है. आई एम नॉट श्योर इफ आई कैन टेक ऑल दीज क्वेश्चंस एट दिस पॉइंट, बट Okay, let me discuss at a final point, office of profit. Okay, I'll just give you a brief about office of profit. I'll give you an understanding as to what it basically means, right? And also the specific points to learn and memorize from the prelims perspective. Office of profit. What is an office of profit? Okay, now basically look at this. Imagine this to be a situation. Let's say you are an IAS officer who's serving in a district, and because of the work that you have done within that district, you become immensely popular in that district. Everyone knows you by name and by face, and you've become very popular as an IAS officer in that district. So popular that you have the confidence that if tomorrow you get elections, if you step into fighting elections, you will be voted as a member of parliament or a member of legislative assembly from that district somewhere or the other. Okay? It's possible, right? If an IAS officer becomes very popular, he becomes a kind of a face of the public administration, has a kind of a vigilantism inside him, he can become very popular. And he also has the possibility of making sure that he can be, kal election karwa lo, main khada ho gaya, main jeet jaunga, that kind of an attitude, right? Now, the reason why an IAS officer who can become popular cannot at the same time when he is an IAS officer become a member of parliament or a member of legislative assembly is because of the disqualification given in article 102 clause 2, 102 clause 1, which is office of profit. Office of profit basically simply states this, that if you are a person holding an office in the executive organ of the state, you cannot hold an office at the same time in a legislative organ of the state. I'll tell you why. Because the concept of separation of powers that is exercised in India and even the concept of parliamentary democracy or parliamentary form of government exercised in India, both of them are structured in such a manner that the legislative organ, the parliament, is supposed to exercise control over the executive organ. Okay? The legislative organ is supposed to exercise control over the executive organ. A very good example of this would be this. Let's, for example, the salary of the Reserve Bank of India governor, RBI governor, is decided by the amendments made to the RBI Act, and the amendments to the RBI Act can be made only by the parliament. Now let's say if you have a very popular Reserve Bank of India governor, okay, and that very popular Reserve Bank of India governor fights an election and becomes an MP and forms a small political party and comes inside the Lok Sabha, right? And then within the Lok Sabha, he introduces an amendment in the Reserve Bank of India Act 1934 that the powers of the RBI governor should be expanded. You see the point? While he is the Reserve Bank of India governor, he becomes very popular and he also becomes a member of parliament from Lok Sabha, and he has 7-8 MPs with himself, and he's made a little bit of a lobby of MPs, and he's pushing a legislation which gives wider powers to the Reserve Bank of India governor, which is himself. You see the point? So this kind of a possibility could have existed, and it's very easy to think, in politics, for example, you see a same person is the president of a party, he's also the chief campaigner, he's also the chief minister, he's also, possibly the most important face of election rallies, etc., etc. So politicians have the ability to occupy multiple role at the same time. It's not necessarily that they're doing a job of one kind of a category itself. Right? They have the ability to wear multiple shoes. President of a political party can also be the prime minister of the country, and he can shuttle between the two and do a good job about it. So it is possible for a Reserve Bank of India governor to also be a member of parliament and shuttle between the two. So it's not unthinkable not to do it. The only reason he cannot do it is Article 102 clause 1 clause A, that anywhere in which a executive of organ of any person who's occupying the executive organ of the state is at the same time also present in the legislative organ of the state, means that the seeker of the accountability and the person who is giving the accountability are both the same, which is a violation of two principles: separation of powers and parliamentary form of government, which means the accountability of the government to the parliament. And this is basically the definition of office of profit. So what it basically simply implies is that if you are holding a position under the executive organ, you cannot, while you're holding a position under the executive organ, become a member of the legislative organ. And I'm telling you, this is not entirely unthinkable. In fact, what is stopping a lot of IAS officers who are in a way populistic and vigilantistic in nature from getting tickets to MLAs and MPs by political parties is Article 102 Clause 1 Clause A, which tells that office of profit, which is an IAS officer, cannot contest into elections. So either you vacate that or you vacate this. You see the point? This is the definition of office of profit, that an executive cannot at the same time become a legislature, because the executive is governed by the legislature. And if you are maintaining yourself at the legislature, drawing some profit out of it or power out of it, if you are sitting in the legislature from which the profit and power is determined, then you're going to make yourself more profitable and more powerful. This is what is known as office of profit. Okay? Does it make sense? Now, let me give you one hitch about it. Under Article 102 Clause 1 Clause A, it is mentioned that a person who's holding office of profit under it is mentioned that a person who's holding office of profit under the what you can call under the government of India or government of state cannot at the same time become a legislature. But the government of Indira Gandhi made an amendment to that particular point, and it said, it introduced, let's say for example, if there's an IAS officer who's very popular in the district, and I am a political party leader, and I watch that IAS officer and I say that agar मैं इसको ticket देता हूँ ये जीत जाएगा कभी ना कभी, right? Now, but the only problem that is coming in my way is Article 102 Clause 1 Clause A. But there is a way in which I can bypass it. The way I can bypass it is that what Article 102 Clause 1 Clause A says is that if the Parliament wants, it can specifically make a law to remove a particular post out of the definition of office of profit. So for example, if there's an IAS officer who's very popular and I know that if I'm given the ticket, he will give me one seat in my political party. What I can do is I can ask the Parliament, which is my political party, to make a law by which the IAS officer of this district can be removed from the definition of office of profit, which means that he can be exempted from the disqualification under Article 102 if the Parliament passes a law by a simple majority to that effect. You see? So eventually, if the Parliament wants that a particular person is getting very popular, etc., and he can be utilized for political gains, then the Parliament can make a law under Article 102 to create an exemption for that particular person. So for example, if an election commissioner gets very popular and he is very well respected, etc., and a political party thinks that as long as he is the election commissioner, he is respected. So the best way to utilize his political popularity is to give him a ticket right now. But he is disqualified under Article 102 because he is holding an office of profit. I can make a law as a Parliament to make an exemption saying that the election commissioner of India will not fall under the definition of under the disqualification of Article 102. And that kind of a power has been given by the Constitution into the Parliament. And this power itself was given to the Parliament by a Constitution Amendment Act made by the Indira Gandhi. It was a 1976 Amendment Act, or I think 1974 Amendment Act, which gave these powers to the Parliament to take one post if it thinks it is politically exploitable, remove it out of the definition of the disqualification of Article 102 Clause 2. Clause 1. Take a look at Article 102 to get a sense of what office of profit is. Okay. Take a look at this. A person shall be disqualified for being chosen as and for being a member of either House of Parliament if he holds any office of profit under the government of India or the government of any state. Okay, so this is something which is clear. But the additional point about it is, more important to hear. Other than an office declared by Parliament by law not to disqualify its holder. इसको आपको समझ रहे हो कि Parliament एक पर्टिकुलर पोस्ट को आर्टिकल 102 क्लॉज 1 क्लॉज ए के डिस्क्वालिफिकेशन से एग्जेम्प्ट करा सकता है. ये प्रीलिम्स में क्वेश्चन आता है इस तरह का, है ना, कि मतलब पार्लियामेंट हैज अ फाइनल अथॉरिटी टू डिसाइड वेदर अ पर्टिकुलर पर्सन कैन बी एग्जेम्प्टेड फ्रॉम द डिस्क्वालिफिकेशन एक्सपोज टू हिम अंडर आर्टिकल व्हाट यू कैन कॉल 102 क्लॉज 1 क्लॉज ए. मेक सेंस टू यू? ओके, Ayush, who finally decides the disqualification as per Representation of People Act 1951? The President. Not even the President, the President in consultation with the Election Commission of India, whose opinion is binding upon the President. So the answer can actually be the Election Commission of India, but it will be constructed, अगर option में आया तो President with the consultation of the Election Commission of India. President plus the Election Commission of India. Okay? All right, I think that's all for today. It's been a very long day for all of us. Thank you for your time and patience. You've been extraordinarily patient and considerate. It only reflects the sincerity that you have for the exam. I'm really, oh, Deepak is here. Awesome. Good to see you, man. Give a shout out if we have met before on the chat. If we have met otherwise in offline online classes, give a shout out. I can remember some names. Deepak, I remember. What is the confusion between LS Secretary and President in that respect? The confusion is whether the Lok Sabha Secretary should have gone to the President directly without having given the order himself. That's the confusion. You see? But the Lok Sabha Secretary does not give any direct, what you can call, power under any of the acts to sign the notification. The explicit powers are given only to the President. So the question is whether the Lok Sabha Secretary should have taken it to the President or he should have had the power to sign it directly. No act, either RPA or the Constitution, gives the power to the Lok Sabha Secretary to make any kind of a explicit order in this particular regard. The power is given only to the President of India under Article 103 explicitly. So that's the confusion. Is the power of the Lok Sabha Secretary implied or implicit under the RPA, as Lily Thomas versus Union of India has observed, or it is not implicit at all? It has to be done by the President directly. Okay? Oh, Raksha, I remember you. Oh, thank you. It's nice to hear all of you guys again. Thank you for attending this session. Vedbani is here. Hi, Vedbani. My friends from Calcutta. Vidyut is here. I'm good. I'm just a little tired. That's it. But I'm happy. Good intellectual stimulation is always very fulfilling. All the best for your examination. I hope and I wish and I pray with all my being that you get what you deserve, and you have worked extremely hard sitting on this session. It is a testament to your sincerity, and my best of my prayers and wishes and my commitments and my dedications are with you on this journey. Thank you for your time and patience today. It's been a wonderful session for me. All right. Be in touch in some way or the other. Okay, last tip for pre. I'll tell you something for pre. Whenever you're looking at a question, okay, the first time you look at a question and the answer that you feel is correct, if you don't know the answer otherwise, mark it out. मतलब जो पहली दिल से आवाज़ आती है ना किसी भी आंसर क्वेश्चन को देख के, अगर आपको नहीं पता सर्टेनिटी से उसका आंसर क्या है, और अगर आपके दिल से आवाज़ आ रही है कि सही होगा पहली बार में, तो इट इज़ मोस्टली द केस इट इज़ करेक्ट. Trust your intuition, and don't make prelims a safe game in which you are trying to calculate too much of, negatives and positive. Try to make more attempts in the examination. Okay, and listen to the intuition. Prelims is not going to be ever for anyone, even if a person is a topper. Even the best of the people who are attempting prelims can't mark too many questions right directly. They have to do an intelligent deduction guesswork kind of a thing, to use all permutations and combinations, take a tip from an option, look at very difficult, very minute evidences which are given in the question as to what the answer can be. So you look at a question once and you may not get the question completely, but come back to that question and look at it again, and you may be able to find cracks in the question in which you can put a foot inside and crack the question. That is the beauty of the prelims examination. It's a very, what you can call a kind of a case solving kind of a paper, in which once you don't understand the question, second time you don't understand the question, you come back to the question again and maybe you find a way to deal with the question one way or the other. Okay, so keep an open mind to not having answers to the questions. It is very clearly possible that you may not know a lot of questions directly once you look at them, but don't take a sentence on those questions at that very point. Just leave it. Return back after this point of time when you've marked the ones you know, and try to find joints in the question which you can use to find the least incorrect answer, and take some risk and trust your intuition. That's, I think, a good way to, maybe go about some of the questions in the prelims. Okay, all right. Sarfaraz is here. Pranali is here. Okay. All right. Thank you so much, all of you. I will see you around. Be in touch, and all the best. Thank you.